You don't get an intro. Nobody gets an intro. It's early and I'm grumpy. No intros for anyone. Take that. Take that. Hey guys. Okay. How the fuck long has Jeff been going? What's he doing up this early? Why is this happening? Let me find this fucking stream if it's even up yet. Michigan versus Ethan Crumbly Miller hearing. What is he even? Why? Oh my God. Here we go. I got a court here. There's nothing happening yet. You know why? Because it's the fucking morning. Why at 8:15? Why do this? Why did anybody do this? Stupid judges. Learn to sleep. I'm going to send out invites. I'm exhausted. Which is my fault because, you know, I have like a show that goes late and all that stuff. Just because it's my fault doesn't mean it's actually my fault. Okay, where are we sending these things? All right, here we go. Here we go. We got this one. For Thursday. This one. For Thursday. I think that's it. I don't know if anybody else wants to join me. Probably not. Everybody's like, ew, gross, cooties. No, it's not the same shirt I wore last night. It's a similar shirt, but the other one was slightly different. Okay, here we go. Getting everything ready. Pop out all these chats. I put everything in the right place. All right, so you know what? A couple friends of mine have posed this question now. I'm still troubled by the sexual assault. I'm still troubled by the fucking sexual assault charge of a corpse. Because, so here's the thing. Wisconsin and effectively every state says it is rape, sexual assault, rape, to engage in sexual activity without consent, and that an unconscious person cannot give consent. So I want to propose something to you. And this is how it was proposed to me. And interestingly, I hadn't thought of it this way. I was thinking of it in more complex ways. Have any of you ever woken up or been woken up by your girlfriend, boyfriend, wife, husband giving you, or have you been receiving oral sex or real sex? If you're a man and your wife or girlfriend or boyfriend, I don't judge, wakes you up with a little bit of a blow job, guess what? Rape. That's rape. It's sexual assault. under the law. No, oral sex is not real sex. We learned. Listen, I thought we answered this question a little while ago. I thought we went ahead and covered this one, nip this one in the bud. You know what I'm saying? And by the way, not yes, it could be. Of course, it could be conceptually that you have engaged in a sexual assault, but it's not could be. It is. It is sexual assault. It's not like it could be. Oh, he liked it. I did. It is. You have violated the law with a felony sexual assault. Your partner cannot consent. And the argument made in regards to someone dying or losing consciousness automatically foreclosing consent, even if it was given, states that not only could you not consent, but even if you had previously consented, it is forfeit at the time of unconsciousness. This is the problem with unclear laws that just don't make logical sense. That doesn't make logical sense. It doesn't follow that people engaged in a relationship where they have either agreed to this and stop. Just stop. Stop it. Stop telling me that people have these ultra complex, forethought out sexual agreements that they have discussed in explicit detail. Now, sure, some people have, but that's not how sex works. It just isn't. And we're deluding ourselves into a liberal hellhole, if that is. Why do you have a jury camera at all? Why do you even have one? You can't use it. Why do you have it? Okay. I mean, I think I found the source of the juror doxing problem. Law and crime. But we have to balance, like, there's an obvious sexual assault. Like, if someone's sleeping in a hotel room and you just walk up and you're like, whoa, and you're just right in the mouth. Obviously, that would be sexual assault. But within a relationship, under the law, it still is. There's no excuse for it. There is no getting around the fact that that is unlawful under the existing definitions. And it's frustrating that we have to excuse it with like, well, maybe we had consent beforehand, worked out in a contractual agreement that was notarized as a beginning and end date. It's just a problem. It's just a problem. I hate it. I'm uncomfortable with laws that have silly application on their face. On their face, there's silly application. And how do we navigate? I don't know how to navigate it, right? Like, I do not know the appropriate change because obviously we don't want people walking around shoving their dicks in the mouths of sleeping homeless people and be like, I consented. Look at them. Those chapped up tetanus lips really wanted it. We don't want that. We don't want that. But anyway, couple notes. It is stimulant day. We're in day 4 of trial. It's only day 3 of me being up early, but I am not up this early. So we're going to stack up Pro Vigil Hello, Provigil. And a shitload of caffeine. And then we have some vitamins. And before anybody is weird about it, yes, I have a Provigil prescription to help with narcolepsy, remaining awake and focused throughout the day. So, and yes, I'm one of the 50,000 Americans diagnosed with narcolepsy with an actual diagnosis. Most people do not have a diagnosis. So, in about an hour, I'll probably perk up. Maybe quicker. We'll see. Okay, here we go. Here we go. We got another invite coming here. Just a second. Let me get this. Okay, so a brief update. Trying to get the brain jogging here. A brief update. If you missed it yesterday, I didn't stream the verdict. I was shitting all over Star Wars as a conceptual franchise from its beginnings. That's what I was doing. On Chris Gore's show, Film Threat, I was graciously invited to attend the trial of Star Wars. Now, I think they were inviting me to the trial of the modern Star Wars trilogies under Disney. But I, of course, took the opportunity to spread the truth that I know you like Star Wars. Heck, I kind of like Star Wars. Doesn't matter. Star Wars is bad. Star Wars has always been bad. The storytelling is bad. Characters, not great. Character development, much worse. The acting is bad. The dialogue is bad. And several other aspects of Star Wars are bad and have always been bad. But it's okay. Like, you have to understand. People get me confused on this. I love bad things. I love crappy movies. It doesn't matter if it's bad. Is it fun? Does it make you happy? Did you enjoy it? I enjoy bad things all the time, right? I love our government, and it is bad. But people get very sensitive about Star Wars because they have these warm, like fuzzy, juvenile feelings. Well, I saw Star Wars when I was 14. It changed my life. It made me want to have a giant extendable thing to shove into people. A lightsaber. That's great. That's good. It doesn't make it a good thing, though. Link. Hold on, sending out one more invite. Oh, please. That's what I was doing. I had previously agreed to do that, and the verdict came back, and it took like 10 minutes to read. I think it came back after about 40 minutes of deliberation, another 15 minutes to get the jury in. But link. But yeah, she's guilty on all 3 counts. This is not a surprise. This is not a surprise at all that she was found guilty on all 3 counts by the jury. First count, intentional homicide in the first degree. Second count, mutilation of a corpse. And third count was sexual assault, post-mortem of a sack of meat. So that's what happened yesterday. So now we move on to phase 2. Now we move on to phase 2 of the trial, which this is a weird facet of Wisconsin law that I don't quite get. I haven't seen anything done this way, but remember, I've never professed to have a vast and varied legal career. So I don't know. Like, this isn't something I've encountered, but I don't know the particular rarity of it. It does not seem common, but because her defense is not guilty by reason of insanity, the first phase of the trial was to determine, were she not insane? Is she guilty of the crimes? They say yes. The next phase is now entirely about, is she insane? If the state cannot prove she is not insane beyond any reasonable doubt, and she's not liable for the criminal acts that she's guilty of, would be thus civilly committed until she is fit to resume or return to society. Again, she should lose this phase handily based on what we've seen being proposed and talked about. Can we get on?
CF 363, State of Wisconsin versus Taylor Schabusiness. State appears by Deputy District Attorney Saunders and District Attorney Lizay.
I know the feed is fuzzy.
Calendar, really for a Dahmer type hearing this morning to address.
Okay, so the
Dr.
first,
O'Donnell, who Mr. Freilich had submitted as
the first hour of this case is it's akin to a Dahmer hearing. They're going to
Thank you, Your Honor.
try
well,
and qualify an expert witness.
Does have Dr. Diane Litton, PhD, as an expert to testify in phase 2 of this trial, the NGI phase. I did confer and consult.
The judge
with
doesn't know
Dr.
how to use a
James T.
microphone
O'Donnell,
here.
Yesterday after court to further talk about his opinions in this matter. I've had a number of discussions with him. I know that he is a pharmacologist who has lots of experience and has testified as an expert in the field of pharmacology in the past. I shared with him some of the concerns that the court had with regards to the 4 points of his trial opinion that was discussed yesterday. The defense had retained him some time ago, and he did testify at a motion hearing, I believe, back in June on legal issues related to the statements and other issues of that sort. After further analysis, after further contemplation and discussion, the defense has decided to not call him in phase 2 of this proceeding based on the comments that court made and some of the concerns that the court shared. We do not believe that it would be helpful at this point in time, and so
You're going to lose him.
We're going to not call him at this phase of the case.
Okay. And I respect that opinion, or that decision rather.
Yeah, because you were going to lose this hearing badly.
I want to indicate that I raised the concerns yesterday because I was very much interested in focusing.
You're not even going to try, though.
This hearing today on areas where I thought some testimony would need to be directed. I wasn't deciding what was going to happen at this hearing. So I just want to make clear, I didn't render a decision. That's why I'm here this morning to listen to testimony. But I respect your decision to not call him, and that is your decision. And
wow.
You have another expert that you're calling, who has already testified in this case as well.
So we're just burn this
for a hearing on that this morning.
1 hour morning, I guess.
Be in for another 45 minutes, so we can't get going. We have a little bit of extra time. But a couple of things.
I'll talk about this in a second.
Share on that,
and what the problems were.
Okay. A couple of things. I was asked by security this morning, Mr. Freilich, about whether your client needed to be in street clothes or whether simply the jail scrubs was fine. Frankly, I think the answer probably is she could have come in jail scrubs because that's the point of the proceeding we're at. On the other hand, I didn't care one way or the other. I'm sure security would have preferred it the other way, but I see that she's here in street clothes. And that's something that you wanted, Mr. Freilich, is that correct?
Yes, Your Honor.
All right, so that's been accomplished, and we'll do it that way. Then when the jury returns, I think all I would do is give them instruction 603. And I don't know if the parties have that in front of you. If you don't, I'll get you a copy of it. But 603.
Judge, get on the mic!
options. The first option is if the first phase was resolved with
Hey, what's
plea
up,
of,
Tina?
guilty or no
Hello to
contest,
Dubai. Love to visit
following,
Dubai.
And then I was to insert the elements. That didn't occur in this case. So the only change I would suggest making to 603 is that the defendant has been found guilty of, and then list the offenses as I've done in these instructions so far, and then indicate we will now proceed with the second phase of the trial. During the second phase, you will be asked to determine whether the defendant is now responsible by reason of mental disease or defect, and then continue to read that instruction. First of all, I saw when I mentioned about whether or not you had it in front of you, you nodded, Mr. Saunders, you have it in front of you.
No, I don't, but I
You do.
reviewed it this morning.
Well, let me make, we can just make 2 copies. I'm assuming you need a copy as well.
I've got it in my binder.
Then I'll make Mr. Saunders a copy.
Thank you, Judge.
On long crime, the judges, you can hear it. How the fuck is that? Let me see. I mean, Court TV should be using the long crime
So I'll start with you,
feed.
Mr. Fairlight, because you have it. You probably looked at it as I've been talking. Any objection to my sending out 603 out in that fashion?
Makes sense, Your Honor.
Mr. Saunders?
No objection.
Okay. So that's what I'll do. And then I guess the only other issue is the order of questioning. I know the burden of proof now shifts to the defense. Generally, the party with the burden of proof goes first, although this is kind of one of those cases where the state generally is perceived as going first.
They're about to recess. I'll shift to
Mr.
it
Saunders,
then.
preference?
No, I agree. I think the defense has the burden, so they would start opening
Their
statement,
witness.
we would respond, and then they would call witnesses.
Mr. Freilich?
That makes sense as well. I believe, in talking to Mr. Lissay, at the end, at closing, then I would have the rebuttal.
Right.
So,
That makes sense. So that's what we'll do. And I'm going to keep you under the same timeframes I had for openings and closings during the guilt phase of the trial. Okay, anything else to take up? I'll go briefly modify that that jury instruction. Anything else to bring up, Mr. Saunders?
I don't know if the court also wants to read the opening statement instruction too after 603. I don't know if it's necessary or not, but
I can. That,
okay.
that is not any objection to that, Mr. Freilich?
no, Your Honor.
Okay, I'll get the opening statement instruction. The proposed jury instruction guide is pretty sparse as to what they suggest we read. So, and frankly, at the end as well, there's 605, but nonetheless, we'll talk about that later. I'll get the opening instruction, the opening statement instruction. I'll read 603 first, then I'll read the opening statement instruction, and we'll go from there. Anything else, Mr. Saunders?
no, thank you.
Mr. Freilich, anything else?
Nothing else. Thank you.
Okay, well, the jury will be in at 9:15, so we have a little bit of time, and we'll be back on the record at 9:15. We're in recess.
Thank you.
All right. So there we go. There we go. They're going to be in recess to the tune of about 30 minutes. You boomered the pinned tweet. So here's what happened. This is a story of a girl who did a murder. And though she had looked so sad in photographs, she absolutely loved him in a bucket. Okay. So this was what is effectively called a Dahmer hearing. This is where there is a proposed expert witness, and they are going to challenge this witness's purpose, qualifications, etc., for the proposed reasoning. Now, they have a mental health professional already, who's already testified in this case and will testify to her saying. I think she testified at the competency hearing, She will now testify in this phase of the case. Okay. But they had another witness. I don't remember his name. They talked about this yesterday, I think. This other witness's purpose was to come in, and you could tell that the defense kind of wanted to ask this guy if she had brain damage from meth use. The problem is this guy hasn't examined her and can't make that determination. But you know who can? Natalie Wisco. Hi.
Hi. It's finally happened. I'm finally here.
Yeah. Welcome, welcome. I'm so glad you're here because
Thank you. I'm so happy to be here.
yeah, I need some help with some of this nonsensory.
Yeah, it's not necessarily intuitive at all. So
yeah, but right as you joined, we have another guest as well. So we'll get him in here. What's up, MLS Law Show? How you doing?
Hey, I'm doing good. Natalie, how are you?
oh, I'm okay. Still a little damp, but I'm awake.
Can I ask you a legal question?
Probably.
Why is Wisconsin so fucked up?
I mean, I'm not a politician, so I don't know. I blame the water for real. Lead poisoning. No, because people, especially with, I don't know if it's a situation where like Wisconsin just has really good open records laws like Florida does. That's one of those things about Florida. I mean, granted, crazy shit happens in Florida, but you hear about it a lot because of the sunshine laws. I mean, I don't know if that's part of the situation, is just that you hear about it more because we let people come into courts. But in general, you know, with crazy cases out of Wisconsin, I've had a lot of people ask me, you know, what the hell's going on in Wisconsin? And man, the only thing I can come up with is lead poisoning. Lead poisoning and alcohol that was a thing in like the 60s and 70s, why there was, you know, at least allegedly supposed to be this increase in serial killers was because of lead poisoning. And early introduction of lead into the body as a child can really impact your decision making and mood regulation. And if you look at southeastern Wisconsin, especially water quality, I mean, it's been like 4 times as worse than Flint, Michigan at different points in the past 30 years. So, I mean, honestly, I think there's something in the water.
That's so sad because they're right on Lake Michigan, you know.
Oh, yeah. No, the water quality is terrible. And lead poisoning is a real thing. That's like, I mean, granted, I'm not a scientist and I might just be speculating, but I have before tried and, you know, to make sense of this. And lead at least would be some type of explanation.
Well, I am a scientist, and I think I agree. It's lead, it's liquor. Well, not liquor, it's beer, and it's also you know, it's Binger. I mean, that's the real problem.
I mean,
honestly.
He's an easy target.
No, he just consumed all the lead. Well, first of all, Natalie, I'm so glad to have you. MLS Law, of course, glad to have you as well. I have a question. What is this damn Two-Face thing that's going on? Like, is this a common way to do this?
So I actually, because I was anticipating this question, looked into a little bit more of the history of it, and I have something in front of me. But so, I mean, it started in the 1800s as part of like a bifurcation with the trial. It went back and forth at different points in times with, you know, how it was actually conducted. But it's one of those things wherein you don't have a constitutional right, and their Supreme Court hasn't really, you know, employed any sort of broad-reaching standards about NGI pleas in general and how the actual procedure needs to be conducted amongst the states. And Wisconsin has just adopted this bifurcated part. It kind of turned bifurcated trial. I mean, the ideal behind it, I think, is, you know, although the burden does shift to the defendant in the responsibility phase, it is a much lighter burden. So I think it was sort of intentionally supposed to, you know, accommodate people who might have more questionable cases. However, you know, interpretation of that and the progression over the years has, you know, become a little bit arbitrary sometimes, I think, with how it's held. But
That's what's the interesting thing about Wisconsin, and that's kind of where my question came from: is what the hell's up with Wisconsin? It's not so much the crazy people; it's the crazy system. This is a burden shifting. It's a separate phase where it sounds like the defense is not able to argue insanity during the case in chief.
Well, you can. It really depends on.
Well, he stroked
relevance.
out like McConnell.
It depends on the relevance.
Oh, you're
of
back
things.
now.
I mean, because theoretically, you don't even need an expert to testify in the responsibility phase of an NGI trial. Depending upon your situation, if it's something that's sort of commonly accepted and understood as far as mental disease or defect, in theory, under the law, you don't even need an expert to testify. You could yourself testify alone, or have people who know you, who have experienced you, having memory lapses, things like that, testify. It's, intentionally designed to be accommodating, but, that doesn't necessarily mean that it works in practice.
Okay, I have to ask both of you. MLS, we had a little comment exchange on some of this stuff. Natalie, have you happened to see the defense attorney in this trial?
I mean, not really, but I've heard you guys criticize him. I haven't seen much about him, but because I've been busy, but I do, I commute, so I frequently have like a stream going on, replay crewing on my way home or on my way to work. And this morning I got to hear all about it.
Yeah, this guy's closing was so abysmally underwhelming. I mean,
well,
I'm
here's
sitting
my
there please go ahead.
No, I was just gonna say, so I didn't watch, after I jumped off of your stream, I was kind of hit and miss for the last day or so, day and a half. So I wasn't watching much of it, but I watched his closing. And just watching a defense's closing, I should, one, understand what happened, know the whole story, and be convinced that this defendant is innocent. If that's all I'm watching. And I didn't get any of that. I don't know what he was talking about. I don't know, is his client innocent? Because he's talking about a lot of stuff that kind of makes her look not innocent. And it was just really bad from that standpoint. It's just like, if you just listen to the closing, you should be convinced she's innocent and know the story. And it was incoherent nonsense.
Well, and yeah, I was going to say, are there even any good facts in this? I don't know even that much about the facts of the case.
I think there are facts sufficient to attack the intent element of intentional homicide. And I think there's facts sufficient to attack the consent element of sexual assault. But I have a conceptual problem with sexual assault of a corpse. I just don't know that sexual assault is the appropriate charge. I know in the law it says it doesn't matter if they're alive or dead. But even disregarding my conceptual problem with this, the way the jury instruction decides sexual assault, it says that the jury is allowed to consider all of the circumstances in determining whether consent was given. It doesn't have to be expressly given or expressly denied. And the only evidence we have about the consent of the deceased is that they were engaging in a BDSM style, sexually gratifying asphyxiation. He dies during the asphyxiation. But she said that when they asked if they were having sex, she said it was getting to there and they're engaged in this sex act, though it was not penetrative at the time. So to me, the only evidence presented on the matter of consent was that he did consent. So then we have to get to the next portion, which is, does his death foreclose any consent that was given? And
what type of, was she able to discern his death immediately as it happened?
Yeah, she knew he was dead.
Yeah, that's what I was going to say, is that's really, the optimal question, I suppose.
And I was listening to your analysis of, when somebody's asleep, or say they pass out and then they come to again.
Morning blowjob was also brought up by my locals last night and today. And I mean, technically,
but I have to push back on that a little bit, because I believe there is such a thing as retrospective consent, right? You can't consent before or during, but retrospectively you can consent. So the morning blowjob, right? You're not awake or conscious enough to consent, and technically it's rape, but the retrospective consent, I think, authorizes it. And since somebody dies, they can't then come back alive and give that consent. So I think that's where your argument might fall apart.
It seems to be unnecessarily splitting hairs. I mean,
Well,
are
I
they
get where
charging
Nick's
him
coming from, though.
with homicide?
No,
It's-
but I get where Nick's coming from, because I don't think the third charge should necessarily stand, except because the third charge is essentially sexual assault, right? And can you sexually assault someone who's dead? I don't think you can, except in the statute they also put in there, it doesn't matter if you're alive or dead, which is a weird way of saying, hey, let's not have sex with dead bodies. It's like you would kind of expect to have a standalone statute for it, but it's
Yeah,
just,
is
it's
there a
just a weird way of,
necrophilia? Is there a
Yeah.
necrophilia statute in
literally what
Wisconsin?
I was looking up while you were talking.
Okay.
I don't think there is, and that's the thing.
but they like added an extra little paragraph to the statute that says it doesn't matter if the person's alive or dead.
Yeah, I think that was intentionally done is for getting rid of like an actual necrophilia law.
Yeah.
Yeah,
So
I have a problem with that because to me, the purpose of a sexual assault crime is considering the ongoing and enduring trauma of the victim. But there isn't an actual victim when they're dead. There isn't a victim who will ever experience any of the trauma.
Mm-hmm.
Now, if you're sexually assaulting someone and caused the death, that's a felony murder.
right.
So that seems to mitigate that issue.
Mm.
So but then I have the question. So a mild pushback on your the retrospective consent, which I agree can be a thing. And I can't remember the passage, but it does say that there are some other factors. I was looking for it. I'll find it in the statute eventually. But in favor of just focusing on my question here, I know that a dead or unconscious person cannot give consent. But is consent that was previously given foreclosed by the unconsciousness? Because the law in Wisconsin seems unclear on the face of the statute that once someone becomes unconscious, any consent that was given is revoked. So do you know anything about that idea? Like, I guess you give someone a roofie.
Like how
doesn't
often
kick
does the
in.
consent need to be re-upped, right?
Right. Does it ever? Does it go away?
That's a super great thought exercise. I don't.
I think I put in a comment that the woman has to continuously scream yes, yes, yes during the entire session, and I'm cool with that.
I mean, as an issue of a thought exercise, I don't think it's anything that would, theoretically need to even go to a jury. That's such a gray area, as I would think, if that specific situation ever actually happened, I think that would be, different. In this case, what I really see is just bad charging decisions. That's all it is you don't have to hit them with every single thing that you can possibly charge them with. The only reason you do that is either because you think you have a bad case on the big one, on the homicide, or, you have some personal vendetta or reason to do it. In my opinion, if I was charging the case, you don't charge the sexual assault, but you use that as an extremely aggravating factor as far as sentencing goes. It's because that's detractive. You don't need, if you're looking at trying to convict her on something that's going to put her away for life, if you have a good case, you can put your eggs in that basket.
Right, because she's going to get concurrent sentencing if they get both, right?
Mm.
I can't imagine it would be consecutive sentencing on the single. I mean, it's multiple crimes, but it'd be a single course of action that's going on.
Doesn't
here.
Wisconsin have consecutive sentencing though?
We do. I mean, and you can theoretically have a consecutive sentence on it. If you're looking at, just the specific facts of the case, I wouldn't think that it would justify a consecutive sentence because it's all part of the same transaction. But that, again, is just duplicative charging. Is why do you need to charge somebody with every single thing? All you do is elongate a trial and, confuse issues potentially if you're a prosecutor. If I was the prosecutor, no, we don't even give them a chance to argue that. Is because that takes away from the strength of everything else.
And
Okay,
here's the
so-
problem with that, though, is you say bad charging decision. The only way you can combat that is by having either a good judge or an informed, educated jury.
Mm.
And it seems like we're lacking perhaps both in Wisconsin these days.
It really depends, and it also depends upon, you know, realistically just where you are. As far as the demographics of Wisconsin go, is it something that in the, you know, northern counties outside of populated areas, you have a very slim pickings with people. A lot of people are industrial and not necessarily prone to tons of nuance. A lot of people are straightforward, and, you know, that also gets down to an issue, I think, with it is if you're making a nuanced argument and your goal is to find, you know, to imprison this woman for killing somebody. I know personally, I would just not bury the lead, and, you know, we just go after the big one.
So here's the section on consent of the unconscious. Consent, as used in this section, means words or overt actions by a person who is competent to give informed consent, indicating a freely given agreement to have sexual intercourse or sexual contact. Consent is not an issue in the alleged violations of sub 2C, CM, D, G, H, and I. The following persons are presumed incapable of consent, but the presumption may be rebutted by competent evidence subject to the provisions of section 972.112. A person suffering from a mental illness or defect which impairs capacity to appraise personal conduct, or a person who is unconscious or for any other reason is physically unable to communicate unwillingness to act.
So it sounds like that could be rebutted if the person is unconscious. There's grounds to rebut that.
Right. It can be. It's a presumption. The presumption may be rebutted by competent evidence, which we would go ahead and just say that's probably going to apply to like a marital situation where the consent is that retrospective consent, I guess. But I still am curious about the foreclosure of consent at the time of unconsciousness, because that's an interesting question. But onto a different issue, and this is for Natalie, being an expert in Wisconsin criminal law. Is there not, or how do lesser includeds work here? Because to me, I think the more appropriate charge than intentional homicide, or the more appropriate conviction, is reckless homicide in the first degree. To me, that's where I think the evidence falls, but I didn't see any argument for it. And I seem to remember in Kyle's case that lesser includeds had to be consented to by the defendant. So is that something that's raised by a motion? Is that brought by the prosecution? How does that actually function?
It depends upon the circumstances. Is, you know, I don't think that it was necessarily that we consented to it. It just had been brought up for so long that we were kind of just accepting of it happening at the time, is
Sure.
because we knew they were going to. Is, you know, there has to be a motion generally for lesser includeds to be introduced to the jury. Somebody has to want it. I mean, if the other side opposes it, you know, the judge can make a judgment call decision, but one side can ask it and the other one doesn't. It just depends upon, you know, strategy.
So either side can raise a lesser included offense to be.
You have to specifically request it, though. That's the thing, is it's not just
Right.
automatically included as part of it.
Okay, so to me, then that goes along with my theory of this defense attorney, for whatever, and he may have good reasons because he was brought in, you know, later into the case as her other attorney after she elbowed him in the face in court, ceased representation. But he just seems to have missed out on doing some critical work. One, tracking down the witness. Their only fact witness was
That
not
was bad.
And then I was very surprised he did not ask the judge for at least to have the state provide an offer of proof as to his inability to make it into court, or to enforce the subpoena. That was very weird. Like, hey, judge, okay, so the only people who have ever talked to this are the state, and when we tried, we're never able to get it. So, but the state says that he can't come in. We've tried to contact him to see if that's true, but the only person who's ever talked to him is him or his family's estate. No one will talk to us, but you know what? We'll just accept that. and him saying, him not saying, can we get enforcement of the subpoena, or can we at least get in writing the reason that he's medically incapable of coming in? That was baffling to me.
From what you're telling me, it sounds baffling to me as well. It doesn't sound like there's a legitimate reason for that. I mean, I always kind of like to hope there's a legitimate reason for something not happening, but that's also just me being super, like, you know, not cynical at this moment.
I have
a weird one.
Idea. I actually ran into this on one of my trials last month, where I had a witness that the first time I talked to them, or I hadn't talked to them, I wasn't sure what they were going to say. And I wasn't sure if I was going to call them, because you don't call a witness, you don't ask a question you don't already know the answer to.
Right.
And so I was like, all right, well, we have a subpoena. This person's not here. The question is do we continue this for another day to try to get this person here? Is it going to be worth it at all? Finally got this person on the phone, asked a few questions, and I was like, nope, not going to call this person, because at the end of the day, it's going to be worse off.
Right.
And so I just forewent the appearance of that witness and moved on with my case. And it could have been one of those where, say the state talked to them and said, yeah, we've got him, but you know, he's not going to say what you want him to say. And assuming you have a decent working relationship or whatever, somehow you got the information out as to what this person's going to testify to. Or the state says, all right, yeah, if we track him down, you can ask him this and that, but I'm also going to ask him these questions, and those could be really bad for you. But for whatever reason, you make a judgment call and decide that you're not going to try to enforce this. That could be a legitimate reason to do that as well.
A trial I just had, I had the same thing. Is, you know, I thought I needed a witness for one thing. It actually asked the state to stipulate to it, so we wouldn't have to call her in for that. But then the first witness's testimony ended up, well, I mean, and she was lying. But I didn't want to
They always lie.
even legitimize her lies by calling this person on to have the discussion.
That was my exact situation. I didn't want this witness to legitimize the lies from the defendant in that case. It was a civil matter. That's what I didn't want.
Yeah. And so, I mean, there are things like that. And there's always the opportunity that, you know, they had somebody listed as a witness on their witness list because they thought they might need them, but they didn't know if they actually would or not. And then how trials shook out, they ended up needing them, and they realized, shit, I wasn't prepared, and I don't actually have this person ready to go. I mean, that seems more like the likely scenario to me.
Yeah, this one, I mean, I don't know. What he represented in court was that he never had any opportunity to speak to him. His investigator was never able to make contact. The only person who was able to speak to him was the state at the time of the arrest. And then the complicating factor of this whole thing seems to be that the defense's theory that they brought up in closing was that Taylor Schabusiness didn't actually do this because she wasn't actually present, even though she described everything that happened, including telling them where they would find various parts and things that were used. She didn't do it, but rather this guy did it, was the implication, because it was his van that she used. And it was a dumb theory, but then
if that's going to be your theory, though, you got to get that on opening. It's commit to a theory, even if it's a dumb theory.
Yeah, you should do it on opening. But then, I mean, to me, like, you should ask questions of that witness that would let you bring those, or at least point to those facts in close.
That was interesting because I watched the first part of the trial, a lot of it, and a lot of the questions to the officers and to the mom and to the mom's boyfriend were all centered around the driveway, like who was parked where, and all this stuff, and ownership. And I didn't know what he was getting at with that. We were suspecting that he had something had to do with the way the vehicles were parked or the vehicles that were used or something, but that wasn't clear from his opening that was his angle. So his opening and his closing were bad.
Yeah, clarity doesn't seem to be his strong suit. And that ended up being his only fact witness. It just, his case, as it has progressed, has really reeked of a lack of preparation. Now, again, he comes into the case late. He doesn't get all the groundwork laid, maybe. So maybe there's a little bit of apologetics for that. But I don't know.
No,
I've not
that doesn't mean you can't try.
Right. It seems like you should be trying. He seems to really have dropped the ball on that.
Well,
I disagree with that tactic entirely. It was a nonsense proposition to say that, well, she was kind of foggy and confused. She didn't know where. His theory was she wasn't actually aware of where she was because of the drugs, and she was relaying all this stuff, but she didn't actually know, and no one saw her there, including the mom when she came downstairs in the basement. So she must not have been there. A ludicrous assertion based on the fact that there's no evidence that has happened. His argument was essentially the state didn't prove she was there, despite her interview stating openly that she was there and did everything. I don't know. I would never have taken that approach.
Well, I think that's just like deficiencies in storytelling. And that again goes into preparation, like you're talking about, everybody knows, and I'm sure I've done it on stream before, where you start telling a story and you weren't prepared to tell a story. So you tell it in a very tangential, random way. That's not how you do a trial, though.
Right.
Even if you don't want to script everything out, you need to have some type of outline. Everything in a trial, at least what I try and do, is relate to a hook. That's something that, learned with appellate arguments, oral arguments, things like that, and also writing briefs, is everything has to be, relevant to this overall hook and why we care about the case. And there's a lot that can be said of having a bad case, but anchoring it in something that people are comfortable with. It's a matter of presentation and storytelling. And, that does necessitate a certain amount of preconception if you're going to do it effectively.
Yeah. And his storytelling was terrible, as MLS brought up earlier. Wait, is your first name David?
Yes.
Okay. I thought so.
Should I put that in the
No.
banner as seen
No,
on
I will-
Ricada MLS?
No, I got it now. As David, I just feel weird calling you MLS. As David mentioned, his entire closing was there was no story, there's no plot, there's nothing to follow, there's no narrative hook at all, and he's just kind of bumbling through with this. Well, there's a lot to think about here, guys. And then I don't have the biggest problem with there being a lot to think about. He doesn't point to a single thing that they should think about. And it's like, that's your job. That's your one job on close.
Did he go through the instructions, at least the jury instructions?
Not
In
really.
the closing?
You can't. You have to. That's the thing. I use that as a prop. It's so awkward standing there talking to people.
He definitely read from his notes. He was literally looking
no,
down
you
and
can't
reading
do
from his
that.
notes at the lectern.
Yeah, and I agree. Going through jury instructions, first of all, gives you the elements of each crime, and that is an outline to say, I need to attack this and this and this and this and this.
Exactly.
Yeah. Speaking of attacking this, I want to bring on another guest, and this is Charlie. How you doing, Charlie?
Hi guys, how's it going? I'm doing very well. Is my mic okay? I don't know. Last time I was on...
You sound fine.
Okay,
Sound fine. Welcome. Charlie is an attorney in the Netherlands, but I believe you've been watching this trial pretty intently. Is that accurate?
Pretty much. I've seen more than you, so yeah.
Wow, that's, you know what?
Copy on that.
I'm gonna throw you off this. Stream. Okay, so Charlie, what was your observation of the trial so far? Anything you liked, didn't like, noticed, hasn't been brought up? Have I made terrible legal arguments? I mean, that happens.
No, I'm not an expert on American law, so first we'll have that. But the defense lawyer is the worst defense I've seen in any case in America and the Netherlands.
It's not the worst I've seen, but it's pretty bad.
I've only seen like the internet big cases, so
Yeah, it's I agree. It's been pretty bad.
Well, and that just makes me want to know the behind the scene things about the interpersonal dynamics between the two of them, because
yeah,
I mean, that is the most likely situation that, as an attorney, you see is one of the really hard things to do is when you really hate a client and still fighting for them adequately.
Yeah.
It's hard to do that when you've got somebody who, I mean, regardless of whether they're guilty or not, that you just think is, rude or is cruel to you, I mean, it's hard to do. And that is, something that professionally you have to learn how to reconcile, and that, public defenders know better than anybody else that, sometimes you have to represent somebody you don't like to. But, matter of personality, you have to go into every single case thinking that this is the case that matters. This is because if it doesn't matter for this case, then it doesn't matter for any other case.
But
Right.
it is your job.
Yeah,
It is
it's your job.
That's
Literally, it's your job.
Yeah.
And if you can't get yourself to believe it, then you can't sell it. That's what you spend the week or two before you try a bad case, is you have to talk up the arguments that you're making to yourself to make you believe them before you can deliver them to somebody else. It's you go around the office and you're like, how does this sound? Like, do I look like I mean it when I'm saying this?
I see a lovely comment in the YouTube chat from Sue. She says Nick thinks too much like a criminal defense attorney.
And that's exactly my point. I was trying
Yeah.
to tell you last night. That's exactly what I said to him just on text. It's and I also explained this to my hubby at home. It's because from a legal perspective, so let's get the Jeffrey Dahmer example. From a legal perspective, a burning cross or whatever, Church of Satan, this stuff
Oh yeah, these were
definitely
the.
cannot come in. The search terms on Taylor Schabusiness phone.
Okay, Natalie, are you familiar with that aspect of the case?
No.
Okay, so they brought in a computer or like a cell phone data expert to review her data, and they introduced several search terms into evidence from it. She searched for Jeffrey Dahmer.
It's Wisconsin. That's not weird.
That's what I said. And the
Literally,
state
it's
argued,
not weird at all.
The state argued that it was relevant and went to intent. They also tried to introduce, the judge did reject that she had searched for the Satanic Bible and a burning pentagram.
It has nothing to do with anything either.
Thank you.
Have you seen
Thank
my
you.
search history? Doing the
Well, I said in Locust Chat, I've also searched for Jeffrey Dahmer, haven't we? There's
My
But-
search history includes Jeffrey Dahmer sexy walking into court
Yeah, well,
because that's what she searched for.
exactly.
I was
you
curious.
think
what did
Google
you
would have fixed
find?
it? You think Google would have fixed it by now?
Honestly, the sexy walking into court thing just sounds like it was porn for her.
Yeah.
Could've
What's-
been.
No, but
and
If you're
that's-
saying
the
it's
things-
sexy
the things
walking
why-
into court, yeah, that's
That's why I said it would be more admissible. I don't know if that's the right word, but because of the timing of it, because it was like not 9 days prior to them hanging out together, doing all the drugs the first, and then the next day she killed him and decapitated him. But they
Yeah,
hadn't had
that is-
sex. They hadn't had
that's
sex
part of
until
the,
August. No, but I mean, I don't agree. I'm just saying.
Right. No, I'm saying that's part of that was
Being
part of the
deficit-
state's argument.
Yeah.
Yeah.
So
Yeah,
and that she in her interview she said, well, I knew I was going to choke him anyway, and I started with the head that I knew that was coming off, and that came off first. I didn't even take it, and Jeffrey Dahmer took as souvenirs the skulls and genitals, both, balls and
Did she say that? That Jeffrey
What?
Dahmer took the heads and the genitals?
no, I looked
or-
it up.
Okay,
it up.
yeah.
Dude,
See, now if
See,
she
I live in Wisconsin, and this Jeffrey Dahmer thing isn't a big deal. Like, it is a joke here. In law school, I had a bar trivia. There were like 4 of us who would always go, and we were always Jeffrey Dahmer's custom blinds and lampshades. Like, that's what
People
our
are sick.
team name was every single time we went. Like,
Right
it's
across
like
from-
here.
Ed Gein's drapery.
Yes.
Wait, wasn't Ed Gein in Wisconsin too?
No, yeah, Gein. That's the other one. I meant Ed Gein's custom
Yeah.
dry blinds and lampshades. Yeah, no, that's the thing, is like we just embrace it here.
Right.
Legitimately. It's
So I-
just
And
it's
has
the
your
point
law
where
school
it's funny.
professor murdered anyone to your knowledge?
Well, this is one of the arguments in chat. It's more like they made a comparison to just because you look up Osama bin Laden doesn't mean that you fly planes into buildings or whatever. And then someone said, yeah, but if you look up Osama bin Laden, then you take
Definitely
flying
not.
lessons.
Sorry.
Yeah, I've got a friend who legitimately like has a Twitter, the one that I tagged you in, David, the Jodi Arias meme. My friend runs that account, and I mean, he has made like thousands of Jeffrey Dahmer and Ed Gein memes. I imagine he sits there searching those pictures. Like, it's just something we do here.
I made 3 or 4 Jeffrey Dahmer memes out of my neighbors, for example. They haven't been heard from again. I don't know what happened.
I was going to say, is there an end to that? No, but that's the problem, is that you have these mundane. So first of all, just the idea that you can have mundane everyday activities used against you is so infuriating,
right?
To me.
Yeah,
and,
I mean, go ahead. Sorry.
No, I was just saying that I thought this judge was making good calls on several other things until I heard that, you know, a Jeffrey Dahmer meme was going to be allowed in as evidence. And I'm like, okay, so now we're just going downhill even further.
Yeah, that one really did bother me. I don't think, unfortunately, I don't think it rises to abuse of discretion. So I don't think you're really
not appealable.
Yeah, I don't think you're going to get there. But it was just frustrating. Now, and I stated this before, but I want to reiterate, if the state had some specific thing linking the Jeffrey Dahmer searches to the actual intent, then I could say, sure, now they become more probative than prejudicial. If she had said, you know, I did it like Dahmer in her interview or something like that, or if she had said, as Charlie brought up, he tended to keep the head and the genitals as trophies. If she had said, I knew he did that, so that's why I went for these things, then I think they become relevant. But absent that actual evidence being produced, I still have a problem with the admission of that evidence. But by and large, I do think this judge has run a pretty fair courtroom outside of that decision.
Every single objection was overruled, though.
Okay. Whoa, hold on. Here we go.
Is there anything that we need to take up before we have a new jury?
I might bring this volume down just
briefly,
a hair.
That's okay. Sorry.
He kind of looks like Phil Dunn.
So I told counsel
Yeah,
it doesn't
a
seem
little
like
bit.
there's a large issue, but I just wanted to make a record of incidental contact I had with the juror. I was entering the restroom, he was exiting the restroom, and there were reflexive warning comments. I then realized he was a juror. There wasn't any further contact. That was about 8:40.
Move for mistrial.
So admittedly, a little surprised to see a juror here this early, but I just wanted to make a record of that.
Okay.
We had incidental contact in the bathroom.
Your Honor, Mr. Saunders
We hugged. We
told me
kissed.
about this. I don't believe it's
Did you
really
bring
an issue.
souvenirs?
These types of things periodically happen, and usually it's incredibly innocuous. So you give the instruction to the jurors not to talk to the attorneys and the parties not to talk to the jurors. You see somebody, you feel like you're compelled to say hi. In this case, Mr. Saunders, it seems like wasn't even aware that it was a juror, and was not even expecting to see a juror. Sometimes the jury's sitting there and you don't study their faces so you know what you're dealing with. I'm satisfied given what he's represented. There was no intent in what occurred, and the exchange was innocuous. And
I feel like I would recognize a juror.
Anything else before bringing the jury?
No, thank you.
Mr. Fraley?
No, Your Honor. Thank you so much.
Very good. And we will,
On the 4th day of trial, I feel like I would recognize a juror. I don't know. Maybe I'm weird.
From your live stream where you outed him?
I just love it. There was some incidental contact. I mean, maybe consent and he lost.
Your volume is fluctuating, Nick.
Mine is fluctuating.
Oh, there we go. Now you're back. You
Oh.
were dumping out a little bit.
Sorry. My microphone stopped giving me consent.
It
Charlie,
retroactively, though, consented again, so you're good.
Charlie, did you want to share your news while we have a little lull?
Yeah, well, someone in chat just asked me about it. So I brought a special bottle to celebrate something. Don't worry, it's 0 alcohol because I'm pregnant. I'm having a baby. It's my first one. Yay!
Congrats, that is awesome.
okay, be seated. Ladies and gentlemen, welcome back. I hope you had a good evening. This is the second phase of the trial, and I'm going to give you these instructions. The defendant has been found guilty of first-degree intentional homicide, mutilating a corpse, and third-degree sexual assault. We will now proceed with the second phase of this trial. During the second phase, you will be asked to determine whether the defendant is not responsible by reason of mental disease or defect. Before you may find the defendant is not responsible for the criminal conduct, the defendant must satisfy you to a reasonable certainty by the greater weight of the credible evidence that at the time the crime was committed, the defendant had a mental disease or defect, and as a result lacked substantial capacity either to appreciate the wrongfulness of the conduct or to conform that conduct to the requirements of the law. This issue will be presented to you in the form of two questions. First, at the time the crime was committed, did the defendant have a mental disease or defect? Second, as a result of the mental disease or defect, did the defendant lack substantial capacity either to appreciate the wrongfulness of the conduct or to conform that conduct to the requirements of the law? You will be asked to answer the second question only if you answer the first question, yes. If you find the defendant is not responsible for the criminal conduct, the defendant will be committed to the custody of the Department of Health Services and will be placed in an appropriate institution unless the court determines that the defendant would not pose a danger to herself or to others if released under conditions ordered by the court. The only issue at this second phase of the trial is the defendant's mental condition at the time of the offense. The lawyers will now make opening statements. The purpose of an opening statement is to give the lawyers an opportunity to tell you what they expect the evidence will show so that you will better understand the evidence as it is introduced during the trial. I must caution you, however, that the opening statements are not evidence. And ladies and gentlemen, because this phase of the trial, the burden of proof shifts to the defense, the order of questioning and presentation will change, and Mr. Freilich will go first. Mr. Freilich, are you prepared to make your opening statement?
Yes, I am, Your Honor.
Very good. Go ahead.
Are you really, though?
The
I'm not
defense has the
convinced.
burden.
Yeah, I guess the defense has the burden to prove to.
In the second phase, defense has the burden to prove
Your Honor, may it please the
mental
court.
disease or defect.
Ladies
by
and gentlemen
preponderance of the
of the
evidence,
jury, good morning.
and they need to have 5, 6.
Mr. Lassay, Mr. Saunders,
They don't have to
prosecutors
have
for
all
the state of
12. They just
Wisconsin.
have to have 10 out of 12.
You're going to hear some testimony in this case from the defense expert, Dr. Diane Litton. She's from the Menasha area. She's a PhD. She's a forensic psychologist. You're going to hear testimony from the state doctors as well, Dr. Matthew Seipel and Dr. Christina Engine. The burden does shift to the defense in this particular case. We're in phase 2 now, and the burden shifts to the defense, to me, to ask you to consider whether the defendant, Taylor Denise Schabusiness, is responsible or is not responsible by reason of mental disease or defect. And Wisconsin law, under Wisconsin statutes 971.15, does require the defense to satisfy you jurors to a reasonable certainty by the greater weight of credible evidence that at the time the crimes were committed, which was February 22nd of 2022, that Taylor Schabusiness had a mental disease or had a mental defect, and that as a result, she lacked the substantial capacity either to appreciate the wrongfulness of her conduct or to conform her conduct to the requirements of the law. So that's packed with a lot of information that you're going to have to consider. I did tell you yesterday that you're kind of like analysts. You're going to have to listen to the testimony, listen to the facts, assess the credibility of the witnesses, assess the information that you're receiving, and then you'll have to make some decisions and considerations on these important legal issues. The defense did retain Dr. Diane Litton. She interviewed Taylor Schabusiness. We believe that the evidence will show that she did a thorough evaluation of Ms. Schabusiness's mental status, that you will hear about Dr. Litton's extensive experience in the field of psychology. When you have experts, you kind of heard from other experts, and they have a resume or a CV. In the field, we say CV, curriculum vitae. It's a list of their experience in training and education. And you're going to hear
in the field
that Dr. Litton has been a psychologist since 1993, that she
Natalie,
has
do you know her?
extensive experience, that she has approximately 3,000 hours of postdoctoral training, that she conducted hundreds of forensic evaluations and GI competency evaluations, things of that sort. You will hear testimony that she worked at Mendota Mental Health Institution here in Wisconsin, that she looked at many different evaluations performed on Taylor Schabusiness, including from Dr. Tracy Lucetta, Dr. Matthew Seipel, Dr. Christina Engine, Dr. Deborah Collins. And you will hear that Dr. Litton, we believe she'll testify that she looked at a whole myriad of records, including jail records, mental health records, a court order, an order for civil commitment, mental health order, an order to take psychotropic medications, basically a medication order. She will, I believe, testify that she reviewed Nicolay Psychiatric Center mental health records from Brown County. She will talk and testify about her contacts with Ms. Schabusiness on the different occasions that she met with her. One being a situation where a chair was thrown by my client at her before I got involved in the case.
That means nothing.
She will testify that she did have another interview with her at the jail, and she asked me to sit in. So you're going to hear about all of her findings, her observations, and her opinions in this particular case. We believe that she has extensive experience. She's been in this field for a very long time, and that you need to pay close attention to what she says and give her opinions strong consideration.
It's like he doesn't know how to say a sentence.
And we believe that her testimony will be that she's of the opinion that Taylor Schabusiness does qualify for the NGI plea based on her diagnosis of a serious mental disorder. That she has some other opinions, and she'll tell you about those when she testifies.
Her diagnosis is just bipolar.
I thought there was underlying psychosis.
I believe testimony from my client's father, Arturo Coronado.
I believe
that he will come here.
You should know that.
He's been summoned by the defense.
Feel the confidence dripping off this man.
To answer some questions about his daughter growing up, how she was, what kind of issues or problems did she have, what kind of mental health issues, and what he did to try and help her get treatment.
I'll just open up my bubbly mouth.
You will hear from Dr. Litton about my client's mother, that she lost her mother at a young age, and that was a pivotal event in her life. Dr. Litton will also provide some testimony about the fact that she believes there may have been a budding personality disorder, and that she saw a really disturbed teen when she assessed all of the school records. She looked at all the school records and did a table or a chart. She looked at the mental health history. She did a one-page chart on that. The burden of proof in this case does rest with the defense on the NGI issue. I think that the testimony from all of these different professionals, these different doctors, these psychologists who talk about behavior and things of that sort, you're going to hear their testimony about all of the different problems, all of the different mental health issues, all of the different behavioral issues that Taylor Schabusiness had growing up as a kid, as a youth. She had a lot of obstacles that she had to face growing up. We believe Dr. Litton will also provide some testimony about my client's prior treatment with antipsychotic medications. She will testify about my client going off these antipsychotic medications sometime after her inpatient treatment in 2021. And Dr. Litton will set up and provide the background history and information on Taylor Schabusiness's life and upbringing.
At the
So,
time of the murder.
The defense does have the burden of proof on this issue of whether our client is responsible for these crimes.
Third time.
But we believe that the testimony and the evidence will show that at the time of the offense that she did have a mental disease or defect. We believe that the information and the testimony will show and hopefully lead to you to conclude that she lacked the substantial capacity to appreciate the wrongfulness of her conduct or to conform her conduct to the requirements of the law. And what I ask is that you just
keep an open mind,
sit
right?
back,
Which one do you think he's going
carefully
to
listen
emphasize?
to what these experts have to say and then render a fair and just result. Thank you.
Oh my God, that was terrible.
Again.
Go ahead.
Good morning. So when I said in opening on Monday that this case is about choices and responsibility, this is what we're referring to, right? The responsibility phase is what we're here for now. Essentially, you're being asked, what was the defendant's mental state at the time of the offenses for which she's convicted and whether she should be responsible for that. Let's address the obvious. What Ms. Schabusiness did to Shad is disturbing. It's conduct we don't see often. It's conduct that you may hear about and think, my gosh, that person must not have been in their right mind when that happened. I'm not going to sit here and try to convince you otherwise. But you've already carefully listened to the evidence and followed the law that the judge gave you. And you'll do so going forward as well. Because you will be told what a mental disease or defect is and what it is not. A mental disease is not antisocial conduct. It's not conduct brought about by use of a controlled substance, a temporary mental state caused by a controlled substance. A person is not mentally ill just because they commit something that's unnatural, that's so enormous, that just is beyond comprehension, right? You'll be instructed that those are not mental diseases or defects. So as disturbing as the conduct you already heard about is, and may be, that's not where the analysis ends. You'll hear from several experts. Defense already went over Dr. Litton and her qualifications and how she supports Ms. Schabusiness's NGI plea. But you also hear some issues with Dr. Litton's methodology, her analysis, and ultimately her conclusions. The state will call several psychologists of its own, both of whom were actually
Several
court-appointed,
both.
not by either
Not
party,
really
by the
several.
court, when they did their analysis and meetings with Ms. Schabusiness. Dr. Matthew Seipel will talk about some of the issues that he had with Dr. Litton's methodology and her conclusions. He'll testify about those. You'll also hear from the court-appointed expert, Dr. Christina Engen. Again, came here on a court order, not retained by either side. And she'll tell you that she does not believe Ms. Schabusiness is suffering from a mental disease or defect, or that she was unable or lacked substantial capacity to conform her conduct to the requirements of law or appreciate the wrongfulness of her conduct.
Notice he doesn't hope she'll say
So
that.
hear from
He
a
knows
variety
she
of
will.
witnesses, some of whom are experts, some of whom are lay witnesses or civilians. You'll hear about, and you've already heard about, confounding all of this is the defendant's drug use immediately before the offense. We've all heard about that. Defendants admitting that and acknowledging that. You'll hear about how methamphetamine has those effects, has effects of psychosis, that has that result in people. And again, it's not a mental disease or defect if you're using controlled substances and it causes that result. So you'll hear from these experts and witnesses, but ultimately, in our state, whether somebody is suffering from a mental disease or defect is a jury determination. It's up to you based on the facts and opinions that you hear. Certainly the opinions of the experts will be valuable for you, but you've already heard all the evidence. You know more about this case than any of these experts likely do. You heard testimony about Ms. Schabusiness's mental state both before and after, in close proximity to the offenses that she's convicted of. You've heard her friends, her roommate, officers who had contact with her, Mr. Hendricks, Ms. Pakinich, described their interactions in close proximity to this offense and reported nothing out of the ordinary, some of whom are her friends who've known her for quite a while. Mr. Gannon, Mr. Tomes, you've already heard about their observations of the defendant. But more importantly, you saw the defendant's own words. Hours after all of these offenses occurred, really close proximity, you saw her be able to recall, be able to talk about it, and more importantly, you saw her mannerisms, how she was talking about it. Did not appear anyone was suffering under some manic episode. She's calmly talking about it with officers, providing information that is consistent with everything they're seeing. What does that indicate? She's aware of what's going on. She remembers everything. This isn't somebody who is not appreciating what happened. So that's why we call all these experts, but ultimately at the end of the day, it's a jury determination. It's a factual issue for you. And the state believes that when you hear all that evidence and consider the evidence you heard in the first phase, that you'll find the defendant has failed to meet her burden, that she should be held responsible for the conduct that she's convicted of and what she did to Shad. Thank you.
He got close to a place I would have objected for a little bit, but
Hey, Mr. Frank, are you prepared to call your first witness?
I need to confer with Lieutenant. Oh, yes. My witness is on his way up, Your Honor.
Okay.
Thank you.
they got a lot of white noise on the stream. Okay, so thoughts on that? Those openings.
Can we get our little notepads back?
They'll give you those right there. They want their notepads back.
Well, it's just like a casual, laid-back courtroom, I suppose.
I mean, I did not like the defense's opening. There's no confidence in his statements. He doesn't seem to know what his witnesses are going to testify. He said, we hope they will testify this. Like, we hope they're on our side. I haven't checked.
Where would you have,
I think he's scared that he's going to have witnesses not show again. He's like, he doesn't want to promise the jury he's going to hear from, or they're going to hear from her brother or whatever.
Her dad. You don't know if her dad is going to show up and be like, you know, she had a really troubled childhood after her mom died. I had to get her all these mental issues that she had. You don't know that that's going to happen. Like, what? Did you send him a postcard and say, please show up on this date?
He's in prison. They would have had to writ him out. He's in prison. So they would have had to writ him over. So he knows if it's happening.
Oh, that's why he's checking with the lieutenant, I guess. Sorry, go ahead.
He doesn't know what he's going to say, though. He doesn't know. But what would you have objected to, Nick? And
well, I was close to the idea. He was straying towards the line for me. I don't know about you guys. When he says, Like, you're going to hear from this, but you've already heard testimony about all this, and she wasn't under some manic episode. It's like, wait a minute. One, you're not really qualified to determine if she's manic or not. Two, manic episodes post-arrest have nothing to do with her state of mind at the time of the arrest. So I think he was straying into testifying on behalf of their case in that opening statement in a way that I might have called out as improper.
He also said you've heard from her roommate. And, well, we haven't heard from her roommate. It's the only witness the defense wanted to call, and he didn't show up. So,
yeah, you got a stipulated statement taken at the time of arrest. A self-serving statement, by the way. I didn't kill nobody. But, yeah, I don't know. I really don't like that prosecutor's affectations during his statements, opening and close. Like,
right.
I just don't like the way he delivers it. It's nothing unlawful about it or anything. It's just it's personal preference.
Right.
But he did assert confidently what they'll raise in the trial, and the defense did not. I mean, that's a win right there.
Yeah, I saw someone in chat asking, like, what is he doing? Just telling them what witnesses they have, and I wanted to react
Well,
to
the
it.
idea of the opening statement is to set out a roadmap. You're developing the outline of the picture that you're going to paint during the actual trial. You're going to say you're going to hear from this person. They're going to talk about this and how she suffers from, these mental health conditions, and they existed from her, childhood as a result of her childhood all the way up through the present day, and that she was suffering from this at the time. Whatever, but you didn't get that.
He made it. Yes. He's 1 for 2 on witnesses showing up.
By the way, so insider information that I know,
Arturo Coronado.
the first defense attorney represented her father, and that's why she attacked him to get him off the case.
You solemnly swear to tell the truth, the whole truth,
I don't know
and
if it's
nothing but the
true,
truth
but-
in the matter, now before the court, so help you God. I do. Please have a seat
From a-
and state your name for the record.
Someone close to the family.
Arturo Coronado.
Okay, Mr. Fairlake, the witness is yours.
Thank you. Mr. Coronado, good morning.
Good morning.
Sir,
Is it good? I'm in
Yes.
prison.
51,
what is your date of birth?
5/24/72.
Are you currently married, sir?
I am not.
You are living in Green Bay, correct?
She's having a field day.
Yeah, you know that, Chris.
And
Look at your business.
your daughter is Taylor Denise Schabusiness, is that fair?
She is.
Who is her mother?
Marla,
And you were married to Marla for a while, sir?
of course.
How many years was it?
We were married about 10, together about 15, 16.
Did you live together in Wisconsin or some other state?
Illinois
Illinois.
and Wisconsin.
And where was your daughter Taylor Schabusiness born?
In Evanston, Illinois.
Does Taylor have a sister or brother?
She has a brother that passed away last year.
What was his name?
AJ, Arturo Drep.
Okay.
JREP,
And why did he pass away? What happened?
July 1st last year. Motorcycle accident.
When you were living in Illinois with your daughter Taylor Schabusiness, was she ever brought to a hospital at all?
No.
Okay. Did she ever receive any mental health treatment when you lived in Illinois?
No.
Did something happen to Taylor's mother at some point?
She passed away.
Okay.
She passed away May 20th, 2009. In her sleep.
Okay. Did that take a toll on your daughter Taylor?
Well, of course.
Can you tell me a little bit,
So
sir?
on my son as well and me.
Okay. Took a toll on everybody, correct?
But yeah,
Why are you
And
cross-examining
when
your
her
witness?
mother passed away in May of 2009, how old was Taylor?
He doesn't know how to do it.
11, probably 11 and a half.
Okay.
My
And-
son and daughter were, about 9 and a half, 11 and a half years old.
Okay. Did Taylor go to school that day that her mother passed away?
I tried to get him to go to
Probably
school.
never
but they
talked
knew
to this
something was
witness
going on.
before.
He came back.
Can you describe a little bit how the death of Taylor's mother took a toll on her or impacted her? Can you give me a little bit of commentary on that?
Well, they were pretty young. I mean, obviously, her mom's not around anymore, and Marla she was ill, so just I guess they kind of knew what was going on, but it was unexpected. We watched the movie the night before and fell asleep, and I woke up and my wife was already cold, already passed.
You found her?
She's laying next to me.
Okay. And what about the kids? What about Taylor? Did she see her mom in that state?
They did not see. No, I did not allow that.
Okay. But were the kids in the house?
They were upstairs in their bedrooms.
Okay. After that occurred, did you see any changes in Taylor's
What changes
behavior,
did you
first of
see
all?
in her behavior?
She's a little rambunctious. Nothing. I mean, she played volleyball. She had a good amount of friends she hung out with. She was a normal kid.
Did things change at all for her?
I wouldn't say too much. She got in trouble a little bit at school, but I don't know, something with the band
That's
instrument.
terrible.
What happened with that?
How she took somebody's band instrument
And
and then returned it, but
Remember, he's
little,
trying to show that
nothing,
she was
nothing major.
crazy from her mother's death.
when did you come
She
to
took a
Green Bay?
band instrument though, Nick.
2000. I started
She
working
never
there in
returned
2007.
it.
2007. Where did you work at?
I worked for Verizon
Okay.
before. It was GTE, then turned into Verizon.
Learn how to ask a damn
18
question.
years.
Right. And when you came to Green Bay, did Taylor go to school here then?
Of course.
Of course. Where did she go to school?
She went through the Howard Sonical School District.
Even
Then did
Taylor
she go to
looked at
Bayport High School as
the
well?
defense lawyer like,
Yes, sir.
you know where
Did
I
you get
went."
information that she was having issues at school?
Well, yeah.
Cameraman's having a stroke.
What can you tell me?
From what I can recall, just
Tried to stay away.
normal.
She keeps staring at the cameraman. It's killing me.
Just kind of acting out, I guess. Just there's a couple of little instances that happened.
Like I got a chain and a
high
bucket with your
school,
name
but,
on it, buddy.
It's kind of why
Spot
Maggie yanked
the
her out of there.
camera. Oh, that's creepy.
She did
Sent
that
her to
during
Texas
police
so she
interview.
graduate and kind of get away from
Stared
the
straight into
issues
the camera.
that are going
When
on
she was in
here.
the room alone.
She went to Texas to live with her grandparents.
Correct.
When was that? Do you know?
2017, I believe. I'm not sure.
Okay. How old was she in 2017? Do you know?
She was 16 and a half, probably 17.
16, 17. How long did she live with her grandparents then in Texas?
About a year, a little over a year until she graduated. Maybe 2 years. About a year, maybe a year and a half.
Was that Cotulla, Texas?
That's correct.
Was there a point where she got pregnant?
Well, about a year and a half ago, maybe.
Okay. And
Yeah.
and she had a baby, correct?
Yes, she did.
And the baby is currently living in Texas with the grandparents, correct?
Yeah. How is that relevant to anything here? Why do we need to talk about him?
Let me ask you this.
Oh God, this
Yes,
is going
yes.
so well.
So before the baby was born, was she placed at Nicolay Psychiatric Center?
Before the baby was born?
Yeah.
Possibly.
Did you see her at the Nicolay Psychiatric Center?
Oh,
when she was
yeah,
there?
yeah. I'm sorry. It's just so much going on.
It's through Brown County.
Yeah, I went to take her there myself, actually.
Okay. Why did you
Yeah.
take her there?
She just wasn't in the right state of mind.
Was she suicidal?
Probably.
Was she psychotic?
Tell me
Objection,
about
I
her
don't
state
think
of
this
mind.
witness has the ability to answer that question.
Why did you
Okay.
take her there? What
Was
do you mean
she,
by she's not in the right state of mind?
Experiencing like hallucinations?
She
and
just, she was not in the right state of mind at all. So I feared that she would hurt herself. So that's why I took her. We both agreed. We both went there together.
And
try to get help, and then ended up releasing her, and she came home, and that was about it.
okay, was she prescribed some medications and things like that?
She was at that evening, no, but yeah, she has been on some medications that she never liked taking those pills. I mean, they kind of messed her up even worse.
Did they cause her to
Dad's-
hallucinate or cause her to have?
I think it
Problems?
all started with a Seroquel that was taken, back, I don't understand too much about those prescription drugs, but they never agreed with her at all.
And do you know the other medications that she was?
Sanity never agreed with his daughter.
ADHD, Adderall, I believe.
Anything about Haldol?
I don't know.
Okay.
But I know she was prescribed some stuff. but
Dad's
I
in
don't
prison
know
for
the
sexual
names.
assault of a child. I kind
you
of
talk
wonder
to
if
some
it
of
was
the,
the baby, the way
doctors or
he answered.
psychiatrists
Why are we
at the
talking about
Nicolay
him?
Psychiatric facility?
What was
I'm
his
gonna
first
object.
name?
I think this witness can offer his
name
observations and the
of
facts
the
that he's aware of
witness.
from what he observed.
I was just
in
gonna
the
look him up.
business
Was
With
it
respect to what he
Arturo?
learned from
It was
doctors
some
about
Coronado.
conditions. We have professionals who are going to answer questions based on the records. Those people are better equipped to answer
Does
those
anybody remember
questions.
this guy's first
The
name
information
If you remember,
hearsay
put it in
from
chat.
doctors is hearsay.
in the chat?
It's not hearsay. I didn't ask what they said. I just asked if he talked to the doctors, Your Honor.
Sure. So the question
Arturo
that's
Coronado.
pending is
Arturo?
that's
Okay.
hearsay. I think the objection was made because it sounds like that's where we're headed. So he can answer the question that was just asked. And then I'll just indicate, Mr. Freilich, that objection is probably coming if you go to the next step. But the question that's pending can be answered. So I think the question was.
Objection, Your Honor.
did
I
you talk to
anticipate
anybody at
hearsay.
I did.
Nicolay? Ask another question. Mr.
Okay.
Freilich.
Did Taylor live with you in Green Bay for a while?
For a little bit, yeah.
Was that in 2021 or what year was it?
I believe so, yeah. But again, speaking to them and, her being an adult, they really, even being a father, weren't allowed to disclose anything,
Right. Sure. When she lived with you, sir, what address did she live with you at?
1130 Moraine Way.
And how long did she live with you?
Just a few months.
Did it ever come to a point where you didn't want her to stay there anymore because her behaviors were getting worse or her mental status was getting worse?
No,
Uh,
I love my
meeting?
daughter, so I'll do whatever it takes to help her out.
The state doesn't care about this witness. They're not objecting to any of the
Did you ever review any of
leading
her
questions that are going on.
records at all?
Objection. I don't think he can testify to the content of, again, I think it's the same objection. He can answer whether he reviewed them. He can't answer anything about the content of the record.
Your Honor, the state, what they're trying to do is they're trying to anticipate an objection. They know this one is not an objectionable one, in my opinion. And any good parent, when you go to the doctor, you're going to talk with the physician or the psychologist or whoever it is about the status of your child. So I'm just
Yeah.
asking that.
It's not like I didn't try. I tried talking
Hold
to
it.
her.
Wait. So I'm going
Did you just see Taylor go like this?
the question can be asked.
No, damn it, I missed that. Spending time in the chat, damn it.
Okay, Your Honor. I kind of forgot. So hopefully
Did you review some of the records of your daughter? Did you review
Got his
any of
own
the
question.
records?
Like at the facility.
Yes.
Again, she was an adult at the time, and I can't. Yeah,
The
she
answer
was.
was no,
She was.
Mr.
Yeah.
Freilich.
when she was living at your house, sir, on Moraine Way, was she ever experiencing any hallucinations or anything like that?
Yeah.
Can you tell me about that?
Just know that she wasn't in the right frame of mind. Kind of see things. She'd like to walk around, and we take a walk, cemetery, just right down the street. But she just needed, just to kind of get out and walk around, and I guess ease her mind.
Did you have concerns about her from a physical or mental standpoint?
Always.
Okay.
Always.
All right. Thank you. Nothing further. I appreciate that.
Do you have any cross-examination?
Just briefly, Mr. Coronado, were you aware of whether or not your daughter was employed during the time that she was residing with you on Moraine Way?
She was not at the time, at that, no.
Do you know anything about her employment history as an adult?
Sure.
And had she held jobs in the past?
Oh, yeah.
Do you know where she worked?
She worked for Rebuttal. She worked a couple of years, Rebuttal, 3.5 years probably.
And is that relatively recently? Prior to her arrest, of course.
Well, yeah. Yeah, right. Prior to.
And
She was doing really well there too, until her boyfriend/husband got out of jail. That turned everything upside down.
in part because of the methamphetamine use, right?
Yep.
So Taylor was doing pretty well, and then she started using the drugs. No further questions.
Pretty bad drug too.
Anything on that, Mr. Freilich?
What was the drug?
Meth, heroin, whatever else. I don't know.
Marijuana?
Yeah, I don't know. The kid was already doing that shit before and just a fucking loser, and he got my daughter involved in that shit.
Thank you, sir.
I like that.
Nothing else.
Anything on that?
Okay.
Okay, thank you. You can step down.
Coming from him especially. What's he in for? So,
Next witness, Mr. Freilich.
I call Dr. Diane Litton,
That was his
PhD,
name.
Your Honor.
Man, this defense attorney is so bad at asking questions.
Yeah, for everyone who's not part of our background chat, our father was sentenced 9 days ago for his sexual assault of a child. So I just think that's an interesting timeline.
He just got in there, huh?
Yeah, that's why he wasn't showing up in the DOC locator system. It's because he actually hasn't been transferred to prison yet. It's because he was out on bond. So he, as of the 18th, looks like, is now back to prison.
so Taylor just wanted to see her daddy again before them both going away for.
So the child would not have been the grandson because this happened in 2018. I think her kid's pretty young, like 1.
Yeah, that's what I was gonna say. Is the charges for that? If we look at the incident dates
Okay, Dr.
for
If you wanna
them,
just step right up over
Was she
here.
pregnant during the assault?
offense dates are 4/29/18
Right up over
and
here.
4/29/18. So unless she's got a younger child.
I love this from Tatos. He says, imagine someone who sexually assaulted a child calling you a piece of shit.
Exactly. That was my point. Exactly.
Whoa.
It's rich coming from you. Exactly. Locals chat has a screenshot of Taylor's business going like that.
Well, and if I look at the the charging history with his charges, as he was originally charged with 4 counts of first-degree child sexual assault, intercourse with person under 16, use of threat of force or violence, but then they amended them down to second-degree sexual assault.
The truth in the matter, not before the court, so help you God.
Yes.
Please have a seat and state your name for the record.
Child's initials are AKP, and it looks like Mother
Diane
Kathleen C.
Litton?
Yeah, so it's not her.
Okay, Mr. Freilich, then the witness is yours.
Thank you, Your Honor. Good morning.
Morning.
State your name for the record again.
Diane Litton,
Can you spell that?
Lytton.
And what is your occupation?
I'm an independent forensic psychologist
Where is your office?
in Oshkosh, Wisconsin.
And are you a PhD?
I am.
Does that make you a licensed psychologist?
Well, I earned the PhD first and then became a licensed psychologist.
No.
Could you
So
briefly
bad.
provide me with your educational background?
Sure. I have a bachelor's degree, a master's degree, and a PhD doctoral degree. All three are in the field of psychology.
How long have you been a licensed psychologist?
June 1993.
And
That's
did
30
you work
years.
for UW-Madison?
I was during my PhD program at UW-Madison, during the graduate program, I was what's called a research assistant for the professors, for my professor. So that was my work when I was getting my PhD.
Okay. Initially, when you got your PhD, where did you work?
I worked for the University of Wisconsin, initially in an administrative internship through University of Wisconsin system. I did that for a year, and then I became a research scientist at UW-Madison.
Did you work at Mendota Mental Health Institute?
I did.
Could you tell me a little bit about that?
After taking off about 5 years for family matters, I then retrained to become a clinical licensed psychologist. And that took me 3,000 hours at Mendota Mental Health Institute in Madison. And then they hired me as a staff psychologist. And I was at Mendota for about 7 years, 1991 until 1997, when I became independent forensic psychologist. And I was a therapist too for some years too.
Yes,
Okay.
I'm really old.
As a psychologist, do you conduct NGI evaluations, competency evaluations, psychological evaluations?
Yes.
What kind of patients did you treat as a forensic psychologist?
A variety. The ones inpatient at Mendota Mental Health Institute in Madison, we used to have what called the adult and teenage and child, not forensic units, but child units. For a while, I was on a juvenile adolescent unit, and then I worked for a couple years on what's called the civil unit, adults. They're no longer at Mendota now, but then the last part of that 7 years, I was in the forensic units, people who were committed under the insanity, NGI. And then also, so most of the patients I dealt with had been found not guilty by reason of mental disease or defect. And the other patients were there for competency to proceed to trial evaluation. So I had both.
Did you also deal with guardianships?
Peripherally when I worked at Mendota, but since being privately employed, I do numerous guardianship evaluations for Outagamie County.
Had you also been involved in doing sex offender evaluations as well?
Yes.
Now, you have a curriculum vitae, correct?
Yeah, very small one, yeah, resume.
And you did provide that to me.
I think she's being
Yes.
sarcastic.
Yeah, thanks for clarifying that again.
Please don't be sarcastic.
No.
Council, just to clarify, we're starting over with numbers. This is exhibit 1.
Okay.
Is it not a normal term, CV, in America?
I use it.
It's not really a normal term outside of postgraduate professional settings, I would guess.
Okay.
And it's common for experts in court, but in
That's my
everyday
brief,
conversation, not so much.
like-
Resume.
100% of people in the
Does
Netherlands
your
use the term.
resume or curriculum vitae contain information about your educational background?
Yes.
Does it contain information about other patients or cases you've worked on?
Well, it summarizes my jobs over since 1975. So, yeah.
Okay.
And the type of cases that I do for the last 32 years.
Okay. And your license is still in effect, correct?
Yes.
Is everything in that curriculum vitae exhibit 1 true and accurate as of today?
Well, except I wasn't able to do the online renewal of my American Psychological Association membership. I found that out this year, so I had to call them up and do that. So that's the only thing, as far as I know, that's the only thing that's not accurate.
But you're licensed in the state of Wisconsin.
Correct.
Offer exhibit 1.
Any objection?
No.
One will be received.
Thank you.
So
Now, were you provided with some brief background information about this case?
Yes.
And were you provided information from prior counsel and from me?
Yes.
What kinds of information did you review in this case?
It was voluminous, and I asked for more information too. The records, though, discovery included the criminal complaints for the offense, prior offenses from 2020. That's the police records and the formal criminal complaint. And then inpatient, a 21-day inpatient psychiatric hospitalization at Nicolay.
Can I stop you right there? Did you receive those documents?
Yes.
Did you receive the order for civil commitment?
Yes.
Did you receive an order for psychotropic medications for Taylor Schabusiness?
Yes.
And you looked at those legal documents?
Yes.
What year was that? Do you know?
Which year?
When those orders were entered, the civil commitment order?
2021, I believe, for 6-month order for civil commitment and the order to treat.
I apologize for interrupting you, but Your Honor, can I approach?
You may.
I'm going to show you what's been marked as exhibits.
Like going through her prior stuff.
First,
Yeah.
clarify what exhibit
Okay.
2 is.
2
Hard to
is
tell.
a state of Wisconsin, Brown County order of commitment.
Is that for Taylor Schabusiness?
Yes.
And exhibit 3?
That is a state of Wisconsin, Brown County order for involuntary medication and treatment.
Is that for Taylor Schabusiness?
Yes.
Is that from 2021?
Yes.
Do those documents indicate that she was mentally ill at that time
Yes,
and that she was court ordered to take some medications?
exactly.
Are those documents that you reviewed as part of your evaluation in this case?
Yes.
Offer exhibits 2 and 3.
Any objection?
No.
2 and 3 will be received.
So, Dr. Litton, you can carry on. What other documents or things did you look at as part of your evaluation?
I reviewed the other evaluators in this case, their reports. And then the 2 inpatient psychiatric hospitalizations from Bellin here in Green Bay. I reviewed voluminous school records, which I don't often get in these cases. But the school records for Ms. Schabusiness covered kindergarten through 11th grade and all the behavior incidences. So I think that's about it.
I'm sorry, that's
And then
particularly
the
less voluminous than the normal
Yeah.
person's.
We've
school
asked for those records, but they haven't been received yet.
Did you review Nicolay
Wait, so you didn't get them?
Nicolay Psychiatric Center records from through Brown County?
Yes.
Did you review the report from Dr. Christina Engine,
Yes.
Dr. Tracy Lucetta,
Yes.
Dr. Matthew T. Seipel,
Yes.
Dr. Deborah Collins?
Yes.
she does know her doctor.
Those are all psychologists, correct?
Yes, they are.
Did you also review the criminal complaints and police reports and other case materials?
Yes,
Were you able to, well, before I get into that, did you prepare two tables, so
I
to
did.
speak? Okay.
yes.
Can you tell me what the tables are?
The simpler table, one page, is Ms. Schabusiness's mental health history with just the names of the records, the date of the treatment, if it was known, her age at the time, and then the diagnosis, medications, and the conditions. So that was the one page. And then the other one was prepared by her school, and it reflects 6th grade through 11th grade, but this is just the table that the school had prepared. I had also, though, reviewed her kindergarten through 5th grade. So this table is 6th grade through 11th, but I also reviewed kindergarten through 5th grade too.
Okay. And you brought these tables here and provided them to me, correct?
Yes,
And they've been provided to the state?
I guess. I don't know. Were they provided to the state?
Yes, they were.
Okay, yes. You
Sure.
you told me that.
Thank you. Can I approach, Your Honor?
Is that hearsay?
His man, I don't know.
Were they provided? I don't know.
This guy just cannot. build
Exhibit
rapport.
4 is a one-page table, Taylor
Not
Schabusiness
relatable.
mental health history.
And he sucks at
With
asking
the
questions.
record, the information came from, the date, if it's known, of inpatient or jail records, her approximate ages, and then the conditions during that either psychiatric treatment or in jail, the conditions, if they did make any diagnosis of her, and then medications, if there were medications prescribed. So that's what Exhibit 4 is.
Could you take me through that in a little bit more detail as to the treatments she received and the medications?
Yes. And from the age of about 7 through 14, she was treated, and again, I can't remember how the Prevea, here in Green Bay or this area, probably outpatient, so ages about 7 to 14, and we know the 14 is definite. She was seen for, and she was under psychiatric care, and I believe therapy, counseling, for attention deficit hyperactivity disorder, depression, and she was begun on Zoloft, an antidepressant, 2 to 3 weeks when she was 14 before the admission to Bellin. So that's on the next line. Bellin Health Psychiatric Center Adolescent Unit. She was there for 3 days, 2012, age 14. From the medical records, the conditions that they saw, the psychiatrists, the mental health people at Bellin, a thought disturbance, hallucinations, delusions, suicidal, depression. She was initially diagnosed with bipolar 1, depression, severe, with psychosis.
That's bad.
She was put on an antipsychotic medication, Seroquel, and they discontinued the Zoloft that she had been taking 2 to 3 weeks before the admission. And the reason they discontinued the antidepressant medication is sometimes it can trigger
He might have been. I have
worse
to check his toxicology.
symptoms in a person with bipolar.
I can check.
When she was discharged after the 3 days, no longer suicidal, She was then diagnosed with a mood disorder, not otherwise specified, without psychosis, but still the psychiatrist noted there was still some paranoia.
The psychosis is the
You want
bad
me to
part.
just continue?
It's
Sure.
like it's like
Okay.
really bad.
The next
Um,
admission, psychiatric, was
explain it
to the
properly.
same facility, Bellin Health Psychiatric Center Adolescent
It
Unit
was.
Inpatient.
I knew
That
it
was for
I
3
remember that.
days, 2 years later, in 2014. She was diagnosed with a mood disorder with prior history of psychosis. She had a history of diagnosis of mood disorder, suicidal, attention deficit hyperactivity disorder, history of hypomania, and marijuana use daily. She was prescribed medications to treat some medications, lithobid. They're to manage bipolar disorder. She was prescribed Abilify, which is an antipsychotic medication, and they stopped the Seroquel that she had been on since the age of 14.
That was Laura
The
was on
next
just now.
is St. Mary's Emergency Room. She was there for just a brief visit, the ER, March 22nd, 2021. She was 23 years old. She was observed to have hallucinations, paranoia, delusions, and she was using, or she had a history, but I think she was using at that time, marijuana, methamphetamine. Okay, so that was 1 day at the ER. Then, and I believe, if I have this right, I believe she was in jail for 2020 offenses, and I believe she went to the emergency room in 2021 from the jail because of the psychosis. Okay, then we have the Nicolay Psychiatric Center inpatient from March 22nd, 2021 until April 12th, 2021.
I feel like she's almost qualified to play bass for My Chemical
She had a
Romance.
6-month civil commitment with an order to treat, which was what those exhibits 2 and 4 were,
Playing
I
bass
think.
has got to have a sense of rhythm.
Okay,
though,
this was
and I just
2021 for
don't pick that up from there.
21 days. The records indicate bipolar disorder, substance use, hallucinations, delusional, paranoia. She was initially on Abilify that she had been prescribed since age 16. And again, she was 23 during the 21 day at 23 years old during the 21 days at Nicolay. So they kept her on, I believe they kept her on Abilify, an antipsychotic medication, but then put her on an injected to make it easier. So you get the injections of an antipsychotic, Aristada, I think, Aristada, I can't pronounce it, Aristada. They put her on that, so she hoping that she'd be more compliant, easier. You go to the psychiatrist, get a shot. I don't remember if it's once a week. How some of them last a month, so I'm not sure about that one. And I think I said she was diagnosed with bipolar disorder, substance use, had hallucinations, delusional, paranoia. The last records were the jail, Brown County Jail mental health records. That was from a stay 3 months in 2020, June to September 2020. She was 22 years old, and that regarded 2020 offenses, criminal. She was noted to be suicidal, bizarre behaviors, hallucinations, and had used methamphetamine and heroin.
I mean, who hasn't?
Then,
At the same time,
from the
that's
ages of 24 to 25, currently, records from the jail were from January 4th, 2022 to July 9th, 2023. She had, and I'm getting these from their mental health records, psychiatrists, mental health people at the jail. They noted she had suicidal ideation, bizarre, self-injurious behaviors, many conduct reports. She was nonverbal and isolative in her cell at times. She smeared and drew on her cell walls
With feces?
with feces and menstrual blood. She was naked at times.
Why specifically menstrual?
She
blood?
had
Can't be
hallucinations,
monochromatic.
intense anger at times. She was prescribed Rebuttal, an antipsychotic medication
And then we released
for
her.
quote, psychosis and impulse control. But she was usually non-compliant. Then as far as I know, the antipsychotic olanzapine is currently her medication prescribed at the jail, but she is typically been non-compliant with taking it. And that's it for that exhibit.
Did you generate a report in this particular case?
Yes.
I'm always skeptical of people's crazy behavior after they've been charged with a horrific crime.
Mm-hmm.
You know, if we had mental health hospitals anymore, I don't think she would be out roaming the streets in that condition.
Well, and part of the issue with, they're talking about her escalating behaviors and stuff like that with, the feces and menstrual blood stuff is I actually have recently had a client who just got found competent. He had been in an inpatient competency restoration program, had never before in his life had any behaviors like that. But while he was there, he was just so overwhelmed and upset that he started urinating on walls. Like the environment, when they shove all of these people in the same place,
Dr. Litton,
doesn't help
you
anybody
prepared a
get
written report, correct?
Yes.
more competent.
And was that dated July 3rd of 2023?
Yes.
Well, it's more about making society safe. In my,
Was
Well,
it
I'm just
15
saying with
pages?
that is that, the
about that,
behaviors
yes.
Did you sign
in a
it?
group setting
Yes.
and mental health stuff is always
Oh, 9
especially when you're
pages.
dealing with people with criminal mindset.
You
and
did
such a huge
review
detriment to
her
people's,
medical and mental
ability to
health
process.
history, correct?
Yes.
Her background, correct?
Yes.
Her family and social background, is that fair?
Yes.
Alcohol, drug abuse, and education?
Yes.
Sexual, physical abuse history, fair?
Yeah. Yes,
I'm
jobs,
feeling the state's going to
Yes.
shred this lady, though, on
charges?
cross.
yes.
Tell me about the first interview that you did with her.
That took place February 7th, 2 attempted interviews, February 7th, 2023, at the jail in a conference room. She remained nonverbal the entire time when I attempted to interview her, and she suddenly ran to the corner of the room, picked up a plastic chair and threw it at me. I called the guards. Took them a couple minutes to get there. She sat down, I sat down, tried to calmly ask her why she threw the chair. She, again, was nonverbal. The guards came. I explained the situation. They initially said, yes, I should terminate the interview, but offered the possibility of taking Miss Schabusiness to a secure booth to see if she'd interview. She nodded that she would be willing to go there and talk to me. We got there, and
Competency
she again was
evaluation, right?
nonverbal. That was the first 2 attempted interviews, February 7th, 2023.
So you had 2 interviews with her on that day.
2 on that day.
The one interview, was that in a room with just you and her and a table?
Yeah, yes.
And in that interview room, they have a stack of chairs there?
1 chair in the corner.
Okay. And then later you went to a more secure area where there was glass. Did you talk to her there?
I tried to, and she again was nonverbal.
I mean,
That was before I got involved. Is that fair?
Exactly.
Then did you have the occasion to meet with her on a different date?
I did when the last attorney, the original attorney on the case, after she threw the chair at me, was nonverbal on February 7th, 2023. Her defense attorney went, like the next day, went to discuss things about, why did you throw the chair? She didn't have an explanation. But she agreed, and she was verbal to the defense attorney. She told him, yes, she would then interview with me. He said, I'll come back tomorrow to double check. He returned, I guess, the next day. She again said she was verbal with him and agreed that she'd interview with me. So I returned on February 13th, 2023, and she refused to even come to the interview room. So those were the first 3 attempted interviews.
Okay. Was there an occasion where you had another interview with her?
I did, yes.
When was
By
that?
the way, all of these conditions were present for her competency evaluation
On June
were found
19th, 2023.
or all of this testimony.
And was that at
yeah,
the
that's how
Mount
I
County
would
Jail?
attack it if I was
Yes.
the state.
In the interview room?
In the conference room, yes.
The state is
And
already
What
prepared
is
for
the
all of
conference
this
room? Can you
information.
describe the layout there?
Not a
emphasize it,
huge
move
room,
past it.
but there's a table, a bigger table in the middle, and plastic chairs, thank goodness, plastic chairs. And then there was that the people sit on. And then, 1 plastic chair in the corner, not a huge conference room.
From the incident on February 7th where the chair was thrown at you, did you have some safety concerns, precautions?
With her or me? Or,
Yes.
she was handcuffed to a waist belt.
But I mean, did you have concerns from the incident on February 7th where the chair was thrown at you?
Oh, yeah, definitely.
Okay.
First time in 32 years, anybody anybody I've interviewed ever did that.
Witnesses.
So on June
My
19th of
boyfriend's mom
2023, you
actually
had
is one
another
of these
interview with her.
people that does
Yes.
Did you
I'm
make
sure
any
she's
requests
back
at all?
with her and throw the chair at her. I'll have to
Well, for you to be there, but you know,
Witnesses
you had already met
position
with her several times.
that she was not competent.
She had
to
not
take
been
a
aggressive
chair
with
throw.
you. Ideally, I wanted to meet with her in that conference room as opposed to behind plexiglass in a little tiny booth. So that, you know, so yeah, the June 19th, 2023 interview where she did talk was in that conference room.
And you asked me to sit in.
Yes, I did.
Did I interfere in any way?
No.
And so tell me a little bit about that interview on June 19th of 2023.
We only, you know, I was only with her for 2 hours. She had a great deal of trouble, difficulty with paying attention and concentrating. My impression of her at that 2-hour interview was she was psychotic. She had visual, auditory, hearing, visual hallucinations, auditory hallucinations. She was delusional. She was paranoid. She answered some of my questions. My impression of her was that she was really trying to answer questions, and she was verbal. This time she spoke with me. She was verbal, but my impression and that was that she was really trying to answer
I want this
my
witness
questions.
just to say, just look at her.
But
she's obviously crazy.
her thinking was very, what we call disorganized, very delusional. She was actively hallucinating, hearing things, a train, a loud train whistle that she screaming, which she told me she hears in the courtroom too. Very, as the 2 hours went on, she became so distracted and very, you know, afraid. You could see it on her face, fear, because of the delusions she was experiencing right then. And she got more and more scared about what she thought she saw, a train and of this louder whistle. So after 2 hours, that was it. She was so, in my impression was that she was so distressed. I didn't want to continue the interview. Then I felt I would be inflicting more harm on her if I continued the interview. So she gave me some information about her bipolar condition, her mental health history, family. Yeah, that was.
Dr. Litton, thank you. Do you have an
Describe what
opinion on whether or
psychosis
not Ms. Schabusiness's memory for remote or recent events was impaired when you met with her?
Yes.
Tell me about that a little bit.
Not only did I see that memory issues, impairment in the 2-hour interview, but I see it in her records too. She can sometimes remember remote events, like, you know, pretty well, where she lived, approximate dates, the approximate time her mother died, and so the date when she got married, roughly. It's a little fuzzy, but yeah, better remote memory. But she often will, in the same interview with treaters, evaluators, she'll be confused. And I saw memory impairments during the 2 hours, memory gaps, kind of a person with bipolar disorder or a other psychotic disorder like schizophrenia when they're actively psychotic, we sometimes see memory gaps for the time they were very psychotic, or with bipolar 1 disorder, when they're in a manic state, they can often forget what's going on. Then when they come out of the psychosis, sometimes they'll have a spotty memory. Sometimes the whole memory will come back of what they were doing, what happened during the psychotic episode. But sometimes it's totally blank. Sometimes it comes partially back. And sometimes they try to reconstruct what happened, and you get a kind of a funny reconstruction. How do they explain their behavior when they were manic with bipolar, or psychotic from schizophrenia, for example? They'll do a funny, not funny, haha, but bizarre reconstruction. Well, let's see, if I did that, if I got married while I was psychotic, well, let's see, I must have liked the guy. Or I've heard some really odd memory issues.
What about her speech? Can you give me any commentary on her speech from the observations you made?
Her
She was
speech is
nonverbal.
generally, you can understand, I could understand her.
I thought she was nonverbal, right?
She generally speaks in what we call connected sentences. So
I think
you
it's more
can,
when
you
she's
know,
having
you
an
can
acute mental
understand her
episode that she's saying
speech.
she gets nonverbal.
She's not, there's a,
Yeah, I was
one
just
of,
joking.
you know, there's another term, word salad, for somebody who's psychotic, who just blah, blah, blah. You can't understand. It's called word salad. I've never, in her records, and when I interviewed her, she's never been like that. So you can understand her speech, and she'll speak in brief, what we call connected sentences. Sometimes they're logical, lucid, but other times not. They don't make sense. They're going off track. They're, whatever we're talking about, poof, she goes off track and says something totally different.
Are you saying that she goes off on tangents?
Very much so, yes. Not always, but yes, I observed that in the records
The
too.
problem with this is the
When you
jury watched
discuss
her
certain
interview in
topics,
which
is
none
she
of this happened
connected or
right
disconnected?
after the crime.
Sometimes, like in the 2-hour interview, sometimes she,
Plus her
again, my
lawyer
impression was that
also
she tried really hard
asked witnesses
to answer my
questions.
questions. Sometimes she was
the
connected to what I
officers.
was saying and to reality. Other times, no, definitely not connected in
All the
my
officers-
impression.
All the officers
During
said she
the
wasn't like this
2-hour
during the
interview that you had with her on June 19th, was she distracted by any internal or external stimuli?
Yes.
Tell me a little bit more about that.
I want to
She
know
was
specifically if she
distracted
was on her
by
meds at the time of the
clock on
incident.
the-
Was she on her meds at
This
the
is
time
one
of
of
this
these
interview?
tangents. A clock on the conference room wall. She was distracted by a cord. We had just been talking about past suicide attempts, and she had tried apparently to hang herself. So when she was a teenager or younger, and she was distracted by a cord and a voice telling her to hang herself with that cord, but she said, I'm controlling it though. She had a train. She thought she saw a train and a whistle that got louder and louder and louder. She was delusional in her thinking. So those are just some examples.
Did you ask her about her mood on a scale of 1 to 10?
I did.
And what was the response you got?
007, which was bizarre. And I think a reference to James Bond.
Yep, thank.
What could you take from that?
My impression was that, again, it was some tangent and, it sounds pretty goofy, bizarre. I asked her to clarify that, and she really didn't. It led into a discussion of mania, bipolar 1 mania, and we discussed that, her impressions of bipolar, and has she ever had a manic episode?
Is obsessive compulsive disorder a mental disorder or issue?
Is it for her or just in general?
Just in general.
Yes, it's a mental disorder.
Did you talk to her about any compulsive behaviors or any issues like that?
Yes.
Tell me about that.
I brought up the issue of hypersexuality, also just obsessive
more.
compulsive symptoms, traits. And she said sometimes she's will touch her hair a lot. She'll wash her hands 30 to 40 times with germs.
We all did during COVID.
But
Wash
then
them
I
with
asked her
germs?
about hypersexuality, which is sometimes seen in a person with bipolar 1 disorder when they're in a manic state, manic psychotic state, this hyper, too much interest, arousal with regarding something sexual. And she was very surprised. She had never heard of that. But she clicked on it. It was interesting. She clicked on it like, oh. And then she described some past obsessiveness in, I think she said in 2020, for about a year, when she and her husband viewed a lot, and she called it, obsessive, adult pornography.
As opposed to child pornography or what?
Does hypersexuality
Yeah, I've been in a manic sexual state
give
since I was
you
18.
concern or pause as it relates to mental health issues?
Good for you.
It does,
We all do.
because, and this wasn't the additional evidence about it, that she has likely, well, in my opinion, she has had hypersexuality during the bipolar disorder, when she was diagnosed at least age 14, but probably before that. She made inappropriate sexual comments in her classroom.
Did we find your diagnosis, Nick?
While growing up at school.
Also, no
Then
balls, though.
when she was inpatient, I believe the 21 days, I think it was Nicolay, and was it 2021, she was inappropriate. They caught her in the bathroom, 2 separate incidences with a male, 2 different male patients. I think there's been some incidences in the jail. I don't remember that exactly. But yes, that's definitely a concern. I've seen other people with inpatient, outpatient, who are hypersexual, and again associated with bipolar mania, manic episode, or could be schizophrenia, but typically bipolar disorder. I've certainly seen that at Mendota, and when I treated or evaluated people, it's not incredibly common, but it's one of the classic symptoms of a bipolar manic episode.
Did Ms. Schabusiness say anything about her thinking and her feelings on that?
Yes.
What did she talk to you about?
You mean during that 2-hour interview?
Yes.
Yeah, and I'd have to look at the exact quotes here, but the thinking, she hears screaming in the courtroom. It sounds like quite constant, she said. I'm looking here. Yeah, she said she reported she hears screaming all day long, and not from the other jail inmates, telling her to wake up. Screaming happens, quote, a lot when she goes to court. It, quote, very much so, end of quote, affects her ability to concentrate on a daily basis and when in the courtroom. And then the voices
Wait, it's not normal to hear screaming all the
are
time in your head?
scary and tell her to do stuff.
What if
So
I have like a
her
set of
thinking
rooms full of
is-
people who are doing it?
I always ask people, I evaluate, how is your thinking and memory? And to me, it's just the thinking it's difficult for her to think because of the bipolar symptoms of psychosis thinking. It affects her attention, her concentration, and messes up her thinking. Difficult.
As part of your complete analysis in this case, did you find that Taylor Schabusiness is married?
Yes.
And did she provide you with any information about the marital relationship?
Yes.
What does she say about that?
She said that, I hate to say this about someone not here, but she said that her spouse, who I believe they married in 2020, got her involved in methamphetamine use. He was a dealer.
He's in prison now for it.
Someone who's not here.
Was
he's in
again,
prison for it.
her reports about this vary, but she has reported that he was very physically abusive, hit her. Well, she told me that he hit her on the head numerous times.
I did not hit her.
That was
did
when I
not
was
do it.
evaluating her, any head injuries ever in your past, and she mentioned that he had hit her on the head numerous times. So very controlling person.
Was she
and
punching her though?
She had
Was
gone
he
to a
punching
neighbor's
her?
house at one time in 2020 to ask them to call 911, and another neighbor, when the police came, another neighbor said that she knew them both, and she said, yeah, he was abusive, controlling, drug pusher, addict. Yeah.
I got to
But
jump,
it's
Nick,
also
but
married.
I'll try to come back on.
But she
Natalie,
was going
Charlie.
to
Take care, guys.
in
Sounds good, man.
2020.
See you soon.
She was going to try to get the marriage annulled, but I don't think that's happened. at
Two
this point.
ladies, Nick. Look at you go.
It's a good day.
ladies.
While you're changing topics, I think we'll take our mid-morning break. We started a little bit later, but it's 10:45 right now, folks. We've been going for about an hour and a half. We'll take about a 10-minute break. So all rise for the
Is he wearing a toupee?
I don't know. I love his hair. It reminds me of mine sometimes when you just wake up and you're like, oh, God, this effort. It's not much effort. All he has to do is this, and it's fixed, but it's too much time. Like, it's too early. He's had to listen to the word train and screaming too many times.
recess. Mr. Saunders?
No, thank you.
Thank you.
All right, let's reconvene at 11 o'clock. We're in recess.
Thank you.
Benjamin Bader says, wow, 1.5 hours. It somehow felt like 10. Oh, my gosh.
I thought that lady was going to retire during that interview.
Oh, my God. Okay, so thoughts on how this is going?
I mean, it's interesting. It's not necessarily dispositive to anything, though. And that's kind of the issue is, I mean, granted, I know they brought up, that this was going on during competency interviews. Just want to reiterate for purposes of chat and viewers that, the standards are different for competency dealing with the case as opposed to mental disease or defect. Like I had mentioned earlier, competency, I just had a client who was restored to competency, and there's no way he can help me assist in the defense. No way, shape, or form. But he has, for purposes of the law, been restored to competency because he knows that his attorney is the defense attorney. The state attorney is against him. The judge will decide the issues, and he knows the names of his crimes and also what the plea options are. That's all they need to do in order to restore competency. You don't have to understand how they interact together. You don't have to, have on one day understand it and the other day don't. They just have to have somebody who's able to write a report that says, on this date and time, he understood those 8 things that he's supposed to understand.
Right. Yeah. Competency is a question of, do you understand the circumstances you're in at the bare minimum? Like, and it's a very minimal understanding. This is a question, of course, does her state of mind at the time of the crime alleviate her of criminal liability? And can you explain how that is evaluated in Wisconsin in a case like this?
Well, it can be proven in lots of different ways. You don't theoretically have to have an expert opinion. You could, if it's generally something that is, commonly acceptable, like if somebody is, highly nonverbal, can't even ambulate themselves, something like that, and perhaps strikes someone, like in that situation, the case would never be charged, but if it was, in theory, you don't have to have an expert opinion and able to prove that. You could show the parents of the person, you could show the people who work with them on a regular basis, establishing these things. It's supposed to be proven. So the standard is when the burden shifts, the burden's on the defense to prove mental disease or defect by a preponderance of the evidence, which means the greater weight of credible evidence. They only need to have a 5-6 verdict in order to, not unanimous, in order for her to be found not guilty by reason of mental disease or defect. So it gets compared a lot to civil proceedings. We kind of think of it in the second part as more of a civil proceeding because of the lesser burden, as well as, the requirements as far as a jury goes. So it's kind of taking, it's still quasi-criminal, but the reason it happens in 2 parts is because, at least under Wisconsin law, whether or not you had the mental capacity to understand the wrongness has nothing to do with whether or not you did the crime. And that's the thing about an affirmative defense, is an affirmative defense is something that, even though all of the elements of the crime are present, there's still something overarching that means that it doesn't matter. It just cancels it out. And so with this, they have to make the determination first upon the facts and the actual allegations in the case, are certain things present at all? Because in theory, if a person's found not guilty, straight not guilty, you don't need to go to the next step. So there is the opportunity to, even in an NGI trial, not go to the second step if somebody is found, completely outright not guilty.
Right. Yeah. And that's in a similar way. It's not quite the same 2-step process, but in a similar way with Kyle's case, right? You admit to the facts, pointed the gun, intended to shoot it, intended to strike the person, didn't intend to kill them. Like, you have to kind of be very careful on that. But then you have this justification as your affirmative defense, self-defense. You're in reasonable fear of imminent death or serious bodily injury. This is similar to that, although it's not about a present state of mind. It's about the lack of ability
to comprehend.
To comprehend what you're doing.
Yeah, because you could definitely intend to kill somebody because, there was my dog was telling me that I had to kill that, and I knew I had to listen to my dog. I intended to do that, but that doesn't necessarily mean that you're able to appreciate the difference between right or wrong, or to differentiate reality and realize that that's not a thing.
Yeah, and I think so. We've gotten a lot of testimony from this, and I want to caution people on a couple things. First of all, this is the defense's star witness in this case, on this issue, and really, it's the only witness that they've had bring anything to the table at the evidentiary phase. And the other experts, which of course they're going to, they disagree with her severely. But let's talk about what the mental issues are and whether or not they impact anything. We heard that she was on antipsychotics as a kid. We heard that she had some episodes leading up to the event, and they in some ways were escalating, other ways they didn't seem to be. And then we heard that after the event, after she's charged with this thing, she's in jail, Then she has these, which seemed to end up being the focus of the testimony, and I have cynical reasons as to why that may be. They ended up being kind of the most bizarre, most extreme behaviors involving using bodily fluids and bodily waste to draw on walls, becoming nonverbal, becoming exceedingly and irrationally violent towards people who aren't there to cause you any trouble, suddenly hearing voices, suddenly hallucinating on these issues. And I have to point out that that's very, very convenient for that to occur after a charge. And also you have to realize that even if you don't take a cynical approach, she's been through a significant trauma. Murdering someone or killing someone is not a neutral event. It's a traumatic event. It's not a common occurrence, and people aren't equipped really to deal with that. Even if you wanted to, even if you hated them, people react in very weird ways to the actual act of killing. So all of that being said, though, we've got ADD, bipolar, and then these bouts of psychotic behavior, and she's on and off medicated for them. And she's also on these drugs, in which we've gotten some testimony that the drugs make her act all crazy. I want to point out something, though. Remember that this jury has watched an interview with her contemporaneous to the murder, right after it by a matter of hours. This person is attesting that she couldn't have a 2-hour interview with Taylor Schabusiness because she wasn't competent to do this 2-hour interview. It's too traumatic. She wasn't able to contain her thoughts or focus. Yet we have 6-hour interview occurring with this state, with the detectives. She's lucid, coherent the entire time. She's responding intelligibly to questions. She particularly and accurately describes the criminal acts that she allegedly did. We don't get any evidence from her interview that suggests that she is not aware of what's going on, exhibits any of the behaviors that this particular psychiatrist is testifying to. And that's a big problem, because the jury watched it. They saw that, and they decided based on that interview, in probably almost in whole, that she's guilty of these crimes. So they have a huge burden, or a huge hurdle to overcome with that reality. And I know this psychologist, psychiatrist, whatever she is there to make her sound as crazy as possible. We're going to hear testimony from other people that is going to probably line up more with the Taylor Schabusiness that they all saw in that interview than they're hearing about from this lady. And that's going to create a dissonance between what they're hearing and what they're seeing. And I think that's a big problem for the defense.
Well, and something also with competency that needs to be taken into consideration is also like the location of the interview and stuff like that. They were talking about that is, those things do very much inform somebody's nervousness, especially if you do have underlying mental health program issues. You have to remember that also the incident here that happened was in her home. She's going to be automatically a little bit more high stress, high anxiety, having an interview outside of her home to start with, but then also let alone the fact that she's in custody, regardless of whether it's intentional or not, those factors do play into any type of response that she's going to be having in this clinical setting.
Right. Yeah, that's a huge consideration. And I'm guessing we're going to get to some of those, maybe those challenges on cross. I'm really interested to see how the state intends to cross-examine this witness. Because remember, the state has heard these evaluations from this person before. And this is the only psychiatrist who has found this, who's evaluated her. There are no other psychiatrists who has evaluated her have agreed with these sort of findings from this lady in this trial, I should say. So I'm really interested to see how they tackle that. Real quick, I've been neglecting some super chats. Let me hit those real quick.
Oh, I was going to say, I actually have an 11 o'clock phone call, but I can come back afterwards. So
Absolutely.
I'm going to dip out shortly, but I'll be back.
Thank you so much. Look forward to seeing you back. Well, Charlie, Ninja Works says, why is the legal definition of insanity so far away from what we casually consider insane? I don't know how much more insane you need to be play sexy amputation games, or is it that they didn't make it really hard? If they didn't make it really hard, everyone. Well, yeah. I mean, it's crazy to me to murder someone, but if that were the standard, no one would ever be guilty, right? So we have to determine not whether or not it's deviant or aberrant behavior or activity to do a criminal act. We have to determine whether or not they were capable of knowing what they were doing would produce a result, would cause harm, was wrong or incorrect. Like, are they so far out of it? Deleted. I will wait till Natalie comes back to read your chat because it's directly to her. Missy Laney says her public defender is clearly only being paid in Culver's free custard coupons. Now, apparently, Steve Gosney disagrees with me. I said this guy's terrible, or he's doing terrible. Steve Gosney disagrees and doesn't think so. So we're going to have a fight to the death over that at some point.
He thinks the defense lawyer is not doing a terrible job?
Apparently and allegedly. Yeah.
Okay,
Yeah, I don't
well,
know. But I don't know what he
you
knows.
so much, but
I don't know what he knows about being a defense attorney, so I don't credit his opinion. MS Krim says as long as defense can show she was irrational and not in control, then she can be absolved of the crime. But does this state have guilty by reason of insanity or just not guilty by reason of insanity? I think it's not guilty by reason of insanity, and that's the plea at issue here. But I think they really have a problem saying she's irrational and not in control when she talked about exactly what she did, that
yeah, but
she
was
liked
on
it.
drugs. She was on drugs, so you don't know and it was a while after she had, I mean, slept for 10 minutes. That can do wonders. No, but you don't know what. Just a little power nap to,
Yeah. And the other problem is she is stating what she did and giving updates in the interview about her real-time progression through her mental state. When I was choking him, I liked it. I didn't want him to die, but I knew he would if I kept going. All of this stuff cuts heavily against her. That interview is really bad for this insanity defense.
Well, I think the defense lawyer, the way he handled it by bringing all these things up during the interview, did she seem out of it? Was she slurring her words? Was she? No, she seemed perfectly fine. No giant pupils. No, she didn't redevelop. That's the worst part of everything for me. That's why I think the defense lawyer sucked so much.
Yeah, his manner of
He made
questioning
it worse.
is very, very bad. And I think the detective was answering in a sleazy way, but that is his job to make him answer in the way he wants him to. And he didn't do it.
All the coppers, they said the same thing. You never ask a question you don't know the answer to, and if you know the answer is going to be that, then don't ask the question. Right?
And you don't give him the option. Well, didn't you see this? No, it's like she was rambling. She gave you this incoherent answer about an arm growing back. You got to pick your statements and focus on them, and don't give them away to weasel out.
Be leading.
Your review of the educational records for Taylor Schabusiness, did you make any conclusions about whether she had a budding personality disorder?
No, I did not.
I'll be right back.
No.
Okay. Did you see in the records that she was a really disturbed teen?
Yes, that was my impression.
And did you indicate that you felt that you even went beyond that?
Yes. Which was later confirmed when we later received the Bellin inpatient records from when she was 12 and then again at 14, and was diagnosed with a thought disturbance, bipolar 1, depression, severe with psychosis by age 14.
Did you have a chance to review
24 now.
a colleague's evaluation, Dr. Tracy Lucetta?
Yes.
Is she a PhD?
She is a PhD.
And she reviewed or examined Taylor Schabusiness in the past, correct?
Yes.
So you had a chance to consider her report, correct?
Yes.
Did you also review Dr. Matthew Seipel's report?
Yes.
And he's a forensic psychologist from the Wisconsin Forensic Unit, correct?
Yes.
And then did you also have the opportunity to review Dr. Christina Engin's report?
Yes.
And these are reports that were conducted based off evaluations of Taylor Schabusiness, correct?
Yes.
Before I ask you about whether you agree with their opinions or not, I'm going to ask you about what is your opinion as it relates to your evaluation and assessment of Taylor Schabusiness?
My opinion is that she qualifies for the not guilty by reason of mental disease or defect. My opinions are that she was not responsible because of a mental disease. She wasn't responsible for the criminal conduct because at the time of the event, she had the mental disease and it both affected, she lacked substantial capacity to both appreciate the wrongfulness of her conduct at the time the homicide occurred,
Okay.
but also she could not conduct, she couldn't conform. She lacked volitional control. She couldn't conform her conduct to the requirements of law. She was lacking in her ability to control herself. The volitional control both was lacking. That's my opinion.
You said that she lacked the ability to control herself?
Yes, at the time of the event.
And do you opine that she has a mental disease or a mental defect or both?
Yes.
Both?
It's unclear. I tried to get her to be evaluated. I suggested she be evaluated,
So Nick,
as Dr. Luchetta did
she
too,
just said,
further for
Yeah.
possible defect, mental defect, brain
Nick,
issues. That didn't happen, but
When
my
she's done
impression
talking,
was
just a
that
second.
she has a mental disease, which is the most likely bipolar disorder.
Wait, what'd she say?
so she lacked the volitional control during the time of the act, she just said, and she lacked
Based on your
the-
training and experience, can chemicals exacerbate?
They can, yes.
Did you draw any conclusions on whether Taylor Schabusiness has any kind of chronic brain damage?
I couldn't because that has to be done. For the first step is what we call neuropsychological testing by a neuropsychologist. Pretty elaborate testing. That's the process. And then if those test results are abnormal, then the next step would be a referral to a neurologist and medical doctor who would assess her and then decide whether or not there was enough information from the testing to explore the possibility of some brain defect, brain damage, maybe, yeah.
Okay. In your report, your opinions are on the last page. Is that fair?
Yes.
And did you talk about her presentation when she presents herself? Do you have comments about that?
Yes, it's my comments about that are that it's very, a very, very unusual, what we call presentation. How is she looking? How does she talk? How does she interact? Everything, what's going on in her mind and whatnot. And it's really, really unusual. And I searched my own 32-year memory bank here. And it's exceptionally unusual presentation, how she's coming across to me, the two attorneys, other evaluators in the school.
Would you agree that she has a strange presentation?
She does.
How about her facial expressions? Can you give some commentary on that from what you've seen?
Very unusual. She's been described as smirky. Smirky. She has inappropriate, her grinning, weird grinning when she's talking about the crimes. people have interpreted it to be like laughing at what she did. At times in the jail with the
Weird
evaluators,
people
with me, at
don't lack the
times,
competency to
it's
understand
very
the
strange.
outcome
Other
of their
times looking-
decisions, though.
you know, real, I mean, I
Just
can
because
mimic
you're
it.
weird
Very,
doesn't mean you're crazy.
scowly. A lot of people interpret it superficially to be grinning.
So she said she also
grinning
couldn't
it all, but getting a
understand
kick
the
out of everything.
wrongfulness. And could not appreciate
not
the
me.
wrongfulness of her
Based
acts.
on my
That was the second
experience
killer.
and training, that's a psychotic person right there. That's what's causing this really weird, bizarre. And I'm telling you, to me, it's off the scale. 32 years. I've seen a lot of psychotic people, bipolar, psychotic, manic, and I just haven't seen very many like this.
That
They're
statement is
very
not the
exceptional,
banger
very
that she thinks
exceptional.
it is.
Do you
No.
believe that she has a genuine mental disorder
Yes,
of a psychotic nature?
yes.
What is the nature?
The best, my best opinion is the bipolar 1, with sometimes with psychosis, sometimes not. But that after we got the Bellin records from 2 inpatient admissions at age 12 and 14, or 14 and 16, let me just double check. Yeah, 14 and 16, she was diagnosed at 14 with bipolar depression, severe with psychosis. So that confirmed that's I was thinking about schizophrenia, and sometimes schizophrenia and bipolar are very hard to distinguish. Sometimes not, but sometimes really hard to
Sometimes
tell
it is,
bipolar
not
from
always, a little bit,
schizophrenia.
sometimes
And
from
there's
time to
kind of
time.
a combined
Not
one
really,
called
but on occasion.
schizoaffective
Just the
disorder.
hands down though.
And that's been applied to her too. But I think based on this history we have from
Right.
Bellin when she was diagnosed with bipolar, and then again at Nicolay when she was 22 years old, also bipolar. Yeah, my opinion is, based on my experience and training, is bipolar 1. The more serious, there's bipolar 1, bipolar 2. But bipolar 1 can have psychosis, psychotic episodes. So that's my opinion.
And she
Are
wouldn't
your
remember.
opinions to a reasonable degree of professional certainty or psychological certainty?
Yes.
Sure.
Both, correct?
Yes.
No, they're not. Thanks for
No.
asking.
You did prepare a report on all of these findings, correct?
Yes.
Could I approach your honor?
Again, the question of weirdness, oddity, aberrant, strange behavior
That
is
my
not the
report,
question.
July 3rd,
The question is,
2023.
is she cognizant that what she's
does that
doing will
report
produce
contain
these results?
All of your findings and evaluations.
Her
based
entire
on
interview undermines this.
Taylor Schabusiness.
It's a
Her
brief
decision
summary.
to dismember the
Yes.
body because she was worried about getting away with
Everything
the
in there is
fact that she
accurate,
killed
correct?
this guy undermines this.
I hope so. Yes, I think so.
Yes.
And
Exactly.
the report is
That's
dated July 3rd of 2023, correct?
Yes.
Offer Exhibit 6.
Any objection?
No.
6 is received.
Doctor, you did review Dr. Matthew Seipel's report, correct?
I did two reports.
Okay, you read through both of them?
Yes.
You're aware of the opinions and findings that he rendered, correct?
Yes.
Do you agree or disagree?
Disagree.
Tell me why.
Contrary to how Dr. Seipel, his opinion, which I respect all professionals' opinions.
I don't.
I don't criticize the professional.
Why
I
not?
Can support my own opinion. But in contrast, I believe that my opinion is that she has a genuine mental disorder.
And then Dr. Christina Engine, did you review her evaluation?
Yes.
And do you agree or disagree with hers?
Disagree.
Tell me why.
Similar to Dr. Seipel, if I remember her report well enough, I disagree. My opinion is that Ms. Schabusiness has a genuine mental disorder of a psychotic nature.
Okay, I have
That's
no
why
other
she has
questions.
to
Thank you.
That's why she has to respect all the
Good morning,
opinions,
doctor.
Hi.
because they differ from hers. So,
Little hidden here behind the court for us. I'll try to move over. Can you hear me okay?
Oh, yes.
Okay. So you testified you're an independent forensic psychologist. Is that right?
That's right.
And does that mean that you're just sort of a solo practitioner? You're not employed with a larger facility?
Right. I don't work for anybody. I work for myself.
And you've been retained by the defense in this case?
Yes.
All right. So is there a retainer agreement in place?
No, say the very vast majority of
I
my
work for
cases
free.
were for the public defender. So they have an appointment letter, how much they think they're going to pay, like that.
Okay.
No money up front until the case is done and they bill,
I understand.
or he bills.
Sure. But you are being obviously compensated for your testimony.
No, I haven't been paid anything. No, I've been
You
on this
will
case,
be.
since 20, I don't get paid till the case is all done.
Okay. But at the end of the case, you will.
Right.
Okay.
What's your hourly
you
rate?
were asked questions about having previously conducted NGI evaluations in the past.
Right.
How many?
Hundreds? I don't know. Maybe, a lot.
All right. And how many in the last 10 years?
Many. And I have several right now. Many.
Okay. So like dozens?
Oh, yes, at least. Yeah.
And your CV, do you still have that in front of you? I believe it's Exhibit
No.
1. You outlined some on page 2 publications and presentations that you've completed. Is that right?
Yes.
And for instance, in 2022, you had a publication or presentation on sexually violent persons.
Yes.
And similarly, in 2001, another publication on sexually violent persons.
Those were presentations. Yes.
And would it be fair to say, I mean, looking through 2009 at least, all the publications and presentations we're seeing are with respect to sexually violent persons cases?
Most
Okay.
are, yes.
And do you have publications or have you presented on the topic of conducting NGI evaluations?
No. Other than 2018, a young colleague and I did a fill-in at the Wisconsin Psychological Association just on starting a forensic practice. And, we talked about the different kinds of it. Like, it was to a group of psychologists who were thinking of getting to be a forensic psychologist. So we probably mentioned NGI.
It looks like someone hooked
that
up
wasn't
an
like a
air pump to
presentation on
Alex
how to do
Stein and
NGI
inflated him.
evaluations. I then want to ask about some of your sources of information, and counsel went through some of those with you. With respect to what occurred on February 22nd, 2022, what sort of information did you review?
The criminal complaint. You said what information did I review regarding that
Yes.
event?
Yes.
Okay. Yeah, because nobody was there. Parents were upstairs. So we don't have any direct witnesses, but I reviewed the police reports, all their interviews. That's basically it. What she told other evaluators and what she told me very briefly. So that was it.
So it was when you say police reports, you're referring to like the paper report that a detective or officer wrote?
Right. There's the criminal complaint or information, which is a couple pages long, but then attached usually with it, are the basis for the criminal charges. And, with the police, I guess in this case, the police who went there, arrested her, their interviews with her.
So did you just review the criminal complaint or also all of the police reports?
All the police reports.
So then it sounds like you didn't review the recorded interview itself of Mission Business.
Transcript, the recorded
Oh,
interview
there you
herself,
go. That
and
explains
at
everything.
least an hour and a half,
Explains
2 hours
everything.
of the video interview.
So I'm sorry. Did you review the recorded interview of Mission Business from February 23rd of 2022?
What I was given by the attorney was a transcript of their interviews. And so a transcript, written type.
Okay.
We know what a transcript
Was
is.
it like the police report summarizing it?
If I remember right, it was a transcript of the, I don't know if they had a court
Bitch,
reporter
did you watch
in there.
the
I don't know how
video?
they do that.
No.
Did you watch
But
the video?
not the actual visual image itself. You didn't.
I only saw about an hour and a half, 2 hours of the visual, whatever you call it, video in those conference rooms where the police detectives were interviewing Miss Schabusiness.
Okay.
You didn't review
so
the
you
full
reviewed an
6
hour
hour
and a
video.
half of that. Was that the February 23rd interview?
don't
Yes, I
remember.
believe so.
And so you didn't review the rest of the approximate 5.5 hours of that interview.
No, it didn't transmit to me by computer for some reason. So it was only roughly an hour and a half, 2 hours.
I
of
didn't
what
follow
did
up and ask for the
see.
rest.
I guess the
But all the
defense
other
didn't provide
experts
that,
are
the whole
wrong.
interview for you.
They tried, but for whatever reason, I don't know, technology between the DAs or what. That's
Email or a thumb drive.
I
uncommon.
know, right?
Well, to be clear, we aren't providing you any information to review, right?
What? Pardon?
The state isn't providing you any information to review, right? You're getting that information from other people.
Well, I think it goes from you all to him.
Sure.
Yeah, right. And then to
Okay.
me. Yeah.
So then it also sounds like, Doctor, you haven't reviewed the February 28th interview of Ms. Schabusiness.
I read the police descriptions of it, and I thought I had a transcript. I think it was a summary, pretty decent summary of
How
the
would you
February
know?
28th. Similar, the
How would you
summary,
know?
It's good.
pretty decent, detailed of the February 23, the two
Hit her
interviews
on
they did
that,
on
please.
that
How do
day.
you know it's good if you didn't watch it?
But not, again, the actual visual image, the recorded interview itself.
Not from that one again. If it was sent to me, I couldn't see it.
If it was sent to me, I couldn't. You don't even
and-
know.
What is even happening?
Mentioned that obviously one of your sources of information is from your meeting or meetings with Ms. Schabusiness.
Yes.
All right. And the the February 7th, 2023 interview, that was the instance where Ms. Schabusiness threw a chair at you, right?
Yes.
And after she did that, you said she just sat down.
Yeah.
All right. And was calm after that point?
Very. And I looked at her, as I'm subject to doing, I used that time before the guards came in. Maybe it took a while, 3 minutes or so. And it was weird, bizarre, whatever you want to call it, because she immediately, very calmly, came back, sat down across from me, and I looked at her physiological responses, just totally blank. And again, I've seen violent patients. I got attacked once, beat up at Mendota, got slapped. But I saw very many aggressions on the unit I was on at Mendota for the 14 most aggressive patients, males in the whole state. And we'd have between 3 to 7 aggressions. And usually after a person does something like that, they have a red face, angry, yelling, swearing, breathing heavily, nothing.
So, those prior instances you talked about, those were with people who were at Mendota, you said?
Yeah.
So those were people who were actually found to have a mental illness.
No, not all of them. We were the overflow unit. We mostly had our patients were from around the state, jails, prisons, Winnebago mental health. They were most of them had been found not guilty, legally insane, but we were the overflow unit for the admission unit for competency evaluation. So they were not all necessarily mentally ill, but most were with a psychotic illness.
And those were the people who you made a gesture, like a red face.
Yeah,
things like
but
that after.
I've dealt with many aggressive people in the outpatient setting too. And yeah, it was unusual. I just don't, searching my memory banks, had a hard time coming up with somebody, I've seen it before, but it's unusual for a person to not be aroused, when they're
She
feeling
was
so
aroused.
angry.
That was the problem.
It was unusual.
And then I want to ask about the June
It's
19th,
unusual for a person around me to not be
interview,
aroused.
with Ms. Schabusiness. And that was at the a conference room area,
Yes.
and her attorney was present for that, right?
Yes.
And is it common for you to have those sort of evaluations with an interested party in the room?
I always ask attorneys, going back to when I was at Mendota, I learned this at Mendota. I always ask attorneys, if they have the time, to sit in at least during the initial part, like for a competency evaluation, so I can see the attorney and the client interacting. And so it gives me more information about whether the defendant is understanding what's going on, if they're able to work with their attorney. So I always ask attorneys to do that. Sometimes they do, sometimes they don't have time, whatever. It was unusual, though, in this case, that the defense attorney sat in through the whole thing. I did it for a particular reason, though.
Okay. And then you talked about exhibit number 4. Do you still have that in front of you, Doctor? It's the chart you prepared.
Oh, sure. Yeah, right.
Okay. There's a number of exhibits here. So you kind of listed the age of Ms. Schabusiness at the time of various admissions. Is that right?
Right, approximate age.
So it looks like ages 14, there was a Bellin Health Psychiatric Center.
Yes.
Age 16 from Bellin Health Psychiatric.
Yes.
And then there was nothing that was reviewed until Ms. Schabusiness was 23.
Right.
So you reviewed no mental health history, and you're aware of no mental health history from ages 16 through 23.
Well, 2020, she was in the jail. Or no, I guess that was 2020 when she was 22. So yeah, no, there's a gap. Yeah.
So there wasn't anything, I guess, from 16 to 22 then?
Not that I know of.
And when you were kind of summarizing the chart in Exhibit 4, I noticed a few times that when you were describing hallucinations, there was also sometimes then concurrently reports of methamphetamine use. Is that fair?
Yes.
And in your experience, methamphetamine can produce psychosis as a side effect.
Yes, it can in some cases.
And that was actually reported in quite a few of these records, wasn't it?
It was.
All right. So then I want to ask about the Bellin stay in 2012. You reviewed those records, right?
Yes.
Okay. And in particular, did you review the discharge summary?
Yes.
And I guess the discharge summary, that's kind of like the
My
exit interview
expertise in
process.
body
Yeah,
composition
exactly.
says there was
Alright.
definitely not a
So you
thigh
would
gap.
recognize that if you were to see it?
Maybe. But I have it on the chart. I believe at the discharge, she was diagnosed with mood disorder, not otherwise specified, without psychosis by the 3 days.
Okay. And that's exactly right, Doctor. So I'm going to show you Exhibit 7. Does that appear to be the discharge summary we're talking about?
Yes.
And in discharge diagnoses, you mentioned a mood disorder without psychosis.
Yes.
Nowhere in the discharge diagnosis is there a bipolar diagnosis, is there?
Yes, that's true.
And in fact, if you could flip to the last page of that, it says page 118 on the bottom, but it's the last page of that stapled packet, Doctor. You see the portion that says condition on discharge?
Yes.
Okay, and it says, quote, on exam, Taylor denied hallucinations or thoughts of harm toward herself or others, a wish to be dead, or that she would be better off dead. Did I state that accurately?
Yes.
And that was the Bellin Health records from 2012.
Yes.
I then want to ask about the Bellin Health records from 2014. You reviewed those as well?
Yes.
And there was a portion that contained the discharge notes as well. Is that right?
Yes.
All right. Okay, I'm going to show you Exhibit 8, Doctor. Do you recognize that?
Yes.
Does that appear to be some of the discharge notes from October 29th, 2014?
This was difficult because you see at the top and all through here, pretty weird, because it's got every page at the top says 10/28/2014 admission, and then parentheses discharged from assess at Bellin. So it's confusing. It was one of the more confusing I've been reviewing medical records since I was age 14, the candy striper. And this was hard. So it's difficult to figure out, is this the final discharge? And I think I finally concluded she was only there for 3 days. So I think it's the discharge, but it's the discharge summary, but it is confusing. You have to look at all the dates and everything, but this is really confusing.
I mean, you gotta look at dates.
But if you could,
have to look
Doctor,
at
flip to the
dates.
last page of that exhibit.
It's your job.
Do you see the area where it lists the diagnosis for
Yes.
Schabusiness? And there's 2 diagnoses, aren't there?
Right,
One of which is cannabis abuse, continuous.
right.
The other is alcohol abuse, episodic.
Yes.
Okay, there's not a bipolar diagnosis listed there, is there?
No, there's not.
And there's not that prior mood disorder that we heard about in 2012, is there?
Somewhere in these
Sounds great.
pages, I believe,
She
that
said it's hard
And
to
I'm
read
sorry,
the
Doctor,
report because you
question
have to
is
look
there
at the
in
dates.
diagnosis part, neither of those diagnoses are listed, are they?
exactly, no bipolar, and what else was the other thing you said? Mood
The
disorder.
mood disorder.
Yes, you're right.
And that was the Bellin from 2012, right?
Yes, age 16.
I then want to ask about these records from Nicolay Psychiatric, and that's sort of the county admission, right, to locked facility?
Yes.
Okay. And actually, the St. Mary's hospital visit you testified to on direct, that was like the day before the admission to the Nicolay Center, right?
I think it was the day of. I
Okay.
think that it looks like, because it's March 22nd, 2021. I think St. Mary's ER discharged her right to Nicolay.
Right.
I think that's how
think.
that went down.
Okay.
Date.
So when Ms. Schabusiness was admitted into Nicolay, she had a drug screen done, did she not?
Yes.
And that drug screen was positive for controlled substance, was it not?
I believe so. I don't have it written down here, but substance use, yes. And then by then, my memory is that it was meth, I think. Meth, probably THC, marijuana.
And those are different. A little. Have you, in fact, actually read any report ever in your life? Has that actually occurred? Be honest this time.
Was it a report with dates?
It's kind of confusing reading these reports that I've been reading for 30 years.
I walked away because I had to go to the bathroom and I wanted to go grab a drink because I need a drink for this. So I have another 0.0. This is Gordon's gin. So
It's no
hopefully-
alcohol gin.
Yeah, it's actually pretty good. So when my friend, so the 0.0 means no alcohol. My friend had a baby last year, my best friend. And we went through all the 0.0s when she was pregnant. And this was the one that was actually kind of drinkable. But the vinos, the wines, they're pretty good. The sparkling wines are great. They're just as good as actual product. But
I've
Thumbs
seen
up.
like gin making kits that they sell. So you can make gin at home and they're non-alcoholic. They sell them at like Target here. But I was wondering if they were at all worth it.
don't get pregnant. But
You had
Don't worry
reviewed
about
those
it.
records from Nicolay Psychiatric, right?
Yes.
And those helped you reach your conclusion?
Yes.
All right. So I'm going to show you Exhibit 9. Now I didn't mean to test your memory. I know you reviewed a lot of records. So does that appear to be the notes from Ms. Schabusiness's admission into Nicolay Psychiatric?
Yes.
And that's dated March 22nd of 2021.
Did you say 27th? It's 23rd.
March 20, you're correct. The admission date is March 22nd.
Yes.
And the date of service that's listed here is March 23rd.
Right.
And then in the history of present illness, it states in the second line, she has been using methamphetamine. She would not tell me how often and how much she has been using it, but drug screen was positive for methamphetamine, amphetamine, and THC. Did I state that accurately?
Yes.
All right. And then Nicolay Psychiatric, that's a sort of locked facility, right?
That's my understanding is it is. I don't think I've ever been there, but my understanding is it's probably locked, I would guess.
Is it a facility that's sort of closely monitored? And
Yes. I think they do. I think I did read that they lock their units, I believe.
I guess the purpose of all that staff presumably is to watch after patients.
Well, right, because she was there on a mental health commitment, so she either had to have been dangerous to herself or to somebody else, and those are usually locked units.
So presumably, people who are in that facility aren't, using controlled substances anymore.
Usually.
So then I'm going to show you exhibit number 10. Does that appear to be the discharge notes from Nicolay Psychiatric?
Yes, this one we know because it says final summary on the top.
And that date is April 12th of 2021.
Yes.
And there still is for the discharge diagnosis, as you mentioned, a bipolar diagnosis, right?
Yes.
Can you flip to the second page? On condition on discharge, it states the patient has a bright affect. Is that right?
Yes.
That she is forward looking.
Yes.
That she showed some motivation regarding remaining clean and sober.
Yes.
That she denies any delusional beliefs.
Yes.
That she, I guess it notes there's still some degree of paranoia is present, but denies any thoughts of self-harm.
Yes.
And that was after being in that facility for that time.
And she was just she was on oral antipsychotic, but she just was started on the injected medicine, the longer acting injected antipsychotic, it's called atypical antipsychotic medication, which then she didn't stay on after the 6-month order to treat.
But also on April 12th, she presumably would have been free from methamphetamine, amphetamine, and THC.
From so 21 days, usually in general, it would have been out of her system, but it could be still possibly affecting her thought processes. You just don't know because the testing wasn't done.
Sure.
But no, but totally, yeah. She still had some paranoia. It says some degree of paranoia was still there. However, she wasn't no delusional beliefs. So she wasn't super psychotic. Wasn't psychotic.
Just
And actually, I glossed over two.
Just a little bit.
Discharge diagnoses. One was the bipolar, right?
Yes.
Well, there was a second one, wasn't there?
Yes. Substance use disorder, i.e., in other words, THC, marijuana, and methamphetamine.
Thank you. You talked then about some of these hallucinations that are scattered throughout the records you reviewed, right?
Yes.
And some of those are things that the defendant is endorsing. Isn't that fair?
Yes.
And what does endorsing mean?
She's saying self-report. She's reporting them herself. She's describing some of them herself. Not a lot over her history. Are you talking about the hallucinations?
Just the concept of what endorsing means. And
Yeah,
I think you stated
that's
it.
yeah. Just
I'd love
saying.
to know her-
Reported by a person.
Do you have a
Google
headache?
search
And if you
like-
say yes, that you're endorsing the headache.
Thehank you.
Did you
and
look up their
actually,
symptoms
While we're still on the
for those
topic of
conditions?
the
to fake them?
bipolar diagnosis at Nicolay Psychiatric, you mentioned that you reviewed a report authored by Dr. Lucetta. Is that right?
Yes.
And Dr. Lucetta was a expert retained by the defense earlier in the case.
Yes,
And she prepared a report that you reviewed.
yes,
And part of that report, Dr. Lucetta spoke with Ms. Schabusiness.
yes.
And do you recall a portion where they were discussing that bipolar diagnosis?
I don't remember that exactly.
Would it
I'd have
assist
to look at it.
Would it assist to review
Sure.
Dr. Lucetta's report?
Oh boy.
Did they do any search record on that? On if Taylor Schabusiness looked up those terms, how to fake symptoms?
What's been marked as
Hasn't been any testimony about it.
Exhibit number 11. Does that appear to be consistent with Dr. Lucetta's report?
I believe so.
And you reviewed that report?
Yes.
Doctor, if you could turn to page 3 of that report. In the second paragraph, I guess it's the first full paragraph. Sort of the last sentence of that. And it says, quote, she, and that refers to Ms. Schabusiness, questioned the bipolar diagnosis, hypothesizing that her symptoms were attributable to methamphetamine abuse, explaining that prior to admission, she had been administering the drug intravenously up to 9 times per day for 5 to 8 months prior to her admission. Did I read that right?
Yes.
And that's referencing the Nicolay records that we just talked about, right?
Yes.
And that's where the bipolar diagnosis came from.
Just a second here.
Shooting up 9 times a day.
She seems to be, at the right beginning, it says Miss Schabusiness reported that she was previously admitted, blah, 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 blah. And it seems like that's what she's telling to Dr. Lucetta. But then at the point where that last sentence, she questioned the bipolar. That's, I had difficulty. I remember reading this and I couldn't quite figure it out. I think you're right that when she's questioning, she questioned the bipolar diagnosis, attributing it maybe to methamphetamine abuse. I think Dr. Lucetta is taking that Miss Schabusiness, that's what she told Nicolay, the psychiatric staff there, I think.
That your interpretation is that sentence refers to what Ms. Schabusiness told Nicolay?
Well, Miss Schabusiness told Dr. Lucetta at the beginning of the paragraph that she was admitted to Nicolay. Okay, so that's her self-report. She was vague about why admitted, bipolar. She was diagnosed with bipolar. She was discharged. She discontinued the medication. She doesn't like to take medication. She questioned the bipolar diagnosis. So I'm not sure if that reflects when she was at Nicolay or what she's telling Dr. Lucetta. I'll go, and you think it was Dr. Lucetta, so that's okay because she's done that. Sometimes she will say, this is Miss Schabusiness, yeah, I've been diagnosed with bipolar. Other times she will say, I don't think I've got it. I don't like to take medications. It varies. It does vary. So let's just agree that this is what she's telling Dr. Lucetta.
Let's just agree. No, bitch.
And I guess the point, Doctor, in any
Not how this
the
works.
sentence I read, those were the statements of Ms. Schabusiness regarding the bipolar diagnosis.
Right, regardless if she's telling Dr. Lucetta or the treaters at Nicolay. She questioned it. Not unusual.
Sure.
Did you say she had
I
to shoot up?
then, Doctor, would like to talk a little bit more about bipolar 1.
Uh-oh.
What is the diagnostic criteria for?
When a person has, by definition, they have to have had at least one what's called a manic episode, which is extremely elevated mood. And it can be with psychosis, thought disorder, or not. But they have to have at least one prior or current manic episode. By two things. It's either you go from depression, really bad depression with bipolar 1, super duper suicidal type, real depression. And then they have to have it in their history at least one of these real super duper elevated moods. And it's bizarre when you see it. It's pretty bizarre.
Pretty bizarre.
Yeah, so that's
Strange and
basically
wild.
it.
So you need at least one manic episode.
Yes, I believe that's in the diagnosis.
And
I'm
in order
about
to
to have
diagnose
one.
a manic episode, there are 4 criteria, aren't there?
I believe
you know, we look at the mood, a very elevated, exceptionally elevated mood, and then some other, usually there's these other behaviors that go along with it. Again, it can be, the person can be psychotic, not necessarily, but they can be psychotic in this very elevated mood. And then they usually are some other behaviors. They can stay up for 3-4 days. They wildly spend,
Like
sometimes gamble away, hypersexual, energy, feeling super energetic.
So there are 4 criteria, right?
Yeah, and I don't have my DSM book in front of me, but
So the DSM-5 that you referenced, what is that?
that's the American Psychiatric, MD's Psychiatric Association Diagnostic and Statistical Manual, the 5th edition. Oh, I think out in about 2015, I think it was.
Just like 5th
Put
edition
out,
D&D.
and it's used in this
Coincidence?
country for mental health diagnoses
think
and
no.
billing.
You would agree it's a pretty commonly used and widely accepted
In the
source.
United States, yes.
So for a bipolar 1 diagnosis,
He's about to torture with the
first criteria
DSM.
is that there's a distinct period of abnormally and persistently elevated behavior. Is that fair?
Yes.
And
That
that
dick-sucking
period
mouth.
has to last, quote, at least 1 week and present most of the day, nearly every day. Does that sound right?
Yes.
So it's not just a manic episode that, is an hour, right? It's a long period of time that somebody's manic
Right.
in a heightened state. Is that
Yes. Yes.
fair? And then the second criteria is some of those, symptoms, mood disturbances. You mentioned gambling, things like that are exhibited.
Yes.
And that mood disturbance, the third criteria, also has to cause an impairment of some kind, right?
A what?
An impairment of some kind?
Yes, an impairment. Yes.
And then the fourth criteria for a bipolar 1 diagnosis is that the manic episode is not attributable to the physiological effects of a substance,
Yes.
i.e. a drug,
Yes.
such as methamphetamine.
Exactly.
So,
Or LSD.
sure.
Something.
So if you're observing a manic episode, but you have information that there was recent methamphetamine use, that would be a concern for bipolar 1 diagnosis.
Yes, without further
can't make it.
information or more observations.
Wait, no. That's not in the DSM-5. She just made that up right now.
She got retroactively diagnosed her anyway for it, right?
Doctor, I then want to ask some questions about your report. I believe it's exhibit 6. Is that still in front of you?
Yes.
Okay. Is that exhibit 6?
Yes, that's the most recent
Okay.
exhibit.
So your report and your opinions that you're testifying to today regarding NGI rely in part based on your observations of Ms. Schabusiness on June 19th, right?
Correct. Yes.
And actually, as a result of that interview, based on your observations, you had a concern about her present competency in that moment, didn't you?
Yes.
And in fact, your report that you're referencing in Exhibit 6 is sort of a combination NGI report and competency.
Yes, that's what I was asked to do.
And those legally are different concepts, right?
They are.
Competency is sort of in the moment.
Yes.
And NGI obviously refers to the date of the offense.
Exact. The time of the offense.
Okay, so during your interview with Ms. Schabusiness, you had a concern about her competency.
Yes.
Objection, relevance. Move to strike.
Objection. This is about to shred my case.
Yet you're using her statements to form your NGI opinion.
Her statements, my observations, but not just that 2-hour interview. It was the entire information I had about the case. But yes, you're right. During the interview, it helped me to form my opinions because I submitted a mini report months before that where I couldn't make an opinion because I hadn't been able to interview her. That was well, both competency and NGI.
Bad objection. He just
Thank you.
indicated what he was afraid of, and he
so then
already lost that
I,
objection
wanna
earlier
ask
at the competency
about,
hearing.
Malingering. What does that mean to you?
Uh-oh.
Malingering
Oh.
is intentional faking of symptoms. Could be about anything, any symptoms, but in the psychiatric profession, malingering is intentional faking of mental health system. You know.
Is that sort of a synonym for feigning or something like that?
Yeah, that's a fan. Yeah, malingering, feigning. Yeah, faking. I simplify it. Faking.
Sure.
Intentional faking.
And you would agree that's been a concern for evaluators who have met with Schabusiness.
Yes.
Is there an unintentional
Dr.
faking?
Seipel had that concern. Did he not?
I think he concluded, if my memory's right,
He just
I
went
think
ahead
he
and said
concluded that's
she
it.
did
Yes.
it. Yeah.
I think you're right. Dr. Seipel concluded she was faking, right?
Yeah, I believe so.
And it was a concern raised by Dr. Lucetta, was it not?
Yes, definitely.
And again, she was a
Intern?
expert retained by the defendant.
Yes.
Oh, God.
And that she
Ooh,
suggested
ouch.
these potential for feigning should be explored further.
Exactly.
And in fact,
Impatient.
and in fact, in your field, there are tools that can be used to help determine if somebody is accurately providing you information, right?
Yes.
One of those is the MMPI.
Yes.
And those, have you used those before?
Oh, yeah.
And they're helpful for you to know if a patient is providing you accurate
Did you use
information.
one in this case? Well, no.
But,
But-
yes, but you have to take that. It's one part of the clinical evaluation, but you got to evaluate it with other information to decide if it's an accurate test result.
Sure.
Sure.
But you need that information to then know if it's accurate, right?
You need what information?
You need to perform the test.
You got to
You don't
do
have
the
to
test.
perform. I don't have to perform fancy
Oh,
500,
God.
300. I don't have to do that.
God,
That's not a
it's
requirement.
missing.
Psychiatrists don't do psychological testing. So sometimes I might
happening?
do it, but I've done
What's happening?
many evaluations without that when I have enough other information.
She's pouring gasoline
I
on
don't,
herself and
you're
lighting
not
herself on
required.
fire.
There's nothing that says you're a psychologist, you got to do MMPI. No, you don't have to do that.
And
But I've done it many times.
Did you
And-
do
Well,
it in
in
this
this
case?
I wasn't suggesting that. What I was suggesting is you mentioned that you need to take that test into account and see if it's accurate, essentially, right?
If you've done the test,
Yeah.
sure. Or if somebody else, like in this case, it had been done by all these other people. So I consider that information and that they found that, yes, she had, the other thing, she had over-presented, we call it the test, can detect. When you're over-presenting a symptom, like, oh my God, I really got a bad headache, really super, like that, you over-present it. It basically, again, it could be faking, but it's just an exaggeration.
It did show
That's another
that.
term we use.
She just disagrees with all
Sure.
those
So,
other doctors.
but in your report, again,
Okay.
Exhibit 6, I think you quote, psychological testing by other evaluators found signs of possible malingering or intentional faking of mental disorder symptoms. Is that a fair summary of what you wrote in your report?
Yes.
All right. And at the end of your report, it says, quote, testing can reveal attempts to fake a mental disorder, end quote. Did I quote that accurately? It's on page 9 of your report, doctor. Last sentence.
Natalie, were you
Right.
watching?
Yes.
Just now?
And so what
I have
attempts
been
did you
paying
make
attention.
to use
It's
some of those
absurd.
tests to determine if Schabusiness was fake?
I haven't heard
Yeah,
everything,
good
but I've had
question.
the
I looked
subtitle
at-
on, so
The other psychologists' test results, plus another evaluator done concerning her baby, Child Protective Services. I think he did testing too. So I look at those results. Yes, they showed exactly what you're saying, but then I take that in the context of the rest of the evaluation and my experience and training.
So doctor, you did not conduct any of those tests with Schabusiness on June 19th.
Yes. Or is that no? Which way do I answer that?
Just say correct.
I did not
infant.
conduct any of those tests, right, on whenever I,
Even though those
Yeah.
tests can be helpful to determine if a patient is providing you accurate information.
yes,
And you didn't utilize any of those tests in this case.
no.
Asked and answered objection.
Okay, fair enough.
First objection I've heard.
There's one earlier that was bad. It's like, objection, this sounds bad for us. I mean, that's how it came across in what he said. And he lost it too, so it made it worse.
Thank you, doctor. I have nothing further.
Good end.
It's going to be a bit, Your Honor. Do you want to take a break or should I ask some questions? Okay. With regards to your report and evaluation of my client, did you get a sense that she was feigning or faking?
At times with me, or not with me during our interview, I didn't think that was, or my interview, I didn't think that was faking at all. No, but with other evaluators, and again, the test results, it's my based on my education, my training in this field, my impression was that if there was any, I don't think there was intentional faking, period. I think we're dealing with my opinion is we're dealing with a genuine mentally ill person who occasionally is treated, takes medications. I don't think she's intentionally faking symptoms. Even in the test results, the test results show that she was exaggerating symptoms of a mental illness. However, Dr. Tracy Lucetta, in her report, I believe it's in her writer report, she points out that the majority of people with those feigning, malingering test results, they're later found out not to have been intentionally faking.
When in your experience, in your training, do people sometimes who are going through a psychological
make any
evaluation or some kind of an assessment
Nothing
tend
she has
to
said in the past
overpresent? They
20
wanna put
minutes has made
themselves in a
sense.
good light?
Sometimes I've done those tests, yeah, and every forensic evaluation, I assess a person for malingering. Everyone, I do. I don't necessarily give all the tests.
Don't use the
Occasionally I
test.
do, but
You didn't
we
use
have even
any.
other
Zero
tests for
tests.
just faking,
And
and I sometimes use that. But yeah, sometimes people do that for various reasons.
with regards to Dr. Lucetta, you read the whole report, correct?
Yes,
And she had recommended transfer to one of the state psychiatric facilities like Mendota Mental Health or Winnebago, correct?
right, for testing, neuropsychological testing and medications. Yes.
And before you wrote your July 3rd, 2023 report, you did consider all of the information, the interview on June 19th, the interviews in February, is that true?
Yes.
And all the records, correct?
Yes.
And you're indicating to the court that you did review some of the video clipped information between Ms. Schabusiness and the detectives?
Yes.
So you
Some of
considered
it, not all
that
of it, though.
information, correct?
Yes.
Your opinions aren't just based off of what happened on June 19th, correct?
No.
And as it relates to the DSM-5 manual, the diagnostic statistical manual that psychologists use, you're familiar with the elements for bipolar 1?
Yes.
And did
And how
Taylor
you can't
Schabusiness
diagnose
exhibit
it?
some of those elements based on what you saw?
Yes. And
Did
she
she exhibit all of
confirmed
them?
she had had those experiences in the past too.
And oftentimes when psychologists do testing, they would do the MMPI, the Minnesota Multiphasic Personality Inventory, correct?
Yes.
It's a series of questions, correct?
The short version is 300.
And then you gotta answer these questions and then you gather information from that. Fair?
Yeah, it's put into it. Nowadays it's put into a computer and
It's a computer test, right?
well, I don't know. I don't have the computer version. I don't know if it's all.
What are
I
you
don't know how that
even
works.
saying?
Let me ask you this. With the other test, the other gold standard test for psychologists is the MCMI, correct?
Yeah.
The Milan Clinical Multi-Axial Inventory Test?
Yes,
Is that another written test?
it is.
Was it your understanding that Dr. Matthew Seipel did not use the MMPI or the MCMI?
No, he didn't use them.
Other psychologists had already done that, correct?
Right.
And you reviewed those reports, correct?
Yes.
So you went right to it and got the materials and analyzed things from a psychological standpoint, correct?
Right. I didn't think there was any utility, any use to giving her the whole test again when she had it, I don't know, 3-4 times.
Except you determined that
Wasn't
she lied
necessary,
to
is that fair?
everyone.
I didn't
except
think so.
you.
No.
In some of these records from Bellin, did you see that she was
There's only one bell
huffing
in
gas-
here.
or, excuse me, huffing nail polish in 2013?
Yeah.
Jack, this is outside the scope of cross.
It's in the
Yep.
exhibit. It's in Exhibit 8. I can grab the exhibit, Your Honor.
Yeah, but it wasn't asked on direct or on cross. It's in the exhibit, but you didn't ask any questions about it, and now you're on redirect, dude. Notice the importance of this. She's saying she didn't need to perform these tests because other people did them, but she disagrees with the test results given to other people and swears that what they experienced was not what she experienced. If that's your answer, then you have to determine that the test giver is faulty or that the test taker is lying to them, but not you. So you should then determine to do the test yourself to verify that that's an
true,
accurate
right? She was,
representation.
she admitted to
You
huffing nail
overruled it.
polish in 2013.
About then, yes.
Your Honor, could
I
have
think part of the
exhibits,
problem is also just
8,
with
9,
people
10?
who've been doing this forever. You know, they get used to my opinion and what my opinion is, and I don't have to justify it. So they just talk in circles.
Yep, we saw that in the Depp trial, very specifically with Amber Heard's psychologist, the same type of stuff.
Mhm.
She just ignored all the stuff that she should have done. She did a bad job on the MMPI, and she just, from the
With
first
regards
question, it just
to
determined that she was,
Bellin
you know,
Psychiatric
completely abused or whatever.
Center, her
Well,
discharge
and there's a difference
summary.
between
It
like a
does
fact and
indicate,
inference and a conclusion. You have to have
Axis
facts
one
to
that she had a
support
mood disorder,
inferences to
correct?
support your
I believe
conclusion.
so, yes.
You can't just conclude something without.
Was that
having
from the
reviewed it.
2012?
Yes.
Yes.
And at least at that time, it did talk about hallucinations, correct?
Yes. And when she came in, they,
Doctor, if you
oh,
just focus
yes.
on his question, he asked if it referenced it, okay?
yes.
It did. Okay.
10 years ago.
And Exhibit 9 here, the Nicolay Psychiatric Center Inpatient Mental Health Unit. The initial evaluation did indicate on the bottom, diagnosis was bipolar disorder, correct?
Yes.
And on the Exhibit 10, fair to say that the final summary for Nicolay Psychiatric Center for Taylor Schabusiness, she was admitted 3/22 of 2021, admitted with a diagnosis of bipolar disorder, correct? That was one of them.
Yes.
And then she was discharged
Is that self-report thing?
April 12th of 2021, again with bipolar disorder as one of the discharge diagnoses, correct?
Yes.
And then on admission, that her thought content showed that she appeared to be having auditory hallucinations and delusions of persecution, correct?
Yes.
And suicidal ideation.
I believe so, yes. Oh, yes.
Longer this lady talks, I'm getting suicidal ideation.
And is it fair to say that based on what you understood, that Ms. Schabusiness did not take her medications after she was released from Nicolay Psychiatric Center in April of 2021?
Yes, that's my understanding.
And that, at least according to that document, her affect was flat?
Yes.
What does that mean? Her affect was flat?
Oh, I'm gonna get a little cough drop here. That means that, I mean, facial expression is just emotionless, flat emotions.
She's just chewing on a big crystal of MDMA right now.
As it relates to these other exhibits, Exhibit 9, she was prescribed Abilify for mood stabilization. Is that correct?
Yes, and what was that one from? Is it,
The date of service, it indicates 3/23 of 21.
so that was Nicolay?
Yes.
Yeah, she was prescribed, yes. Prescribed, the first she was on Abilify, I think when she came in, and then they switched her to the longer acting injected medicine just to make it easier. But then she didn't like it because it hurt. The injection hurt.
And at least at Nicolay, she was brought in on an EM1 petition because she was hearing voices, correct?
Yes,
And she was seeing people who were not there. Is that correct?
yes.
So this is the injectable should take 9 times a day.
Okay, no other questions. Thank you.
Mr. Saunders, any further questions?
Just very briefly, the question about having a flat affect, about the reported hallucinations, about being brought in on a Chapter 51, that was upon admission into Nicolay, right?
Yes,
When she was testing positive for methamphetamine and other substances.
right, substance use.
Thank you, doctor.
She can't be diagnosed for it
No,
under
Your
the
Honor, thank you.
DSM as he covered earlier.
I think I did forget to move 7, 8, 9, and 10.
Any objections to 7, 8, 9, and 10?
No objection.
Those will be received.
Thank you.
Oh,
Your Honor, can I just make sure? A lot of things are going on in my head. Were all my exhibits offered and accepted? Okay. Exhibit 5, if it's not, I'll offer it.
That's a nasty bald spot right there.
No.
Thank you, Judge.
Ladies and gentlemen, we're going to take our lunch break now. It is 5 after 12. I'm going to ask that you be back in the jury room no later than 1:15. I'd like to get underway right at that time. All rise for the jury.
yeah. The medications were too painful, but she injects meth 9 times a day.
Now, I don't know if the medication was 9 times a day or the meth. I missed that. Maybe chat knows.
That's from chat. I'm pretty sure. 5 minutes alone. I'm reading this chat. How you doing? What up? 5 minutes alone. All right. Do we have any pre-lunch issues?
I'm going to talk to my client, Your Honor, about whether I'm going to have her testify, but other than that, no.
Sure.
I may not have her testify. I have to talk to her.
Yeah, and I appreciate that, and that's something I wanted to cover because in my research, they tell judges that we don't necessarily have to make inquiry of a defendant at this phase, but it's best practice to do so, and far be it for me to try to avoid best practice. So I think I would undertake that qualification or that the colloquy with your client when we return and when you advise me whether you have other witnesses. If you're indicating after lunch that she would be your only witness and you don't intend to call her, then I'd have that colloquy before we bring the jury back in.
Okay, Your Honor.
Just so everybody knows that.
Thank you.
She's got to
Then,
testify.
The other
In
thing
my
I want the
opinion on
parties to
this
take
one.
a look at, I'm going to provide you after the lunch break, is the proposed jury instructions, and I want you to give some thought to how you want that laid out. My suggestion is that, and I'm open-minded on this, so I just want you to think about it, and you can certainly push back a little bit if you want. That I would give the at the conclusion of evidence, I would give the instruction 160 regarding closings. Then I would have you close. Then I would give a modified version of 100. That's the preliminary instruction indicating to the jurors that I'll instruct them upon the principles of the law, that they shouldn't use any impression that they may have of my thoughts in any way, and that they're to follow the instructions that I give them. So I propose to give a modified 100. I'll modify it over the lunch hour, give it to you. You can take a look at it, and your response might be, I don't want you to give that at all, or I want you to modify it differently, but that I would give 100. I might give 315, Mr. Freilich. That is the instruction that if your client chooses not to testify, I could certainly give that instruction again. Although this is a civil matter and I'm not sure that it's really necessary, but that is a possibility. Then I would give 640, which is mental disease or defect expert opinion testimony, and 605, which is the instruction, the base instruction on this proceeding. And then the jury would go into deliberations. That's what I would propose. I'll give you my draft of those instructions after lunch. You can think about it and we can have further conversation then. Anything else before we break? Mr. Saunders?
No.
Mr. Freilich?
No, Your Honor. Thank you.
Okay, then I'd ask you to be back in about an hour. That'll be 1:05. The jury will be back at 1:15. We can take up anything then. All right, we're in recess.
Thank you.
Right. As soon as this court feed is done, I'll remove it. We can get on to some good old-fashioned discusserating. I'll just go ahead and remove it now. If anything comes up, I'll pull it back. Okay, welcome back, Natalie. How are you?
That lady was very interesting.
Yeah. I don't know if I want to hang my life on that lady's testimony, honestly.
Well, I mean, when you only get one person who's going to be giving you the information you need, you kind of take what you can get.
Yeah. Yeah, I think that's the indication here. What do you think, Charlie and Natalie, what do you think about the idea of her taking the stand now that this is not a criminal matter? She cannot further implicate herself in the crime. I mean, she is guilty. She now has to prove, she bears the burden to prove by a preponderance of the evidence that she was not capable of making these decisions at the time of the act. Do you think she takes the stand or no, or she should or not?
Well, question first, though. Did they show any interviews with her or anything on the first part of the trial? Any of like her actual interviews footage?
Yes. Yeah, they showed. So
Okay.
she had 6 hours of interview. This was actually really interesting testimony that came from the psychologist. She had about a 6-hour interview, and then I think another 30
I didn't know if
minutes
it actually got
interview.
played to the jury, though.
An hour and 20 minutes of stipulated
Okay.
segments got played. Or no, an hour and 25 minutes, I think, all told, between the two. An hour and 20 minutes of the first day and about 5 minutes of the second one.
She was really calm and together, and she was just describing what happened. Yeah, and I was gonna choke him anyway. He put on the chain. He came out. We were going towards having sex, something like that, and then she started choking him, and then he, tried to fight back a bit. He turned purple, blood came out of his mouth, but she kept yanking the chain. Wanted to see what would happen, and after a while, he wasn't moving. She realized he was dead, and then she had to cut up the body to get it out of there because he was too heavy to drag him up the stairs by herself. So that's why she started cutting him up.
Yeah, I would need her to testify then. They need to be able to.
Yeah.
They need to be able to observe her. That's
She
the
needed
thing.
to testify yesterday.
It's there. You have to. The thing about it is, regardless of what the standard is, beyond a reasonable doubt, people are going to be skeptical of this every single time, and you have to show them what they need to see in order to, get the outcome that you want. Sometimes if there had been an incident wherein, she had this crazy, mental episode or something, that was on video, then that might be something. But that's the thing is, unless, and it gets into so many different evidentiary issues as far as everything goes with hearsay and stuff like that, as far as the initial trial goes. So, I mean, if nothing else, if she did freak out at different points in time during video, I would think you probably would need her at least to authenticate it. when you get into this instance. So, I mean, at least for the minimal portions of authenticating, video footage of her previous freakouts, she has to.
The issue I think that they have is that the stipulated video that was played, there were no video freakouts. She was
Nothing.
entirely composed. I think the
Details.
weirdest thing that happened was one comment where she said so the detective played this game where he sat down and he was trying to clarify details about what happened. And he was asking her stuff that I think that they at that point knew had not occurred. For example, he says, well, did you cut off the arms? Like you said, where did you make cuts on the arms? And she says something like, no, the arms would grow back or would repair themselves.
Muscle would repair.
Yeah, that was about the weirdest thing that happened in the interview. But of course, I think he was fishing for her, whether or not she was telling the truth about what happened, because she didn't cut off the arms. Like that didn't happen. And they seemed to know that was like that was just such an odd question to me for him to ask that specifically, knowing that it didn't occur later on. But to listen to her on everything else she said and let her lead on, that was the one thing. And it seemed like one of those, I'm going to ask you a fake fact to verify if you're telling me the truth type thing. That's how I could be wrong. But that was the weirdest response. The rest of them all seemed pretty cognizant of exactly what she did, exactly where everything was, exactly where she was, her state of mind in saying that she chopped up the body because he was dead. His mother was upstairs and she didn't know how she was going to get out of the house with him being dead downstairs. So she chopped up the body to transport it out. But then she got lazy, and so she only brought the legs out and didn't go back for the head that she wanted to take.
Those were her actual words. Like you might think Nick is kidding. Sounds like a Nick joke.
Yeah,
she actually said she became lazy several times because she wanted to take the head and the chicken ball.
It's so disturbingly calm, but it was very clear and specific. So, and that's the impression. This is the same jury from the criminal trial. That's got to be the impression that they're carrying away. And they just use that video to convict her. I think she has to take the stand and try and explain how she went from I'm insane to I'm not insane by the time I'm collected and interviewed.
Well, I mean, even if she can't explain, she can be used as a prop by her attorney to bring out some of these episodes. And that's really the issue here is, she's already been convicted. Like you said, she can't be convicted again. It's an issue at this point of, what do you have to lose? Right.
Now, Natalie, can you clarify something? We talked about this a little bit before, but Steve Gosney, Florida defense attorney, is asking, can you explain why the judge said this is a civil issue at this point versus a criminal issue as it would be recognized in some other states?
Yeah, part of it is just because of the standard of proof as well as the requirements in order to find somebody not guilty by reason of mental disease or defect is, generally in criminal proceedings, unless you voluntarily submit to a court trial or, if you have a juror leave and you agree to proceed with 11, it always has to be 12 or 1. That is one of your constitutional trial rights. And one of the differences in the proceedings here is because of the nature of it. You only have to have a 5/6 verdict for it being somebody finding mental disease or not guilty by mental disease or defect. So there's that. And then also the transference of the burden of proof is significant in making it a civil proceeding instead of a criminal proceeding, because in criminal proceedings, that's your constitutional right as the state has to prove you guilty beyond a reasonable doubt. But with, the process of finding some of states in themselves, they're basically allowed to statutorily make their own procedure for how somebody is determined not guilty by reason of insanity. And this just happens to be the system that's developed over about the past 200 years almost, is that it turned into this kind of, well, first it was quasi-civil, but then they started calling it a civil proceeding.
Gotcha. Thank you for that explanation. And yeah, I mean, it's, I don't know. I don't know if I like it in general, but that's the system that is happening. And
oh yeah, and that's what I tell my clients all the time. I'm like, if I knew how to fix this or to make a better system, I'd be a politician. I'm working with what I have, and
Right.
I just know how it works. I don't necessarily, think that there's not a better option. I just can't figure one out myself.
What would be,
Yeah.
if I may ask, what would be the difference in outcome if she would be, what could be the difference in outcome for her, depending on how this goes, this second part?
I mean, the difference is going to be life in prison or life in a mental institution. That's really the difference here.
Or I think the judge suggested that the jury could determine that she could be fit to be released today in theory.
Yeah, in theory, but I just don't think that's
right.
There's a difference between possibility and reality, and I don't really believe that is a reality, because if nothing else, and I've seen lots of people mention in the comments, is if she really is to this level cognitively impaired and unable to make judgment calls, then she isn't necessarily in a position where she should be around other people. So it's, she's made her own, the bed has already been made in that regard. If this was a less serious offense, perhaps if it was party to a crime and her culpability level was lower, that would really be the only situation where I could see her actually being released.
Yeah, but sorry, you go.
Oh, and I was just going to add to that. The defense has gone ahead and made the case that this is a persistent problem that has existed since she was 12 years old, that this bipolar, these manic episodes where she enters psychosis have been that's part of their entire argument, is that this is something that manifested about the time when she was 12, when she's first diagnosed with it, carries on to this thing at 14, carries on to 16, carries on to 22, and that it's carried on into this event when she's 24 years old. So it's going to be hard for them to say, well, but now she's fine. Like they've dug this hole. And I feel like it might have been maybe, and I honestly think it might have been a more convincing strategy to state that these mental issues are not an ongoing persistent danger to people around her, but they're exacerbated by other circumstances or some other triggering event that brought her to this state at this particular time. And that's also why we don't observe her in this ongoing crazy state. Because the other thing to consider is that the jury has been in the room with this lady for 4 days now, and they have not seen her not listen. They have not seen her not able to communicate with her attorney. They have not seen her not able to answer questions from the judge. I mean, and I know that it's a different standard for competency versus insanity, but their perception of her is that she makes some weird faces from time to time, but otherwise she's able to see what's going on, and she seems like she knows what's happening.
More importantly, when her dad left the courtroom, the way she interacted with her dad was almost completely normal. Like she said something like, "Oh, go Rangers" or whatever. I don't know, like some sort of sports team or something. Like she was faking the facial expressions, and then when her dad left, like, "Oh, bye kiddo, bye dad," like that was sort of completely normal.
I know. Part of me with this is, every case you look at as an attorney, you think of what would I do in that position. And thinking about myself in the position for this defense attorney, I've thought a lot about, something that, I see frequently all the time is, your brain chemistry changes until you're 25. I would try and bring that in. She's 25 now. Her brain chemistry settled down. So maybe she's getting better effect on her medications because her brain isn't changing constantly. And where one thing has an effect someday, it might not have an effect the other day. Something like that. There's a lot of, science and tools that you can use in your arsenal, but you have to actually use them. That's part of being a spin doctor, is knowing what your options are and then being able to make that judgment call as to how can I incorporate this in something else. And I think that's been, at least in my opinion, a big problem with, as far as the defense attorney goes, is it seems to be everything being very specifically planned out and not willing to improvise, or, I think that's just part and parcel of how people get so focused on your case. You think that you're hitting the important parts, but you have to tell a story because you have to convince other people. As I'm sure in his head, he's thought, okay, these are the points I need to hit, But you have to, that's the difference between explaining something and teaching something. Is you can explain something and no one will understand what you're saying. To actually teach it to somebody and impose upon, this is how things mean, you have to really do that intentionally and structurally.
Yeah, it's stated in an alternate way. It's really easy to forget what you haven't expressed from your head to someone who's not in it.
Yes.
Because you're carrying all these details and facts. You're like, okay, I know all these things. Now I need to hit these points about these things, but you might forget that you haven't actually given that thing to someone else. And
they need to know why it's important.
Right. And
But
speaking of me
it's a
giving
rookie
something
mistake.
to someone else, I've given a link to this guy. What's up, Kurt?
Hi, Kurt.
Hello, how are you guys doing?
Oh, hanging around.
So I actually have a question about this phase of the process because the judge said something just now and it raised a question in my mind. He said something about civil. Is this technically considered a civil proceeding at this point?
Yes, you missed my explanation to Gosney in the chat. So Wisconsin, there is no Supreme Court or constitutional directive regarding the not guilty pleas and how that has to procedurally be done. Wisconsin, it's been codified into a statutory right that it's the bifurcated system, and part of the bifurcated system involves burden shifting, where the burden shifts from the prosecution to the defense. The burden is lower, significantly lower. It becomes a preponderance of the evidence standard, and they have to prove by a preponderance of the evidence that, and it doesn't have to be a 12-0 jury verdict. It can be 5/6, so 10-12. They just need 10 in that situation. So that's why is because, and also, part of it is intentionally also designed. I mentioned earlier with Nick is that, the standard I think is, sort of designed to allow a little bit more accommodation, but at the same time, it's grounded in a statutory right. So if there's any, errors in it, it doesn't necessarily implicate the same constitutional protections. So because it's a statutory right, not a vested right in the Constitution. So it has this double serving purpose of, on the surface, allowing more leniency as far as what qualifies as being mental disease or defect, but at the same time, kneecaps your ability to appeal any decisions.
Okay, and then here's my follow-up question. So since this is technically considered a civil process, and since she's already been convicted, this defense might not want to call her, but technically speaking, could the prosecution call her as a witness, or does she still have a Fifth Amendment privilege because it's not considered final?
It's
because
quasi-criminal.
her appeal isn't pending?
Think of it as being quasi-criminal as opposed to being civil.
Yeah.
She still can't be compelled to testify against herself.
Okay, because I was curious. I was like,
Yeah,
wait a
no,
second.
that's
If this
the
is
only
civil,
difference is the
this is civil.
the-
Can they force her to testify? Because that'd be hilarious.
No, I mean, they can't compel her testimony.
Okay, well, I was curious. All right. So my questions have been answered.
Would that they could.
Yeah, would that they could.
Hey,
Welcome, Jeff. How's it going?
so somebody kill me, please. Kurt, if that's the question you were going to ask me, I'm glad I ended my stream because I would have got.
Yeah, that was the question I was going to ask you because I thought who would have the answer to this question? Legal Vices will know.
She's right
And
over
you're
there.
the mind,
She's right
you're the
above
one that
you.
came to mind.
She's the only person above you. The person above you is the only one that would know the answer to that. Wow. So what do y'all think about the maybe possible that one lady?
Well,
dates lady?
I don't have to administer the test. I'm a psychologist. You can't tell me what I have to do.
I'm
Actually,
just wondering.
Sorry,
Go ahead.
the explanation Natalie gave really helped me. Thank you for that, Natalie.
Made
it a bit.
It's
bit more clear.
the difference is, and I think that also goes to the defense attorney as well, is there is, and the law in general is really bad on catching up with trends. And there has been a significant change in the world since, like when I was born until now. So I'm using the year I was born as a reference because, for example, my boss has been an attorney a year longer than I've been alive. So we have very different, ways that we do things. And part of it is because you have to be familiar with tools available to you, familiar with technology, and not afraid of it in order to actually use it. And so you get these people who have been around for so long and they have the experience. If you're just looking at it in a vacuum, I've had a lot of experience dealing with specific people with this type of situations. But if you don't have experience working with changing tools, then your opinion really diminishes in its validity. And also that has to do with like his, the approach, things like that. Is you can, in essence, do a very even keeled, very effective, very unemotional job as an attorney. But at the same time, you also have to remember that this comes down almost to the level of the level of entertainment for people. So you have to take that into consideration with your presentation. Is you have to keep people interested, and you have to make sure that they actually get what you're saying.
Well, I did a Control F search of the DSM-5, and I must have problems because I was unable to find anywhere in the DSM-5 super duper suicidal depression as a diagnosis.
You can't find the entire DSM-5, I don't think, the current updated version online without paying for it. So.
Well, okay, that might be it.
But a
I'm
way
sure
to
that's
figure it
it. It was
out,
behind a
actually,
paywall.
the tricks is go through the SSI, SSDI rules, because they incorporate the text of the DSM in the actual standards for those, because it has to be available because it's legal principle.
And she was so proud of not having the MMPI on computer.
Yeah.
Not administering the test.
She didn't know if it even is administered by computer at this point. So then the question I have is like, well, when was the last time you administered an MMPI? Like, if you don't even know, her whole thing was kind of weird. She comes out, she has a different opinion from everybody else, but then she doesn't seem to have performed any test to go ahead and challenge their opinions and draw her own evidence out of this person who she swears.
She can't explain it. That's the thing, is it doesn't matter if she didn't believe their tests. If she could explain where her opinions came from, that would be, again, an entirely different story. Is you can't explain a conclusion with another conclusion.
Right.
Well, and one thing that
she didn't come off as particularly credible. It's like I'm listening to her and I was like, I just don't really believe anything that you have to say or that you have any particular expertise or knowledge. I felt more qualified than her, and I'm like, that's sad. Will they just give a PhD to anyone? If so, how many box stops do I need?
Kurt,
we decided that Schabusiness would have done a better job.
Nuclear weapon under her hotel room door. She just didn't come across as very credible. She was horrid.
Oh, yeah, I was trying to be nice-ish.
It's not your thing, though.
What the prosecutor
and
did
also
is
she talks with an up talk, and everything's a question.
It's a vocal fry up talk. That makes it worse. What the prosecution did here is exactly what he did during the competency hearing, was just ask a bunch of questions that make you go, this guy isn't very good either. And then once she got sort of thinking she's smarter than him, he just unleashed on the whole malingering stuff and just devastated her.
Yeah, she let her talk first. She let her talk, and then he came in, snap.
And I mean, it's really bad that she must be the only person in the entire United States that would take the government public defender money to testify, because she's literally the witness that the judge said at the motion hearing. She's been evaluated by 4 different people 5 different times, and she's the one that I don't believe she's competent to stand trial. This is one that the judge has already said he doesn't believe, and that's the one that they have to bring in to try to prove she was nuts at the time she committed the murder.
Well, and that's part of it is you, like I said earlier, you take what you can get sometimes. But that doesn't mean that the defense attorney and things like that can't do a better job. If you don't have somebody like who's credible on their own, you have to do something to make up.
I think the defense attorney's been doing good. I won't give any criticism for the defense attorney. I think he's been doing great with the nothing. He has nothing to work with, but he's been doing fine with the nothing he has to work with. I think he's, at least from my vantage point, seems to be very professional. It's just that his client, unfortunately, has nothing to work with.
I disagree.
He's very good at checking all of the boxes he needs to check to avoid incompetency.
Have you watched everything, Kurt? Have you watched all?
Oh yeah, I've watched the entire trial. Oh yeah.
So there have been things. Oh, you didn't watch Nick's stream then?
He's doing his own. He's doing his own.
There you go.
But that's fine. Like people can disagree with me. That doesn't bother me. I disagree that he's done a good job. I think one of the things that Natalie kind of brought up earlier came through at closing argument and at opening argument today. Even if you think he's kind of getting to the various thin points that he has, he's developed no narrative structure. He is not good at communicating anything to the jury. And then it's come through in direct examination of his own witness and cross-examination of other witnesses. He is just really terrible at asking questions and developing any kind of rapport with the person on the stand. And you have to be able to, for your own witnesses, you should not have to do much work on this because you should have already had conversations and built up some level of rapport with them commensurate to the amount of questions you're going to ask and the depth of those questions. He should be friends with this psychologist. He has to be. And he gets her on the stand and he starts asking the questions. They're rambling. They're weird. They're stilted. I felt like I was watching two people with various diagnoses trying to communicate with each other when they can't actually relate to another human. And it is very awkward, and it should come across relationally so it can be communicated to people who are used to communicating normally. And I don't think he's done that at all in this case. I think it's very much to his detriment.
I'll give Kurt half credit because I was with Kurt up until the defense closing argument. I thought up until then he was doing the best he could with what he had, checking off the ineffective assistance of counsel boxes. He has to ask a few questions on cross. I think he asked way too many questions on each cross examination. But other than that, I think I would give him a good B until he got to closing arguments, and then it just seemed like he just went, "I'm fucked."
Yeah, but we're talking about
And
His
he just
opening
gave
argument
up.
wasn't very good either. So,
Wow.
but then neither was the prosecution's opening argument. He was so nervous and
Well, the opening
touching
argument was
touching his face, and
it was the
Today's like the
standard.
only day
We're
of school,
screwed.
so.
You know, anytime a defense starts their opening arguments with, "Please try to keep and have an open mind," you know it's not good. When that's their whole.
Yeah, and again, like the open mind, reasonable doubt argument is sometimes what you got. But what you do have, and he did have this, and this is what really bothers me. The main piece of evidence that they have about all of the facts of this case comes from the video that the jury all watched. And in that video, and here's my theory of what should have happened. The state says, look, you're asked to look into the mind of a defendant to try and figure out their intent. But here, you don't have to do all that work because the defendant has told you exactly what you need to know, and you have no reason to disbelieve the defendant. She has given you everything you need to work with. And then what they did was point to the specific statements that they thought went to the elements of the crime, which is perfectly fine. What he should do at that point is say, you know what? I actually agree that you should take the defendant at her word on her intent, on consent, and all of these other things. But let me point something out. The state did not choose, for whatever reason, to point to these statements that came directly from the defendant. She said she did not intend to kill him. She said she did not want him to die. She said this was part of a consensual activity. He wanted this. He asked her to keep going. She thought he might die at some point, but she never says she thought he would die from this right now. The state has conveniently left out these elements of intent that she has said, but I think we should take them at their word that you can rely on what she has said to you. At least point them to the things she said that go against intent. And then you hit on, now the state has to prove beyond a reasonable doubt. What you've got here is a couple statements that the state wants you to infer intent from, but we've shown you the statements where she expressly denies an intent to kill. The state has to prove beyond a reasonable doubt that she intended it. And they say you should believe everything she says. On the balance of the evidence, we have them having to prove beyond any reasonable doubt. And then we have these statements that give you more than enough reason to doubt what the state's narrative is from her mouth that they say you should trust. That should have been in his close,
Absolutely.
and it wasn't.
Yeah.
Well, because that's another tool that you have that people don't use is like one of the most effective tools in something like a closing is you use what has happened in the courtroom itself. Like because I just got out of a trial last week, I had a domestic violence trial. And you know what? I bring up in my closing the fact that you didn't see the victim, a single time other than when she testified. because she has a right to be here, but she chose not to be here because she doesn't care because this is a game. But this is my client's life. And I'm sorry if he's been sitting there and he hasn't necessarily been making the faces that the state thinks he should make, but he has been put through 18 months before he's been able to even tell his story. Like, you can and have to anchor people in reality. And the actual happenings of the courtroom and what happens are the most important part of the trial, because we can plan it out as much as we want to, but we don't ever know exactly how it's going to go until it happens. You use people's demeanors and behaviors and you spell them out. This is a clue as to that. Even if you don't have facts, you can use extraneous things about what's going on in order to make your point.
Yeah, absolutely. And I think it's critical to contextualize the contemporaneous experience of the jurors into your storytelling, especially when you're short on facts. Like that, you're watching this. You just watched her say these things. And the fact that he's writing notes the whole time. And I'm like, wow, this guy's attentive. He's writing notes. I'm not a great note taker in general. He's writing notes. He's doing all these things. Not one of those notes was anything towards any element of the crime from anyone's testimony. That blows me away. That I know it's not, but that seems like malpractice, that he doesn't point to a single thing. And instead his theory is something that no testimony explored. And again, getting back to this thing, I'm going to agree with what you said, Kurt. I was giving him, or Jeff, and I think Kurt, you agreed with Jeff. I was giving him kind of okay passing until the closing argument, but then I had to retroactively go back and look at all the failures that manifested from that closing argument. When you realize that his story is that the one witness that they can't produce must have been the guy who used the van to go there and murder this guy, and it wasn't his client. And I'm like, wait, so your whole theory is predicated on the idea that this other guy did it, and you didn't produce him, and you didn't ask the judge to produce him, and you just took the state's word that he wasn't able to make it, and you just accepted the state's elicited statement from him, and you have none of your own. But your whole theory is that this guy is a viable alternative perpetrator and not her. And you got nothing on that? Like, that blows me away. And then he carries that theory into closing after that change of pace. That's mind-blowing to me. I cannot endorse that this guy is a good, has run a good defense in this case.
No practice.
Can't do it.
Okay.
But,
well, I'm going to sign off for now because I want to be back on streaming in a half hour and I need to eat lunch, but I just want to drop by and ask my question. So, and if Natalie or anyone else wants to drop by my stream, you can, and I'm sure Vices will be happy to have you on his stream. And
oh, I know.
Anyway,
I've been trying to jump on everybody's streams all week. I've just had crazy stuff going on, and I figured I'd see everybody here anyway.
It's all good. I'll talk to you guys later. All right, bye-bye.
see you, Kurt.
We're just not good enough for Natalie. We're just not good enough for Natalie.
I've been
so
prodding her all week.
Yeah.
Your word.
I'm like, hey,
Oh,
Natalie,
man,
you
this is
want to
so
come
bad.
on? It's a Wisconsin case. You want to show up? Come on.
You're not the only one.
When I have time, I love just like doing thought exercises and things. I just also really love my job, and I also really like spending time with my boyfriend. So I like prioritize other things.
Makes sense.
Yeah.
But
And
how
pets.
bad is it? Like your only witness other than crazy cat lady is pedo dad.
And his testimony wasn't good. So,
but weirdly, it was better than hers.
Yeah, that's true. But like, imagine this. So your theory is that she's broken from the time her mom dies, and that's what you want to elicit from the dad. And so your question is, well, did her mother's death affect her? Of course it did. It affected all of us. Her brother. It affected me. You know, it's traumatizing. So how did her behavior was bad after that? No, not really. It was kind of normal. It's like, oh wait,
she stole somebody's instrument once in high school.
So she acted up in high school. Well, not really. That's a terrible answer to get. And look, I know he tried to rehab that a little bit, and he got into these like mental health issues that she would come to later. But what is the prosecutor going to argue at close? The defense wants you to believe that her mother's death when she was 12 years old, 13 years ago, irreparably broke her and drove her into insanity. But when he asked her father, the one person observing her behavior consistently from that time on, if her behavior got worse, he said, nah, it was pretty normal. And he wants you to believe that she's so crazy that it justifies the murder, sexual assault, and dismemberment of Shad Therion. But her behavior was normal to the father who watched her grow up. I don't know. I think that's the big problem. And it,
well, and you have
to,
if you're the defense attorney, you have to follow that up on redirect. It's like, are you saying it was normal in that it was consistent? Because it can be that she was pretty normal. Oh, that she was consistent with herself. People are really bad at answering questions frequently.
Yeah. Well, and
they're going to answer the question you think that you asked, not the one you actually asked.
And he's in prison. So we know he was bad at answering questions recently.
He didn't go to prison. He got sentenced to prison 9 days before he testified.
Yeah.
So.
Yeah. And
again,
to the defense attorney's credit here, maybe his case complicated his ability to confer with and prep his client, or prep the witness. Maybe the witness is preoccupied with his own issues leading up to this trial. At least in that case, we can understand there's some mitigating factors to the preparedness of the defense. But it's at every stage of this case, he doesn't seem prepared. At every stage, he seems to have not done the work. And that bothers me a lot.
Or perhaps that he was focusing his preparation on the wrong spots. I mean, he seems to be way more prepared for this phase than what you guys have told me about the other phase.
Yeah,
maybe he's put all his ducks in one basket.
Yeah, I think maybe she wanted it as well. So, if I'm clear on this, I'm not sure, Emily. So, obviously, she's not coming out, going to be released to the streets today. But is there a sort of possibility that if she does end up in on the psych ward or whatever, that she does get an opportunity to be released one day, because the other possible sentence would be imprisonment for life, right?
Well, that's what bothered me about not motioning for a lesser included. If you had the lesser included of reckless homicide, first of all, I think you can make a very good argument for reckless homicide here based on the facts that you have. Second of all, reckless homicide, which I think she gets convicted of for sure in the absence of an intentional homicide conviction, gives the possibility of parole. And I think that that's a critical element here to defending your client, is mitigating the idea that she'll be in prison forever. And third, I don't think reckless homicide conviction has, or any argument about it or testimony elicited in favor of it, has any bearing on his ability to make the insanity defense. I mean, recklessness still requires the conscious creation of a situation that is necessarily dangerous to human life, and then behavior acting with disregard for human life in that situation, causing death. So you still have to have the consciousness of what's going on. Insanity still works against the conscious creation of that decision. In fact, it might even work better, because it's one thing to say you're too crazy to try and kill someone when you kill them. It's another thing to say you're too crazy to realize that to consciously realize that the situation you're creating is inherently dangerous. People engage in autoerotic or erotic asphyxiation. That's something that people do. Carrying it too far, not realizing the potential impact of this particular asphyxiation, is way different than trying to strangle someone and intentionally killing them.
No, of course. But what would be the likely outcome had she, when she found out he was dead, instead of the thing she did, had she called 911? What would have happened to her then? Because I think that if you focus on that part of it, it was erotic asphyxiation, however you pronounce it. But she wasn't capable of the ability to control her decisions. She wasn't capable of seeing. I mean, I would make that case if you go this route defense has chosen. I'm not saying it's a particularly good case.
I don't know. I don't think the after the fact dismemberment, I do not think goes to either the intent to kill nor the reckless creation of a situation that's dangerous, because what happens is you've got a body on your hands. Either way, that if you intended to kill him, you've got a body. You knew that was going to happen. I don't see the intent, but whatever. If you've got the reckless case, now you've got a body and you go, oh, damn, I need to fix this issue that has come up unexpectedly. In either case, I don't think the dismemberment analysis changes, because I think in either case, the intent is there to cover up the crime. But I do think that on the insanity argument, that it doesn't, I just don't see the recklessness impacting that insanity argument in any way. And I don't think the dismemberment factors into it. Personally, that's my thing. I think you've got one issue of, are you consciously able to make the decision that your actions will kill this person? And then the next thing is, now you have a dead body and you have to figure out what the hell you're doing.
You call 911 and you say, we were just fooling around in the bedroom. He's my ex-boyfriend. We were getting back together. We were, and I think his heart's still beating. Send an ambulance right now. Take off the chain. That's what, if you would take off the chain, just, call 911. Yeah. You have a better, if you would make inconsistent, I don't know, I've never.
Would have, should have, could have.
But counterpoint, factor in that you're on methamphetamines.
Yeah, and then and it didn't do that. And already that hypothetical Johnny Cash's dead body filled whistling train has left the Schabusiness station. So you'll never know the answer to that question.
I gotta hop off for now, Nick.
Me too. I'm gonna go start my stream here.
But maybe join you later.
Yeah. I got about 10 more minutes. I'll stick around. But
well, cool. Nice to talk to you guys.
Hi guys.
Well, Natalie and I will talk for 10 minutes. See you guys.
All right.
So something.
All right, guys. Thanks for having me on. We're out.
Peace, Jeff.
Bye.
Something I kind of had a question about was, as far as the defense goes, did this guy seem comfortable talking about sex?
The defense attorney?
Yeah, because that was something I was wondering with effectiveness. Is like, I don't know, if I'm an attorney and I know that I'm going to be uncomfortable in general talking about sex, I'm not going to take a case about sex play gone wrong, because you have to be able to talk about it in a comfortable way in order to normalize it, in order to make her seem like she's not this psychotic crazy person.
Right. Can you say, and maybe you can't, but are you comfortable saying the phrase, she penetrated his anus with a dildo?
She penetrated his anus with a dildo.
He was not able to say that on closing argument.
And that's part of the problem is, and everybody, it's okay if people have personal things that stop them from doing something. Nobody is, saying that he has to change himself in order to be an effective attorney. But if you know that you have a limitation that's going to impact your ability to adequately represent your client based upon the facts of the situation, then, maybe you shouldn't take the case.
Exactly. Now he's an appointed attorney. I'm not familiar. Do appointed attorneys in Wisconsin have the ability to refuse a case based on something like that?
Well, generally what happens with appointing attorneys, I mean, granted, this is a smaller county, but I mean, we have to accept appointments most of the time. That's right. The thing. And, like I personally have never and can't ever see myself doing an animal cruelty case. Sure. That's just me personally. I can't do that. One time I got begged to take one. And I was like, I don't really want to do this. I don't want to do this. They're still trying to beg me to take one. I was like, I looked at the criminal complaint and I was like, no, absolutely not. I will be ineffective if I do this. And that is something that it does allow for, as voluntary attorney withdrawal, is if there's something in the case that, you have a personal conflict with, that's grounds to withdraw.
Right. I can think of a couple issues that I would have real trouble defending.
Mark didn't take sexual assault, child sexual assault cases for about 15 years because his kids were, young girls. He couldn't do it. It was
Right.
only after they got a little older that he was able to start doing them again.
Yeah, and I've talked about part of the problems with defending that type of case. The people who are very good at it have this ability to do something that most people can't do, and that is to put we'll say a 13-year-old girl who's been allegedly sexually assaulted by the defendant on the stand and make her a liar by exposing every lie she's ever told, and then to suggest to a jury while she's sitting there crying about all the bad things she's ever done, to suggest to the jury that she's lying about this too for some purpose. Most people would have real moral or ethical issues doing that to a witness. But if you're going to effectively defend someone accused of sexually assaulting a minor, you have to do it.
Mm-hmm.
And that'd be a really tough thing for me to do. I only worked on one sexual assault of a minor case, and it wasn't my case. They've never paid me a retainer, so I didn't end up taking it. However, the weird circumstances, the attorney who was trying to pass it off to me thought it was going to get passed off to me, and so he had actually scheduled something out of state on the date that the court ended up scheduling the plea hearing. So then he hired me just to do the plea hearing. So it ended up being this weird thing. But I wasn't going to represent them in a non-guilty or in a not guilty capacity at that point, because the genetics test, he did it. He did it. There was a child produced from it. He was guilty, right? That was the thing. And so he says, do you want it? Will you do this for me? I'll pay you for the hearing. All you have to do, he's ready to plead guilty. Go do the guilty plea hearing. So I agreed to do that, but I would have had a massive amount of struggle actually representing that person in that case once the facts came to light.
Well, because in sentencing, all you're asking is for it to be fair most of the time, and that certain things to be taken into consideration. It's not saying that this person doesn't deserve to be punished. It's, saying that perhaps the level of punishment that the state is asking for isn't as necessary as they believe it is, because this person's actually rehabilitatable in a way that the state didn't think of. Those are the type of arguments you make in those cases. And, also sometimes getting the best sentence is getting your client to actually admit their problems.
Yeah.
So that is, I've had terrible cases with terrible facts, and then we get a good sentencing outcome because, finally, eventually you agreed to break that wall. And even if you can't say that in front of the judge, I can tell the judge that, I've met with him on so many occasions, and we've talked from the beginning about how he felt about this, and he's had a really hard time talking about it. But, one day he finally let his guard down, and I can tell you, judge, what happened because I was there. Those are ways to be an effective attorney.
That became an issue in this hearing, actually. The judge, now I think the judge was improperly pushing for unnecessary details, because this judge, it was Judge Spilseth, who is now retired, openly stated in court to me in another case that he didn't care what the law is because he's a judge. But let's ignore that for a little bit. He was asking for details from this guy that were not necessary to lay the factual basis for his guilty plea, but he wanted them, and he thought that the guy was evading. But this guy was on medications that impaired his memory. We said from the start, his memory is foggy, but he admits that he did this thing, and he wants to lay sufficient foundation for the court. He wants to do this, but there's some details that are going to be hard. And so the judge said, what were you wearing to sleep the night that you intruded on your daughter's bedroom to do this? And he's like, I don't know. Sometimes I would wear pajama pants. Sometimes I'd just wear boxers. He's like, well, what were you wearing on that night? It's like, this isn't relevant at all.
I don't know. I took 4 Xanax.
Yeah. It's like, this doesn't matter. And the judge got really mad that he was being evasive. And then the judge took me into chambers and started yelling at me to get him to say to get him to admit to this. And I said, well, judge, do you want him to tell the truth? Or would you like him to say what you're asking? Which one is it? And then he yelled at me a little more and sent me out. And I had to talk to my client. Well, I guess he was my client. I had to talk to the client and say, look, you have to, I know that this is tough. I know that you probably don't want to relive this horrific act that you've done, but you have to, or they're not going to accept your plea. So you are going to have to dig into your memory and pull out as many facts as you can for this. We went back in, he broke down crying on the stand and then started getting into more details, but it took that realization that baseball bat, like, dude, you got 12 years in prison for this, or you're going to get 60. What are you choosing? Are you going to admit to these facts? Are you going to do the hard thing and go back into your disgusting crime, or you're not? And it was it worked on him that time, I guess, in his benefit, but it was weird.
Well, and also just the ability to have somebody say that and not fight back shows so much growth for so many of these people when you're dealing with impulse control problems. Is, on the street before this stuff happened, and that's, again, using the tools that you have to your advantage. Is like, you guys, this is such big growth for him. The fact he's even here able to listen to me talk about his flaws without, freaking out.
Yeah, exactly. That is part of it. Now, in this case, the other attorney had pre-negotiated the sentencing and all of that stuff, and so it was pretty much just lay the factual basis, but it was annoying to get to. So there are a couple. I know you have to go soon. There's a couple chats just for you.
We'll do that first. That's fine. Yeah.
Yep. Deleted says, can you ask Natalie if she ever got confirmation that Kyle actually saw my Kyle Rittenhouse Friends intro meme video that YouTube so ungraciously removed?
Man, I've tried to rewatch that and show that to people. So, I mean, if you can find my email, like, if you want it to exist, I'll show it to him personally. Just email it to me. Because I thought that was hilarious, but it's not on YouTube anymore. I don't know if he actually saw that or not. I know Richards did because I showed it to Richards, but
I love Mark Richards, man. I felt so bad when he said my phone was getting like 10,000 text messages a day. I was like, oh my God.
It wasn't Also, it's his own damn fault for the fact that he used to have his cell phone number publicly available. That's why I've never done that.
Good job, Mark.
I set myself up for that.
Justin Wright says, for Miss Wisco, who do I get a hold of to assist a good friend who was railroaded into a 35-year sentence, has been denied appeals due to COVID backups? Heard you were helping the Anderson case and hoped you had contacts.
I need more information from that. I did try and respond in the chat that I need way more details about where to direct people to, things like that. I did respond and chat with my Twitter.
Sure.
My email is on my work website. You can either email me or DM me. I just need more information about the actual facts.
A 6'4" midget says, Natalie, what was the hardest part of Kyle's case and how did y'all argue and overcome it, i.e. interpolation, argument, or other issues?
Hardest part of Kyle's case, generally or personally, are two different things. The hardest part was getting through it. That's honestly the thing. The hardest part was getting through it, for lots of reasons. I think from an actual procedural standpoint, just, we had the same frustrations that everybody who's watching it did, about a lot of things. As far as everything goes, though, with the exception of, the attention on it, it wasn't really that bad of a trial, to prepare for and do things like that because, we did so much preparation, but we had the facts on our side. So, that's, what was the hardest part of most cases, overcoming the facts. We didn't have that.
Right. It was, that's what blew my mind about this case. The right after it happened, I watched the video and I said, looks like self-defense to me. But I can imagine how a prosecutor will write this complaint in a particular way to make it seem like he's guilty of murder. And then I got the complaint, which was released shortly after that. And it was like, this is what they wrote in the complaint. Why is this a case? Like the complaint contained sufficient reasonable doubt. And it was written by the prosecution. Yeah. And that blew my mind.
The problem with it also, with that, gets to the issue of an affirmative defense, is at least in the state of Wisconsin, is if you have an affirmative defense, that doesn't negate probable cause. That's the issue is, you know, and that's how I explained earlier with people is, you know, an affirmative defense is something with all of the elements are met, but there's something else that means you shouldn't be criminally responsible for it. And, you know, in theory, they could have, there is a possible reading that it, you know, could have been interpreted that, but that's just part of the issues with probable cause standard being so low is like, I literally explain it to my clients as being a shit pie. Like they can literally throw shit in a pie pan, but as long as it's got whipped cream on top, it's going to be enough to go to the next step.
Yeah. And yeah, probable cause is a very, very low bar. I don't think it's supposed to be as low as it effectively is.
But it is. It's if the information was true, did a crime probably happened, and are you probably the person who committed it?
Right. But
if this is true.
But my problem is they didn't have to write the affirmative defense into the complaint, and they basically did. And the testimony, the statement, the witness statement was from the favorable witness for Kyle Rittenhouse.
McGinnis, Richie's was in there. Yeah.
Right. And it's like, wait, you have him saying that the guy reached for the gun. You have all this happening in the complaint. It was very weird. It's like, this should not have been charged. And it was pretty clear.
And it's also really strange because there were so many people involved with that case who didn't come into trial that, you know, their witness list was like, you know, 120 people long. People who made completely BS statements that we were able to completely disprove. You know, it's actually you weren't anywhere near this when this happened because we were able to tell this, so you're a liar type of things. They didn't even try and use any of those people in the criminal complaint, and they could have. Once I saw the complaint, I was like, why are you charging this? I mean, you were telling everybody why he's not guilty in the charging document. Very weird. But then, you know, Binger and Krause they did some things that just bothered me so much. I really hated their pinch and zoom testimony. It was really frustrating how they tried to get across this idea that this video in particular shows this thing. It came in last minute under very weird circumstances. And then the technical arguments that they made were demonstrably false. And that was annoying. And I know that was bothering you. Oh, I know.
You actually
That's
were
the only time I actually talked.
Right. And that's when we were like, oh, and she comes in with the tech know-how because
I just suck at explaining things. And I was not expecting to talk. And I was in such a bad mental spot at that. For people who don't know, we buried my dad 6 weeks before the trial started. So it was, and he died of terminal brain cancer. It was a really rough time for me to get through. So I was very much fine with me not talking and having to actually interact with people during the time. So I was under the impression, you know, that I'm not going to be talking at all during this. And all of a sudden I'm talking about everything.
Yeah. And well, you did very well.
Except for the fact I still can't say megabyte. I have to stop and say it.
Well, to be fair, it's a confusing term.
It's just the metric system's the problem. That's what it is I just think I'm like, oh, there's an M. It's going to be like Milla.
Right. Yeah. Well, and I mean, to be fair, I'm not going to say that's rude to a colleague of yours named Binger. So I'm not going to do it. Did you watch any of his follow-up? He did that follow-up interview with the former New York.
I watched part of your review of it, but at the time also that was just my life starting over again.
Right.
So there was a lot of there's different things I've watched at different points in time. That was such a weird thing to process, is being part of you know, not only having such personal crazy things going on, but the biggest effectively event of my career that I can anticipate will ever happen, you know, going through hell during it. So I needed to not do anything for a while. So I didn't, there's some stuff I've watched since then, but.
Okay. If you're willing to talk about this at all, this is my last question for you specifically about this event at all. There was some chatter about Binger having issues being back in that courtroom or maybe in that county practicing there. Was any of that like, did any of that manifest that like he was decalendared from Judge Schrader or anything like that due
No,
to
that didn't
maybe
happen
his
until like
behavior?
afterwards.
Okay, but no, so afterwards that did happen? You're saying?
Oh, I mean, part of it is also just it's one of those things of explanations given versus explanations inferred, you know,
Sure.
or I mean, I don't know exactly when, but those ended up being the only cases that he had in front of Schrader was Rittenhouse and Zemetzky. You know, they do part of the issue, and see, this is again, I don't know, and I really don't want to speculate just
Right.
like, publicly, but you
Well,
know,
yeah, I wouldn't want you to do that in any
and
way.
there
But
is not the best retention rate in Kenosha County in general. So as far as the district attorneys go, so a lot of times they've got to switch spots. And how they do caseloads there is like every county kind of does their own thing. You know, there are certain counties that, like in Racine, for the most, which is where my office is, for the most part, you know, the district attorneys are in front of one judge and they handle one type of case and they're in front of that judge.
Right.
You know, Kenosha does a little bit more rotating, but usually it's between like two branches. So, I mean, I don't know how things actually lined up time-wise.
Gotcha. So is Zemetzky still on, or were those charges dropped? I've heard some.
I think he
conflicting
recently
things.
took a plea to something. I don't remember.
Okay, but we're not going to see a Zemetzky trial.
I don't think so. Let me check.
Okay. I've heard so many different things over, you know, since all this happened about
part of the
Zemetzky.
issue was that he and his wife got new charges for this dumb thing. I don't know if you're aware of that. The new charges with the burglary, robbery, intimidate witness, false imprisonment, false ID.
I heard about that. Well, the intimidation of the witness was Nathan DeBruin, right?
That's a different one. This is
Okay.
no. So that was a different case, as that was its own standalone case. Since then, they've had a new one, and you know that generally can interfere with you know, trial, because people are like, okay, well, let's try and get a good global now.
Right.
But no, it looks like he's got a sentencing hearing coming up in like 2 weeks.
Okay. So yeah, sounds like a plea deal then on that one. Well, may he receive the justice that he has earned in whatever capacity.
And I think, let's see. Yep, and it's a Schrader case, so we'll see what happens.
He seems like a troubled individual with a checkered ability to interact with law enforcement.
And part of the issue is like being involved in these cases and like seeing discovery and stuff. Like you kind of feel bad for people for different reasons that I won't go into. But like also people need to be responsible for their own actions and decisions that they make. And he put himself in Kenosha that night. So at the same time, you don't necessarily feel that bad for him.
Right. And he seems to have repeated interactions with law enforcement where he ends up on the bad end of it. So, but that doesn't necessarily mean that someone is a criminal. My read of him is he kind of seems that way, that he has several minor criminal acts. But I don't actually know the guy. But I mean, I've met people in my practice where they run into the cops all the time for bad stuff, and they're not actually bad people. And they're not actually routine criminals. It's just they keep having these encounters. It's like, this would be easier for you if you could avoid just meeting the cops.
Yeah, exactly. And part of that has to deal with, again, you know, police and stuff in general, and time and, you know, beats. Sometimes certain people are in the same place, same time. If you know that person's going to be there, maybe avoid that spot.
Right.
But anyway, I have to not actually leave court, but it was been delightful.
Yeah, thank you so much for coming on. I'm glad
I finally got to come on, but
awesome. You're welcome anytime.
Okay. You just usually stream so late.
Well, I don't have to. Okay, so here's one thing I've been doing recently is I've created this new show format that I do on occasion called Direct Examination, where the only question I have prepared is, please state your name. And then we go from there, and we have a 2 hour, basically a 2 hour uninterrupted conversation me and my guest, and we get to know their story. And so I grab things from answers that are either interesting to me or I feel might be interesting to them, and we go down wherever it takes us. No agenda, and just kind of get to know someone. If you'd ever be interested in doing that, I will certainly do that.
That sounds exactly like my bag. So
perfect. Well,
because I hate well, and that was the one of the reasons why, there are several reasons why, I intentionally chose YouTube, LawTube for, me making a public statement. But part of it is just because the format is, that's what I'm so much more comfortable with, is just having a conversation with someone as opposed to like feeling like I'm being drilled.
Here's my list of interrogating questions that I want you to answer, or I think you'll answer in a particular way to make my point. So,
exactly.
So we will certainly be able to set that up at a non-late time. I'll message you and we'll figure that out. Cause I would love to interview you and get your, your life story, how you got to, well, I mean, maybe we'll go there. Maybe we'll talk about books. I don't know. It'll kind of depend on how
my undergraduate degree is in printmaking. I briefly studied opera. We have lots of options.
Printmaking?
Yeah, like lithography, intaglio.
Oh, okay.
Yeah. No, I have a BFA in printmaking.
Awesome.
I'm a strange. I was one of those ADHD people who didn't get like that under control until later in life, and so I had tons of interests. So I just kind of tried to do all of them.
Well, perfect. We can explore all of that.
Yeah.
I'll let you get to court. Thank you so much for joining me.
Thank you for having me. Bye.
Of course. Bye. All right. Oh, that was fun. I've been waiting. So Natalie and I have spoken via DM a couple different times. And I think I was briefly on one or two panels for a total of maybe 10, 15 minutes that she was also incidentally on. But we've never had a good opportunity to have like a face-to-face conversation like that. So that was delightful and something I've been waiting to do for a long time. And I swindled her into agreeing to a direct examination, which I think will be a great show when we can line that up. So that's very cool. So court should be starting up. Actually, they're past the time that the judge demanded they would be starting up, but here it is. Here it is. I mean, the judge is very adamant that he wanted everybody to start no later than 1:15, that they deal with the colloquy issues by 1:10. Who knows what the holdup is? But hey, here we are. Here we are. Let me hit a couple more of these super chats. Thank you so much, by the way, for the super chats and the Rumble rants. Very much appreciated in how they help facilitate my ability to do this show in the way that I do. So thank you so much for that. Nix Hex says she talks. So he's talking about the witness, the psychologist lady. She talks like the guy in that Sublime song. Quote, they were living in an apartment with 3 other people. One of them was male and the other 2, well, the other 2 were female. Lord only knows what they were doing in there. What Sublime song was that? My Sublime discography lexicon is pretty robust. I mean, it's not perfect, but I can't place that song. Someone tell me if you know the reference. If you know the reference. That's Smoke 2 Joints. Okay, I'm going to have to rethink through those lyrics. The start of Smoke 2 Joints isn't it? I smoke 2 joints in the morning, smoke 2 joints at night, I smoke 2 joints in the afternoon, makes me feel all right. Isn't that how it starts? Smoke 2 joints in time of peace, or is that just a chorus? 2 in time of war. Okay, I'll have to go re-listen to it. It's been a minute. Mike the Dad Crosby says, so if we are going to say weird equals psychosis, is this 32-year-old gray-haired doctor psychotic? No, she's not 32 years old, to be very clear. She's had a PhD in psychology for 32 years. Nick never owned the album. I own 40 Ounce to Freedom. Still, my physical copy of 40 Ounces to Freedom, I still own. Was it the self-titled Sublime one? With, the kind of the popular one with Santeria and Wrong Way and all that stuff. And then I have a Bradley Nowell acoustic album that I really, really like. The recordings are all kind of shitty. It sounds like he's just recording at a party. But that album's awesome. Let's see. Floppy Turtle says, this doctor makes me want to voluntarily commit myself to an institution. Scott Roush says, here's for a drink after that testimony. Cheers. Uh-oh. Judge is back. Cheers to you, Scott Roush. Let me pour one.
Okay, we're back on the record. I'm going to turn to you, Mr. Freilich. First of all, other than potentially
Serena,
fines, do you have any other
40 ounce, the song
I
itself.
do not, Your Honor.
Okay.
You
and then,
got your
have
hip,
you had an opportunity to speak with your
you
client
got that
about,
red dress on,
testimony
screaming
at
that
this phase of
second
trial?
gear was such
Yes,
a
Your Honor, I
turn
spent
on.
extra time with my client, Ms. Schabusiness. We talked about her right to testify at phase 2 of this proceeding, the NGI phase of the proceeding. She understands what that means. She understands that she could take the witness stand and answer questions and testify about
Do it, girl.
various topics. I've also explained to her that she has a right not to testify, that she doesn't have to get up on the witness stand, that she can stay at counsel table and remain silent. That's her right. That's her choice. I gave her time to think about it, to reflect on it. She had questions. I answered those questions. We had a good dialogue and conversation on this particular topic. She's advised me that she wishes to waive her right to testify. She's not going to take the witness stand.
Ah,
Mr. Business, your
God,
attorney
no!
tells me that you choose not to testify at this phase. Is that correct?
You're
That is correct.
Okay.
you
You understand
sinking
that
your
you have a
only
right
chance.
to testify, and you also have a right not to testify. And if you don't testify, your choosing not to testify can't be used against you. Do you understand that?
Yes, I do.
Okay. You understand those rights belong not to Mr. Freilich. They don't belong to me. They don't belong to the state. Those rights are yours and yours alone. Do you understand that?
I do.
Do you feel you need any more time to talk to Mr. Freilich about this decision?
No, I don't.
And it's your decision not to testify here today. Is that correct?
Correct.
Okay. Any further inquiry the state would like me to make regarding that?
No, thank you.
Mr. Freilich, any further inquiry you'd like me to make regarding that issue?
Only if the court would inquire as to whether she felt any pressure or coercion in order to make this decision.
Mr. Business, do you feel you've had any pressure by anybody or coercion to make this choice?
No.
Okay.
Do you realize you're going to
I'm
prison
satisfied
literally
with,
forever? Did he tell you that?
It's her rights. She's had a full opportunity to speak with her attorney about it.
I'm going to go to the
And she's
bathroom
made a
while
choice
we
here today, freely and
wait for the next
voluntarily
witness.
Not to testify at this phase of the trial. And I'm going to accept that, and we are going to move forward. So I think how the matter would unfold then is when the jury comes back in, I'll ask Mr. Freilich if he has any further witnesses to call. Based upon what I've heard, the answer will be no, the defense rests, and then we would move to the state. And as I'm presuming the state is ready to call its first witness.
Yeah.
Okay. And then I did want to place on the record, because I was advised that when we excused Dr. Layton, we weren't on the record, but there was no objection to Dr. Layton. It's too late now. Both parties indicated there was no objection to her being excused, and that's what I did. Is that correct, Mr. Freilich?
That's accurate.
And Mr. Saunders?
Yes.
Okay, and then I just want to confirm, we don't need to go over these now. The jury has already been waiting a little longer than I told them they'd have to. But I did place on the on council table copies of proposed jury instructions, and then also just recently copies of what comes in the form of jury instruction 605B, but it's not a jury instruction, it's a proposed verdict form. Did both parties get a copy of those, Mr. Freilich
Yes.
and Mr. Saunders?
Yes.
Okay, we can discuss those at the conclusion of evidence, but at this time then, I'm going to bring the jury in. I'll rise to the jury. Okay, be seated. All right, we are back on the record this afternoon. The case is still with the defense. Mr. Freilich, do you have any other witnesses to call?
Your Honor, the defense rests at this time, no other witnesses.
All right, then the matter turns to the state. I don't know, Mr. Lizet or Mr. Saunders, who's going to be questioning the first witness. So, Mr. Lizet, your first witness.
Your Honor, the state calls Dr. Matthew Seipel.
Okay. Dr. Seipel, if you want to step forward here. And
Please raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth in the matter now before the court, so help you God?
I do.
Please have a seat and state your name for the record.
Matthew Seipel. My last name is spelled Seipel.
okay, then the witness is yours, Mr. Lizet.
Good afternoon, Dr. Seipel.
Good afternoon.
How are you currently employed?
I am employed as a licensed psychologist with Behavioral Consultants Incorporated and the Wisconsin Forensic Unit, where I perform forensic mental health assessments on a full-time basis.
How long have you been with the Wisconsin Forensic Unit?
I began with the Behavioral Consultants and the Forensic
case
Unit
now?
in September of
Vince is
2020 as a postdoctoral
fucked.
forensic psychology fellow, and I've continued with those organizations since February 2022 when I obtained psychology licensure in the state of Wisconsin.
And you indicated that your full-time duties is to perform forensic evaluations. Is that right?
Yes.
What types of evaluations do you typically perform?
I complete competency to proceed examinations, mental responsibility or NGI evaluations, evaluations of people who are petitioning for conditional release from the state mental health institutes, as well as legal guardianship, and several types of juvenile evaluations.
You indicated that is your full-time employment. Do you know about how many of each of those evaluations you might perform in a calendar year?
And so I would say in total, I've completed over the past 3 years, roughly 1,000 across those types of evaluations. So in a calendar year, it would break down to typically at least 300 evaluations. About 3/4 of those would be competency evaluations. And then roughly, I would say another 10 to 20% would be NGI evaluations.
You indicated that you are a licensed psychologist in the state of Wisconsin.
Yes.
What does that process entail?
And so to become a licensed psychologist, one needs to complete a doctorate in psychology from an institution that is either accredited by the American Psychological Association or determined to meet equivalency of those accreditation standards. And then at the time that I obtained licensure, 1 year of full-time postdoctoral supervised practice was required. I believe that standard has changed, but that was the standard for licensure at the time that I gained my license.
And you indicated that you must have that doctoral degree. Where did you obtain that degree?
I was from Iowa State University.
And do you
I don't
have,
trust
can you
him
just
now.
go through briefly your education prior
Everyone
to
in
that
Iowa is
degree?
crazy.
I completed a bachelor's degree in psychology from Cardinal Stritch University, as well as a Master of Science in Clinical Mental Health Counseling from Marquette University before completing my doctorate at Iowa State.
And doctor, through your professional work at the Wisconsin Forensic Unit, did you have an opportunity to work on the present case, State of Wisconsin versus Taylor Schabusiness?
Yes, I did.
How did you become involved in that case?
And so I was requested to complete 2 court-ordered competency evaluations in this matter.
When you say court ordered, does that mean that the court is the party that retained you rather than either the state or the defense?
Correct.
Yeah, and when was that first evaluation? When was the first report filed?
That was in November of 2022.
And when was the second report filed?
That was earlier this month in July of 2023.
Can you, you mentioned that you were retained by the court to do a competency evaluation, and earlier you also mentioned that you do NGI evaluations. Can you explain for the jury the difference between those two types of evaluations?
Yeah, so those are 2 entirely different types of evaluations that are guided by 2 different state statutes. And so competency pertains to a defendant's current mental status. It is independent of the mental state at the time of the alleged offenses.
I love it.
And it pertains to whether or not the defendant presently has substantial mental capacity to understand the pending proceedings or to meaningfully assist in their defense. Whereas the state statute for NGI dictates it is about the defendant's mental state at the time of the alleged offenses. And specifically, Was there a qualifying mental disease or defect that contributed to a substantial lack of capacity to appreciate wrongfulness of conduct or to conform conduct to the standards of the law?
And you indicate that you have substantial present experience in both of those types of evaluations. Is that correct?
Yes.
Now, they are different evaluations with different standards. However, are the materials used to evaluate those often similar?
I would say that collateral records are critical in both evaluations, although in competency, those records would focus most heavily on the present time and present functioning, whereas for NGI, it would be focused upon functioning at the time of the alleged offenses.
And can you talk about the records that you reviewed regarding Ms. Schabusiness for each of the two competency evaluations that you performed?
Yes, and so I reviewed the criminal complaint for the underlying matter. I reviewed all previous psychological evaluations that were completed in reference to this case, including competency and NGI reports from multiple examiners. At both times, I reviewed her contemporary treatment records from the Brown County Jail. And during the most recent evaluation, I also had the opportunity to review a discharge summary from a treatment episode at the Nicolay Psychiatric Center in 2021.
Did you, subsequent to the evaluation, were you also provided with copies of materials from an inpatient stay at Bellin Psychiatric or two different inpatient stays at Bellin Psychiatric?
Yes, after submitting my most recent report, defense counsel provided me discharge summaries pertaining to those two episodes of inpatient care.
And were all of those records taken into consideration when you either rendered your opinion or provided testimony at competency hearings in this case?
I would say that all of the sources that I mentioned initially were considered in reaching my opinion in my report. And then those Bellin records I did consider in preparing for testimony, but they did not alter any of the opinions offered in my report.
And in addition to reviewing collateral records, did you conduct personal interviews with Ms. Schabusiness?
Yes, I did.
And what were the dates of those interviews?
And so the most recent interview, I'm just referencing my report here, was on July 12th of 2023. And for the initial interview, I would reference to refresh my memory, that report from November of 2022, the date of the interview was November 17th, 2022.
And were both of those in-person interviews?
Yes.
And can you estimate approximately how long you met with Ms. Schabusiness in those interviews?
On both occasions, it was roughly 90 minutes, perhaps give or take a few minutes.
This guy comes across.
Doctor, when you were reviewing the
immediately
records and ultimately when you had to
more
come
relatable,
to
likable,
an
incredible.
opinion in this
just
case,
in
had
how
you
he answers
encountered
questions.
prior diagnoses that had been assigned to Ms. Schabusiness at various points in time?
Yes.
Were you aware that at some point in time she had received a bipolar diagnosis?
Yes.
And do you recall where that came from?
That was during her inpatient treatment at the Nicolay Psychiatric Center in 2021.
And Doctor, what did you note with respect to that particular diagnosis? Were there any concerns when you saw that?
Yes, a concern I had with that diagnosis is that for one to be diagnosed with bipolar disorder, it's specifically within the diagnostic criteria for that condition that the symptoms cannot occur exclusively in the course of substance intoxication. And I noted that there's multiple collateral sources suggesting that she was abusing methamphetamine very extensively leading up to that treatment episode. So I was unable to really see how the treatment providers could have parsed out to what extent any psychiatric instability derived from the methamphetamine use versus an actual underlying mental illness.
And did you have an opportunity to review the discharge summary from Nicolay Psychiatric?
Yes.
And in that discharge summary, is there a discussion of how she presented upon arrival compared to how she presented upon her release 21 days later?
Yes, it was noted that there was a remarkable difference and that psychotic symptoms were evident upon admission, including hallucinations and very disorganized behavior, although those symptoms were determined to be largely resolved by the end of that treatment episode.
Does that suggest anything to you with respect to the substance abuse that was indicated at the outset?
And so it's, again, difficult to disentangle to what extent that improved mental status resulted from any medication she received in the facility versus her mere forced abstinence from intoxicants.
Based on your professional education and experience of the types of symptoms that were noted upon arrival at Nicolay Psychiatric, can those symptoms also be associated with the methamphetamine use solely?
Yes.
So it's possible for someone to manifest those symptoms solely based on meth use without having any underlying mental health illness?
Objection
Yes.
calls for speculation.
Overruled.
Yes.
You indicated that you had the opportunity to review reports from other evaluators who met with Ms. Schabusiness and provided opinions in this case. Is that correct?
Yes.
Did you note whether or not any of the other evaluators shared similar concerns about the bipolar diagnosis assigned to her by Nicolay Psychiatric?
Yes, I noted that in Dr. Engen's mental responsibility evaluation, she took most specific and direct issue with the basis for that diagnosis. And she ultimately, in her report, offered that she did not see sufficient support to assign a diagnosis of bipolar disorder. I also noted that, for example, in Dr. Lucetta's competency report, while she did not necessarily completely rule out bipolar disorder, she also noted again that the substance abuse was a significant factor leading up to that diagnosis, and she merely essentially sought to rule out that diagnosis but did not assign it.
So I want to just sort of speak generally about bipolar. Can you describe for the jury what bipolar is and what is required to diagnose such a disorder?
Yes, and so there are two different types of bipolar disorder. There's bipolar 1 disorder, which is a more severe condition, and that is the diagnosis that has appeared in some of the records in this case. Bipolar 1 disorder is characterized predominantly by manic episodes, which are periods of it lasting at least a week, where more often than not, the individual has a significantly elevated mood. They may behave impulsively, erratically, have a decreased need for sleep. And in some instances with bipolar 1, that is alternated by depressive episodes, which typically last at least 2 weeks and are largely the opposite of mania. That means there's a persistently low mood, low energy, feelings of worthlessness, guilt, or hopelessness, things of that like. Whereas bipolar 2 disorder has hypomanic episodes, which are not as prolonged or severe as a manic episode. And by diagnostic criteria, someone must also experience depression in order to qualify for bipolar 2 disorder.
So is it fair to say that to diagnose someone with bipolar 1, we would have that expectation of seeing those prolonged manic episodes, at least one instance of a prolonged manic episode?
Yes, and it would need to occur outside voluntary substance intoxication.
Is it possible for a person who has been diagnosed with a bipolar disorder, is that the type of condition that could occasionally wax and wane over the course of someone's lifetime?
To the extent that someone does indeed meet diagnostic criteria for bipolar disorder, yes, there certainly can be a waxing or waning or a cyclical pattern of symptoms.
I also want to harken back to the fact that you have done NGI evaluations. Is that correct?
Yes.
And is bipolar a condition that can sometimes contribute to an opinion that someone does meet NGI criteria?
Yes, it certainly can.
And under what circumstances might you expect to see that?
Yes, and so in order to reach an opinion of supporting an NGI plea in the context of bipolar disorder, one, there would need to be a firmly established diagnosis of bipolar disorder, again, in the absence of substance intoxication, and there would need to be a very direct linkage between the symptoms of that mental illness at the time of the alleged offenses and the substantial lack of capacity to either appreciate wrongfulness or to conform conduct to the requirements of the law. It's not enough for the defendant to simply be symptomatic, but that linkage needs to be established with the lack of capacity.
When you talk about establishing that linkage between the crimes alleged and the mental illness that's been assigned to an individual, what sorts of facts or circumstances do you consider when you do NGI evaluations?
And so there would need to be converging data sources indicating that indeed the defendant was symptomatic of that legitimate mental illness at the time, and there would need to be conceptually, it would need to make sense for the alleged misconduct. There would need to be some sort of reason that mania, for instance, would have caused that behavior. There would need to be evidence to suggest that the person was fundamentally unable to control their behavior. And so again, that would typically comprise a pattern that extends beyond that one momentary act, but it would need to be a broader pattern encompassing that time frame.
So if you were evaluating whether someone's bipolar disorder might be causal of the criminal offenses, would it be significant to you to evaluate the defendant's symptoms or how someone presents immediately before and immediately after the alleged offenses?
Yes, those would be critical time frames in which to gather as much data as possible.
Is that because one would expect that someone with bipolar wouldn't manifest those symptoms solely for a short period of time, but typically over a much longer period?
Yes, that is correct.
Objection calls for speculation.
I think it calls for his professional opinion.
Yes, it would be expected to see, again, a symptom duration longer than just the mere moments of committing a criminal offense.
Yeah, he's not speculating on that. He's talking about the
Doctor, I
DSM
want to
requirement.
quickly return back to some of the other records that had been mentioned. You indicated that you did have an opportunity to review the medical records from Bellin Health from two different stays that Ms. Schabusiness had, one in 2012 and one in 2014.
Yes.
And I'll first call your attention to the 2012 records. If you recall those, do you remember if Ms. Schabusiness was assigned a diagnosis by the treatment providers at Bellin Health at the outset of her stay in 2012?
She was assigned a diagnosis of mood disorder not otherwise specified.
So she was not assigned a bipolar diagnosis at that time. Is that correct?
Correct.
And then in 2014, did she likewise have some sort of diagnosis following her 3-day stay in Bellin?
She was again assigned a diagnosis of mood disorder not otherwise specified, and they did add, which is not a diagnosis per se, but they noted alongside the diagnosis a history of psychosis. But in looking closer at the records, that history of psychosis derived squarely from an adverse medication reaction, which prompted the initial inpatient stay. So she was prescribed sertraline, and then only after that did she begin to have psychotic symptoms, and those symptoms resolved as soon as that medication was discontinued.
Again, she was not assigned a bipolar diagnosis in 2014 either.
Correct.
Dr. Seipel, you indicated that you did have an opportunity to review Dr. Litton's report from July 3rd of 2023.
Yes, I did.
And what type of report from a forensic standpoint was Dr. Litton's report?
It appeared to be a combined competency and NGI report.
In your experience and training, is it best practice for someone to engage in a combined report of both competency and NGI?
Typically, a separate report would be submitted to address each issue independently.
What are some of the reasons why you might not combine those two reports?
For one, there can be information introduced in the issue of criminal responsibility that might be inappropriate to be contained within a competency report. A competency report is not supposed to contain incriminating information with regard to the alleged offenses, but also, and from a psychological standpoint, it makes it difficult to parse out which data and which arguments are directed at each respective issue if they're addressed alongside each other in the same report.
Is it particularly concerning if you come to a conclusion that a person is not presently competent, that you would also rely on that information to form an NGI opinion?
I would say that it's not inappropriate if that's a data point that is considered, but that there should not be a strong linkage in that reasoning, as again, it's two different legal issues pertaining to two different time points.
Doctor, when you looked at that report as it relates to NGI and Dr. Litton's report, I'm just going to ask you generally, did you have any concerns with the methodology that was shown in that particular report?
I found that it seemed appropriate data sources were consulted, at least that's what the methods section suggested in that report, although there was essentially no discussion or review of the discovery materials that were reviewed, and really no account from a defendant's perspective of the alleged misconduct, which are very critical pieces of information that would always be included in an NGI report.
So those pieces of information that you just discussed, like the account of the offense and the specific discovery materials outlining the offense, why is it important to include that type of information in the report?
Because again, the statute for NGI pertains squarely to the moments of the alleged offense, and that is the data that most directly captures those moments. And so it becomes somewhat of a black box issue if those moments are not discussed in the report and inferences instead are appearing to be made based upon presentation at other time points. That's not sound professional reasoning with regard to the issue of NGI.
And I want to talk about information being based on other time points. Did it appear to you that Dr. Litton relied very strongly on her personal observations of Ms. Schabusiness in the interview?
I would say it seemed that the symptoms that were portrayed during the moments of that interview seemed to weigh heavily, as well as the mere fact of a bipolar diagnosis being assigned roughly a year before the alleged offenses.
Were you able to determine whether or not Dr. Litton actually assigned a diagnosis herself?
It seemed implicit in the report that she concurred with the bipolar diagnosis, although it was not explicitly stated. For instance, I am assigning the defendant a diagnosis of bipolar disorder.
Is that typical in your experience to not assign a diagnosis during such an evaluation?
In an NGI evaluation, as the identification of a qualifying mental disease or defect is critical and necessary to support an NGI plea, it would be essential for the diagnosis to be very explicitly indicated.
And that was not done here.
I would say, again, it was not explicit, rather it was more so inferred, being embedded in text.
And Doctor, the report from Dr. Litton, does that include a relatively lengthy or specific discussion of the observations of Dr. Litton from the interview that occurred in June of 2023?
Yes, the greatest detail seemed to pertain to that which would have been her second contact with the defendant.
And you personally had contact with the defendant within about a month of that particular interview. Is that fair?
It would have been roughly like 3 or 4 weeks per my estimation.
The observations that Dr. Litton is making of the defendant, her actions, her behaviors, her psychotic state, did you witness those same things when you met with Ms. Schabusiness?
I did not notice the evident distraction that was evidently apparent during the interview with Dr. Litton. The defendant easily maintained focus and was able to supply coherent, relevant responses to questioning. She remained behaviorally appropriate and was able to engage in detailed discussion of her legal situation. There was a brief moment in which she referenced claiming to see a supposed green train within the room, which is something that was evidently very distracting during the interview with Dr. Litton. I essentially ignored when that symptom was mentioned, and there was no further mention of it thereafter, and there was no evidence that she was in any way distracted by that or any similar psychotic symptom.
Did you form a conclusion with respect to the psychotic manifestations that Ms. Schabusiness was outwardly claiming to have?
I found that there was not sufficient support for assigning a diagnosis such as bipolar disorder or schizophrenia that could presumably underlie those symptoms.
Did you have any concerns about the validity of the claimed symptoms?
She wants to strangle that cameraman.
And what were those concerns?
And so my concerns were manifold. There has been a remarkable inconsistency in presentation over the pendency of this case in terms of the symptoms the defendant has claimed to forensic examiners versus to clinical providers within the jail. And even during very similar time frames, she's offered contradictory remarks. And apparently, only during the interview with Dr. Litton has anyone observed her during the pendency of this case to seem to be preoccupied with internal stimuli. That's not something that I have observed. And jail providers have noted that even in the isolated instances where the defendant has endorsed hallucinations, they have viewed no outward indication.
I would object only because that calls for hearsay. I apologize, but overruled.
I forgot where you were in your answer, but if you're
another question.
Sure. Had other doctors who evaluated the defendant shared concerns that you reported about the possibility of feigning or embellishing symptoms?
Yes.
And who was that?
I noted that first in Dr. Lucetta's competency report as part of a competency instrument that she administered to the defendant. Embedded within that were validity indices. That means there were testing items which sought to determine the credibility of the defendant's endorsement of psychiatric symptoms. And her responses to those items suggested an elevated probability of a non-credible response style with regard to endorsing psychiatric symptoms. And similarly, when Dr. Engen completed her NGI evaluation, she administered the Minnesota Multiphasic Personality Inventory, or MMPI as it's widely known. And the extent of her invalid responses on that instrument made it where her clinical profile could not be interpreted because the validity skills for that instrument suggested she was grossly exaggerating psychiatric symptoms in a manner that would be extreme and inconsistent even for a patient with legitimate schizophrenia.
And did you note whether or not Dr. Lighton performed any such psychological testing to determine the validity of the symptoms that she was observing from Ms. Schabusiness?
I found no mention of any type of instrument for symptom validity within her report.
Was that surprising to you?
I would say yes, in general, but especially specifically given that those psychotic symptoms really seem to be the crux of her opinion regarding the issues of both competency and criminal responsibility, and especially in light of prior testing data that cast significant doubt over the legitimacy of those symptoms. So under those circumstances, it would be extremely unusual for an examiner to not administer testing.
Now, did you administer testing of Ms. Schabusiness when you met with her?
I was prepared to administer testing upon entering the evaluation, although her clinical presentation suggested such testing would not be necessary to reach an opinion regarding her adjudicative competency.
Can you explain that maybe just in a little more layman's details?
Yes, and so to the extent that the defendant would have presented similarly as she did with Dr. Lighton, for instance, presenting herself as very distracted by hallucinations, unable to supply linear or coherent responses, then I would have administered psychological testing to see where the validity lied with such symptoms. Although she did not portray those symptoms and with relative ease was able to discuss her legal situation in a rational manner, so the validity of symptoms became a moot point, that the results of that testing would have had no influence on my opinion regarding competency.
Essentially, you didn't need to test the validity of the symptoms because you didn't see the symptoms.
Correct.
See how much better his answer was to why he didn't give the test? I mean, one second, guys.
Now, Doctor, you also had an opportunity to review the report of Dr. Engen, which I believe you previously mentioned. Is that right?
Yes.
Now, Dr. Engen's report is a report on NGI and not competency. Is that right?
Yes, it is specifically and solely to the issue of NGI.
Now, some of the shortfalls of Dr. Lighton's report that you already pointed out, did you see those same concerns in the report of Dr. Engen?
I did not.
Can you compare or contrast the methodology that Dr. Engen used to the methodology used by Dr. Lighton?
And so in Dr. Engen's report, I found to be consistent with my training, experience, and my understanding of best practice in the field of forensic psychology, and that she engaged in a thorough review and detailed in her report the discovery materials. She supplied a detailed accounting of the defendant's personal account to her of the index offenses. She reviewed medical records from the Nicolay Psychiatric Treatment Center that again would have been in that time period leading up to this offense. And she administered psychological testing to aid in determining the validity of any of the psychiatric symptoms that the defendant claimed during the evaluation. And so that represented to me a full and comprehensive NGI evaluation.
And in contrast, did Dr. Engen's report specifically tie Ms. Schabusiness's behavior at and around the time of the offense to any mental illness or lack thereof?
Dr. Engen supplied a detailed articulation of why she ultimately did not assign a qualifying mental disease or defect diagnosis to the defendant. And then she in turn articulated why she did not believe there was any support for the conclusion that outside of voluntary substance intoxication, the defendant would have substantially lacked capacity to appreciate wrongfulness or conform her conduct to the requirements of the law.
I think we touched on this earlier as it related to general diagnoses of a mental health condition, but can you talk briefly about the impact that acute substance intoxication has on attempting to determine whether or not someone would be NGI?
And so according to the Wisconsin jury instructions, mental disturbance brought on by voluntary substance intoxication is not considered to be a qualifying mental disease or defect. So to the extent that an examiner cannot rule out the sequelae of that voluntary intoxication as being the primary contributing factor to behavior, then the reason would dictate that an NGI plea cannot be supported.
Thank you, Doctor. No further questions at this time.
Cross-examination, Mr. Freilich.
Thank you, Your Honor. Dr. Seipel, good afternoon.
Good afternoon.
You prepared two reports concerning Taylor Schabusiness, correct?
Yes.
One in November of 2022 and then one in July of 2023, correct?
Yes,
And you received police reports, correct?
I did not review the police reports.
Did you review the criminal complaint?
Yes,
Did you have a chance to review any video footage from the incident on February 22nd or February 23rd of 2022?
I did not.
In this particular case, did you administer the two gold standard tests, the MMPI and the MCMI?
I did not administer either of those instruments.
Yet you criticize Dr. Lighton for not doing it, correct?
Yes,
Now, you've been a licensed psychologist since February of 2022, correct?
yes,
That's when you obtained your license to practice and do evaluations and reports and all of that, correct?
my license enabled me to practice independently, although I performed all of these evaluations
What
under
I missed.
supervision from September 2020.
Did
up
he
until
not
that
watch the
time.
fucking video either?
In September of 2020, that's when you were a fellow.
That's when I began my postdoctoral fellowship in forensic psychology.
When you've had a chance to review Dr. Lighton's curriculum vitae, correct?
Yes,
You've had a chance to review her evaluation from July 3rd of 2023, correct?
yes,
What's up with these motherfuckers not
as
doing
far
their
as-
job?
Experience level, she has more experience than you. Is that fair?
I would say she's been a practicing psychologist longer, although the extent to which she has conducted NGI evaluations, I don't know if she has more experience than me.
You understand that she worked at Mendota Mental Health in the past, correct?
Yes, and typically NGI evaluations are not performed for patients already within the State Mental Health Institute.
And with regards to Dr. Christina Engine, she works in the Wisconsin Forensic Unit as well.
Yes, she is employed by behavioral consultants in the Wisconsin Forensic Unit.
Would she be a colleague or a coworker of yours?
I would say we are similarly employed, although we practice typically in different areas of the state and have pretty minimal contact with each other.
And the two of you are aligned as far as opinions in this particular case. Is that fair?
Well, we opined on different issues, so I would not agree with that statement.
But the ultimate recommendation is the same, correct?
I guess I'm not sure what you're asking, sir.
What
That
ultimate
you
recommendation?
And her both find insufficient evidence to support the special plea, the NGI plea.
I would say I did not offer an opinion with regard to NGI, so again, I can't agree with that statement.
Okay. You've had a chance to review Brown County Jail records, correct?
Yes,
You reviewed Bellin Health records that I sent, correct?
yes,
You had a chance to review the Nicolay Psychiatric Center records through Brown County, correct?
yes,
You reviewed a lot of mental health records, correct?
yes.
Fair to say that Taylor Denise Schabusiness does have a mental health history. Would that be fair?
I would say in general terms, yes, she has had contact with mental health treatment.
And fair to say that she was the subject of a civil commitment in 2021, correct?
Yes, it is my understanding that she became subject to a 6-month civil commitment during the course of her inpatient treatment in 2021.
And she was found by a court of law to be mentally ill, at least in 2021. Is that fair?
According to that court order, it would suggest that, yes.
And then she was on a medication order in order to take psychotropic medications for that same period of time, correct?
Yes, it is my understanding she was court ordered to medication compliance.
So here's
A
I'll have
lot
some
of different
thoughts on this in just a minute.
doctors evaluated and took a look at Ms. Schabusiness, correct?
With respect to the pendency of this case or more generally?
Just with respect to the pendency of this case.
Yes, I would say there have been a handful of us that have completed evaluations.
Dr. Deborah Collins, yes?
Yes,
Dr. Tracy Lucetta,
yes,
Dr. Diane Lighton,
yes,
yourself,
yes,
Dr. Christina Engine,
yes.
with regards to Ms. Schabusiness's treatment at Nicolay Psychiatric Center, was she diagnosed over there in May of 2021 with bipolar disorder, current episode manic severe with psychotic features?
Yes, that was the diagnosis those providers assigned.
She was prescribed medications, correct?
Yes, I believe it was an antipsychotic medication that was prescribed.
Do you know if that was Aristotle?
I would have to consult the records to refresh my memory.
Was it your understanding that she was prescribed a medication that would be by injection?
To the extent that it is Abilify Aristana, yes, that is a long-acting injectable medication.
It's an antipsychotic medication, correct?
Yes, with mood stabilizing properties
This is
as
his
well.
best witness examination so far. I'll give him some credit.
And fair to say that through Brown County, through Nicolay, that Ms. Schabusiness was given a diagnosis of bipolar disorder.
Yes.
She was at Nicolay for about a month, correct?
I believe it was roughly 3 weeks.
A couple weeks, and then she was discharged.
Yes.
She was discharged, after she had her baby.
What was the question, sir?
Do you know? I'm sorry. Do you know if she was discharged after she had her baby?
I do not believe she gave birth during the course of that
Furby, he's
hospitalization.
appointed counsel. it
Subsequent to that, she gave birth, correct?
I would again have to consult the records for the dates on that.
When you looked at all these records, did you come to find that there were some references to Ms. Schabusiness suffering from paranoia?
That word was mentioned in the records on some occasions, yes.
And was it mentioned that she had experienced some delusional thoughts?
Again, that was a word that has been used in the records, yes.
And was it mentioned in some of these records that we're talking about that she did suffer from distractions, inability to focus or concentrate?
Yes, there were some notations of those concerns as well.
Was it such that, in gleaning through the records, analyzing them, that she had auditory or visual hallucinations on occasion?
Yes, and most specifically that first admission to Bellin, as well as the admission to the Nicolay Psychiatric Center where I saw the hallucinations mentioned.
Was that mentioned in 2021?
Yes, upon her admission to Nicolay when she had heavily been abusing methamphetamine recently.
See, you got to cut him off.
You've been
Please answer yes or no.
a doctor
Thank you.
for some time. You've got a PhD. You've got a lot of education. You've had experience with different kinds of patients, correct?
Yes, many, many different kinds.
With all different sorts of problems, correct?
Yes.
And you've dealt with people who have had drug addictions and things of that sort, correct?
Yes.
You've gone to seminars with regards to how substances can affect the brain, correct?
Yes, and I taught an undergraduate course regarding the effect of substances on psychology as well.
The judge is planning
And
how he's
would it
going
be
to steal
fair to
bodies
say
from the
that,
crematorium.
Substances can impact the brain, can cause organic brain damage?
I would say there can certainly cause some functional abnormalities in the brain, although the notion that drug use permanently damages the brain really is not consistently bore out in the literature the way that it is in kind of the public conception of drug use.
Drug use can also exacerbate mental health problems, correct?
It can exacerbate them or cause them of their own accord, yes.
What causes memory impairment?
There can be manifold causes for memory impairment.
Drug usage?
Certainly, if there has been recent and especially significant drug use, yes, that can affect various neurocognitive capacities, including memory functioning.
How about traumatic events like loss of a mother?
I would say that can cause some difficulties with concentration, though typically would not cause amnesia in and of itself.
Is PTSD, post-traumatic stress disorder, is that a mental health condition?
I thought that's
Yes,
what he
it
was
is.
asking. Is PTSD post-traumatic stress
Can that
disorder?
get worse over time if untreated?
It can, yes.
If someone has a mood disorder, is that a mental health issue?
Yes.
It's a mental defect or a mental disease?
I would say it could meet criteria as a mental disease or defect according to Wisconsin state statutes, yes.
That was a good try.
Can that get worse over time, the mood disorder, if it's left untreated?
It can, yes.
It was a good try by the defense there. He just wanted him to say yes. It is a mental defect because then he could say and close that it is. But that, damn, he was on his
People
game.
are not subjected to a civil commitment order unless they have a mental health condition, correct? Is that fair?
It would require a clinician to opine that they have a mental illness, yes.
I saw some records in Brown County. I believe it relates to the Nicolay Psychiatric Center records, that there was a problem addressed, risk for self-injury related to delusional thought process vague. Do you know what that references to?
I believe I recall seeing that verbiage in the records, but I wouldn't be able to supply context without reviewing those records.
Do you know if Ms. Schabusiness had problems or issues with a delusional thought process?
At that time, it was noted that that was a symptom she was displaying upon admission to the facility, yes.
Did you have occasion to, when you met with her, to observe that she had a tangential thought disorder?
During my meetings with the defendant,
Yes.
I did not note signs of a clinically significant thought disorder, no.
How about, was that bore out with Dr. Engine or Dr. Collins?
I would say there was, again, no indications of clinically significant impairment in maintaining linear thought during those evaluations.
In your review of the Brown County progress notes from Nicolay Psychiatric Center, did it have references to Ms. Schabusiness identifying demons in her life?
In terms of the Nicolay psychiatric records,
Yes.
I do believe there was mention of some commentary of that sort, yes.
And was there commentary that her affect appeared to be labile and inappropriate throughout group, and that she had mood changes and inappropriate facial expressions or laughing?
Yes, I did see that bore out on those records.
Did you see that when you talked with her in November of 2022 or July of this year?
I did note that there were some moments of some inappropriate grinning or perhaps very brief isolated instances of laughter. All those were short-lived and did not impair capacity for us to have a linear and meaningful discussion.
In July, when you met with her, you said 90 minutes, give or take. Was it cut off for any reason? Was your interview cut off?
No, they were able to be completed on both occasions to their natural course.
Okay. In some of the records, did you note that it indicated her affect was flat when approached?
Yes, there were some indications of a relatively flat or diminished expression in her emotional presentation, yes.
What does that stem from, do you know?
That's again something that can have manifold causes and could simply be someone's baseline emotional presentation as well.
Could it be related to a mental health defect or disease?
It is possible, although again, it could also be due to many other factors.
Also in these progress notes, did you indicate, or did you review, excuse me, that she was feeling as though different bodies were going in and out of her person?
I do believe I read that in the Nicolay notes as well, yes.
Did she talk about having pressure in her head or having her head hurt?
Yes, that is a complaint that she has made at different occasions across time, yes.
And did she also indicate that she had problems with eye twitching and that her PTSD was triggered from loud noises?
I do believe I recall seeing those symptoms mentioned in the records as well.
Did you, at least in some of the, either the jail records or the Brown County
He's working
records
with what
from
he's
Nicolay,
got.
that she
Problem is he
talked
doesn't have
about
much.
wanting to die and go to heaven to see her mom?
Yes, I do recall seeing such comments made.
Those are not psychotic pranks. Those are suicidal thoughts and expressions. Also, I will
In
address
reviewing
his
these records, because there were a lot of them.
brief tenure as a psychologist. I didn't
indicate
hear
at
all of it,
least
but it merits some
in the
discussion.
records when she was at Brown County at Nicolay that she was hearing voices that would get heavier at night?
I do believe, yes, there was a pattern of time of day seeming to impact symptoms at that time, yes.
And the time of day would be more at night. They'd be more pronounced at night than the daytime.
Per my recollection of the records, I do believe that was the pattern that was mentioned.
And she was encouraged to connect with a dual therapist to address mental health and her AODA issues. Is that fair?
Yeah, consistently over time, she has been referred for substance abuse treatment, yes.
And in those records from Nicolay, it also talked about that she would have racing thoughts that would get overwhelmed and that she'd hear voices in her head.
Yes, those are symptoms I do recall seeing in the records.
It's true, right, that there were discussions about her getting this Aristata injection every 4 weeks to help her?
Yes, that is the typical course in which that medication is administered, and per my recollection, I do believe that's what was ultimately prescribed.
Then there was some discussion about whether she would take the pill or take the injection, correct?
Yes, I do believe that the means of administration was discussed amongst her clinical team.
It's the means of administration.
Even in the notes, it talked about, in the notes from Brown County, from Nicolay Psychiatric Center, it talked about how Miss Schabusiness would have agitation, anxiety, correct?
Yes.
And that there was a discussion about giving her Haldol, correct?
Yes, that would be another antipsychotic medication with pretty heavily sedative properties.
Do you know if that was ever given to her?
I would again have to refresh my recollection with the records.
And even in the Nicolay records, it talked about that it was a struggle to decipher what is a genuine psychiatric symptom and what is otherwise talked about as gaminess, correct?
Yes, I do believe that was a term that was employed in the records.
There were just a lot of records to review and you have a good memory, but it also talked about Zoloft, correct?
Yes, that was mentioned specifically in her adolescent
does have a good
treatment
memory,
records.
a better memory than your
And
witness.
Ms. Schabusiness was given apparently at Nicolay, from what you reviewed in these notes, what are her coping skills and what does she want to do to make progress with mental health? Is that fair?
I don't recall that specific information.
Okay. With regards to
and then he forgets something right after
Dr.
saying
Lighton,
that. Thanks, you cunt.
she says that she believes that my client, Ms. Schabusiness, qualifies for the NGI plea based on a diagnosis of a serious mental disorder. You understand that?
Yes, that's what she wrote in her report.
And she opines that her serious mental disorder affected Ms. Schabusiness's ability to know right from wrong at the time of the offense, correct?
I would say it was relatively tersely worded, although that was what was suggested, yes.
And she also said that it affected her ability to control her behaviors. Is that fair?
Yes, that was the opinion that she reached.
You have a diabolically opposed
Diabolically opposed?
Lytton, correct?
Again, I did not opine on the NGI issue.
Fuck are you talking about?
Thank you, nothing further.
This guy uses words that he doesn't understand all the time.
Just briefly, I think you were asked a great deal again about the records from Nicolay and the specific symptoms that were manifesting at that time at Nicolay. Yeah, do you know if Nicolay actually administered a blood test to determine whether or not there were substances in her system at the time she entered Nicolay?
There was either urine or blood screening performed for toxicology purposes, yes.
And she did test positive for methamphetamine?
It was methamphetamine and I believe also amphetamines and THC as well.
And did the Nicolay records show a marked improvement in her symptoms in the 3-week stay there?
Yes, there was a relatively linear trend over time towards psychiatric stability.
And while that might potentially be attributed to taking psychiatric medications, it might also be attributed to weaning off of the illicit substances.
I would say it's fundamentally impossible to disentangle to what extent precisely the improvement would have derived from those sources.
And you were asked questions about at points in time, did Ms. Schabusiness have potentially paranoia or hallucinations or things that could potentially be associated with psychiatric conditions or psychosis? Did anyone in any of the records that you saw make such an opinion on or around February 22nd and 23rd of 2022?
In terms of those symptoms or diagnoses applying at the time of the alleged misconduct?
Correct.
I would say that from what I saw, Dr. Lighton was the only one that, and again, it wasn't really directly discussed, so at least seemed to imply that those symptoms were at play at the time of the incident.
Now, none of the mental health records that you saw were from February of 2022. Is that correct?
I did not see any indication of her being actively involved in psychiatric treatments, so there was no reliable collateral source to corroborate those symptoms at that time.
And again, just to clarify, I think you've done a good job of this, but you were not asked to opine on the issue of whether
Objection to the good job
an NGI
comment.
offense or an NGI defense is appropriate for Ms. Schabusiness in this case.
That is correct. I was only ordered as a competency examiner.
Thank you. I have no further questions.
On those topics, Mr. Freilich?
No, Your Honor. Thank you,
Okay,
Dr. Seid.
Doctor. You can step down.
Okay, so a couple things. This guy was hired as a competency
witness.
examiner, not a
Say
not
Paul
guilty by
Star,
reason of
Christina
examination or of insanity examiner. So he didn't perform the evaluations for this thing. And there's some criticism about him not reading those tests, but he wasn't actually asked to opine on the issue of her insanity, only of her competency to stand trial, which is an issue that's already done. Another thing is related to his youth or lack of experience as a licensed psychologist. While that is true that he apparently was only licensed about a year ago, lots of that, lots of licensed psychologists involves therapy work, internships, clinical, experience prior to achieving that PhD in psychology license. That can be in the realms of therapy, treatment, counseling, drug rehab, and other things that might be relevant experience. I don't know, at all about this. What I tell you is that largely came across more credible than the much more credentialed attorney and witness. And just as you should not credit automatically an expert based on their experience and their education and
Christina Engen,
qualifications. You should similarly not discount
CHRISTINAENGE.
an expert opinion based on a perceived
Saunders,
lack
this
of
is
credential.
All right, Doctor.
Evaluate
how are
what
you
they
employed?
say.
As
You
a
can take those
psychologist with
factors
behavioral
in for
consultants.
sure.
And
You should not
how long have you
automatically
been
go one way or
employed,
another
with behavioral consultants?
for any reason.
12 years.
And do you have any degrees?
I do. I have a PhD in counseling psychology from UW-Madison, which I earned in 2010.
And I guess what do you do as a psychologist with behavioral consultants?
I conduct almost exclusively criminal forensic evaluations.
And we've heard that term a few times. What is forensic evaluations? What does that mean?
Court principals will approach a psychologist with a psycholegal question. So a psychological question that applies to the legal
Remember that
situation. And
Dr.
our
Mommy
job
was
is to
less
help answer
qualified than
that,
either of
and
the
to,
other
provide
doctors
information
in
to the
Depp's
trier
case
of
by
fact, the judge
credential.
or the jury, to help them answer that question.
Are some of those evaluations that you're asked to conduct what are referred to as NGI evaluations?
Yes.
And I guess, what does NGI refer to?
It's for the plea of not guilty by reason of mental disease or defect. It's an evaluation of criminal responsibility.
And you have performed those evaluations in the past?
Yes.
Are you able to approximate how many NGI evaluations you've completed in your career?
Over the course of 12 years, approximately 250 NGI evaluations.
And are those typically done at the request of a court?
Yes.
Have you, in your career, in those 250 evaluations, reached an opinion that somebody would be appropriate for an NGI plea?
Yes.
And contrary, have you formed the opinion that they are not, they don't fit for the NGI plea?
Yes.
All right. And doctor, do you maintain a curriculum vitae with respect to your educational background and qualifications?
Yes.
All right. Showing us the marked exhibit 12. Do you recognize that?
Yes.
And what is that?
It is my curriculum vitae.
And does that appear to be up to date?
Yes.
All right. That's a document that you prepared?
It is.
I'd move 12. The objection?
No objection.
12 will be received. Do you maintain any licensures?
Yes, I'm licensed to practice psychology in the state of Wisconsin.
And are you also board certified?
I am.
What does that mean?
I'm board certified by the American Board of Professional Psychology. Applicants can specialize in several different areas of psychology. My area of specialty is forensic psychology.
And do you maintain any professional memberships?
Yes.
And what are some of those?
With the American Psychological Association and the Wisconsin Psychological Association.
In addition to your employment, do you also, or have you had any teaching experience in this role?
Yes.
All right. What are some of those?
I've provided guest lectures for Marquette Law School, for trainees at Mendota Mental Health Institute, once for the Department of Corrections psychologists.
Doctor, then I want to ask you about this case. Did you become or asked to become involved in an NGI evaluation of Taylor Schabusiness?
Yes.
No.
And how did you become involved in that?
I was court ordered to conduct an NGI evaluation.
Were you retained by the state of Wisconsin?
Appointed by the court.
By the court, but not the district attorney's office?
Correct.
And you weren't retained by the defense either?
Correct.
And is it's the case that most of the evaluations you perform are at the request of the court?
That is correct.
And did you ultimately prepare a report with respect to your findings regarding that NGI evaluation?
Yes.
Doctor, I'm showing you Exhibit 13. Do you recognize that exhibit?
Yes.
And what is that?
It's a copy of my report.
Does that contain your I guess, factual findings and ultimately your opinions with respect to the NGI evaluation?
Yes.
I'd move 13.
The objection? Subject to cross, Your Honor, no objection. 13 will be received.
So I guess generally, can you describe the process that you undergo to conduct an NGI evaluation?
Wonder if we're going to be done
Yes,
today.
the evaluation consists of a clinical interview, so a meeting with Ms. Schabusiness. I also conducted a full discovery review, so review of all of the police reports, videos, documents of that. And then I also, in this case, reviewed her available medical records, which included a prior competency evaluation, records generated through Brown County, and then in this case, I did administer psychological testing.
So I want to first start with the clinical interview that you mentioned conducting. What date was the date that you met with Ms. Schabusiness?
So I attempted to meet with her first on October 12, 2022. However, because of her security status in the jail, I was not able to meet with her confidentially. So I returned on October 21, 2022, and we met in a conference room. That's when I conducted the interview and the psychological testing.
And October 21st, 2022, would that have been about 8 months after the offense that she was charged with?
Yes.
Okay. And you also mentioned you conducted a full discovery review, and that included reviewing videos. Is that right?
Correct.
Okay. Was one of those interviews that you reviewed an interview of Ms. Schabusiness from February 23rd of 2022?
Yes,
Was that a rather lengthy interview?
it was.
Did you review the
This is
entirety of it?
right after
To the best of my recollection,
23rd. I think that's the day
I
after.
believe that I reviewed
arrest
the
or
vast
something.
majority of it. If I would say the majority of it.
Were there a lot of dead parts in the middle of it?
There were, but I thought it was important to review that video footage to listen for comments that Ms. Schabusiness would have made in the room by herself to observe her behaviors and the like.
So it wasn't just the comments that were made to law enforcement that you were looking for, but also her independent behaviors?
Correct.
And you also mentioned you reviewed the police reports and other various attachments that were part of the case?
Yes.
The medical records that you reviewed, you mentioned there were prior competency evaluations, but also Brown County Health Services records. Is that right?
Correct.
Was that in reference to a stay at Nicolay Psychiatric?
Correct.
All right. And when was that?
That spanned March of 2021 to April 2021.
All right. And you then indicated you also conducted a, I guess, personality test, or what was the fourth collateral source you reviewed?
I can administer an objective personality test. It's called the Minnesota Multiphasic Personality Inventory, 3rd edition.
Well, her
the
camera
acronym
froze.
is MMPI.
She's ventriloquating.
So I want to then go through your report, if that's okay, Doctor.
How's she doing that?
Beginning on page 2.
Oh, they fixed it.
One of the things you start with is called relevant history. Do you see that section of the report?
Yes.
And I guess why is it important to review the history as part of your NGI evaluation?
When gathering history about a defendant, we are touching on topics that are potentially relevant to the issue of criminal responsibility. Things like early childhood events, history of mental health treatment, substance use, any learning difficulties, difficulty working, all of this can potentially inform the issue of criminal responsibility.
Okay. And as part of that, did you review Ms. Schabusiness's employment history?
Yes.
And I guess what did you note with respect to her employment history?
What I recall is that she has worked primarily in factory settings. Relevant to this evaluation was that she was working up until about a week before the underlying offenses.
Why is one's employment history relevant to an NGI evaluation?
It speaks to the prong of behavioral control. So later on, when we discuss the prongs of the NGI plea, one of them has to do with one's ability to conform their behavior with the requirements of the law. It's a capacity issue. So can a person do that under normal circumstances? And one's ability to work, maintain employment, show up, perform their job duties, that speaks to an individual's capacity to conform their behavior and meet the demands of daily living.
Okay. And you noted employment history fairly consistently up to about, I think you said a week before the offense?
Correct.
And you also reviewed Ms. Schabusiness's mental health history as well?
Yes.
As we talked about. As well, did you review her during the course of your clinical interview with Ms. Schabusiness, her current presentation?
Yes.
And I guess what is the importance of kind of noting as you do the current clinical presentation of a patient?
So that's another piece of information that informs the diagnosis that is required of the evaluation.
Okay. As part of the clinical interview with Ms. Schabusiness, do you get a narrative from her about the alleged offense?
To the extent that I was able,
Robin Sage, you
I
ain't
did.
right.
Ms. Schabusiness recalled the time period leading up to the offenses, but then she reported that she had no memory for the offenses themselves, and she did not. She reported she did not regain memory until after her arrest.
Okay. With respect to Ms. Schabusiness recalling the time period leading up to the offense, what sort of information did she provide?
What I learned was that she had been living in Texas and returned to Wisconsin in early 2022 to tend to legal matters. She made a court appearance. I believe she was sentenced to 5 years probation. She was making arrangements to have her community supervision transferred to Texas so that she could resume caring for her newborn baby, who was in the care of her grandparents. She was working. She had started Suboxone treatment to maintain sobriety. And I understand that she struggled during this time period, was feeling what sounded like to me some alienation in the workplace. Not feeling like she was connecting with her coworkers, and then began to, she reported to me she was hearing voices that were telling her to relapse on methamphetamine.
Okay. And some of those, you mentioned, employment, you mentioned some arrangements with respect to childcare. Why are some of those acts kind of relevant from an NGI evaluation standpoint?
Again, it speaks to the issue of one's capacity to conform their behavior. So all of those are very goal-directed tasks.
And those were all kind of leading up to the date of the offense.
Correct.
With respect to February 21st, 2022 specifically, did she have a narrative about sort of the timeline of events leading up to the offense?
Yes, on February 21st, 2022, she recalled that she was socializing with friends. They had come to the residence she was staying in. I believe they were smoking marijuana. She expressed an interest in finding methamphetamine, and so she said that she went on a quote meth hunt, unquote.
Did she indicate whether she had ingested methamphetamine leading up to the homicide?
Yes, she told me that she took 52 hits of methamphetamine.
Did she also refer to that amount as, quote, a lot?
Yes.
All right. And did she indicate at some point that night meeting up with the crime victim, Mr. Therian?
Yes.
And then you indicated around the time of the alleged offense, she reported having no memory of that time.
Correct.
Did she, and then you indicated she regained her memory sort of in speaking with law enforcement?
Yes.
Was that professed amnesia of a concern to you?
It was notable. As I indicated in my report, I found her self-reported amnesia to be inconsistent with my review of the discovery material. So specifically, I observed her describe in great detail to the detective the details of that evening. So that stands in contrast to her self-reported amnesia in the present or at the time of the October interview.
You also indicated during the interview with Ms. Schabusiness, you performed some psychological testing, is that right?
Yes.
What testing did you administer?
It was the MMPI-3.
What is the MMPI-3?
It's a very well-established psychological instrument dating back to the 1940s, very well researched and respected. So this test can provide indication of different types of psychopathology or different types of mental illness. It also contains a number of validity indices to help psychologists understand the response style of the test taker.
So the validity indices, I think I said that right, that you mentioned, I guess, what does that mean?
What that means is that built into the test are several items that when they're all combined at the end, they'll indicate if a person is answering questions in a forthright manner, if they're minimizing their symptoms, or potentially if they're exaggerating their symptoms.
So is this test like a true-false questions, or how does this test administer?
Correct. It's a true-false instrument.
And I guess what were some of your findings with respect to Ms. Schabusiness's performance on the MMPI test?
Well, first, let me be clear that the test does not say anything about Ms. Schabusiness's functioning. In February of 2022, it only provides information about her functioning at the time of the test. So what was relevant from that was that there was indication of symptom exaggeration. She responded to items, she endorsed a number of symptoms that genuine individuals with genuine mental illness would not endorse. The frequency, number of unusual symptoms that she acknowledged was greater than those with genuine mental illness. And then there was also indication of non-credible memory impairment built into those, the results of those validity indices.
So I just want to go back a little bit. And that's a good point. So this testing is sort of in the moment as you're meeting with Ms. Schabusiness, is that right?
Correct.
But why is it still something you administer in the course of an NGI evaluation?
So getting back to that term of response style, that's very important to understand if the individual is being forthright in their account of information that they provide to me. And what I found with these elevated indices indicating the exaggerated descriptions of mental illness, unusual descriptions of mental illness, is that the information that was being reported to me needed to be interpreted with caution. Ms. Schabusiness's self-report could not be taken at face value.
And I think you state that anything that's not objectively observed should be closely scrutinized. Is that right?
Correct. So then it would be important to find other sources of information that would support what she's telling me versus relying just exclusively on her self-report.
And one of the phrases you used was endorsed symptoms. What does that mean?
Self-reported. We covered this. Come on.
For example, I'm just making this test example up, but I feel depressed. A true response would be an endorsement of that symptom.
So an endorsement is something somebody's telling you.
Yes.
All right. So based on the interview you had with Ms. Schabusiness, your review of some of those collateral sources of information, were you able to offer an opinion with respect to whether Ms. Schabusiness was suffering from a mental disease or defect?
Yes.
And what was, I guess, that opinion?
I reached the opinion that while she did have a mental health conditions, these did not appear to qualify as mental diseases and defects.
And in your report, you outlined, I guess, 3 mental health conditions. Is that right?
Correct.
What are those?
The diagnoses that I offered were methamphetamine-related use disorder, and that was applied in acknowledgement of Ms. Schabusiness's general use of methamphetamine in that time period. The diagnosis of methamphetamine intoxication was applied because she was using methamphetamine at the time of the crime. And then the final diagnosis I gave was methamphetamine-induced psychotic disorder. And I offered that one because Ms. Schabusiness was describing, and the records contained indication of paranoia. I think she made a comment about muscle rebuilding during the homicide, and this indicated to me the presence of psychotic symptoms, which I attributed to the recent methamphetamine use.
So, and that's a question I have. So mental health conditions, in your opinion, are different from mental diseases or defect?
Correct.
And the 3 diagnoses you offered, you stated those are not mental diseases or defects.
That is my understanding.
And why is that?
Because, excuse me. So if one ingests an intoxicant voluntarily, so they took it of their own volition, and if they were not naive to its effects, that would mean it's my understanding, based on the case law, that the defendant
Why
would
are
be
you
subsequently
not objecting to a
responsible
legal
for,
conclusion here?
all alterations of thinking, judgment, behavior related to that.
Oh my God.
intoxication.
I guess, were you aware of any information in the materials you reviewed that Bishop
You
Business's
just asked a
methamphetamine
non-lawyer
use
legal
was anything
question.
but
The defense
voluntary?
didn't
No.
object.
And that obviously she reported a history of using methamphetamine to you?
Yes,
You
So
can
I guess
do
were
that,
you
by the
of
way. They just
opinion
should
that she was not
object.
naive to its effect?
correct. Yes. And I'm also aware that she had psychotic symptoms in the context of methamphetamine use the year prior. So certainly she was aware of its effects, broadly speaking, to include psychosis.
So I want to pause just here. Methamphetamine use in general, I guess in your experience and in your education training, are you aware of some of the symptoms that may manifest as a result of that?
Yes.
And what are some of those?
So excessive energy, decreased need for sleep, and then oftentimes we see in the field of forensic psychology that it can induce psychotic symptoms. So misperceptions of reality and paranoia.
You also mentioned a year prior there was a diagnosis of at the Nicolay Psychiatric Center. Is that right?
Yes.
And did you consider, I guess, the applicability or the appropriateness of a bipolar 1 disorder?
I did.
And what was your conclusion with respect to that propriety of that diagnosis?
After considering the diagnosis of bipolar 1 disorder, I did rule it out because I am aware that being intoxicated or having a methamphetamine-induced psychosis can look virtually similar or indistinguishable from a manic episode with psychosis. So the two look similar. And so what I would be looking for if I were to support a bipolar 1 disorder diagnosis is the presence of that psychosis and the mood elevation when there's no methamphetamine use present.
And are you aware of any of those symptoms absent in the context of methamphetamine use?
I am never, I'm not aware of a time ever that Ms. Schabusiness displayed psychotic symptoms or elevated mood outside of the methamphetamine use.
And I guess you are aware, though, that bipolar 1 diagnosis was applied to Ms. Schabusiness in April of 2021.
Yes.
Are you aware, though, that there was concerns about recent methamphetamine use around that same time?
Yes, I believe that she tested positive for several drugs, including methamphetamine at that time.
So that's why that's not a diagnosis you are willing to give to Ms. Schabusiness. Just clarifying the testimony. I'm just clarifying the testimony.
Overruled.
Thank you. So I guess in sum then, is there any mental disease or defect that you would diagnose Ms. Schabusiness with?
Yes, also offered at Nicolay or Nicolette, I'm not sure the pronunciation. There was a diagnosis of I believe it was polysubstance abuse or something to that effect, meaning multiple substances were being abused at that time. I believe that's an appropriate diagnosis for her. I do believe that I believe firmly in the diagnoses that I offered in my report.
Okay. But those are not diagnoses that I guess are mental diseases or defect.
Correct.
Whoa. There we go.
Did you also then reach an opinion with respect to the, I guess, second question or the second part of the NGI evaluation, whether she was responsible for the conduct?
Yes.
Okay. And what was that opinion?
I found insufficient support for the conclusion that as a result of a mental disease or defect that she either A, was unable to conform her behavior to the requirements of the law, or B, was unable to appreciate the wrongfulness of her conduct.
What are some of the reasons you reached that conclusion?
Well, first, and most importantly, I was not able to find support for a diagnosis that would qualify as a mental disease or defect. So really at that point, then the analysis could end. That's a requirement of the plea. But I found in my report, I outlined various different factors, but focusing on the two issues, one's ability to conform their behavior to the requirements of the law and one's ability to appreciate wrongfulness. First of all, I did pull from her behavior outside of the moments of her known intoxication to observe that she was able to engage in very goal-directed behavior. So I assumed that any alterations in her behavioral control were directly related to the methamphetamine use. So that was the first issue. And the second issue having to do with wrongfulness, it was my opinion that she did demonstrate appreciation of wrongfulness. There were several comments that were made to law enforcement expressing apologies to the victim's sister, indication that she was trying to conceal the body was dismembered because she wanted to conceal it. These all speak to awareness of consequences, appreciation of wrongfulness, that she grasped wrongdoing had occurred.
And did you also consider, I guess, the validity of the professed amnesia for the time surrounding the offense?
Yes, I did not find
to have any amnesia around the
self-reported
offense.
amnesia to be credible. First of all, there was that disconnect between what she was reporting to me in the interview as compared to the recollection she had during an interview with the detective immediately thereafter. And then I also found indication in the results of the MMPI-3 that she was
That was a really brutal statement.
that she was reporting non-credible memory impairment.
That was a brutal statement. It calls attention to the interview, which shows that she doesn't have any amnesia, very much mitigates one of the key things, though she didn't know what was going on, et cetera, et cetera. And it shows that she might have been over-presenting in the interest of trying to be crazy. You don't have to agree with it, but I think the state's going to pounce on that one.
Do you have just a few more questions, Doctor? Your report was done in November of 2022, is that right?
Yes.
And subsequent to that time, have you had the chance to review any other NGI evaluations conducted in this case?
Yes.
And who authored
Again,
those reports?
Conventional
Diane
understanding,
Litton.
colloquial crazy is
And
different from
in your
legally
review of
insane.
Dr. Litton's report, did any of her findings or conclusions alter your opinion from November of 2022?
No,
I guess the same opinions you're testifying here to today.
it did not alter my opinion.
And then all of the opinions that you're offering here today, are they to a reasonable degree of professional certainty?
Yes.
Thank you, Doctor. Nothing further, Your Honor.
Cross-examination, Mr. Freilich.
Would we be able to take a break right now or not?
Okay.
Okay.
Ladies and gentlemen, we'll take a 10-minute break and we'll resume. All rise for the jury.
Oh, I'm wondering if we're gonna get through this trial today. I think it's gonna carry into tomorrow. But jury instruction should actually be pretty short. So maybe we still get there by 5.
And Doctor, you can step down. We'll be in recess then for 10 minutes. I'd like the attorneys to return. Obviously, 10 minutes is a little bit before 3. I'd like to hear a little bit before 3 so I can speak to you a little bit about these instructions. Okay? So we're in recess.
This might be the last witness, though. So who knows? Whitney, she's already said she's not taking the stand, passed up the opportunity to do so. Oh my gosh. Oh, early morning catching up to me. All right, let's put that on pause. Okay, so testimony case, I guess the case for the state here seems to be going pretty well, honestly. I know some people had issues with the first witness because he was underexperienced, didn't do reports, et cetera, et cetera. But remember, he wasn't actually brought in for the not guilty by reason of insanity defense. He wasn't asked to make that evaluation. I'm not sure entirely why they called him. I don't know what they elicited from him that was important. This woman seems much more relevant to the discussion. She actually did the MMPI, which is directly related to these sorts of things. She examined her contemporaneously to the offense, I think a day or two after the alleged offense occurred. Or no, it's the day after the alleged offense occurred. She's got quite a bit of experience under her belt. And she makes these not guilty by reason of insanity determinations. She says she'd done 250 before. Now, of course, on cross, you're going to ask if you know the answer, if she's ever found anyone not guilty by reason of insanity. If you know she's never found anyone not guilty by reason of insanity, then you go ahead and ask that question. Point out that she's a shill for the state, paid by the state to find people sane in all instances and to explain away everything they've done. But we have to focus for just a minute on the difference between someone being fucking crazy and someone being not guilty by reason of insanity. Murdering someone, chopping up a body, and fucking their dead corpse is insane. It's crazy behavior. You don't do it. The question is not, are you doing something that a normal person would not do? Even if you do it all the time, that's not crazy. Or that's not insane. We might call that person crazy, but they are not insane sufficient to the level that they're not guilty of their actions. Just because someone does shit that isn't normal, even if that is egregious shit, does not mean that we find them insane sufficient to not be held liable for their decisions. The question is, can they make those decisions? Are they in control of their decision-making and their physical faculties? Do they understand the consequences of what they're doing? Taylor Schabusiness has never manifested any sort of recognition that what she did was not serious, did not have a consequence, or that she wasn't in charge of doing it. She's never manifested that. Even on meth, she seemed to be fully... Remember, they argued that the interview that she gave was on methamphetamine. So even on meth, we know that she seemed to understand the consequences of her actions. Now, it does not necessarily mean you know the exact legal outcome or the exact statute that you're violating. It just means, do you understand that if you pull on the chain, he will eventually die? Yes, she does. Do you understand that pulling on the chain causes asphyxiation? Yes, she does. Did you understand when he was dead that he was dead? Yes, she does. Did you understand that you were going to have sex with a dead body? Yes, she did. Did you understand you were chopping up a dead body that you caused the death of? Yes, she did. All of these things weigh directly into her being in charge of her volitional acts. She knew what she was doing. She knew the consequences of those actions. She even expressed fear on how she would get away from the dead body that she caused. Are there ways to mitigate those facts? Yes, but I haven't seen them yet. So that is the difference between insane to the purpose of being relieved from legal liability versus just being cray bitch. She's crazy. She'll peg you, she'll strangle you, she'll chop you up, she'll spit you out, she'll wink at the camera, make silly smirks. That's not crazy. Lots of people are that level of crazy, and they're still guilty of crimes. So can't rely on that. So what are we left with? We're left with this this question. Did the meth do it? Whatever. She's really short on evidence here. And she's long on evidence that she is lucid and aware while on meth and while off of it. That's a big problem for her. So with that, I mean, I think the state is winning this side of the case. I don't think she was ever going to win the insanity defense. And it's why I think moving for the lesser included of reckless homicide was the right move, and they didn't do it. In fact, I think it's almost a required move to do that. I do not see the tactical benefit of not adding it. And maybe I'm missing something. Maybe I am missing something about adding that as a lesser included offense. I guess you could argue, well, the jury will see it as a compromise verdict, but that only applies if you think you're going to win on the insanity defense, which they can't think it. They don't have the facts. They don't have the experts. They don't have the testimony, and they know they don't have it. They know they don't have these things for her. So to me, this whole thing's a clusterfuck of bad planning. But hey, that's my interpretation. So there's this beautiful facet of ProVigil. In that, it makes you have to pee a lot. So what I'm going to do is I'm going to bring the law and crime thing up. I'm going to go to the bathroom. I'm going to play the pee. There we go. I'm going to play the Peeing Wasted Lawyer song while I'm gone because we still have a couple minutes and it's shorter than the time we have left. And then I'll be back. We'll get back on. If I can, I'll read some more super chats. Other than Cad Bear says 6 it is. I don't know what 6 it is means. I don't remember what that's in reference to, but it is true and I agree with it. All right, guys, I'll be back in just a minute.
He drank a fair bit and then realized that his bladder can't handle the liquor inside, leaving us with his chair while he runs up the stairs, hoping the stream doesn't suddenly die. While we are waiting, we'll be laughing at you. The drinking along is what most of us do. The chat is united, getting excited. What you have for us when you're feeling is through. When you have a small bladder and no sphincter control, freedom of liquor doesn't mean freedom from soaking your drawers. Now you're washing your hands and you realize that you've forgotten to scrub both the front and the back. kiss your lady goodnight, and remember to thank her for all of the snacks. Whoa, water will cure your hangover. Oh, just drink some when the stream is over. When you have small bladder and no sphincter control, freedom of liquor doesn't mean freedom from soaking your drawers. Soaking your drawers.
Okay, before we bring the jury out, just briefly, I've had distributed to you a set of instructions and a proposed instructions and a proposed set of outline as to how they should be given. There's certainly other instructions that could be given, that were given to the jury the first time, regarding objections of counsel, improper questions, things of that nature. Although they've gotten all those instructions already, I'm not sure the need to do that. But I'm going to start with the state. Mr. Saunders, do you have any feedback regarding the proposed instructions I laid out, alternative suggestions?
No, and I have no additions. I'm fine with the ones the court selected. I guess our one quibble, our preference would be to do the instructions then closing, but that's the only change the state would have.
Mr. Freilich?
Your Honor, I agree with that. I'd ask that the court give the jury the instructions and then we can do the closings. When I look at 605B on question 1, it talks about at the time the crime was committed, did the defendant have a mental disease or defect? But then in question 2, it says, it uses the word mental disease or defect as well. I'm wondering if the court would consider mental disease or mental defect. Because it's either a mental disease or a mental defect.
Sure. I'd certainly consider that. The other thing is you'll note, and I'll consider the issue that you've mentioned regarding when I give the instructions. And I want to just a brief conversation about that, but we can take that up when evidence is concluded. I gave you 605B. It was actually 605B, the version with the comments, because of the paragraph on the second page of 605B, the comment about the possibility of using the phrasing mental disease and defect, and then it's cited the case. I don't think that's appropriate to use and in this case, given how the evidence comes in. That case that cites phrasing it mental disease and defect apparently was in a situation wherein the assertion was that there was a combination that went into the events. A mental disease and defect were co-occurring, and so counsel asked that the word be changed. I don't think that's what's going on in this case. The evidence seems to come in this case that either there is a mental disease or a mental defect, and there's one or the other, and the jury can look at it and decide. They can choose either one. But it's not a case where we're driving at a specific argument that there's a combination of the two and therefore changing the word to and. Nonetheless, I wanted to call it to your attention. I don't have any problem with your request, Mr. Freilich, to change that question 2 to as a result of the mental disease or mental defect. Any problem with that, Mr. Saunders?
No.
Any concern with leaving it as an or, Mr. Freilich, versus an and?
I've always thought that it was an or, Your Honor.
And that's the pattern instruction. I only provided that one case note to indicate that there is a situation in which it was changed to and that's permissible. I don't think it's appropriate for how the evidence is coming in this case, but I'm going to leave it as or. You're not asking for anything else. You don't have any objection to or, do you, Mr. Saunders?
No.
Okay. Very good. I'll add that one word in. And then we'll discuss the order of the instructions versus your closings at the conclusion of the evidence, and we'll actually have an official instruction conference at that time. Okay, then anything else before the jury comes in? Mr. Saunders?
No.
Mr. Fraley?
Judge is
All right.
heading off these issues as fast as possible. He wants to get this thing done. He really does. Oh, Cadbury says it was fingers, Nick. 6 fingers, though in this case, it might be good to keep them out of each other's Schabusiness. Unless. That's right. Okay, that was in reference to an earlier chat. Sorry about that.
Okay, be seated. All right. Then we're back on the record, and we're up for cross-examination. Mr. Fraley, do you have cross-examination?
Yes, I do, Your Honor. Thank you very much.
All right, let's see what you got.
Dr. Engine, good afternoon.
Hello.
Hi. So you work for Behavioral Consultants, is that correct?
Yes.
That's in Milwaukee.
Yes.
Is that part of the Wisconsin Forensic Unit?
Wisconsin Forensic Unit is a division of behavioral consultants.
And with regards to this case, you did not do a competency evaluation. You did an NGI evaluation?
Correct.
You met with Taylor Schabusiness, correct?
Yes.
You recognize her here?
I do.
And ma'am, you met with her at the Brown County Jail on October 12th and October 21st of 2022?
Yes.
Have you met with her since?
No.
So it's been,
why not?
Is it fair to say that it's been about 9 months since you've seen her, correct?
Yes.
The first
This is irrelevant to whether or not
time that
she
you
was insane
tried
at
to
the
see
time of the
her, there was some
offense.
sort of a security issue going on and you were not allowed to see her, is that correct?
I was allowed to see her, but only cell side, and I thought that would be inappropriate to conduct an interview cell side.
As far as the things that you did to, put your report together, you relied on the 2 clinical contacts on October 12th and October 21st of 2022, correct?
Yes.
You administered the MMPI, the Minnesota Multiphasic Personality Inventory 3, correct?
Yes.
I see that number changes oftentimes. Has it changed?
It actually, I can't recall how long it was the MMPI-2, but it was that edition for several decades. And the MMPI-3 was based on 2017 population estimate. So it's a relatively recent addition.
And it gets updated and upgraded every few years. Is that fair?
No, it was many decades before it was updated.
Okay. And it's essentially a true false test?
That's the response format. It's more complicated than that.
Okay. What kind of questions are on this MMPI?
So I provided, an example that I made up, but there's various statements, and the respondent is asked to respond true or false if they agree or mostly agree with the statement, or disagree or mostly disagree with the statement.
Strongly disagree?
I can't recall the test instructions, but something to that effect.
Do people that have, education issues or lack of education, do they struggle with the MMPI?
There is a reading level that's required to administer the MMPI. I don't recall it off the top of my head.
How many questions are on the MMPI?
About 335.
Okay. How long does it take to get through the test?
In the case of Ms. Schabusiness, I believe it was completed within about 90 minutes, maybe an hour and 45 minutes.
sometimes longer if you have difficulty reading?
Could be.
What? But this
so that
time it
was
was
done.
this long.
You reviewed some
That's the
police
critical
reports
question.
in this case,
Yes.
a criminal complaint and some video footage. Is that fair?
Yes.
Photographs.
Yes.
How did you get that information?
It was provided as part of the entire file. That's standard. It comes along when we receive a referral for an NGI evaluation.
Was it sent to you by the district attorney's office?
My office would have taken care of that. I received it from my office.
Okay. And then you looked up some information on CCAP, the Circuit Court Access Program,
Yes.
basically a search on the internet of her background,
Correct.
specifically her prior record.
Yes.
And then you looked at some Brown County Human Services records.
Yes.
Would that be the Nicolay Psychiatric Center records?
Yes.
So you looked at those?
Yes.
And then you looked at some jail records?
I did not. I requested the jail records, but they had not been received.
And was there a request to see some Purveya health records?
Yes.
Did you get to see those?
No.
Did you review any Bellin health records?
No.
Was it your understanding that Taylor Schabusiness had some treatment stays at Bellin Health in the past?
Yes, I understood that she attempted suicide at age 14, resulting in the admission to Bellin.
And what about at Purveya? Was it your understanding that she had gone there for some mental health treatment as well?
Yes, outpatient treatment.
Okay. So you were missing the Bellin records and the Purveya records, correct?
Correct.
Now, you got some relevant history, some background information about my client, correct?
Yes.
You found out that she
Why
was
didn't you have
born
the
in
records?
Chicago.
These are always interesting questions. Why don't you have the
correct?
records?
She was raised in Lindenhurst, Illinois. Is that fair?
Yes.
And then she moved to Green Bay
She
in
seemed to request
2009
them. Why
at
didn't you get
maybe
them?
age 11.
Yes.
Who'd she
And
request
that
them
same
from?
year, her mother passed away.
Yes.
Was it your understanding that her mother died in the house when she was there?
I don't know those details.
Was it your understanding then that she was raised by her father, Arturo Coronado?
Yes.
And then did she also relate to you that she moved to Cotulla, Texas when she was 16 to live with her grandparents?
Yes.
And that she had a series of moves. She lived in Cotulla and Alice, Texas, and Jackson, Mississippi.
Yes.
And then came back to Green Bay.
Yes.
That's kind of the progression. Is that fair?
Correct.
She got Chuck's on with Sailor Moon.
You found out that she was also married in February of 2020.
Yes.
And when you were involved,
I hope he
had
brings
she
this
given
around to
birth
something interesting.
Her child.
Yes, that was October 2021.
Ultimately, the child went to live with the grandparents, correct?
Yes.
In Texas.
Yes.
Did you garner information that
She still is
she
married,
was in
JW.
an abusive marriage with her husband?
What I gathered was that she was married. There was discord within the marital relationship, which led Ms. Schabusiness to rekindle her friendship and romance with the victim in this case, and that would have been in 2020. I can't speculate beyond that, the
did you-
nature of the relationship.
Did you get any information that her husband was hitting her in the head?
Objection
No.
asked and answered. She doesn't know.
No, that's a different question.
Overruled.
It's a different question.
No.
Fair.
Okay.
Fair question, defense.
So you got some background regarding her life, correct?
Yes.
Did you find out that she went to middle school in Green Bay and went to Bayport High School as well?
I don't recall that specific detail. I know that she graduated high school in Texas.
As part of the educational, assessment, as part of your report, did she report a history of some learning disabilities or difficulties?
She did. She attributed them to a diagnosis of attention deficit hyperactivity disorder.
I'm glad she did that.
And was it such that she had some issues with school, suspensions, ultimate expulsion?
Yes, she was expelled, the result of fighting.
Based.
The information that you have as far as your November 14th, 2022 report, it's somewhat stale. Is that fair?
I would disagree with that.
It is from last year though, correct?
Correct.
Nobody gave you any reports from Bellin Health to review, correct?
Correct.
You could have, doctor, upgraded your report by looking at additional records, Bellin Health and the Purveyor records. Is that fair?
Where I left my report, as indicated on the last page, is that I would be happy to receive any additional records that I was unable to obtain. And I would update my report once received if it changed my opinion. I received no additional records after submission of this report.
Your
wow.
colleague in the field is Dr. Matthew Seipel, correct?
Yes.
And did
Why
you
didn't she receive
confer
him,
with
defense?
him with regards to, your opinions, your assessment, your evaluation?
No.
Did you share any information with him?
I did provide him a copy of my records that I obtained from Brown County at his request, and that's a common practice among evaluators.
Sure. But fair to say that he did not send you, he didn't reciprocate by sending you the Bellin Health records that he had?
No, he did not.
Did you, defense?
That is
You got a
something
copy
could
of
have
that
been done,
report.
correct?
If I was not alerted that those were part of our practice, I wouldn't have known to request those. And it's not clear to me that Dr. Seipel would know that I was looking for those. Typically, what will happen is that I will receive additional records from one of the court principals with an indication that they would like a second review of the
That'd be
issue.
defense counsel in this
Does
case.
it surprise you that,
That was that.
as far as Dr. Seipel is concerned, I provided the Bellin Health records to him for his evaluation and that he didn't send them to you?
Can you repeat the question, please?
Does it surprise you that, I sent the Bellin Health records to Dr. Seipel and he didn't send them to you?
That would not surprise me because unless he had instruction to provide them to me, that would not be common practice.
You don't share information then, correct?
Only upon request, if it's appropriate, if it would be appropriate and permissible and specifically requested, but we don't as a general practice.
On
pass
redirect.
records
Did the
between
defense
doctors.
counsel send you the
Um,
records?
If
No.
you had received these records, you could have done a
Could the defense
supplemental
counsel
report. Is that fair?
Have
If
done
it changed my opinion, if I felt that it was relevant and added meaningfully to this evaluation, I would have, yes.
This is back to the issue where he just seems to be routinely unprepared and not doing
As it
his
relates
job.
to the Nicolay Psychiatric Center, you had a chance to look at all those records, correct?
Yes.
And was it your understanding that Taylor Schabusiness was committed and she was sent to that facility for, mental health treatment, correct?
Yes.
And you were aware, tell me if you were you aware of an order for civil commitment for her?
I was not.
Had you ever been made aware that she was under an order to take psychotropic medications?
No.
if I told you that she was civilly committed in April of 2021, where the court, a court of law, determined that she was mentally ill, would that cause you to have any concerns?
It would certainly be relevant, but it does fit with the information I already had, that Ms. Schabusiness was discharged from that facility to outpatient treatment with the goal of receiving substance use treatment.
And did you know when she was at the Nicolay Psychiatric Center that she was under an order to take medication?
No.
Did you know that she was required to take antipsychotic medication?
Yes, I was aware that she was prescribed Abilify, an antipsychotic.
Injectable antipsychotic?
Initially oral, later injectable.
So she submits this report
Now,
to the
during
court.
your
Counsel has the opportunity to review it. If defense finds the report
two contacts
deficient
with
because
her
it's
in
lacking other
October of
data,
2022,
it's his
did
job to
you,
send it. That's his job. He
get a
didn't do his
sense that
job.
she was suffering from any kind of auditory or other hallucinations?
She reported that to me, but the her behavioral presentation to me was inconsistent with her self-report. And the quality of her self-report was not consistent with genuine psychosis.
Did you gain any information that she was suffering from a mood disorder when you met with her?
Her emotional expression was odd when I met with her, but I would, she did not present as acutely depressed or hypomanic, let alone manic. So I wasn't seeing significant indication of a major mood disorder.
You did see in the Nicolay records that there was a diagnosis for her of bipolar 1, correct?
Yes.
With psychotic features, is that correct?
I don't recall that qualifier, but certainly the record does indicate that she was experiencing psychotic symptoms at that time.
And that is a qualifiable mental disease or mental defect, correct?
Yes.
Do you agree that if someone has an underlying mental health disorder, that using or abusing drugs can exacerbate that mental health disease or defect or condition?
I would agree with that statement.
Did you notice that Ms. Schabusiness was a poor historian when you asked her questions and asked her to expound on whatever topics of discussion?
Where I found that she provided a sufficiently detailed history. Where she was lacking was when I asked her to describe her recollection of the underlying offenses.
Did you note her to have memory loss or memory impairment?
I did not, aside from that self-reported amnesia, I did not detect memory loss.
How much time did you spend with her on October 12th of 2022? Do you know?
I would estimate about 15 minutes.
15?
Yes.
Okay. And then doctor, on October 21st, 2022, how much time did you spend with her then?
I can't recall. My best estimate would be about 3 hours, but again, that's 9 months old.
Long time ago, right?
9 months, yes.
Ugh.
Do you agree that methamphetamine use does cause brain damage?
It does have that potential.
And how about adolescent long-term marijuana use? Same thing?
I'm less certain about that.
Going back to those 80s talking points on weed.
certainly if you're using heroin or cocaine or drugs like that, that can cause brain damage as well.
Yes.
When you met with her, you did find that she
No one
exhibited some
has found
psychotic symptoms. Is that fair?
any brain damage
No.
with this lady. That's the problem with this
In
argument.
some of the records that you reviewed through Nicolay, did you recall reading anything about a recommendation for her to be on Haldol?
No. And then to be clear with your last question, I did not personally observe psychotic symptoms during the moments of my evaluation of Ms. Schabusiness, but I did see in the record indication of past psychotic symptoms, to be clear.
Okay, yeah, thank you. Did you see in the
shouldn't
records
have let
there
her
was a
go with that.
recommendation for her to be on
You
Haldol?
already answered.
No, I don't recall that.
You were asked to opine on the NGI issue, correct?
Yes.
Dr. Seipel was asked to opine on the competency issue, correct?
That is correct.
We're not talking about competency, we're talking about NGI. Is that fair?
Yes.
You had a chance to review Dr. Layton's report. Is that fair?
Yes.
You read through the entire report and you're familiar with Dr. Layton's opinions, correct?
Yes.
And do you agree with her findings?
No.
You would agree that Dr. Layton's report is more current than yours. Is that fair?
Well, it was authored more recently, but the authoring of the
tends to
report
go
has little to
closer
do
to the proximity
with,
of the event.
Its relevancy, because we were both doing an evaluation that was retrospective. So if you're looking at it, my evaluation would be more current than Dr. Layton's.
That's a dumb
because mine was in
question.
closer proximity to the alleged offenses. So that's another way to look at it.
But another way to look at
No,
it
that's
is
the way to look at it.
with due respect, your report is lacking because you haven't reviewed the Bell and Health records, correct?
It is missing that piece of information, but I would like to point out that it's not common for me as an evaluator when I'm looking at an offense that occurred in 2022 to be requesting records from when one was a teenager. Those would not be, they're certainly generally relevant, but they say little about what was going on in 2022.
Did Taylor Schabusiness
Also,
tell you
reminder,
that she
doesn't
no
know
memory
those reports
of the
exist.
alleged offense? Did
She
tell
did.
you? When did she tell you that on both dates? October 12th and October 21st?
I did not ask her about the offenses on the first date. I only asked her on the second date, which is when she reported the amnesia.
That was on October 21st of 2022.
Yes.
And in reviewing those Nicolay records, it's true that she was hospitalized, correct?
Yes.
For about a month, right?
A
couple weeks.
Solve Laxatov. It's not her job to
somewhere
know those
between a
reports
couple of weeks
exist.
and a month.
It's his
And
job
that,
to let
she
her
was
know those reports
prescribed,
exist.
Some medication for nightmares.
I believe that she was prescribed Abilify.
And
I can
go ahead.
refresh my recollection.
Page 3.
Thank you. Okay, sure. She did say Prazosin for nightmares.
No, Solve Laxatov. He didn't
And
send
it
her
was
those reports. That's the
such
problem. He
that,
sent them to a different doctor and just hoped
when
that
you
that
talked
doctor
with
might send them to her.
Taylor
When she
Schabusiness
sent
that she
her
was
report back, which
actively
lists all the
hearing
things
voices, that
she
those were the
reviewed,
comments that
he
she
did
made
not
to you.
check or
Yes.
did not care that she didn't review those other reports
She
and get
indicated
them
to
to
you
her.
that she was hearing voices.
That's on the defense.
in her cell.
He's
Yes.
the one who's interested
they
in
of?
that and those reports being included.
I think she
He
was
needs
less
to get them to her.
clear. They were very vague. She may have suggested that she was hearing voices of her coworkers, pejorative in nature. She also said that she was hearing of voice saying, "I love you." I don't know who she said was saying, "I love you."
Can you help me with this? What is a manic symptom?
That would be extreme mood elevation, increased goal-directed activity, decreased need for sleep, decreased risk appraisal. Those are some primary characteristics.
I would
Extreme
assume
mood, like throwing a chair at a doctor.
on redirect, they're going to hit out whose responsibility is it to get you that report.
What I gather that you're referring to is the evaluation of Dr. Lighton of
Yes.
Ms. Schabusiness. I'm hesitant to characterize that as a product of a manic episode.
As far as you understand, it happened out of the blue, correct?
Yes.
I think when there's a break, I'm going to have to more clearly explain how this process was discussed. I
Did
think
you
people are
have the
missing
occasion
very
to
critical
review
elements of it and who's
Report
responsible
from
for it.
Dr. Tracy Lucetta?
No.
This is a yes or no. You could have gone back to see Ms. Schabusiness after October 21st of 2022. Is that correct? Correct.
If you're looking for a yes or no answer, I'm not able to answer that in a yes or no fashion.
The fact is you didn't, correct?
That is correct.
No, Saul, it's not a failure of the system. It's a failure of the defense attorney who wants the facts introduced. She doesn't have a way to know that those reports
Did you
exist.
see?
She requested in her
when you
report
met
that
with her in
anything
October, did you see
missing
her
needs to be provided to her, and he
use
didn't do it.
odd or unusual facial expressions?
He's the guy who knows
Yes,
they
I believe
exist.
there were instances
She
of,
doesn't. This is
her
insane.
smiling inappropriately.
I don't know how this keeps getting missed.
It didn't track or it didn't follow, correct? It was out of context. Is that fair?
Yes.
And she did request anything that was missing that would be relevant
Okay,
be
I have
sent
nothing
her,
further.
and
Thank you.
he would be the guy who reviews that request and
Doctor, I want to pick
did
up on
not send it.
questions towards the end there. You were asked to describe what a manic episode or manic symptoms are. Is that right?
Yes.
With respect to a bipolar 1 diagnosis, one of the requirements is a manic episode, right?
Yes.
And how long do those typically last?
They can last for quite a long time. And then that would be, based on my experience, that they can last as long as months. Oftentimes until treatment is administered.
The diagnostic criteria sort of requires there to be a week of manic episode. Is that fair?
I would need to look at the DSM, but that would make sense.
All right. So you said that you were hesitant to say the instance of
Sal,
chair
that's an
throwing was a
insane
manic
proposition.
episode. Is that what you said?
Yes.
It's the defense attorney's
explain why?
job to provide them. That he's the only one. It's solely
There are
in his
many
interest.
reasons for a
You
person
say, we
to throw
think
a
this
chair.
is relevant. Will you please
One of
review
them
it?
could be
It's only
due to a
him.
manic episode.
No one else
But
has any
before I would
interest
make
in
that
providing
conclusion,
that.
I would want
And
to
she has no way to know they exist.
have
He
compelling
literally
evidence
requested
that
it
such a
to the extent that she could possibly do it.
diagnosis is appropriate.
Baffling.
And that would need to include objective evidence, meaning observation over time when a person is not being, thinking that they're being viewed, things of that nature.
So I guess then would some of that objective evidence be to consider time periods both before and
Andrew
subsequent
Schnatter,
to the
she's not making a
manic episode
diagnosis.
that you're observing?
Yes.
Why would that be helpful to know?
It would speak to consistency of behavior. There's a lot of information that can be gathered by looking at behavior over time. When is the onset?
Oh my God.
Does it happen? I mentioned this earlier. Does it happen when people are not being, when they do not know that
I'll
they're
wait
being
till there's
observed,
adequate
things
time
like
to
that.
explain
And
this.
then there's
I'm gonna
more,
go
the
fucking
more objective
insane.
evidence there is, the more credible that diagnosis can be.
So I guess in general, if you're attempting to determine whether somebody is actively having a legitimate manic episode, you sort of look at the time frame both before and after.
Yes.
You were asked some questions about your interactions with Ms. Schabusiness, about her reporting or endorsing that she was hearing voices. You remember those questions?
Yes.
And you indicated sort of her response to those were sort of vague in terms of what she was experiencing.
Correct.
In your opinion, did that appear to be consistent with genuine psychosis?
No.
Why is that?
To me, my take on them
Sal,
was that they were
respectfully, you're retarded. I'll
represented
explain
some
it in a
social
minute.
Anxiety, some rumination.
I think you're
her
missing
thinking about her
something,
circumstances.
or you're
They
refusing to
seemed
hear
like
it.
More
I'm
of
not
an
sure.
internal dialogue versus an actual auditory hallucination, which can tend to be more bizarre. You also will see behavioral indication that a person is responding to internal stimuli or the auditory hallucination. So you'll see indication, maybe the person won't even say that they are experiencing these voices, but they'll be distracted, have a difficult time completing their thoughts. It's a lot more subtle of an expression than simply saying, I'm hearing voices.
And none of the sort of other things you are trained to look for, you observed in Ms. Schabusiness?
Correct.
And in addition, you've already testified to concerns about exaggerating of symptoms.
Yes.
You were asked questions about review of certain records, particularly the Bellin Health records. You were aware that there was a prior attempt of self-harm previous in Ms. Schabusiness's history?
Yes, at age 14.
Okay. And records from that age, 10 years or so from prior to the date of the offense that you're attempting to determine here, do you believe anything in those records would substantially change the opinions you're testifying here to today?
As I know it, there's not anything that would speak specifically to the issue of the NGI plea. But as I indicated, I would have been happy to receive those records if they had been made available to me. I felt, though, that for me, one of the main issues was Ms. Schabusiness's use of methamphetamine at the time of these offenses. And I don't think that information generated 10 years prior would change that. So, so in sum, no, I do not believe those records would change my opinion.
Okay. And then I'll sort of pick up on the methamphetamine you brought up because you were asked some questions about that, about psychotic symptoms that you had observed in Ms. Schabusiness's records in the past. Is that fair?
Yes.
And are you aware of any of those symptoms that were reported absent the context of methamphetamine use?
No, I am not.
And so like concepts like, psychosis or meth-induced psychosis, I think you mentioned, those are as a result of methamphetamine use.
Yes, my review of the record indicates that all of the psychosis observed objectively occurred in the context of methamphetamine use.
And then finally, you were asked some questions about the MMPI. I think there was a question about like lack of education and if that can impact that. Is that you remember that question?
Yes.
All right. Is there any information you're aware of any cognitive deficit for the defendant?
No, my understanding was that she attributed her learning difficulties to ADHD. She did not have an individual education program or IEP that would signify learning deficits, and she has a high school diploma, which indicates she had sufficient reading level to take the MMPI-3.
Thank you, doctor. Nothing further.
Anything on those topics, Mr. Freilich?
Did she say that she had concentration issues?
Said she had ADHD.
I don't recall that.
When you talked to her, she was very quiet, correct?
She was soft-spoken.
Didn't give a lot of information, correct?
I disagree with that. I obtained a reasonable history from her.
It wasn't like she gave one-word answers,
No,
but the responses were short. Is that fair?
no.
Nothing further.
Anything on that?
No.
Thank you, Dr. Ukasek.
Thank you.
Okay. Briefly, the issue here, her report.
Any other
on
witnesses from the state?
state
No,
rest?
Your Honor, the state rests.
Any rebuttal testimony, Mr. Freilich?
No.
Wait just a second.
Ladies and gentlemen of the jury, the evidentiary portion of this case is now closed. So to give you a sense of what's next, it's similar to the process that you've already experienced, and that is I'm going to instruct you as to the rules of the law that you need to apply. The attorneys will make their closing arguments, and then you'll deliberate. I need a few minutes to work with the attorneys. The instructions are much shorter this time, so I won't need as much time to work with them on it. But I do need a few minutes to finish those up, so I'm going to excuse you at this time. All rise for the jury.
Okay, very briefly, the issue here, I think people might have missed something in the process. So, the attorneys hire their witnesses. The attorneys have access to some information. The defense uses the client to procure the client's medical records that they believe will be relevant to the defense. They then provide those
So,
as
counsel,
requested.
I want to address
This
some of the
guy
issues that you
provided
raised,
all of the records to
before
one
we talked
doctor,
about the
but not
instruction.
the other
I don't have a
doctor.
problem delivering the instructions.
So this
before,
doctor only gets something
closing
from the
arguments,
defense that
and
she is to
so
review.
I would probably
She
take
prepares a
160
report.
And move it.
At the end of the
And I
report, she
wanted
says,
to just
if
indicate
there's
the reason that I
anything else
proposed
relevant,
that
please
is-
send it
is
to
for
me.
this
I
reason.
will consider it. She
when I
doesn't
look
know what
at
exists. She can't know what exists.
605, the last
She
two
sends that report
paragraphs in
back to the
605
attorney.
seem
The attorney
very
reads
similar
the
to
report. He
515,
should go,
which
this
is
report
read
wasn't covered, this report
after
wasn't
the
covered, this
closing
report wasn't
arguments
covered,
before the jury
and
goes
send
out.
those to her.
And so
He doesn't.
I was looking for something as a way to kind of
She makes the
conclude
request.
matter as opposed
He
to
fails
the
to
last
provide it.
argument is made and I just
He's
say,
the guy who knows what was
go.
sent. He's the guy who
So
gets the
my
report.
suggestion is,
No
if
one
I read
else
the
gets the
instructions
report.
in the order that you've proposed.
No one
other
else knows
than
what documents are out
moving
there.
160
That's
to
it.
after 605.
That's how this
Other
works.
than that,
There's no system overseeing all the facts that she's supposed to have.
proposing that
He is the system.
I give a
He's the
modified
only
460
guy. He's the
just
only
before the
one
jurors leave.
defending his client.
So after closings, I give a modified
court doesn't know how many
460
reports
is
there
the
are.
instruction, and I'm having
Court
my
doesn't
judicial
know what the
assistant
defense
draft that up.
finds relevant.
That's the one that says
Only that guy.
something as follows, and I know you
And
don't.
he had the
heard it before.
information.
Now
All
members
of
of the
it.
jury, the
His
duties of
choice.
counsel in the
He
court
didn't
have been
do it.
performed. The case has been argued by counsel. It's that instruction. And the only thing I would eliminate is the second paragraph of that instruction, which says, you are to decide only whether the defendant is guilty or not guilty of the offenses charged. Any consequences of your verdict are matters for the court alone to decide and must not affect your deliberations. I delete that paragraph because, first of all, this isn't a question of guilt or innocence at this phase. And secondly, because they're actually informed about the consequences of their action when I read 605. So I think that paragraph should come out. But in exchange for giving the instructions before you close, my suggestion is give that modified 460 after your closings. I then swear the bailiffs and send the jury out. Any objection to that, Mr. Saunders?
No.
Mr. Freilich?
No, Your Honor.
Okay. I gave you the proposed verdict forms, and what I noticed as I was looking at them, There's spots for the dissenting jurors to sign, but there was no spot for
Andrew
the court
Schnatter,
judicial assistant
her diagnosis of
making that change.
meth-induced psychosis.
So what I'm gonna
She
do is I'm
did
gonna
rule
go
out
make
mental
these,
defects
revisions,
based on the information
and then
she
bring
was
them
given.
back to you, but
She
there are a couple of
cannot
other
know
things
what
I
other
need to call to your
information
attention.
exists
First of all,
unless
change
someone
that I
provides
made
it to her.
in
The other
100,
doctor
the opening
cannot know
instruction
what report
is,
she has
in
or
the
doesn't have.
third paragraph. You should have that. I put it in
Neither
bold,
of them
that if any
should,
member of
would
the jury has an
automatically
impression of
assume
my
that they
opinion as
didn't
to
get the information
the
from the
issues
party
in this
interested in
phase,
producing the diagnosis.
disregard that
It's
impression. That
insane
would
to think,
take the
did I
place
get
of the language
everything?
that's
They
given in
must
the first
not have
phase, which
sent me
is,
everything.
If any
How
member of the
would
jury
they
has an
know
impression
that?
of my opinion as to whether
And
the
she
defendant is
still
guilty or
did
not
request
guilty.
it,
So I
and he
switched that. Any
still
objection,
didn't
Mr.
give it.
Saunders?
No.
It's
Mr. Freilich?
mind-blowing how you're
Okay.
not understanding this.
Um,
Andrew, she
Then,
doesn't know that there's information she didn't review. She can't know unless he tells her. So to
Mr. Freilich,
her,
I need
her
to,
diagnosis
speak
is
with
literally
you
based
and
on all the
perhaps you need to
information.
Speak with your client about whether you want me to give 315. That's the instruction that your client during the first phase elected that I give. That's the instruction that says a defendant in a criminal case has the absolute constitutional right not to testify. And that's really, she has an option to have me give that or not give it.
Talk to my client. We both agree that you could read 315.
You're
The
asking
failure
that I-
of the
that I give
system,
that.
the only
Yes, I am.
system is a fucking defense
Business,
attorney.
you've had an
That
opportunity
is the
to speak with your
system.
attorney
He's
about
the
that
guy with the
decision?
info.
Okay, I know you spoke
There
with him about it
isn't
at the beginning
some
of the
system
first phase.
that tracks all
You'd
this
like
to
me
give it
that
to
instruction
someone.
in this phase?
It's him.
All right. I'll give 315. 640 mental disease or
What
defect
system do you
expert
fucking think
opinion testimony.
exists?
The interesting piece there is that the last paragraph, the court has appointed, and then it says to fill in the name. Two of the people that were appointed by this court testified. Only one on the NGI piece, but two of them testified, and they both testified they were court appointed. And it indicates that you shouldn't give the weight, give their testimony any greater weight. I think probably both of their names should be in there, but I could see an argument that only Dr. Engen's name should be on there because she was appointed on the NGI. On the other hand, they were both appointed by the court, and the notion that they shouldn't be given any greater weight than anybody else seems to apply to both of them. Mr. Saunders, any opinion on that?
Andrew, respectfully,
Not really.
it's not
I guess
malpractice.
Preference would be to include both.
She can only make a
Mr. Freilich?
diagnosis off the information she is able to know exists. There's one guy
it
who's
would be my
supposed to give her
position
the information.
that
A
we
defense
would only
attorney
use
cannot
Dr.
withhold
Christina
information
Engin
and then
because she's
invalidate
the one
the
that did the
expert's
NGI
opinion because
evaluation.
he withheld it. I don't know what to tell you. That would be an impossible system
I'll
to
give,
uphold.
I'll just give Dr. Engen's. We keep pronouncing her name differently. I've heard it pronounced both ways. Is it engine, like an engine, or is it Engen? I thought I heard her say Engen.
It's the latter.
Engin, I think.
That's how I'm going to pronounce it. Moving on then to 605, there are some options that we need to address. And that is under the subheading meaning of mental disease or defect. I have some thoughts about which ones seem appropriate.
No, it's not
given the
malpractice
evidence,
against
but,
this.
let's just run
It's not
through them.
malpractice against the
First
defense attorney
option
because it
is,
might be
because
his
it indicates
tactical
in that
choice
particular
to
portion,
not
add the
include certain
following if
reports
supported by the evidence.
that
First,
he doesn't
temporary
find
passion or
relevant
frenzy prompted by
or maybe
revenge,
doesn't
hatred,
want them to
jealousy,
review.
envy. That just doesn't seem to apply. I don't think it should be inserted. Agree with that, Mr.
She agrees,
Saunders?
by the way.
Yes.
Those
Mr.
reports
Freilich?
and the
Yes, I
data
do.
in them that she
That'll
has
be
now
out.
heard are not relevant
The
to her
next one,
decision.
an abnormality
This is actually
manifested
also covered.
only by repeated
I haven't even
criminal
gotten
or
into that
otherwise
yet.
Antisocial conduct does not constitute a mental disease or defect. Mr. Saunders?
I think that should be included.
All right, I'm done. I want to listen.
Well, there was testimony about the criminal conduct, but antisocial, I think that kind of fits into a lot of the jail conduct reports, other behavioral things that the defense has raised.
Mr. Freilich?
I disagree. I didn't hear anybody, any doctor or professional say anything about antisocial conduct. So I would object to that.
I'm going to give that instruction for this reason. there was a lot of testimony about conduct that the average person could characterize as antisocial.
You
And I think,
elicited it,
that's an important piece
defense
of
attorney.
information for them to have. So I'm going to.
She was weird. She's acting
note
strange.
Mr. Freilich's objection.
She was quiet.
That's going to be the order of the court. The next
She was
one,
evasive. She was nonverbal.
voluntarily
You
induced
elicited
state
that
of
testimony.
intoxication by drugs or alcohol or
Yet
both does not
again.
constitute a mental disease or defect. I note that the parties stipulated at the last phase that that should come in. I'm assuming that's where we're at now. But Mr. Saunders, you're asking for that?
Yes.
Mr. Freilich?
I'll agree.
Okay. The next one is a temporary mental state which is brought into existence by the voluntary taking of drugs or alcohol does not constitute a mental disease or defect. Mr. Saunders, you're asking for that?
Yes.
Any objection, Mr. Freilich?
Yes, I would argue that it's duplicitous. It's, it's doubling up. The
Duplicative.
paragraph
That's
before
not
is-
duplicitous.
Says enough. It's mentioning it twice, basically.
So, well, I think the difference
I want the
is,
judge to snap on him on the misuse of words at
voluntarily
some
induced
point.
state of intoxication by drugs or alcohol or both does not constitute a mental disease or defect. The other one is a temporary mental state. The other one referenced temporary mental state versus voluntary intoxication. Temporary mental state, which is brought into existence by the voluntary taking. And I think that's consistent with some of the testimony that has been offered here. So I understand the argument, Mr. Freilich. I'm going to include that option. I think it's appropriate in light of the evidence that's come into this case.
Your Honor?
Yes.
One more argument, and I respect the court's ruling, but just to make sure I'm doing my part, is that just saying it a different way? I would make that argument too.
Well, a voluntarily induced state of intoxication by drugs or alcohol does not constitute a mental disease or defect.
Oof.
And
Earlier, he misused diabolical instead of
I was
diametrically.
just saying it a different way, in my opinion, my humble opinion.
It's like that
Mr. Saunders,
D&D
any response to that?
Yes, I
curse
think they're
spell
pretty
book.
clearly different.
All the
voluntary
spells are
induced state of
misspelled.
intoxication refers to using methamphetamine, using alcohol, using some other illicit substance. A temporary mental state brought into existence, I think, refers to the circumstances that Dr. Engen testified to about meth-induced psychosis or symptoms that are brought about by use of substances, because that speaks to the mental state. Induced is basically the same thing as which is brought into existence. So I think they're different.
Okay, I think the difference, Mr. Freilich, in response to your objection is for someone to be in a voluntary induced state of intoxication, the jury couldn't find that that's a mental disease or defect. The next option is if a mental state exists, if there's a potentially a diagnosable mental state that exists on a temporary basis. So not just the intoxication, the mental state, which was brought into existence by the use of drugs, that does not constitute a mental disease or defect. I think they're different. So I note your objections and your amendment to your objections, but I'm going to give both of those because I think they're different.
Thank you, Your Honor.
The next then is chronic use of drugs or alcohol may produce a condition that can constitute a mental disease or defect if the condition has become permanent. Mr. Saunders?
I don't think this one should be given. We didn't hear testimony about the latter part of that there is some permanent, and we talked about this with Dr. O'Donnell, that there is some permanent condition that the defendant has. So I don't think it's an appropriate instruction to include.
Mr. Freilich?
I strongly disagree with the state on this. I think this
Should have raised some
language should
evidence of
come
it
in. The
somewhere.
court should consider it. I asked, I believe Dr. Engine and Dr. Seipel, and I believe Dr. Layton, that, using drugs over time can cause brain damage. And so I'd ask that you allow that as part of the jury instruction, Your Honor.
Anything else?
Well, yes, it can, but there's been no evidence that if the condition has become permanent, that is something the defendant's afflicted by. So I don't think it's proper to instruct the jury on something that can be out there if there's no evidence that this actually is in existence. I think it invites speculation. I think it kind of is confusing to some extent as well. If counsel wanted to have an expert to testify about a permanent condition the defendant has, they could have done that.
Your Honor?
Yes.
He tried
It's
and
crystal
failed.
clear to me that this should absolutely come in. This young lady, Taylor Denise Schabusiness, was under a court order for involuntary medication and an order for civil commitment, which it doesn't happen very often. She was found by a court of law, by Judge Lee Joyce, to be mentally ill. And she was at the Nicolay Psychiatric Center for approximately a few weeks, where she was receiving injectable Abilify antipsychotic. She was getting treatment.
And no one ruled that it was
clear the
permanent
records
brain
replete
damage
with the fact that she had a chronic
from meth.
problem with methamphetamine, marijuana. So I think it's totally on point, and that should be something that the court should consider. The operative word, in my humble opinion, is can. That word can. I think that makes it such that it would be applicable in this particular case.
I think the focus is if the condition has become permanent, and whether that's supported by the evidence. There's no doubt that chronic use of drugs or alcohol has come into this case.
I don't care if he puts this in, but it shouldn't be in there because he didn't elicit any testimony from any witness that this exists.
I'm satisfied in
He
light
tried
of the state of the record
and failed.
That it ultimately comes down to what the jurors heard. There has
There you
been
go.
a great deal of testimony regarding the use of drugs or
So
alcohol.
I
There
don't
were
care if
some
it comes in.
questions
I don't
posed
think it should, but I don't
to,
care if it does.
To the defense expert about impacts on a person long-term using various drugs. Satisfied the jury can assess that. I'm going to give that instruction. Certainly the parties can argue that they don't believe the evidence supports that particular aspect, but
There's no evidence of this. You're going to hear him say this. There's no evidence of this. When he asked about it, no one said yes.
That's the last option that has to be selected. I'm going to make these revisions then, and then I will give you a final copy of them. And then we will move, we'll bring the jury back in and we'll move to instructions and closings. All right, we are in recess. Thank you.
Are we going to do closings tonight? I guess we will. We'll get closings in tonight. There we go. Okay. What you doing? Where is it? So I have all of these different ones because Long Crime kept moving the logo on me. Oh God. Are trials usually this quick? So yes, normal murder trials for 3 to 5 days are very, very common for a normal murder trial. And really the things you have to factor in, how many witnesses are there? I mean, how much evidence is being presented? Think about your average run-of-the-mill murder. Lots of times domestic issues or close associate issues. Lots of times they're not done in public. The number of actual fact witnesses to the murder and the events leading up to it and following it are pretty minimal, right? Someone's in a house, they shoot someone in the face. Someone's stab someone in a car, whatever that is. Typically speaking, you got maybe 1 or 2 witnesses plus the defendant because you've got a dead victim. Then you've got any police witnesses or expert witnesses that are required to prove out the case, and that's about it. There's not a ton of people testifying in most of these cases. Now, we get a skewed perspective because you got things like Rittenhouse, right? who he's accused of murder in this giant crowd of people, multiple victims. You've got crazy video footage from everywhere. You got to get that video footage in. You've got a bunch of this propensity evidence that they try to bring in based on interviews. They have to authenticate all these interviews. They have to do all that. Normally, murders take place pretty privately, usually in the dark. But that's going to determine the scope of the trial. How many witnesses are there? O.J. Simpson trial, what, like 6 months, something like that? I think it was 6 months of trial. It's a fucking insane amount of time because you've got a very famous person. Lots of people know them. Everybody watched the thing on the TV. A whole bunch of stuff happened around that. Mostly they're pretty quick. So that's something that's come up a couple times. All right, let me hit. Hey, girl, let me hit. Shroom Dukem says, it just got here. Who do we want to win? I don't care who wins. Let me phrase it this way. I think that the conviction of Taylor Schabusiness on the charges. Let's wait a second. What's up, Joe?
Yo.
How you doing, buddy?
I felt bad. You're sitting here all by yourself.
Why would you feel bad?
In a dark corner of the internet, and I said, "Let me join my friend there. Weigh in."
Welcome.
I watched a little bit of the trial myself, so I just have a clue about what's going on here, as opposed to other streams that I join where I'll just opine without knowing anything.
Yeah.
So yeah. So what are your thoughts here? What would you have done differently if she was your client?
A bunch. But let me. I was about to issue one point about the overall trial and my opinion on Taylor Schabusiness. I think what she is convicted of, and I'm pretty sure they're not going to find her insane, but I think what she is convicted of is the wrong charge. I think the appropriate charge, based on the facts that I have seen at trial, is reckless homicide in the first degree. Not intentional homicide in the first degree, but reckless. I think that's the appropriate charge. And I still have conceptual problems with the sexual assault charge. I think it should have been dismissed, but I think the dismemberment of the corpse charge is absolutely appropriate. So I think that is where I stand. That being said, that's where I want Taylor Schabusiness to be in the ideal circumstances of justice. I don't care if she wins or loses on anything, but I do want this defense attorney to lose at this point because I hate him. I hate him. I hate the case he has put up on this girl. I think he has failed her. I do not think he was ever going to have any jury that has any reasonability find her innocent, even under this not guilty by reason of insanity. It was never going to happen. You have a bloody, brutal, gross murder and someone telling police exactly what they did, exactly how they did it, and saying they liked it. There's no way you're getting around the fact that she is guilty in the eyes of any sensible jury, right? So my problem is, run with your insanity defense, I guess, although he seems to have done plenty to indicate he's dropped the ball. But make your motion for a lesser included offense of reckless homicide. That should have been done. I don't know why it wasn't done. I think it was a strategy point, and he didn't do it. And it's probably because his tactical approach, I wholly disagree with, and I think was the worst defense approach he could have taken. Did you see it in his closing argument?
I didn't see any tactician at work at all. That was just a hodgepodge of different issues without feeling any kind of theme at all.
It's like Lizzo. If you lift up enough layers of fat viscera and cheese pizzas, you'll eventually find a person underneath it. In the same way, if you peel through the layers of his god-awful closing argument, you find that his theory of the case, which he never effectively states, I think he also references it at a different point, outside of the ears of the jury, importantly. But his theory of the case is essentially that no one saw Taylor Schabusiness in the basement, so therefore she wasn't in the basement.
Yeah, that's fair.
That it wasn't her van because
that's a fair read of what his theory was.
Yeah. Yeah,
That's
yeah.
what I mean. And it's a terrible theory. It's a terrible
Right.
theory. Awful.
Yeah.
Lousy. It's completely belied by the fact that she knew before the cops did where everything was. She knew more about this case than anyone, and how the body was laid out. And she's explaining how you can manage to drain all that blood without the place looking like it's a horror film. You know, it's like a stage of Saw. So, which is what you would think it would look like when you're completely taking apart a body. But
Right.
so how does she have all this information if there's some other person there and she's not even there? It's like that was such a that was a lousy.
And then it's all confirmed. That's the other thing. So she lays out the case, and then subsequent forensics confirms it to a T.
Yep.
Yeah, I took the blood, I drained it into this tote, I drained it into this bucket, I dumped it in the shower, I used the squeegee to clean up the shower. She explains everything away, and then it's all confirmed exactly as she says. I don't think she got a single detail wrong.
Nope.
So how can you take the approach?
And you can't come
that
to
she
and you
wasn't
can't
there?
come to not recognizing the not and being too insane to be legally liable, because when the standard is either she can't control herself, which they never even tried pushing that because that didn't make any sense. But they tried basically, I guess, coming under a theory of she can't tell right from wrong. There's so many indicia that she knew was wrong, from apologizing to pretending she blacked out before she starts expressing all the details, which shows that she feels guilty about it. You know, that's why she's claiming she blacked out. All these different the fear of someone coming downstairs. If you're not doing anything wrong, you're not afraid of the mother coming downstairs. So all of these different things are undercutting any sort of insanity defense. I wholly agree with you with respect to the fact that he had every opportunity to lean in on this was an accident and give a very solid theory as to why she would lie to the police and pretend that it was intentional. Why would you? And this is what you say. You lean in on the Jeffrey Dahmer stuff. You say, yeah, when it happened, they're engaging in kinky sex play and stuff like that. And now she's in a position like, oh my God, he's dead. And when she comes to the police and she's talking about it, this is a woman who fetishizes Jeffrey Dahmer as a sexy beast in court or whatever it is. This is a woman who takes pictures of Jeffrey. Like, did you see the picture? Because I know it was blocked on Court TV, but you saw it on Law on Court on Law and Cox. It was blocked, but Court TV, they showed the picture. It's worse than just holding up a selfie. She's like laying in bed with a picture of him next to him as if they're in bed together. So if this is the nature, she's a very different person from, this is what you say to the jury. She's a very different person from you or me. So once she sees she's actually done the deed that she's never had the willpower, fortitude, or inclination to do, now that it's happened by accident, she takes that opportunity to pretend she's Mrs. Jeffrey Dahmer. She did do it on purpose. And that's why she lied to the police. She's that cuckoo that she lies to the police. And that's why, so now you're sitting here and the only reason you think she did it is because she sat there lying that it was intentional when it clearly had to be an accident. And that's how you bring it down. Yeah. What's your thought?
I mildly disagree on this is just a difference in tactic. I'm very close to where you are. I do not say that she's lying to police. I actually embrace the state's argument that she's telling the truth and should be trusted. And here's why. Because while she gives a couple statements that infer intent, she never actually says, I tried to kill him.
Right.
They draw it out of, have you ever loved something so much you wanted to kill it? That's not actually intent to kill. That's a weird statement, but I actually kind of understand. And I compare it to Lenny from Of Mice and Men.
That's what I actually came up with. I actually said she thinks she's Lenny here. That's
right.
She's
I
like
squeeze it and love it.
She's hugging it to death.
I know people who not actually crush things to death, but they think like little kittens. They're like, oh, I just want to squeeze them, right? Like they just love that idea. They don't actually want to kill them, but it's an expression. Okay. So I think that's an inference that they draw. And the other one is that she liked it. And then finally, the state relies on her continuing on because they asked her, well, did you know that if you kept choking him, he would die? And she says, yes. that doesn't mean she intended for him to die when he did, or that she intended for him to die at all.
But that she was pleasuring him. I mean, they obviously did this many times before. They had 2 chains there. It's not the first time they engaged in strangulation.
Sorry,
it's not the first time they probably engaged in strangulation play. So if you know, sometimes it goes too far. You're saying that that she intended to do it out of love. That's what your thought process is?
No. So I'm saying, so the state makes their intent argument based on that. And if you remember the state's closing argument, he said, she told you everything you need to know, and we should believe everything she says, right? That's what he said. She's telling the truth. I say, yeah. Do you remember? Because the state didn't want to remind you. They just left out these very specific phrases where she says, I didn't want to kill him. I didn't want him to die. I looked down when I thought things were going too far, and he told me to keep going. She says these things that counter indicate intent. And I think he should have gone, yeah, we should believe everything she says. Now, the interesting thing is when you're looking at a defendant and you're believing everything they say, as the state suggests, and you have comparable statements about intent going the opposite direction, what you have is reasonable doubt. And I think that's the argument. To be clear, I don't think she's not guilty. But I think you get to reckless homicide as a lesser included.
It's some type of manslaughter.
So in Wisconsin, first degree reckless homicide is acting in a way, or recklessly acting in a way with utter disregard for human life. And I think that's what she does here. I mean, she knows that choking someone can produce death. So she's fulfilled the first element of recklessness, willfully creating an environment where death can occur. And then she acts with disregard to his life when she sees signs that he might be dying, and she continues on. Not that she intended to kill him, but her actions do produce death despite the fact that there's evidence that it was going south. I think that perfectly fills the standard. It's still first degree murder. She gets life without parole life with parole versus life without parole. But I think that's probably the only way you win this case.
And with respect to the mutilation, you had to hit on the fact that there's really no evidence that the intent was to conceal a crime. I mean, for all we know, she didn't want Shad's mother to find him there, and that's why, because she felt concerned for him. Maybe she wanted to take him home as a souvenir. She's putting him in suitcases. So if you think that her objective was that she was trying to hide from the police, ask yourself why it is that as soon as she's picked up by the police, she tells them everything. She's obviously not concerned about concealing a crime from them. She waived her Fifth Amendment rights and just started blah 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 because she didn't have any concerns about concealing from the police, either when she was talking to them or when she was cutting up the body. So
frankly, I don't care if she loses on dismemberment and sexual assault, because the overwhelming likelihood is those sentences will run concurrent with her life sentence and it'll be irrelevant.
Well, I'm talking about if you manage to talk it down to a lesser included offense on the murder.
Well, remember that reckless homicides lesser included is life with the possibility of parole.
Really?
So I think it's a minimum 20 years, maximum 60 years with the possibility of parole.
Reckless homicide is 20 years.
First degree reckless homicide.
Wow.
And I think that's what you get. Now, maybe you could get second degree reckless homicide, which ticks it down a little bit more, but I think she acted with utter disregard for human life. I mean, I think that element's easy to fulfill on the reckless thing. If I'm a defense attorney, I want to go lower, right? We can always go lower, but I think this is where you end up. I do not think you're going to get anywhere. I think they could easily fulfill that element.
And by the way, I was sniping Legal Mindset when he was sniping you yesterday.
I think someone told me you need to snipe Joe right now.
Yeah, a real circle jerk right there.
Yeah.
And you were going off about consent of the dead to sexual activity, and everything you were saying there, I was like, this is the stupidest thing I've ever heard Nick say. This was so bad.
I'm 100% correct on that.
And I want you to know, a day earlier, I actually engaged in the exact same thought exercise you did. And I was like,
and you came to the wrong conclusion.
No, I actually came to a similar conclusion as you for briefly. And then I thought it through more. I mean, what you were saying, you were basically saying that once, I never came to this part, which you were at, which is once you've given consent, the person just has consent to keep going. I don't know, for eternity or something like that. By that logic, if a man's wife dies, I mean, a married couple.
Not for eternity, until the end of the sexual encounter.
So even if she has a coma you think that you have a right to just keep going, and she's just person
she
is having
goes-
an
so you're-
epileptic fit,
You're having sex with her. She's having an epileptic fit.
and
You
you
just
know
keep
it,
going?
and you know that she had an epileptic fit. To just
I
that
don't know.
that you have a right to keep going. That sounds so ridiculous. I'm sorry.
It sounds weird, but it also sounds weird that consent ends because your wife's having an epileptic fit,
no,
right?
No, that doesn't sound weird at all because
Why
you
not?
understand because because any reasonable person, you use a reasonable man standard, any reasonable man would recognize that her mental state now is not the same as it was 20 minutes ago when she gave me the consent. And that's why when someone dies, you can recognize that that's not the same mental state that she has.
Well, first of all, these are way different. When someone dies, there's not a someone anymore.
Right. Okay.
There's not a someone. That's my biggest problem with the sexual assault with a
By that
corpse.
logic, by that logic, though, necrophilia should never be criminal because
Not true.
Why would it matter if a person dies and you're saying why would the consent they give before death help them? Either they're a thing, and if they're a thing, it's no different than having sex with a tree.
Why can't necrophilia independently be illegal? We can decide as a society that we don't want people having sex with dead bodies.
I think it definitely should be illegal. I think it's
Right. I do
disturbing
too.
and
I'm
and
100%
lacking
on board
dignity.
with it being illegal.
Yes. Okay. I think anyone who thinks otherwise is kind of is very creepy individual.
I think bestiality should be illegal too.
100%.
Right. Like,
100%.
but I don't care about the consent of the fucking animal. I just think that bestiality should be illegal because it's gross.
Okay. Be seated.
But I'm saying sexual assault is the
You
wrong
should have now a
charge
copy of the,
for that. What? Goddamn.
Of the instructions that I propose to give.
I just think
to the jury, and
necrophilia
again,
should
I
be the
will give
crime.
This before closing arguments, I'll start with the modified 100.
But I still disagree with the loss of consciousness thing. I don't think loss of consciousness automatically ends consent. I think that's actually a strange thing to decide.
Do you think a woman has a capacity to withdraw her consent?
Yeah.
So, in other words, you're in the middle of doing it. She says, "Stop." You know, at first she's like,
Stop
"Yeah, go,"
immediately.
and then she says, "Stop," and she says,
There's
"So if she has the
the,
capacity to withdraw
add-on
her
at the end of
consent,
100.
don't you think that a change in her
But I'll get to that in a minute.
mental
I'll give
capacity
315.
would serve as an
I'll
inherent
give
termination of
640,
the consent?"
Mental disease
No.
or defect expert.
Because now,
opinion
okay,
testimony. 605.
So if you're having sex with someone and they
instruction
suddenly
on the
get
issue
really,
of
really
defendant's
drunk and can
criminal
no longer
responsibility,
manifest consent, are they suddenly no longer consenting? Like, did it change? Even though they're into it, but they can't be into it because they can't
then I'll
manifest
give
the intent. They're
160
too
closing
intoxicated.
arguments of counsel,
Right?
Then you can do closing arguments, and then
I don't think you. I don't.
You
I'm not
pound
saying
6 shots of vodka and
460
race the
after you've completed the.
What
after you've
okay, the
completed
difference
your
there is
closing
they're
arguments.
changing their mental
I've
capacity,
added the,
voluntarily changing their mental capacity,
the
as
verdict
opposed
form.
to
wait.
that the
And,
mental capacity being
verdict
visited
form
upon them.
actually,
Isn't
needs to have the heading
asphyxiation
on it.
and
And I'll
unconsciousness
make
a
sure that
voluntary
gets
change
corrected
in mental
before it goes
capacity
into the
during
jury, but
sex?
I did fix the request you
Yeah,
had.
I'm
Mr.
agreeing with the
Fairley.
Cardi Batman. I
So
think
the
you're
question
trolling me
one
now.
is, at the time the crime was committed, did the defendant have a mental disease or
Again,
mental
remember, this is about the
defect?
removal of
I
liberty
have
from
for
someone.
Question 2 as well.
Oh, I
and in the
understand that.
instructions, when I indicate you're going to be getting
Hey, guys.
this verdict
Hey.
form,
Welcome
I
back.
made that correction there as well.
Thank you.
Rich talking about sex, so thought I'd join.
I just have an issue with the lack of clarity in Wisconsin. Now, to be clear, I think Wisconsin could write a law that says if someone loses consciousness during sexual activity, the consent is revoked. But that's not what the law says. The law says that someone who is unconscious lacks the capacity to give consent, which also means, by the way, that if a spouse wakes their spouse up with oral sex, that is criminal sexual conduct.
I know, and I
Which is
disagree with it. I actually have a client with a similar situation to this, with the hotel room example that you posted this afternoon or this morning for you, where someone walks into someone else's hotel room and starts.
What I was thinking was missing. I don't think it is missing. I was thinking
That she had a similar thing like that happening when it was in a house, after a house party, and it was very known to everyone that she was not into having any relations, and woke up with some guy's finger up her. Obviously, no
That's
consent.
assault. Absolutely.
Yeah.
There's no pre-existing relationship. But I think spouses who have kind of this understanding that, oh, well, you know, you can go ahead and do this.
Well,
Under the law, though, it's still illegal.
This person's spouse, she wanted him to wake her up, but he was really reluctant to do that because she had that prior experience. So
I think your best argument against me, Nick, okay, in the interest of intellectual integrity, your best argument against me is what if a woman falls asleep in the middle? So does that mean
Just
that
on
a
the
guy?
verdict form,
Then you should probably
question
tie
one.
yourself a noose and end it all.
I think it should read at the time.
You want to tell us something,
crimes
Joe?
were committed, plural.
Okay, let's listen to
Instead of
this
the
argument.
singular.
Because we're dealing with 3, so that can be corrected. And then when I
What are we drinking?
605, question 1 at the time, crimes.
I got to propel.
Any objection to that, Mr. Fraley?
No, that
Sweet.
makes sense. Crimes were
Alcohol
that's
free.
What we're talking
Oh
about.
yeah, congrats on your
pregnant.
pregnancy.
Thank
Yes.
you.
That's very exciting. Is this your
I
first?
know.
There's
Yeah.
one more instance.
Oh wow. Best of luck to you.
Thank you so much.
In the top of 605, the defendant's mental condition at the time.
I also
of
think
the
there's a
offenses.
problem in this particular case because the only evidence about consent that was elicited from Taylor
Your Honor,
Schabusiness and that
are
they
we
were on
talking
their way
605,
towards
the
sexual
number one?
activity that was
605,
consensual.
The very first sentence.
So people are like, well, how do you know he
says,
consented?
You have just heard testimony about the
Because that's the only evidence. Remember, the state has to prove beyond a reasonable doubt that he did not consent.
I agree.
I
We
don't
had
think
to-
they did that here,
We had to trust everything she was saying, right?
I guess it's also on the next page.
according to the
The
state.
first question heading.
Martin Peterson. So
What's
Nick
on that
thinks rape
same
is
page?
okay. No, not at
Number
all.
1. At the time the crimes were committed.
I get such a Matt Walsh vibe from this defense attorney. The voice, the face. He looks like Matt Walsh's dad to me.
Bad takes.
No, it's not. Look at it again. Listen to his voice.
No, I said the bad takes.
Oh, the
Matt
bad.
Walsh.
Oh, that's what you meant.
I do think because he brought the colors, they agreed upon the choking part of it, that the consent for that was given. There's no record of
I
him
don't think it appears any other place.
stating
Manifesting
otherwise.
any non-consent at any point except his
Anything
death.
else, Mr. Saunders?
But that, again, the law does not say when you die, consent terminates. Maybe it should. I don't know, but it doesn't.
Your Honor, I see what
I also think
Mr.
there are problems with
Saunders
it,
was
so-
talking about on that second page,
Conceptually.
where it's in writing. The first question is, and then it should say at the time the crimes were committed.
We've caught that already.
Okay, but on the first page, what I was talking about, we corrected that first paragraph with an S for offenses.
Yes.
But then if we look down, it says 2 questions, and then it's got question 1 and question 2. Was that changed to at the time the crimes were committed?
Yes.
Okay, I just wanted to make sure. Thank you.
And just so everyone knows, I'm not intending to go back and get that corrected now. I will make sure my judicial assistant corrects that as I'm listening to closings. And so when this is delivered to the jury, they will have it corrected.
Okay, thank you.
In addition, as I've indicated, I'm also going to have the heading inserted on the top of the verdict form. So instead of the title of 605B, which is where this verdict form comes from, it'll have the heading in this case. If there's nothing else, then I'm going to use the same time limits as we had yesterday, but they're going to be flipped. So yesterday I gave the state a half hour and 10 minutes of rebuttal. That's what you'll get, Mr. Freilich, but the state will get 35 minutes for their closing. I'm not sure if you're going to need that much time. The time that I've given everyone each time they haven't used, but I will keep track of that for this time.
Okay.
Anything else before we bring the jury in, Mr. Saunders?
No.
Mr. Freilich?
No, thank
I
you.
actually thought that the prosecutor, the bald prosecutor, did the best job in closing. It
Yeah.
wasn't close.
Oh, absolutely. He was way better than
phenomenal.
everybody.
Yeah.
So back to this question. I want people to conceptualize the idea that I pull out a gun and shoot a corpse with it. Have I committed assault or battery on the corpse?
Well, I mean, what about
And if
the,
not, why not? What's the difference, right?
well,
What is
because
the difference?
your religious views just say that it's an empty shell and you've gone someplace else doesn't mean everyone's religious or spiritual views.
I'm not talking about religious views. I mean, under the law, if I pull out a gun and I shoot a dead body, have I committed battery?
A lot of states have laws that relate to not defaming or disgracing a corpse.
Exactly. No problem with that. But it's not a battery. In the same way,
I
it
agree
shouldn't
with
be
you
a
on that.
sexual assault.
I agree with you on that.
I agree.
And
I
we
think it
should
was-
have a law against having sex with a corpse. I cannot say this enough because it keeps getting missed. There should be a law against having sex with corpses. Make 10 laws. Throw them in a well. Shoot him to the sun. I don't
So
care.
you think all corpses should have, people should have sex with corpses every day? That's what you're saying.
That's what I'm saying.
That's what Chet thinks.
I was like, why do I have to be right next to
By
him? Put
these
Charlie right next
instructions
to
and
him.
from these alone, guided by your soundest reason and best judgment, reach your verdict. If any member of the jury has any impression of my opinion as to the issues in this phase of the trial, disregard that impression entirely and decide the issues of fact solely as you view the evidence. You, the jury, are the judges, are the sole judges of the facts, and the court is the judge of the law only. A defendant in a criminal case has the absolute constitutional right not to testify. The defendant's decision not to testify but must not be considered by you in any way and must not influence your verdict in any manner. Ordinarily, a witness may testify only about facts. However, a witness with specialized knowledge in a particular field may give an opinion in that field. In determining the weight to give this opinion, you should consider the qualifications and credibility of the witness, the facts upon which the opinion is based, and the reasons given for the opinion. Opinion evidence was received to help you reach a conclusion. However, you are not bound by any witness's opinion.
And some
In
opinions
resolving
suck.
conflicts in opinion testimony, weigh the different opinions against each other. Also consider the qualifications and credibility of the witnesses and the facts supporting their opinions. The court has appointed Dr. Christina Engen to examine the defendant and to testify at trial. You should weigh the testimony of Dr. Christina Engen as you would weigh any other opinion testimony. You have just heard testimony about the defendant's mental condition at the time of the offenses. You will now be asked to determine whether the defendant is not responsible by reason of mental disease or defect. This issue will be presented to you in the form of two questions. First, at the time the crimes were committed, did the defendant have a mental disease or mental defect? Second, as a result of the mental disease or mental defect, did the defendant lack substantial capacity either to appreciate the wrongfulness of the conduct or to conform that conduct to the requirements of the law? You will be asked to answer the second question only if you answer the first question, yes. Before you may answer a question yes, the defendant must satisfy you to a reasonable certainty by the greater weight of the credible evidence that the answer to that question should be yes. Evidence has a greater weight when it has more convincing power than the evidence opposed to it. Credible evidence is evidence which, in the light of reason and common sense, is worthy of belief. The first question is, at the time the crimes were committed, did the defendant have a mental disease or mental defect? Mental disease or defect is an abnormal condition of the mind which substantially affects mental or emotional processes. The term mental disease or defect identifies a legal standard that may not exactly match the medical terms used by mental health professionals. You are not bound by medical labels, definitions, or conclusions as to what is or is not a mental disease or defect to which the witnesses may have referred. You should not find that a person is suffering from a mental disease or defect merely because the person committed a criminal act, or because the unnaturalness or enormity of the act, or because a motive for the act may be lacking. An abnormality manifested only by repeated criminal or otherwise antisocial conduct does not constitute a mental disease or defect. A voluntarily induced state of intoxication by drugs or alcohol or both does not constitute a mental disease or defect. A temporary mental state which is brought into existence by the voluntary taking of drugs or alcohol does not constitute a mental disease or defect. Chronic use of drugs or alcohol may produce a condition that can constitute a mental disease or defect if the condition has become permanent. If you answer the first question yes, you must go on to answer the second question. If you answer the first question no, you should not consider the second question. The second question is, as a result of the mental disease or mental defect, did the defendant lack substantial capacity either to appreciate the wrongfulness of the conduct or to conform that conduct to the requirements of the law? If you answer both of these questions yes, the defendant will be found to be not responsible for the offense and will be committed to the Department of Health Services and will be placed in an appropriate institution unless the court determines that the defendant would not pose a danger to herself or to others if released under conditions ordered by the court. In deciding whether the defendant is responsible for the criminal conduct, you are to consider only the issue of the defendant's mental condition
Cameraman's
at the time
doing the
the
shit
offenses
job right
were
now.
committed.
I thought she was gone, but
Agreement by
They've gotten
10
worse
or
and
more
worse at this.
jurors is sufficient to become the verdict of the jury. Jurors have a duty to consult with one another and to deliberate for the purposes of reaching agreement. At least the same 10 jurors should agree in all the answers made. I ask you to be unanimous if you can. At the bottom of the verdict, you will find a place provided where dissenting jurors, if any, will sign their names and state the answer or answers with which they do not agree. Either the blank lines or the space below them may be used for that purpose. Consider carefully the closing arguments of the attorneys, but their arguments and conclusions and opinions are not evidence. Draw your own conclusions from the evidence and decide upon your verdict according to the evidence under the instructions given you by the court. Now, ladies and gentlemen, the attorneys will make their closing arguments, and as indicated, because the different burden of proof in this case, Mr. Freilich will start. Mr. Freilich, are you prepared to make a closing argument?
Yes, Your Honor.
Go ahead.
Thank you.
This is going to be well organized, conscious thought right here.
Oh God, stop it. This is his whole plan, so maybe it'll be good.
Your Honor, may
I
I please
know.
support, ladies and
I think so
gentlemen of the
too.
jury,
Has
Mr.
to be.
Saunders, Mr. Lissay. I want to thank you again for your attention. I know that you've been thinking and analyzing and listening very attentively to the testimony from these experts in phase 2 of this trial. Now, the question is whether or not Taylor D. Schabusiness is legally responsible for the crimes that she's been convicted of. And in this case, Taylor Schabusiness has elected not to testify. That's her right. You are not to use that against her in any way, shape, or form. This case is a battle of the experts.
Oh God, don't say
We
that.
have Dr. Seipel,
that battle has
we
been
have
decided.
Dr. Engine, and we have Dr. Lighton. The case started off by my client's father, Arturo Coronado, who came in and he testified that his daughter had some problems, some mental health problems growing up as an adolescent, that he got her some treatment, some counseling, some professional help, that he helped her at Nicolay Psychiatric Center, and that my client lived with him for a period of time. So he provided the framework and the background for some of the issues that this young lady has. And we heard about the fact that her mother died in the home, and she was there. And that was I would submit that was a pivotal event in her
Stop
life, that she loved her
submitting
mother.
or believing.
He doesn't believe
Then we
it.
moved on.
Would you say that's fair?
Dr.
Would you say that's fair?
Diane Lighton,
He asked a question
PhD,
today.
a doctor, forensic psychologist.
Taylor's
And she provided
your daughter. Would you say that's fair?
testimony as to her extensive background,
I missed that. That's hilarious.
her training and experience. And she
No, I think it's a
provided
cool twist of
testimony that she worked at UW-Madison as a scientist, that she completed over 3,000 hours of post-doctoral training at Mendota Mental Health Institution, a well-known institution that treats people with mental health problems, and that she became a licensed psychologist in 1993. She worked there doing competency evaluations, NGI evaluations, many other evaluations. And then in 1997,
Just reading off the paper.
she went and became an independent forensic psychologist, where she conducted hundreds of forensic evaluations, including competency, NGI, not guilty by reason of insanity or not guilty by reason of mental disease or defect. We call it NGI. Evidence-based sentencings and guardianship.
Never use acronyms.
And so she
in your closing
testified
argument.
about her background and her resume. Lawyers call it a curriculum vitae, her CV. Bores out all of the experience that she has working in this field.
Bores
technical
out.
field.
You're boring me out.
And she went on to testify about the fact that she met with Taylor Schabusiness in February of 2023 at the Brown County Jail. And Ms. Schabusiness was nonverbal, non-responsive, apparently threw a chair. She tried another approach where Dr. Lighton met with her behind glass and didn't really get any response. Then we heard about the fact that she did meet with Ms. Schabusiness in June of this year, and she was able to conduct her interview and glean and garner information with regards to her mental status and this report that she was tasked with. And I submit that Dr. Lighton testified that she didn't have to do an MMPI, a Minnesota Multiphasic Personality Inventory. She was able to gather enough information from reviewing all of the other materials and information that she had. Interviews, consults with the prior attorney, with me, reviewing all of the other doctors' reports, Dr. Lucetta, Dr. Seipel, Dr. Collins, and other doctors that have been involved in this case. She reviewed police reports, looked at interviews, looked at the criminal complaint, looked at Brown County Jail records, looked at Nicolay Psychiatric Center records when my client was inpatient there, looked at her school records,
And
looked
still
at
couldn't
the Bell and
diagnose
Health
her.
records, looked at a lot of information.
Okay.
Basically, what we have here is Dr. Lighton, who's very experienced. She did the NGI evaluation. You heard from Dr. Seipel, Matthew Seipel, that he did a competency evaluation. He did not do the NGI evaluation. Dr. Christina Engine, she's the one that did the NGI evaluation. Now, as it relates to Dr. Lighton, she is of the opinion, to a reasonable degree of psychological certainty, she testified that Ms. Schabusiness
Why
Taylor
is
Schabusiness
Taylor? Why isn't she
qualifies
smiling
for the NGI plea based on her diagnosis of a serious mental disorder. she concludes that the serious mental disorder affected Taylor Schabusiness's ability to know right from wrong at the time of the alleged offense, dating back to February of 2022, and affected her ability to control her behaviors. And she finds and opines that Taylor has been diagnosed with bipolar disorder for at least several years. And that was confirmed in the records from Bellin Health.
Not actually.
She also says and opines that Ms. Schabusiness continues to have prominent psychotic symptoms and has not used substances for at least 1 year.
Because she's been in fucking jail.
There was some talk about the feigning, the faking, the malingering. Feigning means faking.
Say feigning, faking, and
With that
malingering
topic.
more. It's helping.
And Dr. Lighton indicated that
Lying,
it was her
misrepresenting,
opinion that
pretending,
my client was
charading.
psychotic at the time of the alleged offense, and it wasn't simply due to drug use. It's clear that Taylor Schabusiness had a problem with methamphetamine, with drugs, marijuana, other drugs maybe.
The state's so happy
Dr.
right now.
Lighton says that Ms. Schabusiness had a very strange presentation, had facial expressions that can appear inconsistent with the context. If you're talking to her about something, she might smile or grin, and it may not be the appropriate time for that.
He's now laying
But
the
she,
foundation for that jury instruction
opines
about
that her
social,
assessment finds that Taylor Schabusiness
antisocial
has a
personality.
genuine mental disorder of a psychotic nature, which is most likely bipolar 1 disorder. Now, in this case, you heard that Dr. Engine, with respect to her, she didn't know that my client was under a civil commitment order for Brown County.
Because you
by
didn't
Judge
share that
Legis.
information.
Taylor Schabusiness was
Right?
found
How's that?
by the court to be the subject of a civil
How does that
commitment. And
invalidate
that's
her
why she
opinion?
went to
No, but
Nicolay
he's the one who
Psychiatric
didn't share that information. Am
My
I
client
right?
was also
Has this
the
been-
subject of an
this
order
guy over
for
the coals
involuntary
on that.
medication. She had to take
It's been discussed.
medications ordered by the court. No ifs, ands, or buts. Why? Because
Unless
she
that
was
butt's
deemed to
getting a
be
dildo.
having a mental illness. So that's something, ladies and gentlemen, that you should really strongly, seriously take into account. That in April of 2021, for a 6-month period, she was under a civil commitment order because she was mentally ill.
You didn't give her the report.
Has that been discussed while I was gone?
When
Yeah.
you look at
I mean, I assume the state's
know,
going to just
the-
dump it on him.
the report from Dr. Seipel, or you heard about his testimony, I would argue that his focus is on competency, and competency and NGI are two legal theories, two legal issues that have to be determined separately. But his focus is on competency, and that I would argue that his testimony is not relevant, not germane to the issues that you are tasked with, and that is to determine if my client is NGI, if she meets that criteria.
Stop using acronyms.
Well, stop
Dr.
using your
Seipel,
hands as much.
Although he's
like-
a PhD,
It's not like NGI is an acronym
his training
everyone
and
uses all the
experience
time.
is much less than Dr. Lighton's.
This guy's a terrible communicator.
His focus was competency, and that's not why we're here.
Small
Dr.
microbial
Engine,
hands.
Engen, she testified, and she
Keep
met
reading,
with my
homie.
client
You got like a 15-minute close and you're
on
reading
October
it.
12th,
That's embarrassing.
2022, and then again on October 21st, 2022.
And you keep getting
It
your
appeared
client's
that
name wrong.
On October 12th of 2022, there
Dr.
was some
Engine?
security issues, so she wasn't necessarily able to meet with my client. But she did meet with my client on October 21st of 2022 and had a 3-hour interview with my client.
Take your time.
That's 9 months ago. It's a long time ago. I would argue and submit to you that her report is stale. She didn't receive the Mellon records.
Her report is what happened
She didn't look
at
at
the
those
time of the
records.
occurrence. Being older is
Someone else
better.
could have given her the records.
Closer in time.
Maybe Dr. Seipel, he's on the same letterhead. And Dr. Seipel knew that he was doing his evaluation. There was a disconnect. There was no communication between the two doctors.
Isn't he supposed to
Which
send
is
them?
something you should consider. There
Isn't
was
he
no
supposed to send them?
connectivity there.
Object to this. I would object to it. It's not.
Also,
it's not been
with
established
due
as their
respect,
job to communicate.
Dr. Engine, didn't
This closing is diabolical and diametrical.
from Milwaukee to the Brown County Jail to meet with Ms. Schabusiness to do
The only
further
time
assessments or
I have
supplements.
ever wanted to be a government employee.
Didn't do anything to
is be
supplement
the
the
state
report.
attorney right now.
So that's something you should take into account as well.
Is he finished?
He doesn't know, Joe. He's got to rifle through his papers and see if
There's
you
a
wrote down anything else.
instruction, I believe the judge already gave it to you, but it indicates chronic use of drugs or alcohol may produce a condition that can constitute a mental disease or defect if the condition has become permanent. Something to take into account here.
Your only point.
We believe that Dr. Leighton was very clear that Taylor Schabusiness has bipolar 1 disorder, that she has psychiatric symptoms, she has mental health problems. And she made that clear. She talked about the fact that Taylor Schabusiness heard the train, heard the whistle.
I hear the train a coming.
That Miss Schabusiness lacked volitional control, lacked the ability to control herself, that she is a psychotic person off the scale, that she has a very unusual presentation.
Who said she was off the scale?
And she
psychotic?
testified that
I don't
Taylor
remember that at
Schabusiness,
all.
when she interacted with Dr. Litton, that Taylor tried really hard to answer her questions.
She
But
gave it a go.
Miss Schabusiness was distracted by internal stimuli, the clock, the cord, voices telling her to hang herself, the train with the whistle that got louder and louder. Talked about 007 and James Bond when she was asked about her mood. Dr.
Hey, wait,
Litton
I've been in
talked
a
about
James Bond mood before. That's
hypersexuality,
not weird.
and that was a concern for Dr. Litton. And about OCD, obsessive compulsive disorder, where Miss Schabusiness was washing her hands 30 to 40 times or touching her hair, things that
And no one
were a
diagnosed
cause
her
for
with
concern.
that, including the doctor who observed it, which is obvious bullshit.
Wisconsin law, we all have to follow the law. And Wisconsin law is such that the defense and a defendant must satisfy you jurors to a reasonable certainty by the greater weight of the credible evidence that at the time the crime was
Incredible's your
committed,
problem, bro.
that Ms. Schabusiness had a mental disease or mental defect,
So is evidence.
and that as a result, she lacked the substantial capacity to either appreciate the wrongfulness of the conduct or conform her conduct to the requirements of the law. And you're going to be given some jury verdicts, basically questions. Not many, just two, I believe. One is, at the time the crime was committed, did the defendant have a mental disease or mental defect? I would submit that the answer would be yes. That's my argument. That's my request that you consider that, and that it was bipolar 1 disorder based on the testimony from Dr. Litton. Then number two, you'll have to consider, as a result of the mental disease or mental defect, did Taylor Schabusiness lack the substantial capacity either to appreciate the wrongfulness of her conduct or conform her conduct to the requirements of the law? And you'll have to consider that as well. I would submit that that would be a yes.
Thanks.
And I know you know this, but I want to make sure the only issue at this hearing, at this phase 2, the second phase of the trial, is Taylor Schabusiness's mental condition at the time of the offense. So take that into account.
That's not a good argument for you, homie.
It's a difficult case. It's a very complex case.
Not at all.
Deals with law, deals with psychology,
It
deals
could
with
have been a
mental
difficult
health.
case. You didn't make it a difficult case. You made it easy.
A lot of things going on.
It's about as complex as trying to figure out whether or not he's bald.
But I would ask that you take all of this into account
Very
when
complex.
rendering your decision. Thank you very much.
There's visuals.
Look at her. God, you're my only hope.
She realizes now because she hasn't been reacting like this. She's like, homeboy, you said that if we did this approach, there was a chance that they would go with this. She knows now. She's not smirking anymore. She hasn't been grinning.
Hate this attorney.
I think it was the dope.
Oh, shit.
I blame it on being on drugs and the come down. I barely do drugs, then months go by, then I do drugs. Admitting on multiple occasions, both to evaluators and to law enforcement, about consuming a significant amount of methamphetamine for these offenses, admitting that she and Chad were toking methamphetamine beforehand.
Reminder that voluntary
She even talks
consumption
about
of meth
how she was still
negates
tweaking on meth during the
insanity.
dismemberment process. Ultimately, that's what this case comes down to, right? Because as we heard from, I think, every doctor, it's difficult to parse out psychotic symptoms versus drug use. So when we're talking about whether somebody has a mental disease or defect and they're voluntarily ingesting methamphetamine, it's really hard to say that that's due to some other underlying mental health issue, right? And that kind of makes sense in our common sense. But ultimately, that's what this case comes down to. It's the defendant's own words that this was fueled by meth. And now it's, well, no, it's bipolar. It's something else, some diagnosis from way before this offense. And that's not the standard you are to apply. Okay, so first, 2 questions you'll have. Was Ms. Schabusiness suffering from a mental disease or defect at the time of the offense? Not in 2012, not in 2014, not in April of 2021, not in June of 2023 when she's meeting with Dr. Litton, or in July with the other doctor, Dr. Seipel. The relevant
his affectations.
question
I
is at
hate
the
the way he
time of
talks.
the offense. Okay. And I disagree with counsel. And you all sat through Dr. Litton's testimony. I don't think it's clear at all that she's diagnosing the defendant with bipolar 1. She said most likely, seemingly based on the prior diagnosis. There's never a firm diagnosis, and we heard Dr. Seipel comment on that as well. You also heard about what bipolar entails, right? What's required? What are some diagnostic criteria, right? We heard about these manic episodes that last a week or thereabout, or even longer, where there's this heightened and manic state followed by a depressive state. You've heard none of that. What part of the interview the defendant gave to law enforcement on February 23rd indicates that she's still going through some manic episode?
what part of all of the witnesses and evidence you've heard about the time in the night of February 21st indicates that she's going through some manic episode? You've heard none of that. So this idea that this manic episode arose and dissipated in a flash, just happening to be around the 5 minutes where she's actually strangling him and then the day that she dismembers Shad, it's utter farce. There's no basis for that.
Could have elicited
Relying on
testimony from her
bipolar
about
1
it if you put her on the stand.
April of 2021. It was
Didn't
a
do
year
it.
before the offense. And you heard from Dr. Seipel and Dr. Engen, both of whom are court appointed. State didn't hire them to come. They're the court's appointed experts. Both of them have issues with that initial diagnosis. You heard why, about the concurrent methamphetamine use around the time of the Nicolay admission. And that's the same story we're seeing now, right? It's the same thing. Methamphetamine use, exhibiting psychosis, and that's unfortunately what led to Shad's death in this case. It's the same thing. So this concept of a civil commitment and the judge ordered voluntary medication, it's not relevant. It's not consistent with the other evidence you saw in this case. What did you see that led you to think the defendant was going through a manic episode, to have bipolar 1 at the time of the offense? That's what's relevant. You're told what a mental disease or defect is. It's something that substantially affects the mental process. That's something else you heard nothing about, right? People can have bipolar 1 and not have their mental state substantially affected. You heard nothing from Dr. Litton to tie that diagnosis, even if we'll give the benefit of the doubt and say she did diagnose bipolar 1, despite the testimony. You heard nothing to tie that into it being a mental disease or a defect. You're instructed that, as we talked about in opening, it's not just because somebody does something really abhorrent and really awful, unnatural. That's not a mental disease or defect. That would be a perverse incentive to sort of reward people to do more deranged things, right? That's not enough. It's not a voluntarily induced intoxicated state. That's what we have here. Mental disease or defect is not a mental state brought about by the ingestion of a controlled substance. So when we heard about meth-induced psychosis, right? Again, that's something that's being brought about by a controlled substance. Those aren't mental diseases or defects. You're responsible in this state for anything you do because you choose to ingest methamphetamine. That's the law.
I'll be right back.
You heard nothing in this case about there being some permanent condition. None of the doctors diagnosed the defendant from suffering from any brain disease because of methamphetamine use or some other substance. Not even her doctors will say that. So when the defense argues that chronic use of drugs or alcohol may produce a condition that can constitute a mental disease or defect, if the condition has become permanent, nobody is testifying to that in this case. That's not any evidence that you heard.
The defense attorney's writing down because he does get a rebuttal to this if people are confused about that.
You heard and saw the defendant in the time almost immediately before and immediately after this offense, right? We heard from Dr. Seipel about that, and I think the defense fundamentally misunderstands why the state called Dr. Seipel. Obviously, he didn't do an NGI evaluation. We asked him about that. The relevance is because he highlights flaws in Dr. Litton's report, in her opinion. And that's the sole opinion the defendant's relying on to meet her burden. We heard about why, when you're considering, a bipolar diagnosis, particularly in the NGI context, it's really important to look as close as you can to the proximity of the offense, right? And that makes sense, right? It helps validate if this is actually some manic episode or something that would be throwing a chair randomly at a person, right? But there's a difference between those two things. And we heard none of that. We heard none of that from Dr. Litton, did we? We heard a lot about mental diseases and illnesses that she thinks happened way before, way after. And yeah, she reviewed a lot of material, but Dr. Litton tied none of it into February 22nd of 2022, did she? No testimony about, well, okay, so if somebody has bipolar 1, how is that manifesting? How is that utterly inhibiting the defendant from her awareness of what's going on, or her ability to conform conduct?
And that's
Right?
really the big problem. Even if there was some mental
A
defect.
statement at the end that, well, I think she's NGI. I would support the plea. You heard no analysis, right? No analysis of, well, I considered the defendant's actions the night of the incident, and this raised this concern.
Or her statements.
That would support my opinion. We heard none of that, right? And it's their burden to do so. You heard none of that from Dr. Litton. She's, yes, qualified, experience. We heard about that. But there are real issues with her methodology in this case.
She also doesn't testify to any evidence in
Based
support of
largely,
the conclusion.
her opinion is on her interactions with Ms. Schabusiness on June 19th of 2023. And we heard ample reason why that should be a red flag. People who actually administered personality tests to kind of determine feigning and over-exaggerating of symptoms, including experts hired by the defense, have raised that concern for the defendant that she over-reports symptoms, that she exaggerates symptoms. And Dr. Seipel is exactly right. And you heard the testimony from Dr. Litton. Most of her opinions based on her interactions with the defendant and this bizarre behavior that she's observing. Incidentally, bizarre behavior you haven't observed for 1 second during this trial. For the last 4 days, there's no throwing chairs, there's no outbursts, there's no staring or off, right?
You didn't see it in the video either.
So this idea that
I would hit that.
Dr. Litton's opinion based on her interactions with the defendant and some old bipolar diagnosis, there's nothing tying it together. There's nothing showing you that would allow you to agree with her opinion that the defendant had a mental disease or defect on the date of the offense, which is the relevant question you have to answer.
Mental disease or defect. This guy should be played by Nathan Lane in the musical.
You have reported behaviors by Dr. Litton that aren't in any other reports that are observed by doctors. Dr. Seipel meets with her really close proximity, isn't reporting any of these behaviors. And again, one of the questions you have is capacity, right? Substantial capacity to do things. And there's a big difference between capacity and desire to do so, with volition, with choice, right? The capacity to go skydiving. I don't have the volition to go skydiving. I have the volition to dunk a basketball. I probably don't have the capacity to dunk a basketball.
There's
right?
no probably in there, homie.
No kidding.
The information you heard about in the records.
You couldn't dunk a basketball into a desk garbage can.
It's something that the defendant can control to some extent, right? There's no outbursts or any of the behavior Dr. Litton's talking about that Dr. Seipel observes, that the court-appointed expert Dr. Engen observes. None of that, right?
Well,
to the contrary, you have Dr. Engen doing scientific tests to determine about the validity of some of the observations and determining the opposite, right?
And Mandy, he can't even dunk on the Dallas Cowboys.
Litton was under no requirement to do that sort of testing. But when she says she just looked at the prior results and relied on those, well, what she should have been relying on is that the information the defendant's telling her isn't accurate. That's the only prior analysis that we heard about. So again, there's real methodological issues with Dr. Litton's report. Most importantly, none of it ties together with the date of the offense. Her testimony for the better part of this morning, maybe 2 or 3 questions dealt with the date of the offense, tying it together. Dr. Litton, how are you able to tell this jury that Ms. Schabusiness was unable to conform her conduct, was not aware of what's going on? You heard none of that. She didn't even review the entire video, the recorded interview that you observed, to see firsthand, really close proximity to the date of this offense, what the defendant's behaviors were. She reviewed a transcript. I think she said she may have reviewed 90 minutes of it or something like that.
out of 6 hours. You don't even know if she saw the same thing.
Which incidentally, as you observed, and you heard from Detective Graff, the same behavior, same mannerisms, same lack of outbursts or anything like that throughout this time. Again, this manic episode that is allegedly occurring. You observed that over several days and didn't observe any of that. So that's the concern with Dr. Litton's testimony, and that's the relevance of Dr. Seipel's testimonies. He points out some of these issues. And he interacted with the defendant as well. Didn't observe any of that on multiple occasions as a court-appointed expert. Again, not hired by the state to come in and say that, report that. So you have the report from Dr. Engen, the court's expert, and you heard the testimony. And if you review the report, it jives with common sense, right? There's no mental disease or defect that she talks about. The mental illnesses, which there seem to be, are all substance abuse related. And again, the law of this state says that's not enough. That's not a mental disease or defect. So sure, there's, I think, amphetamine disorders and methamphetamine intoxication. She says, yeah, I would support these illnesses. Those aren't mental diseases or defect. She considered a bipolar 1 disorder and rejected it for the reasons we talked about. Given the concurrent use of methamphetamine, it seems like the doctors that the court appointed agree that you're using meth. You're not psychotic. Any psychotic symptoms you're exhibiting are because you took meth, not because you have some diagnosis or of a mental disease or defect. So when you're asked the first question, when you see the verdict form, that question should be answered no. You've heard insufficient evidence that the defendant suffered from a mental disease or defect on February 22nd, 2022. Okay.
And this is the burden of the defense to prove
you answer that question, yes. And only if you answer that question, yes, do you get to the second question.
If you somehow manage to cobble together the answer to that question is
Second question asks sort of a compound question. As a result of that mental disease or defect, did the defendant lack substantial capacity, again, capacity, to understand the seriousness of her conduct or to conform her conduct to the requirements of law, right? So understanding and conformity are kind of the two things there. So let's talk about that. You obviously heard from Dr. Engen about that, about how she does not support that. She does not believe that she lacked substantial capacity to have either of those two things, right? And her reasoning makes sense. And really, it's kind of reasoning you probably would have gotten to without her testifying in some respects. It helps that this expert that the court appointed comes in and tells you that too. But it jives with common sense, right? Because you heard all this evidence for Monday, Tuesday, Wednesday, and today about the defendant's conduct on February 22nd, 21st, and into the 23rd. She's aware of the wrongfulness of her conduct, and she's telling you as much, right? She tells law enforcement, I took these Clorox wipes and I was wiping up, right? Specifically, even accurately remembering it's Clorox wipes, where she put them in the bags. Detective Scanlon on February 28th asks her, hey, we saw some wiping pattern on the floor. I mean, what was going on with that? And she was like, yeah, I was cleaning up. And they're like, well, did you move the bed over? She said yes. And why did she say it? Why did she say she did that? She was covering it up.
He looks like he's auditioning for My Fair Lady, but at least there's some passion.
The blood that you saw on the floor under the mattress.
He is auditioning for the part of the lady.
It's coming because
for the lead in My Fair
Lady. Over it because she's trying to cover up her crime. And now they want you to believe that she's not aware of the wrongfulness of her conduct. She's telling law enforcement, how am I going to get away with this? That was her motivation for dismembering his body for a lengthy period of time after the fact. Hearing footsteps upstairs, worrying mom was going to find him.
Well, she did.
She's telling you she's aware of the wrongfulness of her conduct, and she's exhibiting action and volition to clean up. Everything you're objectively seeing evidence-wise in this case shows you that she knows exactly what's going on. She even remembers details about this night. Now that we hear this professed amnesia in her comments to Dr. Engen about this offense, and you saw the interview, she had every detail down to the T. She could have drawn that entire basement for you from memory. Everything was located. She told you where the meth is located, where the dildo is located, what color the dildo was. She's aware of what's going on.
Say dildo again.
He was very
dildo
fixated
one
on the
more
color of the
goddamn
dildo. He's very fixated. Wait, it comes in multicolors?
Have her.
Well, this
How
one
many
gave
memory of
How
the
many
incident.
ripples there were? If it vibrated, if it wiggled.
How many
How
ripples?
she's describing, you could probably infer from the nature of the offense how blood was going everywhere in the course of the conduct. Yet you heard about the condition of that basement, right?
Right.
Pretty spotless. Pretty
Okay,
clean,
drinking
especially
game,
considering
guys,
what
and
happened.
shit. Every time he says right,
She cleaned
take
up.
a shot.
Because
Let's
she
get
was
hammered.
aware of the wrongfulness of what she did. She didn't just massacre somebody, dismember him, and leave a war zone down in that basement. No, she cleaned up because she knew what was going on. Then you get to the second part, right? If she's able to conform her
shot.
conduct to the requirements of law. And again, you heard nothing from Dr. Litton to kind of help you with that, right? Like,
Right? Take
okay,
a shot.
if I'll accept she has this bipolar diagnosis, well, tell me, Dr. Litton, how is she unable, because of that diagnosis, to conform her conduct on February 22nd? And you heard none of that. To the contrary, as Dr. Engen points out, you have a lot of information to tell you she's able to conform her conduct pretty well, right? She's employed. We heard about court cases that she was dealing with. We heard about paternity things she was arranging in the time leading up to the offense. We heard about after the fact, we saw the contact with law enforcement, right? She's ordered to take her hands out of her pockets for officers. She does that. Order to put her hands behind her back. She does that. Complying with orders, complying with commands, complying with questions. She's conforming her conduct pretty well, right? She's following the law enforcement's commands. In her interview with law enforcement for a lengthy period of time, she's conforming her conduct. She's not exhibiting any manic symptoms. She's not exhibiting any psychosis in that you heard about. There's just nothing in this case to show that she's not able to conform her conduct. To the contrary, you heard a lot
God
of
pouring the
evidence
water
that
there just killed me.
not only does she not lack that ability to conform her conduct, that what she did to Shad was volitional, was a choice. She liked it. She was aroused by it, right? She told law enforcement that. She wanted to do this. She did. Because that was a volitional choice. It's not because she lacked substantial capacity to not do so. It's because she wanted to do so. And she did.
His hands are always at right angles.
You heard about her saying, well, yeah, I knew I was killing him, but quote, I did it anyway, right? Because that's what she wanted to do. And again, a mental disease or defect is not because you may not have a clear understanding of a motive. I would say you should, but that's not a mental disease or defect. Just because what she ultimately did is in some respects quite disturbing, it's not a mental disease or defect. You have insufficient evidence to support that. And again, it's not the state's burden to disprove an NGI plea. I think we have, but it's the defendant's burden to convince you of the NGI plea, and they've utterly failed in that respect.
End it. He's already dead.
We heard about the burden of proof, that it's a reasonable certainty by the greater weight of the credible evidence. And you should be, even though it's not a burden, I would say you should be reasonably certain the defendant's not suffering from a mental disease or defect. Again, it's their burden to convince you that you should be reasonably certain by a greater weight of the credible evidence that she does. It's their burden. If they wanted the court's expert to review documents from 10 years prior,
thank you,
they could have done so. They could have provided those materials. If they wanted, hey, please interview my client again, they could have done so. It's their burden. And they chose not to. If there was additional jail records, they could have produced those. And actually, Dr. Engen's comments about that make sense. You know, her findings and all the objective evidence you have is this is a meth-induced crime, that whether she had a civil commitment a year prior, had, I think, a mood disorder 10 years prior as a 14-year-old, that's not relevant. It wouldn't change anything. I don't understand these arguments about the reports being stale. As Dr. Engen told you, it's a retrospective review, right? We don't really care. You're not asked to decide, does she have mental disease or defect today? That's not important. The proximity to today isn't relevant. It's the proximity to the offense. You should actually be entirely convinced Dr. Engen's report is the more relevant report. It's closer in time to the actual mental state the defendant had on February 22nd. It's obviously a complex case in some respects, right? It's a serious offense that the defendant was convicted of. It's obviously it's an important case, right? And the defendant has had experiences in her personal life that nobody should have. Losing parents at a young age, it's something many of us deal with, and it's awful to hear about. It really is. But that doesn't change the law. That doesn't change the standard in this state, because there's simply no evidence to support she had a mental disease or defect on February 22nd, 2022. Not only did she not have a mental disease or defect on that day, you have no evidence to say that that mental disease or defect rendered her substantially incapable of conforming her conduct or appreciating the wrongfulness of her conduct. You simply don't have that evidence here. You have ample evidence to the contrary. The defendant is telling you that meth made her do this. She's repeatedly told that to law enforcement. Every objective piece of evidence you have in this case supports that finding. And it's simply the case that that is not enough in this state. That's not a mental disease or defect. So don't let her now try to come in and say this was some other thing. That no, now the meth really didn't have anything to do with it. It's important to note, a meth-induced psychotic state is also not a mental disease or defect, as you'll read in the instruction. There's no mental disease or defect. There's no lack of awareness. There's no inability to conform your conduct. You have ample evidence to the contrary. And that leads to one inevitable result, is that she's responsible for what she did to Shad on February 22nd. As a result, you should answer both questions no, or answer the first question no, and don't get to the second question. Thank you.
Mr. CRAY, do you have a rebuttal?
Yes, I do, Your Honor. Thank you.
Why? And he said a bunch of stuff.
Your Honor, again, may it please the court,
He's
ladies and
probably
gentlemen,
right.
Mr. Saunders, Mr. Lissay.
I can't do this again. I'll be right back.
You know, this case illustrates that this young lady, Taylor Schabusiness, has a lifetime of mental health issues. She has bipolar 1 disorder. That is a mental disease or mental defect. You know, who is the state fooling? We have a young lady that was under a civil commitment order and a medication order by the Brown County Circuit Court in 2021. So she already had a mental health disorder, a mental defect, I submit a mental disease that predated the incident that has brought us here to court on February 22nd of 2022.
It's actually kind of your problem, homie.
It's clear in this record that Ms. Schabusiness was at the Nicolay Psychiatric Center for 3 weeks or so, maybe a month in 2021. You got to see in phase 1 of this trial, Green Bay police officer Garth Russell, who parked his squad down quite a ways, and he walked in the dark of night across the snowy parking lot up to the Eastman Avenue apartment at 2353 Eastman Avenue. And Ms. Schabusiness Officer Russell met her at the door out on the porch. And you could see on the video her face. You could see her eyes. You could see her demeanor. She didn't look right. I submit to you, she didn't look right. Something was going on.
That's
a terrible defense. If they remember that, she looked
Did
completely
this
normal.
happen when she was in a manic state or a psychotic state? I submit that, once you have a mental health issue, mental health diagnosis, a mental health issue like bipolar 1 disorder, it's not going away. It follows you for the rest of your life.
He's dangerously close to misstating the law.
What we have here is someone who has a very serious mental health issue, mental health disorder. And you pile drugs on top of that. It can constitute a mental disease or defect if the condition has become permanent. I would submit that Taylor has had mental health issues dating back to her early years. She went to Purveya, she went to Bellin, she went to Nicolay, she was under a court order where she had to have injectable antipsychotic medications. She apparently was psychotic when she was at the Nicolay Psychiatric Center. I would submit that it wasn't necessarily from drugs. She's got this underlying issue here.
Wow.
The DSM-5
She has ongoing
disagrees
mental
with
health
you.
issues.
Your own
She's only
witness
25
disagrees
years
with you.
old. And they've been going on since her youth. I would argue that the mental health issues that she has caused this whole situation. And that'll be something you have to think about.
To think about? Stop saying that. You have
Is
the
she
burden to
able to
prove it.
appreciate, or was she able to appreciate the wrongfulness of her conduct on February 22nd of 2022? Was she able to conform her conduct to the requirements of the law at that particular time? And you saw the video. We all saw it.
Yeah.
It was very bizarre, very unusual, very odd, her demeanor. In this case, there are a lot of doctors, but Dr. Engine, she never knew about the civil commitment order. Come on. You didn't know about a court order?
Your job to tell her about it.
She's a PhD and she deserves respect, but something happened here where it fell through the cracks that she didn't
Yeah, you
know
didn't
about
send
this
it.
civil commitment order or this
didn't
medication
send-
order. And then we have Dr.
Why is
Seipel,
he looking up
he
court
got the
records?
Bellin records, got them from me. And, he does a report for this case, and I find it incredible. It's incredible that he doesn't send, with due respect to him, he doesn't send the Bellin records over to Dr. Engine, knowing that she's going to come in here and testify in a court of law in front of you jurors. I find that unbelievable.
Why is he sending them
I don't
to
make
her?
the law. But the law, the law because the judge read it to you. You have to consider whether she's responsible because of a mental disease or defect. So you've got to think about all of that. The defense didn't fail. There is a plethora of evidence to show her mental health history.
He's trying to
Did
invalidate
her-
the expert by
was her
not sending
bipolar
the
1
expert the
condition
materials he's
permanent?
supposed to
I
send.
submit to you that it was. Did it cause a crazed situation for her on the date of this fatal incident? You heard Detective Groff, who's a very seasoned detective with the Green Bay Police Department. You heard him go through very methodically questions. He was patient. He asked Taylor Schabusiness lots of questions about what was going on. And he testified that the police detectives and the officers, it was an ongoing investigation and they didn't have all the facts. They didn't know all the things that were going on. It was evolving. Detective Scanlon was over on Stony Brook and
therefore
Detective Groff was at the police department. She told Detective Groff, I didn't intend to do this. Me and Shad were buddies. Words to that effect. So I submit that she did not want to do this. At the
You
time,
should have argued that
was she in a
at the
state of
last
psychosis?
phase, you idiot.
Who knows? That's for you jurors to decide. But we've presented the lawyers, Mr. Saunders, Mr. Lassay, and I have given you the information, the evidence for you to wrangle with and think about and analyze and assess. I would ask that you consider the fact that Ms. Schabusiness was taking the antipsychotic meds, injectable meds, when she was at Nicolay Psychiatric. And then once she was released, didn't take it anymore. We all know if you don't take your medications, you're going to have problems, especially if it's a mental health condition.
Oh, God.
If you don't take your high blood pressure medication, what's going to happen?
Oh my
Your
God.
blood pressure is going to go up to the sky and you could have a heart attack or stroke.
I know what
How
that
long-
feels
Same
like.
thing rings true for other medications. And in this particular case, Ms. Schabusiness did not take these medications. So I would submit, her mental health problems, her bipolar 1, got worse and worse and worse and worse to the point where it went off the cliff.
How long is this going to take?
I would
only
submit
had
that
6 minutes.
based on everything that's
Left.
been presented,
Or no, wait,
I'd
I
ask
think
that
he had
you
about 12 minutes.
consider returning a verdict that she is not responsible for these crimes by reason of mental disease or mental defect as applied with the jury instruction. Thank you very much.
We didn't ask him to actually return the verdict. He just asked him to consider returning that verdict. So I think
Now,
they'll do
members of the
that.
jury, the duties of counsel in the court have been performed. The case has been argued by counsel. The court has instructed you regarding the rules of law, which should govern you in your deliberations. The time has now come when the great burden of reaching a fair, just, and conscientious decision of this case is to be thrown wholly upon you, the jurors selected for this important duty. Do not be swayed by sympathy, passion, or prejudice. You will be very careful and deliberate in weighing the evidence. I charge you to keep your duty steadfastly in mind and as upright citizens to render a just and true verdict. As with the case in the prior phase, you will be getting a copy of these instructions with you during your deliberations. With that, I'd ask the bailiffs to step forward to be sworn.
Gosney asked about if anyone on the panel knows about drug-induced mental defect or mental infirmity. The jury instructions specifically say that the voluntary consumption of drugs is not a mental defect or disability.
Yeah, but the question is, if there's an underlying mental defect, and that does it still does it invalidate the mental defect defense?
Also, when you choose not to take your
All rise for the
cuckoo
jury.
medication, that's the same thing but opposite, right?
So you could maybe argue that the voluntary consumption of drugs doesn't undermine an underlying mental defect if you had any evidence of an underlying mental defect at the time of the crime.
Yeah, but he just ended, the defense lawyer just ended on saying that she didn't take her medication for the bipolar. And if she chose not to do that, then that defense goes out the window too.
Ghazni says, really, do you have anyone commenting who can talk about what it is like to voluntarily consume drugs? I did not pick up on the dig. Oh, wait, were you making fun of me? Well, Mr. Ghazni, shots fired, my friend.
Why doesn't he come on?
He's afraid. He's afraid. That's the only conclusion I can draw.
Only
There's no
logical
other
conclusion.
conclusion than that Stephen Ghazni is physically in fear of coming on this panel.
I wanted to show him my new guitar, though.
Did he read the jury charges off already? Did I miss that?
Yeah, Judge
Let's
did
not
that
do that.
before. That's before close. I'm gonna take this off the air. I'm gonna go to the bathroom. If you guys want to chat for a minute, and then I'll come back, chat. Got to catch up on super chats and stuff like that.
Yeah.
I'll be right back though.
All right, Charlie.
How's it going?
It's going good. Nothing's going with you.
Well, I just got to stop smiling.
I
You're
am
very- you're
coming
very-
for you, infidel.
Yeah. So yeah, this is your first one. That's very, very exciting.
Yeah. So I just wanted to tell chat again. I've only been drinking non-alcoholic drinks.
Only non-alcoholic drinks. One
I've
is.
shown them.
When are you
okay?
expecting?
Oh, it's far away. I'm only going for my first ultrasound, just very closely. So
Okay, so you got. It's like not something like next spring.
I think maybe end of winter, beginning of spring.
Wow, that's great. That's great. Well, best of luck to you.
Thank you. How are
And-
your grandchildren?
Oh,
you have a new one like recently, sort of.
Yeah. I had my third recently, so he's like 4 months now. But it's a really, it's like when the first time you feel that life inside you when you go for that ultrasound for the first time. Ooh, that's
Inside of you, Joe. Were you carrying the child? Are you
Hey,
this
why
most-
are you
most
judging? You don't know
actually-
me. You don't know me. You don't know me. What's all the judgy stuff? Gosh, it's 2023. Hello.
Oh, I'm sorry. Is that just a Jew thing? Am I not allowed to?
So is the father as bubbly about this as you are?
He's maybe possibly even more excited.
Oh wow, that's so awesome.
I get every time he leaves the house, I get a kiss on my belly now too.
Nice.
It's just so yeah. I'm sorry. I'm just like a giggling teenager.
Yeah. Wow.
It's great.
That-
We're really happy and excited.
That is really awesome.
Read some
So-
chats. I don't have chat windows, so
You want me to open chat? What do you want me to do? What was that? Huh?
just see if chat has any questions or things to say. I don't have any chat windows, so I can't.
Yeah. Oh, so yeah, you don't see it scrolling here, the comments here? Because everyone
Nah.
here is very happy for you.
That's
Everyone
great.
here is yeah, they're very, very excited for you. But coming back to Taylor Schabusiness.
Is that her actual surname, or did she change it?
She changed it. Her father was she
Okay,
was born
okay.
Coronado or something like that. Her father testified. That was his
No,
last name
I
was
saw
Coronado.
that. I saw that. I saw that. I just didn't know.
I'm very bothered that if you're gonna change your name to Schabusiness, it's got to be like all Z's, not S's. That doesn't make any like seriously. If
That's
you're gonna
why.
be
That's
that
why I
immature,
doubted it. That's why I doubted it because I told my hubby that she had changed her name into Schabusiness,
Schabusiness.
which I thought it's pretty cool. Not gonna lie to you.
Yeah.
But then I saw the spelling and I was like, maybe this is a legit surname. Like I didn't
No,
understand the spelling.
yeah, nah, that's not no, that's not like anything. No one's. It's not like America's forebears are littered with like there's a long legacy in American history of the Schabusiness family. Oh yeah, fighting in the Revolutionary War was the
I
Schabusiness.
cannot believe you're denying the strong lineage of the Schabusiness. Very, very, very.
Colonel Schabusiness, who fought off the British in the Revolutionary War. Oh my gosh.
Oh my goodness.
So,
yeah.
do you
okay,
think the
go-
deliberations here? You think deliberations here are going to take more than an hour and a half?
No.
If they take an hour and a half, I'm going to slam my head into the desk.
Are you gonna stop
Yeah.
your stream again just 10 minutes before they come back with the
Well,
verdict?
I don't know. I've got a lot of super chats to read.
Yeah. Yesterday you closed down like right when they came out. That was like perfect. I was like, Nick has the worst luck when it comes to timing out things mid trial. Oh my god, it's so bad. I was laughing when I saw that. I was like, oh, let me see about sniping Nick because I'm bored. And I see so like, all right, I'm out of here. Goodbye. And like 90 seconds later,
Same thing
it's
happened.
like I got a thing. Yeah, that
I had
the
committed to
jury's
go
coming
on
out.
committed to go on another stream, and then I only had a limited time because my parents were in town and we're taking me and Lady Raggets out to dinner. So I had to get done with that stream and get to dinner with my parents.
Well, there you go. There you
So,
go.
Okay, so
Yeah, get to your chats.
is it well? No, just real quick. Is there any concept that they're going to return a 10, 11, or 12 juror verdict of not guilty by reason of insanity? Does anybody think that that's a I don't think it's even in the realm of probability.
No, I mean, this was as half-assed as you can do something like this. I think. I don't. This is such a. I mean, he felt and looked and sounded like he was going through the motions at this point. Like he's done and he's just. Yeah, this was
That's
not.
That's how he's felt a while for a long
for
time.
the entire trial.
Yeah.
Yeah.
I gave him the benefit of the doubt at first because I'm like, look, his job is just to argue for this reasonable doubt. His job is not to do all this stuff. And he's what he's got to do is focus on these elements like intent. And so he doesn't need to address all these arguments. So he doesn't need to do all this stuff. And I'm like apologizing for this guy. And then we get to that spot where he gets to his case in chief, and the only witness he's going to call is the guy who he's subpoenaed, who doesn't show up, and he only has the statement elicited from the state when they arrested him that is self-serving, and the only information he has about why the guy won't show up is from the state saying, well, he's got a medical issue. We won't say what it is because we don't know what it is. We just heard about it from a family member. He hasn't talked to him. His investigator hasn't talked to him. And then he moves for a mistrial, which was not going to happen, but he doesn't ask the judge to enforce the subpoena. He doesn't ask for an offer of proof as to what medical condition is preventing this guy for multiple weeks from being able to come into trial. None of this happens. And then he's just like, yeah, we'll just stipulate to some statements and have the judge read them to the jury. And they're supposed to just accept them as if they came from the guy they've never met or seen interviewed or anything. It was insane. And that's what I'm like, no, actually, this guy might just be bad. And then it got worse and worse and worse. And it's never stopped getting worse from that point on.
I mean, I think it's possible, to be fair, different people have different skills in any industry, and his skill, he did in certain ways, he displayed certain aptitude, meaning with respect to objections, like he was very good at like jumping in and recognizing that, hey, this is going in a direction that shouldn't go. And he was very attuned to following the case. He seemed invested, like he was locked in on that. I think he was very weak in his storytelling. He's very weak in developing his theme, and his preparation seemed like it was lacking. But
he didn't prep a single witness.
Yeah, his preparation.
He didn't prep the dad, and he didn't really seem to prep his star witness on the.
And let's face it, his star witness should have been Taylor. That's who it should have been. His star witness should have been Taylor. He had nothing to lose because he's leaving the jury that the only time they hear her voice is when she's confessing to these horrible crimes. So,
Yeah.
like,
and once
what's the
that's coming
downside?
in, once that interview comes in, the only thing you can do, in my opinion, is get her on the stand and reinforce the fact that she didn't want to kill him. She didn't intend to kill him. She didn't want him dead. She loved him so much. All of those things that she said in there. And when the state comes back, you know what they're going to come back with. You liked killing him, didn't you? It's like, well, I was really foggy. I liked the sexual act. I didn't like that he died from it.
Mm-hmm.
Like,
Right.
yeah, I liked choking him. He liked choking me. We're a couple of chokers. We're choke bros. We do the choking all the time. That's what she was. Even if that's
And
not
by the
what
way,
she was
when she's
saying,
up
you
there,
want her to say that.
and I'll tell you something, I would actually prep her, like, to actually throw it back at the DA. Like, you don't like choking? Like, you're gonna be asked about choking, like, to make it as if, like, in her brain, that's totally normal. That's what everyone
Yes.
does.
I
It's like,
think that
don't
the
you-
reason.
Or even, don't you like sex?
Yeah.
Don't you like foreplay?
And that's what that's what sex is. To make it clear that to her and people she's having sex with, that is what sex is. So yeah, I think there's so many missed opportunities that it's just very very, very frustrating. And like I said, I really would have leaned on the Jeffrey Dahmer thing. Oh my God. There was so many opportunities to basically set up that this was not intentional, and that anything she said to that made it seem like it was intentional is just because she's a fangirl of Jeffrey Dahmer. She's clearly a fangirl. I mean, every one of us knows that she's clear, but that doesn't mean that she's going to do what he does any more than a fangirl of Justin Timberlake is going to be starring in a movie. You know what I'm saying? It doesn't make any. It's and that's how you play it. That's how he had a chance to play it, but instead he was very vested in getting this NGI, like, as if that's a real win, when it's not even if he were to win, that's not even a win. She spend the rest of her life in an institution. So
Yeah, it's I don't know. The whole thing was a mess, and I'm generally of the opinion that you should not testify in a murder trial, except when
We
you're
have nothing to lose.
already and when you're already testifying, because they're using a recorded interview in which you admit to everything, then the only chance you have is to explain your admissions.
Well, I
Like,
think
that's it.
If
Clarify
Kyle wouldn't have taken the stand, I don't necessarily think he would have won. Kyle
Maybe not.
Rittenhouse.
Maybe not. But
You were against it then, I think.
Yeah. And I don't know that I've changed my mind on that decision. I've
You know he
certainly
won,
been.
right?
Yeah, I know he won, of course. But I don't know that Kyle needed to take the stand to win. I'm not quite sure he did. I think he did really well on the stand. I don't think it ended up bad for him, for sure. But that's hindsight on how it worked out. But I do want to say this. Bronca persuaded me, I think, the most when he said, look, in a self-defense case, people want to know why you shot, why you pulled the trigger. They want to hear from you. So the conventional wisdom, and Bronca's a self-defense guy, conventional wisdom says you don't take the stand. But when you got to explain why you shot a guy and killed him, the only way you can do that sometimes is by taking the stand, unless there's someone else who can testify to that for you somehow. And in Kyle's case, there just wasn't anyone
no,
other
that's
than
not
Kyle who
true.
could say it.
That's not true. Kyle, the reason I agree with you that Kyle did not have to take the stand, I mean, and maybe the only reason he did was because he had to take the stand was because culturally, if you trust Mark Richards, and he's certainly effective, and Natalie Wisco, they were of the mindset that no one in Wisconsin is going to win on self-defense if they refuse to take the stand. The reason I think this is different is because the witness he had was the video. I mean, the video was the best testimony imaginable. So in that sense,
Should be, yeah.
Yeah, it's better than someone getting on the stand. If you have to choose between someone on the stand or the video there, you take the video 100 times out of 100. So in that sense, I agreed with you. I didn't think he should take the stand. We were all shocked when he got up there.
Mm-hmm.
But Mark Richards said that there was never a moment that they thought otherwise from the time he took this case over, that he was definitely going to put him on the stand. So Look, it worked.
Yeah.
It worked out here. But the point being, in this case,
we'll never know the alternative, right?
No, I wasn't shocked at all. But
Yep.
this is the thing. I wasn't shocked at all. But with all these things that that we've talked about in previous streams, where I kind of take the side of chat, because I'm not a lawyer.
Either is chat.
In America. No, I'm just, you guys are. All you guys are lawyers in America. I'm not. Neither is chat. Exactly. Thanks for.
Oh, I
my
see.
point,
I
Nick.
see. I gotcha. I guess I'll do this. What are you doing here? What do you want? What do you want?
I'm calling you out. I'm calling you out. I'm challenging you to a rumble. 8 o'clock tomorrow night. I'm going to grade the parties, and you want to defend your position. I'm calling you out.
Well, I already have announced that I'm probably not streaming at all tomorrow because I'm not going to be around, but
okay, well,
I will.
So you're just surrendering. All right, okay, well, why don't you send yourself a champion on your behalf? You give them the grade. In fact, I'd volunteer maybe your other guests over here. They can champion your grade.
I told you, you know this. You know this. You're a sleazy little lawyer. I've told you. You send me the link, and I will try and find some moments to pop on from my phone.
Heard this. Where have I heard this before, Mr. Ricada? I'll try. Well, maybe let's see. What does he say here? I'll try to make it. I'll be there if I can, if I have
true
time.
things.
Okay. Okay. Well, it's all right. If you do, there's something called a default judgment, and you're very familiar with this.
I'm not ordered into court here.
And we have
Okay, give me a synopsis of your defense of this guy. You don't have to go into the whole thing. Just embarrass yourself for a minute.
Okay, well, I'm just telling you. You've got, first of all, none of y'all been a public defender before. Okay, we public defenders understand that sometimes you have a case where there is no defense. You have nothing. Your job is to sit there and occupy the seat and make sure the state follows the rules and that the rules are correct, the law is correctly applied. So that is sometimes your job when you have such a case. I would submit to you, this is such a case. There is no great defense that's going to get her a not guilty or an insanity. There's just not. She's guilty and she's not insane. So that's
Do you think
he should have added a motion for lesser included to try and get her sentence mitigated from life without parole to something else?
Well, I mean, okay, and I'm not saying this guy's perfect. I'm not saying.
Wait a minute. What, suddenly you go from no case to
no. We just have to establish the ground rules. What the ground rules are: there is no case. This guy had a very hard job. He has a job, an impossible job, and that's to sit there and defend the indefensible. All right, but that's his job.
Well,
okay.
if you're
grade him fairly, grade him with that understanding.
No, because he could motion for a reckless homicide, a lesser included of reckless homicide, either in the first or second degree, which gives her the possibility of parole.
I don't know.
Do it.
I don't know if I would ever want to have a case that I'm litigating being nitpicked, but but I'll tell you that. Your own words, Steve, hoist you on your petard in defending this guy. Because I asked
your petard is hoisted.
Yeah, your petard has been so hoisted.
By Joe, no less. Okay, Glade, let on me.
I'm simply saying, I asked you to present, like I said, if you were here, if you were a defense counsel, what argument would you make? And you started making this, and you naturally you naturally fell into the very same argument that Nick fell into of there's no intention of murder here. This was an accident, and there's no proof otherwise. And it's this very same argument that I fell into when I was after listening to his closing arguments. I said, if I was giving a closing argument, this is how I would do it, and I basically spelled out very hard, in very strong terms. I spent 30 minutes running through what my closing argument would be, and it was along the exact same lines. 3 separate attorneys coming to the same conclusion as to how you best defend this case, and he went whoop in a whole other direction of let me try to get NGI and use the phrase NGI, which nobody but me knows what it means unless you think
I don't know what it means.
Yeah,
I still don't know. I've been watching the entire trial.
We understand that, so you don't need to say it. That the question is whether or not the defense presented a good defense. Okay, well, I would say that I am not giving this person an A. They are not getting an A. Absolutely not. But
Oh.
they're
Giving him a
not
B?
getting a D minus. They're not getting
What?
a D minus. I'm telling
He shouldn't be disbarred or disciplined. Barely.
Well, okay, see, you're getting into my arguments, but let's just say that there is a path. You hear first thing, you have to choose between the insanity defense or she didn't do it defense. Okay, and I don't think that you can get into the she didn't do it defense. That is like if you go down that road, you're going to lose. So you got to put all your eggs into the insanity defense.
What about a lesser included plus the insanity defense?
The lesser included, you're saying because she didn't intend to choke, but then you'll be crushed by her statement that she gave, her confession, where she says you hug what you kill, and that prosecutor, and what you're doing by doing that is you're losing credibility with the jury. It's a choice. It's a choice.
I don't think so.
Yeah.
No, and here's why I don't think so. Here's why I don't think so. Okay, first of all, that's not the only statement she makes about her intent. She makes at least 3 affirmative statements that she did not intend to kill him. All right? In the exact same speech, in the exact same interview where we're supposed to take her at her word that she did intend to kill him, even though she doesn't ever say that, you have to infer it from analogy and colloquial speech. She expressly says she did not intend to kill him 3 different times. Then, so not only do you have that, but that doesn't destroy an insanity defense. I think it actually feeds into an insanity defense where you say, look, she was clearly not in control of her volition. Her volition, as we stated in the prior phase of trial, as you saw in her interview, that she did not intend to kill him multiple times. She went too far. She clearly went too far, but her intention was not to deliver death to this man. And it happened because she was not in control of her actions and could not manifest a concept of the outcome of those actions. She thought that she could just keep choking him and everything would be fine. In fact, she even said that and this is even better, while he's bleeding, while his face is purple and he's coughing up blood, she says,
and doing the whole job of the hut.
And do you actually believe that this happened? She said he turned and looked at her and said, keep going. I don't believe that happened, but I believe that she does. And you know why? Because she couldn't manifest the intent because she's not sane. He has these things, Steve. These tools are in the tool belt, and he didn't pull out a single hammer.
Whip it out.
Okay. Well, I actually tend to agree with what you're saying. All right.
I know you do because it's the right argument, and you're a better attorney than me.
For the sake of argument here, we are grading him as a defense lawyer. Do you think that defense has a chance in hell of succeeding?
Not on an acquittal, but on a lesser included, yeah.
Okay, so I would definitely, and we talked a little bit about this over on Vices, and we would say that I think that the argument is not the first part that she didn't know what she was doing was wrong, because she clearly knew what she was doing. It's that she's incapable of, because of her mental defect, she's incapable of resisting from once she was engaged in this process. She sort of goes nuts and goes too far because her mental defect causes her to go too far, and she can't control that defect. And like you're saying, that would go for a lesser included, or it would go to support the intent.
Right.
Yes, okay, I agree with that.
And I think he has a duty as her defense attorney to try and get her the possibility of parole, and the only way to do that's lesser included. Because I think the mandatory sentence on
in mental ward, which is what she's trying to do, which is
right. But you can do both of those concurrently, and I think you're right. I think you have the problem with either arguing there is no intent and she should be completely acquitted, or she's crazy. I think that's an issue, and that's the line he ended up walking. But I think he had I would almost say he had an ethical duty to attempt to get her the possibility of parole, and he can't get it with keeping the intentional.
Well, he has an ethical duty to be competent. Do you think that he was incompetent?
By the standards of competent counsel, no.
Okay.
But I wish he was.
All right. No, so I'm going to give you some more questions. So he is competent. Do you think that he was on top of his law and his objections when he made them? Did he miss any major objections? Put it that way.
No, that's the area I said it was good at. It's like
Okay, answer the wait.
Is there, okay, hold on. Is there a follow up to the? So we're just talking objections, nothing else.
I'm just saying. I'm just leading you through this step by step. Were there any objections that he missed?
I don't think he missed any critical objections.
Okay, and the ones that he did make, did he adequately preserve them for the record?
Think so.
Now you're talking to an appellate attorney who's being.
Yes, I'm just saying. What about? Okay,
in
so
his mind, he's a great attorney because he gave him work to do.
Yes. Did he ever lose
self-interest? Okay.
Right. Exactly.
You're such a good lawyer, Steve. You're so good. You're so good. And I mean
You're
that
right.
sincerely.
So
That's what a good lawyer does. He's like, give me something to work with. Give me something to work
by
with.
what standard are we judging this man? He's a Johnny Lunch Bucket going to that. This is one of 100 cases. He's going into court with his lunch bucket.
This
He's
isn't one of
performing
100
his
cases.
job competently.
This isn't one of 100 cases.
Well, he got the short straw. You think he wanted this case?
No. But first of all, I don't think he's a public defender who works for the public defender's office. He has his own law firm, and I believe he's an appointed attorney who accepts appointments. So he's not dealing with the same caseload as a public defender caseload normally is. So that's
Okay,
one
well,
thing.
that makes me feel even better about it.
Number two, though, he knows that this is a media heavy case, salacious details, massive interest. This is not one of 100 cases. This
I
is
have
one of
another
one
question
case.
for you, Mr.
He'll probably never have a case like this again.
Okay, let me ask you this one.
Well, hopefully.
Do you think that this judge would be amenable to theatrical courtroom behavior?
Well, it depends.
No, I didn't get the.
We saw an audition for Oklahoma. Yeah,
okay, so we have that. So we have that. So he is conforming himself to the requirements of the courtroom. Now, let me ask you this: this is
no.
He was
looking
not
like you're
as
dead inside is
performative
not
as the state.
conforming.
Okay,
yeah,
wait. I have an additional question. As a conscious choice, do emotions play in your favor as a defense, or does it play in the state's favor? Or is it more in your interest to cool the emotions and make it as rational and cold? If you want the jury to rule in your favor, are you going to want to dump emotions into the courtroom, or are you going to want to keep it as impartial as possible so that they have to make a cold, calculating decision that applies law to your client?
I don't think the answer to this question that you're fishing for actually goes in favor of this defense attorney.
No, but it's I'm just saying, as a tactical choice, do you go hard emotion or do you go cold and cool and low emotion?
I go cold, cool, and low emotion.
Okay, so which way did this defense attorney go?
I would suggest the opposite.
You think he was emotional?
Yeah.
Really?
He kept calling her young lady. He used her full name on multiple occasions, said she was a victim, said her mother died in her home and that messed her up. He appealed to emotion. That was pretty much his only thing that he did.
I don't
She's
think
a victim
so.
of her circumstances.
His temperament. His
She
temperament
just
was
happened
very
to
even
stumble
keel.
onto all these meth injections.
Listen to Joe over here. See,
His temperament was very even keel. I happen to disagree with both of you that there's a dude that he's tactically better served to cool temperatures. Quite the contrary. I think I wouldn't necessarily try to ramp them up, but I think that's displaying some passion here and trying to turn the direction from the natural inclination towards let's go get the pitchforks out for crazy mutilation woman. Instead, you turn that toward. I would try to turn that towards the misdirection here, that the state is trying to deceive you into thinking that there's any sort of legitimately reliable evidence that there was an intent to kill here, or an intent to conceal a body, or that we have any real reason to think that she sexually mutilated him other than her own crazy, backguana mind.
I'm going to mildly disagree with your assessment of this defense attorney. His inability to convey emotion does not mean he was not attempting to convey emotion and that he had taken a calm, cool, unemotional response.
You don't know
dude.
Oh
No, I know that. I
Well.
read people very well. That guy is like talking to a dead salmon. That guy sucks. If that guy came to your party, you wouldn't only shut down the party and send everyone home. You'd actually lock everyone inside and have a Viking funeral with all the gasoline and fire you could find to put them all out of their misery. That guy could kill a Roman orgy and turn it into an Amish funeral. No way ever does anyone want to talk to that guy ever. Oh, God. And that's obvious.
Mr. Froelich, if you're watching and you want to be interviewed on this, call me.
Right, the editor,
Call
do
me.
your thing.
Me too.
Well, see, you're speaking from a social party animal, Mr. Popularity guy. I'm talking about the excluded, the masses that are out here that aren't in such a popularity position.
Who are
So
you
not
trying
everybody's
to?
a party.
No, who are you? Who is he trying to talk to though? The jury of her peers, right?
No, but my advice when I'm teaching, I teach our trial division occasionally when they ask me to. And one of the things that I always instruct our trial attorneys is be true to yourself. If this guy comes out and tries to be Nick Rekieta, it ain't going to work. Nobody can do that.
I have proof here. I have proof that you're mistaken. Okay, because I actually did a Google search.
You have him partying with a hat on?
Yeah, for him at a party.
No, that guy's funnier than this guy.
I had to choose head in a bucket. So
well, it is Buckethead.
I mean,
Buckethead case.
no, look, not everybody is going to be extroverted, outgoing, charming, whatever it is. There's always a giant scale. But I'm saying the question was, does he take it cool and unemotional, or does he take it emotional?
What do you think? Is Steve, am I right or is Nick right?
I haven't been listening. Mom has.
Okay. Just
Get
tell
mom.
Nick.
Get mom.
You know who's right.
Everyone knows who's right.
Arguing about.
Just go.
It doesn't
over
matter.
You know that Daddy's right. Okay.
Oh, yeah, I'm sure he's correct. Yeah.
Now, look,
He
the
knows me
question.
long enough.
The question was not, does his personality preclude him from being interesting? The question was, did he take it emotional or did he take it cool and unemotional? He attempted to take it emotional. He's just not engaging. And
well, I did not feel that. I felt that he was trying to lower the temperature, not play emotional games. And I thought he was being true to himself he is not the party animal. He is a more methodical kind of guy, and he was true to his own self, which is what I would advise any attorney to do.
as opposed to the other attorney was like, okay, everybody, we have a murder trial here.
Yeah,
Well, he
Andy
was-
Richter was annoying. I don't like that guy.
Yes,
the only
I-
good attorney in that room was the bald-headed state attorney, and I hate saying a state attorney's ever good.
He was actually really good.
Well,
I like this
well,
closing.
let's move to something we can all agree on. Let's not have such disagreement and division within our community. Would we all agree that this is probably the best judge that we've ever seen on Law Tubes?
No, that guy. That guy from Wisconsin, the Green Bay
Borowski?
Packer fan. Oh my God,
Borowski was
I love
awesome.
Borowski.
It was
I
bad.
love Borowski.
You remember you watched a little bit of that trial with me and Bronco,
Yeah,
right, Steve?
yeah.
Borowski was the guy who's like, fine, Chambers, now,
Now.
speed it up. That guy was awesome. I liked him. But I think this guy was actually a really good judge. I stated I mildly disagreed with him on his inclusion of Dahmer in search terms for a Wisconsin person as relevant to her intent to murder. But that being said, I don't think that it was an abuse of discretion. I just disagreed that the state gave us any indication of why that is relevant. They just wanted to draw a negative inference from her searching for Dahmer and also having committed a murder. And I thought that was improper. But I don't think that that's beyond his discretion to make that evidentiary decision. I think that's the only thing I disagreed with him on.
I think the judge was great, and I actually agreed with his call about allowing that in.
I think he was on the money on everything. I think he's the best judge I've seen. I haven't been watching as long as
I
you.
would allow the Dahmer evidence in.
Now, I don't know if the judges in Florida's appellate division heard that, but Stephen Gosney did just say that that was the best judge he's seen, implying inherently that
on
every
the live streaming.
I didn't hear
On the
anything.
live
I didn't
stream,
hear
I
any
qualified that.
qualifications of
We'll edit
Steve.
that out.
Your mic's cutting out, Steve. I don't know. Steve Gosney just said that was the only judge he's ever seen with any competence at all.
I can't
Every
believe he
other
actually
judge,
said-
especially Florida judges, he said, are terrible, awful people.
No, I can't believe he called all of them incompetent like that. That was just, I mean, who goes on the air and says something like that? I mean, seriously. Wow. All right. Look, maybe he's giving up the practice. He's closing down the shingle or something.
No,
right?
I said on the law tubes, on the interwebs, on the live streamings that we've watched.
Revisionist history here.
I'll say,
Sure.
well,
Get your wife out. Let's hear her side of the story. Eh?
His wife wants him to be able to work again, so I don't know.
well, anyways, so let's just agree to disagree on something. I don't know if we disagree that much, but it's fun to disagree, is it not? And I will say that you are welcome to come and argue your position on when I grade the parties tomorrow on Rumble at 8 p.m. Eastern Standard Time. I will grade the Schabusiness, all the parties, the defense, the prosecutor, the judge, maybe somebody else. I don't know. I'll get Matt himself to give me a little more graph, and we'll grade the parties, and we'll see how it goes. And you're welcome to come and defend your D-.
You can't make this tomorrow.
This lawyer was so bad, he belongs in jail with her.
Oh no, see, you're wrong.
Now you're just being hyperbolic.
You're right. You're right. My other option on the poll was better. He belongs on a cross.
Oh, I don't know about this. We just have to disagree, and you're welcome to continue this conversation at a future event. But I can't reveal my grade until tomorrow night. You understand?
No, I'll give you my grade, and I will try and come defend it. It's D-. I think D-.
No.
I do not think he should be
No,
disciplined.
we disagree. We disagree,
I know we
but that's
do.
okay. It's okay to disagree. Who's the weighing in? Joe is good logic. Will have to weigh in on this eventually. I think.
Yeah, well, you're doing it Friday night, so that's not going to happen. But I will tell you, I'll give you my grade. My grade here would be a C-. I wouldn't give him a D-. I think that he's all over the place and poorly prepared and doesn't have and he missed a lot of points he should have. But I think everyone has different skills, and I think you're correct in that he was really good at being on top of the objections and preserving his objections. And I'll tell you something else I didn't like about him.
To be very fair,
not everyone has to be cross-examined. Not everyone you have to go through. This is what you said, isn't it? And then you said this, and then you said this, right? And just to be clear, you said you were there with these other officers who came forward and testified that they were there with you 20 minutes ago. So you were there with them, right? Those are the ones you were with? Yeah. Oh, okay. Okay.
Yeah, that's
fine. No further
something that. Well, that's another good criticism. I'm not disagreeing with you, Joe. You make another valid point, as is your want. But I will say that. Do you think this defense attorney knew his case? Was he familiar with the evidence in the case?
No.
You don't think so?
Nope.
No.
Really?
Based
Now,
on
I'm
his
not saying-
closing argument, he wasn't at all.
Really?
No, but based on
He
his
pointed
closing
to
argument.
He pointed to zero facts in his closing argument.
Well,
Yeah,
what
but he was there during the trial.
I'm changing to a D+.
Here's one thing I do want to say to mitigate my praise of his beautiful objection skills. The state did almost nothing objectionable in this trial.
Yes. Well,
That's something to praise about the state, by the way, because we've seen every trial we're looking at here. It's rare to not see a prosecuting attorney really go overboard in the way they try to push things. You know, they push where you expect them to try to push. You know, they're going to try to get in everything that's on the phone that they think is going to make her look like she's demonic. So but they didn't try to hide the ball. They didn't in no way try to impugn her for availing herself of Fifth Amendment rights. Well, mostly probably because she pretty much waved them away in the interrogation room. But still, I mean, they seem to be looking to play fair here in ways that unfortunately too frequently we've seen other prosecutors
Yeah, but
not.
when the evidence is there, same as in the Darrell Brooks case, when the evidence is there, then the level of competence shoots up.
Perhaps.
And when there's a lack of evidence, then
Prosecutor conduct is directly proportional to the strength of their case.
That's a pretty solid theory there. And when you need to grasp at straws, you're going to start cutting corners in ways that you're trying to win.
Why though? Yeah, I know it's happening, but it really
Because the
shouldn't.
motivation for prosecutors, that our system is screwed up, and that the motivation is not justice, but the motivating factors
win.
are all scalps. Yeah,
Yeah.
that you want to get big name scalps, and that's one of the massive flaws. And that's why they pick the cases that they feel like they're going to win and let the other ones plead down. It's all about what your record is in that courtroom.
Now, Steve, I want you to consider something in your rating of the judge, because I agree. I do think this is a very good, competent judge. But do you think that's because he keeps so young by eating the souls of children?
It could be. It could be. But I think it's not souls. I think it's directly from the blood. Of, yeah.
The Pelosi method.
Yeah. Well, I he reminds me of the best judge that I've ever been in front of, a fellow named the late great Richard O. Watson, who I did many of my trials in front of. And he reminded me the way he would rule, because what he would say, okay, he'd listen to both sides, and he was very good about listening to both sides, making sure everybody had, and then he would make a ruling, and then he would append to that 1 or 2 sentences of the basis for his ruling. I'm going to rule this way because I think there is some evidence, and he points to the evidence and then moves on. That is exactly the way a good judge should do it. And I would say all the good behavior in the courtroom is directly attributable to the judge. He has trained this defense attorney and these prosecutors to follow the law and to do what they're doing. That is, and if they, because prosecutors will cheat if they can get away with it, right? But I'm sure he does not tolerate that in his courtroom. So I'm giving major props to this judge.
He looks like he's the offspring of Nick Rekieta and Quentin Tarantino.
He is, but he got launched into the past and then aged past me.
Do you think she ate him?
I think she took a bite.
You think
I mean, I know she did some gnawing, like I know that happened, but I think she actually took a bite of some piece and ingested it. And I base it on a fact from the case. I think she said something to the tune of, "I don't think you're going to find all of them."
Right.
And I think she also admitted to drinking some of the blood.
The blood, I felt very confident she drank blood. That
Yeah.
I was fairly certain she drank blood. I'm just thinking she didn't cook. I don't think she cooked them.
No.
It's hard to eat raw.
Have you never had
raw meat
tartare?
of anything? I'm just
Well,
saying.
You
I'm
think
just saying.
he was collecting the fillets to cook later?
Ooh, looking
No,
at
she was.
recipes.
It was the shank. Right? She had the legs in the box.
The shank thing,
The shit, one of the feet where the heart used to be, right?
It's typical because.
Well, to be fair, she spit roasted him first. So.
No, I didn't think you had it in you.
This is
You're bringing down the conversation to the gutter.
This is what happens when I'm around bad people.
Erudite discussion here, Joe.
Close your ears, Nick. Don't listen to this guy over here. He's always so.
What are you calling bad people? Me and my unborn child? What is happening? I'm with child, Steve.
Oh boy.
And this terrible man is.
That's how that happens,
All right. Well, I'll be here all week. I'll catch you guys later. It was.
Are you actually out of here? Or is that a joke?
I think it's time for you to get to super chats.
I gotta get to super chats because I gotta finish.
And I gotta
the
bust out of here.
Yeah,
I am
and
going
I
to be
got to
streaming,
eat
God willing,
dinner.
at 10
I haven't eaten all day, and so I'm extra cranky.
Yeah,
Go eat, cranky boy.
I'll be streaming at 10 p.m. Eastern. Are you streaming tonight, by the way?
I'm
because
supposed to.
if you're not going to, I'll seriously run an extra 2 hours because I have like 3 long stories to cover, and if not, I'll just cut one of those stories out. So that's why I was asking you.
I'll text you. I'm supposed to. That was the plan, but I'm on like almost no sleep. And,
I'm not trying to chase you off. If you're doing it,
no, I
you
know.
Do it. I'll keep my eyes open for you, and whatever it is, you don't even have to text me. Whatever it is, I'll work around. I'll work around what you end up doing. All right. Anyway, that's at 10 p.m. Eastern. Great hanging with you, Charlie. Seeing you both you brothers as always, and Godspeed.
Bye.
Bye. Yeah, and I'm going to go. I hear my dinner is being eaten by my family, and I'm not there, so that's not cool. So I've got to sign off too. But
get out of here, brother.
I'll send you a link, and God bless you. You're a good man, and thank you for your forward to prepare. Available only at stevegosney.com. It's a book. It's my most personal book, and Nick, I'm honored that he wrote the forward. So thank you very much.
Happy to do
God
so,
bless you, and good night.
Bye.
Okay. Well, I'm going to start just burning through super
Yeah.
chats and catch up. So
I think Court's gonna be back within
see.
your super chat reading. So I'll shut up.
Yeah, we're almost at 45 minutes. Miscellaneous says, I wish this judge and all lawyers had to wear cheesehead hats in the way the British court wears wigs. Eric the Red, we have Dr. Dickus and Dr. Prickus, defense attorney nerd, probably. Wolfgang Deo, July, American Pride Month is almost over, guys. August, named after Augustus, who was emperor when Christ was born. Is everyone ready for Christian Pride Month? Down with the CCP for Mother Russia. Papal commendation, please. That was intense. I don't know what to do with all of that. Kara Miche says, thanks for covering this difficult trial, Rackets. Oh, it's been a pleasure. This has been a fun trial. Very interesting and engaging all the way through. I've enjoyed covering this very much, and it's not 7 weeks long, so that's good. Gast Grunt says, apologies for bringing up a topic from hours ago. On the question of consent after losing consciousness, I think if you give consent until passing out, you lose consent when you lose consciousness. However, upon regaining consciousness, you can retroactively give consent if you're okay with what happened. You can also remove consent if something you weren't okay with happened. Of course, you can also discuss what you're okay with beforehand if you expect to pass out. That's what makes sense to me. And I think that is, in effect, kind of how things work. I'm just let me be very clear on why I have problems with this from a criminal law perspective specifically. Conceptually, I fully agree. Conceptually, I think that is appropriate. From a criminal law perspective, we must always bear in mind that the rules and standards we are setting result ultimately in the best case scenario for the perpetrator, a removal of liberty. So is the rule sufficiently clear to justify removing someone's liberty, and in the worst case, to justify execution by the state over a conflict that arises from the encounter? I'm not always sure that the laws are sufficiently clear to do so, even though I may think something is conceptually accurate. That's what I'm saying. That's why I want the laws to be clear on these things. And Wisconsin's law just isn't. The letter of the law. There could be a Supreme Court opinion. I don't know from Wisconsin. I haven't researched the issue heavily to say that that this is how it works. But the law is written that you cannot give consent when you're unconscious. It does not say that consent ends when you lose consciousness or when you die. And that, I think, is a problem for how the law is written. It should be clear. It should be concise. And if the Supreme Court rules on it, I think the law should be amended to model the Supreme Court or to make it more clear that they want it in the opposite from the Supreme Court, because that's how we do law. That's what I want. Clarity in the law. And I actually don't particularly care how Wisconsin decides the case. I'm just noodling through my rationale and how the law is written and how I think it should work under the current interpretation. But that's that. Okay. So we won't hammer on that subject anymore because it's taken a large portion of multiple streams now because it's weird. Timothy Tinkliff says, who would you recommend for sharing highlights, news clips from ongoing trials? I want to move a streamer I follow off of copyright cucks, law, and crime. Thanks. I have no idea. Court TV, local news stations, or any law streamer who is doing it would be viable alternatives. Court TV isn't the greatest on copyright issues. Let's do local affiliates being the best ones that you'll find. Visevoldol Vodka says, does that state law have an exception for post-mortem organs examination, or is that a sexual assault too? Is organs examination a coy way of saying organization of the sexual organs? No. The sexual assault law is penetration without consent of the genitals, the anus, or penis to mouth penetration. Any penetration of the genitals or anus, which would include the urethra on a man, vagina of a woman, anus on either, and then penis penetration of a mouth. That's the statute. A mere touching, grabbing, yanking, tugging apparently isn't under this specific statute. There may be another one. Joe Sullivan, I hear the train. I hear the train a coming. Okay, I'm not gonna do all this. Is rolling around the bend. I ain't seen his heads since I threw them in the bin. I'm stuck in Folsom Prison. Time keeps dragging on, but that butter knife keeps sawing down the bone. You can imagine it better than I can sing it. Red One says, this guy is boring to listen to. Please shove a dildo in his mouth if it's still in the courtroom. Woo! Damn. Chris Onion. Hey, Nikki boy, good to see you doing a trial again. You connected with the civil rights lawyer a little bit. I think we've talked on Twitter. His slogan is freedom is scary. Get used to it. And profile pic is him smoking a cigar. Seems like your people. Yeah, we talked about doing a show a long time ago and then kind of lost track. I think we'll probably reconnect at some point. T-Rex trucking more. Doesn't the Wisconsin statute say that sexual assault necessarily includes penetration, though? Yes. This subsection of the sexual assault statute in the third degree requires penetration, which happened here, to be clear. According to her, it happened. Grifty says, is it cucking out to delete a tweet to unlock my account if all appeals are going unanswered and the person I was supporting has been reinstated? No, not my opinion. Marrero says, you did it. You woke up in time to talk some more law. Haha, just chug some rock stars. Dude, so they were supposed to voir dire that witness at 8:15 and then they didn't. That was horrible. Could have started at 9:15, but no. Aniston Jade says, glad to see you back. Ricada, quick up to speed on the trial. No clue what this one is about. I think you've got it by now. This was a long time ago. It's at 8:30 in the morning. King Ginger, the best bad movie of all time is Killer Clowns from Outer Space. Awfully amazing. That's not a bad movie, you bigot. Rick Nikeda, I'm so glad we found a sexual fetish you're not interested in. Necrophilia. It's true. Chris, I wonder how much antidepressant she took. Taking as little as a double dose can remove all inhibitions. Wouldn't have been good for decision making. Tina Bogle. Hi from Dubai. You are waking up and I'm about to sit for dinner. This trial is wild. Every time she smiles, I feel like she's about to attack someone. Me 04120. Get up. Come on, get down with the Schabusiness. Marrero, I sent you a DM on Twitter of the letter that Taylor Schabusiness' husband wrote from jail. If you wanted to give it a read, not right now, but maybe tonight on the stream if I do one, which I'm leaning towards doing a stream. Tara Rayner says lead, meth, and bread knives. Oh my, Natalie, I have so many questions and not enough money. Good morning, all. Loki 177, welcome to Paralegal 200-watt studio. Natalie, Nick talked about illegal morning BJs. I did. I think the statute has issues. Eric Linegar says this judge has also made other bad calls. His choice of ties are a crime. Marrero, man, he's a god-awful lawyer. Save Schabusiness. Rosalind Duke says this evidence is too gross. CS, mania, psychosis from SMPI are pervasive, and you should see symptoms from either directly following because functionality is how we determine disorder. DCV Titan, not that he'll admit to it. Prison marriage is a nasty thing if you're the bottom. Oh, that was when they asked her dad if he was married, I think. 200-watt studio, name of your son, None of Schabusiness. Mary Coppola, she did give the judge gun fingers the first day. Some generic name, why does Schabusiness always look like she's passing a kidney stone? She has a weird aura about her, weird facial tics and behaviors. That doesn't mean she's crazy.
I think that was all fake though, because the whole last couple of hours, she was just unamused, realizing, oh fuck, there's a 0% chance that it's gonna go slightly my way. She didn't do any of the grinning and the laughing and the.
Yeah, I think a lot of her stuff was performative.
Yeah,
including her evaluations post arrest. Ciro says this case has inspired me to cut down my drinking. Zookster, this must be Amber Heard's sister. Ciro, gotta watch that weed to choke collar pipeline. Weed to choke collar pipeline. RP, someone stuck their pee-pee in this. Steven, just getting here. Hey, Charlie, sup, girl? Kristen S. Huzzah for Natalie. Good to see you. Charles Argo, she speaks in a word salad, so why isn't she the vice president? Sarah Holden, she isn't a psychiatrist. She's a psychologist who does not have expert knowledge of medical treatment. DCV Titan, she couldn't appreciate the wrongfulness of her actions at the time, but in the interview, she said she was worried about being caught while leaving after killing Shad at the time.
And that she had to apologize to the sister. That's a big one too, realizing that you've done something wrong.
She definitely knew she had done something wrong. I don't buy. I think you can get past intent. I really do think you can get past intent. I don't think you can get past the realization of what you've done, and knowledge that what you have done was wrong.
I agree 100%.
Kelly G, you know what stinks? Lachlan. Ciro, welcome to Paralegal. Mephisto's movie reviews. That was as bad as the infamous Dr. Spiegel. Jamie Green, behind but listening to the woman doctor, and it sounds like my 11-year-old bipolar son. I've watched him struggle since he was a baby, and so many people tell me he seems normal. Depends on the day. They can be scary. Yes. The problem with her bipolar diagnosis is that when she's making the diagnosis, Taylor Schabusiness fails the final portion of the diagnosis requirements, the final prong, which is, are they under the effects of a mind-altering drug? If they are, they cannot make the diagnosis. She makes the diagnosis while she knows she's on the presence, under the influence of methamphetamine. She can't make that diagnosis. I think that maybe the state could have argued that a little bit more clearly, but they did elicit testimony about it and mentioned it in close. But that's the problem with her diagnosis. Diablo Butai says, I feel like Taylor just does not like other women. She was fine talking to the men, according to the psychologist. She seems a little sketchy to me. Chugi Show Live says, didn't she waive her right to testify yesterday? Yes, but this is the second phase of the trial, and she gets a separate right to testify if she wants to. Victoria Wright says, Britt learning about the U.S. system here. Is her defense limited, or do you think it is, by not having the funds for better expert witnesses? Maybe. I think the problem that they have is there were five psychologists or psychiatrists or whatever, mental health professionals who evaluated her, and only one of those 5. And not all of those were state, including another defense evaluator that they didn't call because they found that she wasn't crazy. Only one of the 5 found any evidence of any diagnosis at the time of the killing. And the judge also said that in his personal opinion, that was the least credible of all 5. So you got an issue with that.
Also, I think the prosecution, I heard them state that she was entitled to have more state-appointed evaluators. That
I think that what he said precisely was, if they wanted her to review more facts in the report, they could have requested it. If they wanted her to interview the defendant again, they could have requested it. I'm not sure they could have kept requesting professionals, because at some point there is a limit on money. But I don't know.
But I don't think the limit. I don't think the limit was reached. That's what I.
Yeah, and I have no idea where that line was for them. 64-bit goodness says, Taylor, Dad, when you commit crimes, do you think of Blink-182 songs? Father, yeah. What's their age again? What's their age again? Oh. Wow. Duncan Ido says, Natalie, branding idea for when you open your own firm. Name change to Natalie, Wisconsin. Yes, no. Lisa Franceschi, you need to place your Pope hat on and perform an exorcism on the PhD who had an outburst on the stand during cross. Duncan says, so basically charisma is essential to be a good trial lawyer. No, it's not. It is not. Steve is right. You play to the type of personality that you are on the stand. This guy, I don't think, I disagree with Steve that he took this to where he was. I think he tried to take it emotional. I think he was bad at conveying that. And I do not see a cool, calm, collected, cold, calculating, factual approach to this case. The facts were missing, the calculating was missing, and the cool and calmness was missing. He's just flat. And he probably should have strayed towards that factual, analytical approach. But there are plenty of attorneys who don't have much personality who can give you that straightforward analysis, and it can be very insightful and very cutting. That just didn't happen here because that guy's not a good attorney. He's just not good. You have all the evidence to figure that out.
Just gonna use the little girl's room.
Sounds good. Sounds like verdict's in, so it's probably gonna take 10 minutes or so for the jury to get in. Oh yeah, verdict reached. I'm looking at it right now. But they're not here yet. So Marrero. Oh wait, no. So he plateaued at not technically incompetent. No, and again, he needs to focus on the facts, and he didn't. He didn't do it. Marrero, was the guy's arms and hands tied or something? Why wasn't he able to just stop her? I don't understand that part. Do you know? Okay, so I've seen this a couple times. People have said, oh, well, he struggled. So therefore she should have stopped. I said this yesterday. I'm going to say it again. I am not a strangle asphyxiation person. Not my thing. Don't want to be close to losing consciousness. Doesn't do it for me. None of that does. But if I had to guess, the appeal of the asphyxiation fetish involves the idea that you get to the point of that struggle. And if you have trust with the other person, maybe you go a little farther. Maybe you go to the point of unconsciousness. Maybe that's a thing that they do. I don't know, but I don't think that a struggle necessarily precludes it. And on that note, if she's on him while he's on his stomach, she's on his back, choking him from behind, and he starts to lose consciousness, or even if he doesn't start to lose consciousness, he'll become weak. If you start getting choked out, your limbs stop working very well. You're not really able to resist in the way you normally are. Me04120 says, if this is a civil trial, can Taylor call the state of Wisconsin to the stand and demand the plaintiff be cross-examined? Jesus Christ. Oh, this is that lady. Thank you so much for your efforts in defending Kyle. You guys are awesome. Brian Miller, did Gage's trial take place yet? Stephen Gosney, Nat, great judge, prosecutor, and insert descriptor here, defense here, and Brooks trial. Yet prosecutor and Rittenhouse and Anderson were terrible. Explain. Shut up, I can cook, says Nick. Family you love, very weird. Thanks for this. Duncan, Idaho, psychologist. We're scientists. This is real science. Speedy the Unsilent. God damn, that woman has a strong chin. Duncan, Idaho. As a layperson, if I were in the jury, I'd say, well, of course, you're saying this wacko belongs in a padded cell. Adverse says, that one, red one.
Okay.
One
Anything to bring up before the jury comes back, Mr. Saunders?
Break with no guards or guns. Throw all these crazy murderers of both genders and see what happens. That's just Escape from New York. Here we go. Here's the jury's coming. Ryan Acorn, since she's still married to a different man, her and ST were committing adultery, so this whole thing is basically divine retribution. Shroom Dukem, I just got here. Who do we want to win? Don't care. Torst says, for the first time, YouTube informed me other people will be able to see that I'm subscribed to you. Very interesting. Thanks for your work from Norway. Thank you. Ryoji Mata says, Andrew is trolling you. American Dreamer, Nick, is this a good time to take a calming gummy? No. Mats Carlson says, Dr. Engine, where's Dr. Head Gasket? Mandy says, Joe, haven't seen a murder this bad since the Dallas Cowboys 2023 playoff run. Roscoe, Mrs. Joe hasn't been D'd down properly. I take, oh, that's rude. Ooh, for Christ. Nick, how could loss of consciousness not impact consent? You cannot reasonably believe an unconscious person is consenting. I guess the question is whether consent is an ongoing, continuously reaffirmed thing, or if consent goes until it's revoked. And I think that is a question that needs to be definitively answered in the law. I'm not sure what the right answer is, but I don't think it's clear. And it's certainly not clear in Wisconsin law by the letter of the statute. Again, maybe in a Supreme Court case, haven't read them. Tortalicious, duty of care for medical emergency during sex. There is no duty of care for medical emergencies, even for doctors in almost every instance in the United States.
You are the foreperson, is that correct? Yeah. If you could hand your verdict to the bailiff.
Hair Frozen says, what if two 17-year-olds doing it at the turn of midnight, one of them turns 18, are they raping a minor when they become 18 and can consent per law? Typically 17 to 18 is permissible under most
Verdict
state
seems
law.
to be in order, and I will read it as follows.
All right, here we go.
Question 1. At the time the crimes were committed, did the defendant have a mental disease or mental defect? Answer, no. There's
Done.
no answer then for question 2. It is dated this date, July 27, 2023, signed by the foreperson. There were no dissenting jurors.
Unanimous.
Yep.
Is there a request by either of the
See-
parties to have the jury polled? Mr. Saunders?
No.
Mr. Freilich?
Yes.
We did this
God.
last time, ladies and
I know
gentlemen.
you
I'm gonna-
have to,
I'm going
but
pull
bruh.
you again. I'm going to start in the back. Ma'am, are these your verdicts?
Yes.
Ma'am, are these your verdicts?
Yes.
See her face now. That's been
Ma'am,
her
are these your
face for the last 2
Ma'am, are these your
hours.
verdicts? Sir, are these your verdicts?
Yes.
Ma'am, are these your verdicts? Start down here. Sir, are these your verdicts?
Yes.
Ma'am, are these your verdicts?
Yes.
Sir, are these your verdicts?
Yes.
Sir, are these your verdicts?
Yes.
Ma'am, are these your verdicts?
Yes.
Ladies and gentlemen of the jury, your service in this case is now completed. Many jurors ask if they are allowed to discuss the case with others after receipt of the verdict. Because your role in this case is over, you are not prohibited from discussing the case with anyone. However, you should know that you do not have to discuss the case with anyone or answer any questions about it from anyone other than from the court. This includes the parties, lawyers, the media, or anyone else. If you do decide to discuss this case with anyone, I would suggest you treat any discussion with a degree of solemnity, such that whatever you do say, you would be willing to say in the presence of your fellow jurors or under oath here in open court in the presence of the parties. It is in the public interest that there be the utmost freedom of debate in the jury room, and that jurors be permitted to express their views without fear of incurring the anger of any litigants or criticism of any person. Please respect the privacy of the views of your fellow jurors. Finally, I'd like to address you before you leave, so if you could just wait in the jury room for a few minutes, I'd appreciate that.
Sentencing
And, you
phase
may
is done
confer
by
with
the
me at
judge
any
in
time
Wisconsin,
before
not by the
answering any
jury.
questions from anyone.
I would assume it'll be at a separate hearing, but
And
we'll
with
find
that,
out in a minute.
We excuse the jury. All rise for the jury.
I did a good job. Steve Gosney said so.
Be seated. Then, having received this verdict as well as the prior two, does the state have a motion regarding the verdicts? Mr. Saunders.
I'd ask the court to accept the verdicts and enter a judgment of conviction. I do have a certified copy of a judgment of conviction, case 20 CF 998, as the basis of the repeater allegation in count 1, 2, and 3 information.
Those will be received. Mr. Freilich, any response to that request?
Your Honor, I bring a motion for judgment notwithstanding the verdict. I believe there's testimony, ample testimony in the record that my client was suffering from a mental disease or defect at the time of these offenses, and that she lacked the substantial capacity to appreciate the wrongfulness of her conduct and conform her conduct to the requirements of the law. I'd ask that you consider all of the testimony from Dr. Lighton, who's a seasoned veteran in the field of
Are you going to hit the element that no reasonable jury could have come to this conclusion? Nope.
Thank you. Well, I've listened to
Never.
the entirety of the
Never.
testimony
0%.
over these last several days, and specifically regarding today's testimony with regard to the responsibility phase. I'm satisfied that the evidence is sufficient to support the jury's verdict, and I'm going to adjudge the defendant guilty on count 1 of first-degree intentional homicide as a repeater, count 2, mutilating a corpse as a repeater, and count 3, third-degree sexual assault as a repeater. I'm going to revoke bond at this time then, and I'm going to order a pre-sentence investigation report be conducted. I'll order that be released no later than 1 week in advance of sentencing, and I'm looking to schedule the sentencing date. September 19th.
Let's check that out here. I already have a scheduled jury trial on September 19th and 20th, Your Honor.
There's no death penalty in Wisconsin.
It's going to be life without parole, right? It's no question.
I don't know
about
what
it.
mitigating factor you got here. They failed to prove any mitigating factors at trial. So they'd have to come up with something else as to why. And they essentially shot their shot on what could be mitigating factors of mental infirmity, stuff like that.
Yeah. Okay, well, that's my cue. I just, it's late. I'm going to join hubby. Thanks for having me on again. It's really nice.
Yeah, my
do
pleasure.
do super chats during your evening show. Go to bed. It's
Nah, we're almost
almost-
done. Not too many more, honestly, so won't be too
Okay.
long. But have a good night.
Bye, guys.
I just have an inquiry. Would it be set for the whole day? For half a day? I've got hearings that day, but I could
8
try to
minutes.
move some things around.
I understand, Mr. Fraley, and I'd appreciate it if you could do that. That's 2 months out. I have things on that day too, and you might be getting a phone call. You might be getting a phone call from my office asking if one of these cases can be moved, which will be easy to get permission for me to do that. But I would schedule it for 8:30 in the morning. I don't know how long it's going to take, but I would plan on the matter taking the entirety of the day.
Your Honor, I think I can move everything, but if it could start at 9:30?
Sure, I don't have a problem with that. 9:30 in the morning. Mr. Saunders, I see you checking in the back with, I'm assuming with the crime victim. Is that an acceptable date to schedule?
Yes, I believe it is.
Okay. September 26th, 9:30 in the morning. I'll have that scheduled for the balance of the day. 9:30. He asked for it to start at 9:30.
Yes.
All right, very good. Anything else before we adjourn, Mr. Saunders?
No.
Mr. Freilich?
Your Honor, that pre-sentence report, if I only have a week, I can imagine this one's going to be long. Could I have a little bit more time, maybe get it 10 days before?
I will, here's what I'm going to do. I'm going to order that it be released no later than 2 weeks in advance of sentencing. This hearing is about 2 months out. I didn't count the weeks, but I think we can get it done in that amount of time because they tell us they can get them done in 6 to 8 weeks. So that's what I'll order. Okay.
Thank you.
And with that, the matter is concluded. Thank you.
Thank you very much.
There she goes. There she goes to jail. She's not getting out 'cause she just ate the shad. Children were molested by her dad. Da 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 da. She's done. Nothing is over. All right. All right. Doesn't look like anything else is going to happen. If it does, I've still got the video up if anything interesting happens, but it's done. It is done. Okay, here we go. We're going to finish these super chats and Rumble and locals, and then I'm going to wrap up because it's been 10 and a half hours. Mary Capola says, BS on OCD. She would have had clean clothes and squeaky clean hands when arrested. She had neither. Duncan Idaho says, do you think this defense attorney has a wife that he makes love to? Matthew Self, the prosecutor, is built like a premature pear. Shut up, I can cook. Perfect. Joe is here. A white Russian Jew about in his later mid-30s tried to pick me up at a bus station estate sale in Flushing. Joe? I said no. Law Kong Express. Hey, Joe, please tell Nick how innocent Zachariah Anderson is. Steel Manning says, I wasn't aware Shadiversity was so kinky. Go for big guys. Does this lawyer make you proud of your profession? Oil King says, Nick, thanks for awesome work. Love from the Matt Christensen from the Matt and Blonde show. Yag, yag, yag. I tooted. There's no sense of crazy person, just a bad person. Lady Lee Bell, did they put her on the stand? Nope. I had to run errands. She refused to take the stand again. Chuck in Tennessee says, could the defense attorney be moonlighting as a Baldo salesperson? I guess anything is possible. Anything is possible. Okay. Now we are over on Iceman says, other than the overcharging, I think this is a very clean prosecution. I agree. The overcharging is the only black mark. It's not much of a black mark. In all honesty, it's not much of a black mark because they were able to prove intent. I think it was on the defense. They had evidence of intent. It's not like they didn't have it. I think it's the proper outcome, but the defense, as we learned from Ms. Wisco earlier today, it's on one of the parties to motion for a lesser included offense. The defense didn't do it. And I think it was incumbent upon him to do that in the interest of having his client have a possibility of getting out of prison at some point in her life. He didn't. He disagreed, I guess. Didn't know. I don't know what his issue was. Didn't do it. They had evidence of intent. I just think they had better evidence of non-intent, of recklessness. So I don't think it's much of a black mark. To me, probably the second best prosecution I've seen on this channel. What do you think, Nick and Joe? Well, that's what I think. Darcy, thank you so much. Says, thank you. Been fun having trial Nick this week. Cheers. I have been looking for an opportunity to do one. Oh, by the way, if you are not subscribed on Rumble, we're really close to 140,000 subscribers on Rumble. So make sure you click that subscribe button, follow button, whatever it is. Also on both of these things, click the thumbs up. Thank you so much. Iceman also says, for Joe, what if she's into it when she passes out? Hard to say the consent is removed. In loss of consciousness, this line of reasoning is how we get rape, called for either party having consumed alcohol. Super slippery slope, in my opinion. Correct. And that's why I think the law needs to be clear. Because if that's the law, make it the law. Let people know. The law does not state anywhere that loss of consciousness removes consent. Again, someone could be like that. Julian Delfici, don't need to read this. Just saying thanks for the trial. Well, Susbert says, watching you chat with Natalie Wisco about Rittenhouse reminded me about this little gem I found. It's the Zeminskis. Oh my God. I'm not watching anything else right now. I'm finishing up and I'm gonna go take a nap. 6'4" midget says, what we make legislation where prosecution and defense attorneys have the budget for each case. Real Patriots Party. Nick, you blew off my $10 Rumble rant and the electrical failure excuse. You owe me, you bitch. It was in reference to this case. I don't have it. Sorry, my computer shut down. Rofflo 1804 says, when's this hag's 30+ year postpartum abortion? We need it televised. Ben Dustin says, Taylor picks up a pen and attacks. Somber moment. It's very likely, if she actually has suicidal ideation, that she doesn't make it much longer after this. You know, that's how it goes sometimes. No, we're at 10 hours and 28 minutes so far. Mild One says, guitar pick check. I don't have a guitar pick. Oh, that was for Gosney. Ogonzo, hey, Nick, do you think this lawyer will have any trouble sleeping, considering he got this innocent queen convicted when it was clearly self-defense? You better be sleeping, watching his back for that Schabusiness coming at you. Matt himself, I really need you to push to have this defense lawyer on for direct assessment with Natalie as a guest on as well. Ryan says, Ricada law, consent doesn't end until the dick gets limp or the pussy goes dry, death or no death. Ogonzo, Joe, imagine you're having sex consensual with your wife. You give her a mind-shattering orgasm and she passes out. Are you now legally required to stop and reobtain consent? I know these situations sound ridiculous, but there are situations that people face. And I, for one, am uncomfortable with the idea that, well, they could retroactively grant or revoke consent. I think there's a lot of danger in allowing a retroactive granting or revoking. Much better, in my opinion, to simply clarify the law. Simply clarify the law. And I do think the circumstances change. And I think there's practical aspects on the application of the law between like married spouses and between one-night stands. Obviously, those are different scenarios and would probably have different treatment. But I don't want to rely on discretionary treatment for my laws. For my laws, I want them clearly written and clearly understandable. Elgonzo, can him not providing the additional requested documents amount to malpractice? Now, in a weird way, it kind of worked out almost in his favor. I think if he had tried to get it too far, it would have he could have gotten in trouble for it, but it just seemed like a stupid move. It didn't seem malicious to me. In all honesty, it just kind of went along with how I felt he handled the whole case. He just seemed unprepared on any of those issues. Dark Omen 42 says, love you, Natalie. Keep being a good lawyer. Look forward to seeing you next time. Miller Welds, Ricada Law, is it too late to call Taylor's cousin Vinny to fill in? I feel like he could do better. Ogonzo, this queen did nothing wrong. She was clearly defending herself. Hashtag justice for Schabusiness. He says, I still can't get over the last name engine. And then finally, Torgo the White says, hey, you drugged up fig. Has the Eventbrite still not been put out? Did I just miss posting for it or something? I will get it done today. I just got to go take a nap. That is what needs to be done. The Eventbrite, for anyone still here, if you're still here, I don't know why, but I love you. I am having a live show September 16th in Nashville. I will try to get the Eventbrite put up today. It will be posted on Locals. I will be sharing it wherever. We'll see about a stream tonight. We'll see. I was not anticipating 10 and a half hours today. Lady 50-ish says a little something for your time. Oh, thank you so much. Thank you, thank you, thank you. But yes, if you want to hang out with me on September 16th, and other people will be there. Camelot, I believe, Dick Masterson, maybe a couple Law Tube folks as well, but I don't want to announce anybody and like artificially commit them to it. The Vegas show was a lot of fun with a lot of people just hanging around, talking, chatting, get autographs, pictures, whatever, buy people drinks, share drinks with people, tongue kiss them. I don't care what you do. They're a lot of fun. The venue is 3rd and Lindsley in Nashville. We have the venue. It is reserved. Deposits made. We're good on it. I just got to get the ticket sales up. So we'll see you guys very soon. Thank you for watching. I'm not going to play the outro because I don't want to wait 3.5 minutes. I got to go to bed. Have a good night. Peace. Marrero says, I'm selfish. Please do a stream tonight. We'll see. I'm not ruling it out, but I'm not ruling it in. It's gonna be how the next couple hours go. Peace. Peace.